ಯಾವ್ದು ಇರೋಲ್ದು ಗೊತ್ತಾಯ್ತು.
Certainly. Sorry. Sorry.
ಇವತ್ತು ಯಾರೋ ಬೇರೆ ಬಂದಿದೆ.
My lords, my
All memos, end of the list, move it tomorrow. Today there are 500, 0 memos for today. ಎಲ್ಲ ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ. ಎಲ್ಲ ನಾಳೆ ಬೆಳಗ್ಗೆ ಸೆಟಲ್ಮೆಂಟ್ ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಿ.
my lords,
ಏನಿದ್ರು ನಾಳೆ ಬೆಳಗ್ಗೆ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ 2:30 ತಗೊಂತೀವಿ. There are 500. How much can I take? ನಾಳೆ ಬೆಳಗ್ಗೆ. All tomorrow morning. ನಾಡಿದ್ದಿಂದ ಇಲ್ಲ. Last 2 days ಇಲ್ಲ. Last 2 days. ನಾನು ಮೊನ್ನೆ ಹೇಳಿದ್ನಲ್ಲ ಕೋರ್ಟಲ್ಲಿ 29, 30th ಐ ಆಮ್ ನಾಟ್ ದೇರ್. ಯಾಕೆ ಬೇರೆಯವ್ರು ಇದಾರಲ್ಲ, ಬೇರೆಯವ್ರು ಇಲ್ವಾ? ಏನಾರು ಇರ್ಲಿ, ನಾಳೆ 2:30 ಮೂವ್ ಮಾಡಿ. ಇವತ್ತು 500 ಇದೆ, ಐ ರಿಯಲಿ ಕಾಂಟ್ ಟೇಕ್. ಅಲ್ಲ, ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್. ನೀವ್ಯಾಕೆ ಸರ್ಪ್ರೈಸ್ ಆಗಿ ನೋಡ್ತಾ ಇದ್ದೀರಾ? ನಿಮ್ಗೂ ಅದೇನೆ ಡೇಟ್ ಇದ್ರೆ ಆಪ್ಷನ್. ಡೇಟ್ ಇತ್ತಾ? ನಾಳೆ ಬರಲಿ, ನಾಳೆ ಮೂವ್ ಮಾಡಿ.
ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡ್ಬೇಕಂತೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. ಎನಿ ಸೆಟಲ್ಮೆಂಟ್ ಪ್ಲೀಸ್ ಗಿವ್. ಟುಮಾರೋಗಾದ್ರೂ ಕೊಡಿ ಸೆಟಲ್ಮೆಂಟ್. ಸೆಟಲ್ಮೆಂಟ್ ಕೊಡಿ. ರಿಸರ್ವ್ಡ್ ಏನಾಗಿದೆ ಕೊಡಿ. ರಿಸರ್ವ್ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? ಯಾವ್ದದು? ದಟ್ ಸೆಟಲ್ಮೆಂಟ್ಗೆ ಏನ್ ಬಂದಿತ್ತಲ್ಲ ಅದು, ಓನ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್. 3 months ಆಗೋಗಿದ್ಯಾ? ಮತ್ತೆ ಬಿಡಿ. ನೋ ಐ ಕಾಂಟ್. ವಾಟ್ ಎವರ್ ಅರ್ಜೆನ್ಸಿ ಐ ರಿಲೀಸ್ ಇಟ್. ಬೇಕಾದ್ರೆ ಸಾಯಂಕಾಲ ಲಿಸ್ಟ್ ಮಾಡಿ ಮೇಡಮ್, ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ವಿಲ್ ರಿಲೀಸ್ ಇಟ್ ಫ್ರಮ್ ಪಾರ್ಟೆಡ್. ಎಸ್, ವಾಟ್ ಇಸ್ ದಿಸ್? ಎಲ್ಲ ಅರ್ಜೆನ್ಸಿ ಏನ್ ಮಾಡ್ಲಿ ನಾನು? ಎಲ್ಲ ಬೇಕೆ, ಏನಾರು ಇರ್ಲಿ, ಏನ್ ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ. ನಾಳೆ ಕೊಡಿ. ನಾಳೆ ಮೆಮೊ ಕೊಡಿ ಬೇಕಾರೆ. ಬಟ್ ನಾಳೆ 2:30 ಬೇಕು ಅಂದ್ರೆ ನಾಳೆ ಮೂವ್ ಮಾಡಿ. ಪರವಾಗಿಲ್ಲ, ಮೆಮೊ ನಾಳೆ ಕೊಡೋಂಗಿದ್ರೆ ಕೊಡಿ. ಇವತ್ತಂತೂ ಯಾವುದೂ ಇಲ್ಲ. ಟುಡೇ ಯು ಗಿವ್ ದ ಮೆಮೊ. ಎಸ್, I want to give the memo. Today no 2:30 matters. Yes. Madam, ಅದು ಮೆಮೊಗಳು ತಗೊಂಡು ಎಲ್ಲ ಕೊಟ್ಟು tomorrow. ಇವತ್ತು ಯಾವುದು ಕೊಡಬೇಡಿ, ನಾಳೆಗೆ. ಸೆಟಲ್ಮೆಂಟ್ ಮಾತ್ರ ಇವತ್ತಿದ್ರೆ ಕೊಡಿಬೇಕು. give the memos.
My lords, we were given
ಇನ್ನು ಉಳಿದಿದೆ ಅಂದ್ರೆ ಇದ್ರೆ ನಾಳೆ ಬೆಳಗ್ಗೆ 10:30 ಮೂವ್ ಮಾಡಿ.
My lords, on Saturday we were given a date for today. It's not listed.
No, yes, next. ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡ್ಬೋದಲ್ಲ? ಯಾಕೆ ವಾರಂಟ್? ಅಲ್ಲ, ಯಾಕೆ ವಾರಂಟ್? ನಾಳೆ ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಎಲ್ಲ what to do?
My lords,
nothing doing. 3 months ಆಗಿದ್ರೆ ಮಾತ್ರ ಹೇಳಿ.
my lords,
tomorrow. See, give it. Yes.
my lords,
ಕೊಟ್ಬಿಡಿ ಮೆಮೊ ಎಲ್ಲ. ಯಾವಾಗ ಬೇಕು ಸೆಟಲ್ಮೆಂಟ್? ಸೆಟಲ್ಮೆಂಟ್ ಕೊಡಿ ಇವತ್ತಿಗೆ. ಸೊ ವಾಟ್ ಸರ್? ಯಾಕೆ ನಾಳೆ ಆಗಲ್ವಾ? 2:30 ಇಲ್ವೇ ಇಲ್ಲ. ನೋ 2:30 ಟುಡೇ. ಗಿವ್ ಇಟ್. ನೋ ಪೆಂಡಿಂಗಾ? 2027 ವಿಲ್ ಟೇಕ್ ಇಟ್. ಎಸ್, ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಮೂವ್ ದಿ ವೆಕೇಶನ್ ಬೆಂಚ್. ಅಲ್ಲ, ಮೆಮೊ ಕೊಡೋದು ಕೊಡಿ. ಕೊಡಿ ಎಲ್ಲ. Where did you come from? Bombay? Listed today? Then?
Last time I have moved the recipe, but I will not got the final number. So therefore matter was not listed. Matter is that that session code has ordered that we have to deposit 50%, 15% in 9 criminal petition.
138 proceedings.
Yes, yes.
Give
There
it.
is there is a no protection for me, and one of the accused is 75 years, he got arrested.
That doesn't mean 20% should not be complied with.
Lordship, I'm relying on the judgment.
Jambu Bandari. What else? Yes.
Lordship, we are ready to, once our appeal is decided, Lordship.
Nothing. Statutory mandate cannot be diluted like that, sir. Nothing. Yes. You move it. You give the memo.
This is a fresh matter.
Give, sir. ಇವತ್ತೇನಿಲ್ಲ ನಾಳೆ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ಅಂದ್ರೆ ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ. ಎಸ್, ನಾಳೆ ಮಧ್ಯಾಹ್ನಕ್ಕೆ ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಸರ್. ಅದೇ ನಾಳೆ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಲ್ಲ, ನಾಳೆ 2:30 ಬೇಕಾಗಿರಲ್ಲ, ನಾಳೆ ಮೂವ್ ಮಾಡಿ. ಎಸ್, ಕಾಲ್ ದಿ ಕೇಸಸ್ ನಾವು.
Tomorrow matter is, in trial court matter is posted for a framing of charges.
ವೆರಿ ಗುಡ್ sir. No problem. Give it.
Case of section
Tonight it's posted for tomorrow,
490
rightly posted.
against the parents who did not even reside with son and
So what were you doing all these years?
So minutes.
Give it.
The
Yes.
stage is now for framing of charges.
ಅದೇ ಇಲ್ಲಿವರೆಗೂ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಲ್ಲ?
My lord,
Nothing. Really, give it.
NBW has been issued. Tomorrow
So
matter is posted.
give it sir. Give it.
Lordship.
ಮೆಮೋಸ್ ತಗೊಂಡ್ಬಿಡಿ ಅಲ್ಲ.
ಪೆಂಡಿಂಗ್ ಲಿಸ್ಟ್ ಹೋಗಿದೆ ಅದು ಲಿಸ್ಟ್ ಆಗಿ ಬರಲ್ಲ.
ಪೆಂಡಿಂಗ್ ಲಿಸ್ಟ್ ಹೋಗಿದ್ರೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಬರುತ್ತೆ.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್, ಅಲ್ಲ ಇದು ಲಾಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಅದ್ರಾಚ ವೀಕ್
No way.
ಮೂವ್ ಮಾಡಿದ್ರು ಬರ್ಲಿಲ್ಲ.
ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಸರ್? ಎಸ್, ಕೊಡಿ.
Lordship, I have
ಅಲ್ಲ ಮೆಮೋ ಕೊಡೋದು ಕೊಡಿ ಸರ್. ಎಸ್.
Your Lordship, I have submitted a memo. It's a fresh matter. It's being settled, Your Lordship. for
ಸೆಟಲ್ಮೆಂಟ್
tomorrow.
ವೆನ್ ಡು ಯು ವಾಂಟ್ ಮೇಡಮ್?
Tomorrow, Your Lordship.
ಆಯ್ತು, ಕೊಡಿ.
Your lordship, getting the interim order.
ವೆಕೇಟಿಂಗ್ ದಿ ಎಂಟ್ರಿ ಮಾಡರ್ 2027 ಅಲ್ಲಿ ಕೇಳೋಣ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಎಸ್,
Your lordship, your lordship, this,
ವೆಕೇಶನ್ 2 ದಿನದ ಮುಂಚೆ ವೆಕೇಟಿಂಗ್ ಎಂಟ್ರಿ ಮಾಡರ್ ಅರ್ಜೆನ್ಸಿನಾ?
your lordship, this is.
ಮಲ್ಟಿಪಲ್
ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್ ಅರ್ಜೆನ್ಸಿನಾ?
Your lordship, this is
FIR
fresh matter, your lordship, this is.
ಗಿವ್ ಇಟ್ ಸರ್.
Sir.
ಎಲ್ಲ ಕೊಡಿ.
FIR ಅಕ್ಯೂಟಲ್ ಆಗಿದೆ ಮೈ ಲಾರ್ಡ್.
ಪರ್ಮಿಷನ್ ಟು ಟ್ರಾವೆಲ್, ವೇರ್ ಡು ಯು ವಾಂಟ್ ಟು ಗೋ? UK? ಯಾಕೆ?
ಮೈ ಲಾರ್ಡ್, ಮಲ್ಟಿಪಲ್ FIRs ಮೈ ಲಾರ್ಡ್.
At least
ಬರಲ್ಲ
listed
ಸರ್.
on-
ಇವು ಕೊಡಿ ಸರ್. ನೋ 230. ಟುಡೇ ಒಂದು ಮ್ಯಾಟರ್ 230 ಕೊಡ್ಬೇಡಿ. 500 ಆರ್ ದೇರ್ ಇನ್ ದಿ ಲಿಸ್ಟ್. ಎಸ್, ದೇರ್ ಶುಡ್ ಬಿ ಸಮ್ ಲಿಮಿಟ್ ಸರ್ ಎಲ್ಲದಕ್ಕೂ. ಮೊನ್ನೆ ಮೂವ್ ಮಾಡಕ್ ತಗೊಂಡ್ರಿ ಅಂದ್ರೆ 100 ಮೆಮೋಸ್ ಮೂವ್ ಮಾಡಿದ್ರೆ, ಯಾರು 100 230 ಮೂವ್ ಮಾಡ್ತಾರ?
ಮೈ ಲಾರ್ಡ್, ಇದು ಮಲ್ಟಿಪಲ್ FIRs ಮೈ ಲಾರ್ಡ್. ಇದರಲ್ಲಿ ಒಂದು FIR ಅಕ್ಯೂಟಲ್ ಆಗಿದೆ ಮೈ ಲಾರ್ಡ್.
ತೊಂದ್ರೆ ಇಲ್ಲ ಸರ್, ಕೊಡಿ ಸರ್.
My lord,
Two
Minister is the Tahsildar.
So what? Ask him to do his work. Give it.
ಮೈ ಲಾರ್ಡ್, kindly tomorrow ಮೈ ಲಾರ್ಡ್.
Withdrawal 230. Yes.
Covered by my lord's judgment, my lord. I am
After
appeal number
vacation.
4, my lord.
My lord, superior
My lord, my
officer is
matter-
targeting this
Time-
according.
After vacation ಎಲ್ಲ ಪೆಂಡಿಂಗ್ ಎಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಫ್ರೆಶ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ. Call the cases now.
My lord, fresh matter, my lord.
My matter will listed and at least end of the board, Lordship.
No sir.
My lord,
Unless you bring a DD that you will pay.
my lord,
Lordship,
there is CCTV.
Lordship, at least they can.
Statutory mandate I will not dilute. Yes.
My lord, there is urgency in this matter, my lord.
Oh, ಕೊಡಿ, ಮೆಮೋ ಕೊಡಿ. Today I will not take.
End of the list.
No. Nothing.
My lord,
No end of the list at all.
Police officer is targeting this.
No
according-
problem at all. No end of the list.
My lords, if I may mention, it's a pending matter, my lords.
After vacation.
No, my lords.
Don't
just-
even mention.
It was about to list on 24th.
About to be listed.
The date was given to 24th, my lords.
Ah.
I mean, now the petitioner has been arrested. The petitioner.
Secure
arrested-
bail.
Outcome of a memo.
Secure
It's
bail,
a civil
madam.
dispute, my lords.
Secure bail.
Kindly, my
yes.
lords.
Secure bail. No 230 today. Yes.
Notes, the parties have
ನಿಮ್ದಂತೂ ಇಲ್ವೇ ಇಲ್ಲ after vacation.
Come to-
Yes. After vacation.
arrived
Call the
to
cases. Call the cases.
settlement.
Call the ಯಾವತ್ ಬೇಕು ಸೆಟಲ್ಮೆಂಟ್? ಸೆಟಲ್ಮೆಂಟ್ ಇದ್ರೆ ಕೊಡಿ. Yes.
Till number 1.
ಯಾಕಂದ್ರೆ ಯಾವ್ದ್ಲೂ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ, ಸುಮ್ನೆ
Either my lords, this my lords,
nothing.
Present.
ಒಂದಾಯ್ತು, buy one get one free ಇಲ್ಲ.
at settlements.
Nothing. Yes. Notice A15 withdraw ಮಾಡ್ಬೇಕಾ? ಯಾವ್ದಕ್ಕೆ ಸರ್? ಕೊಟ್ಬಿಡಿ ಸರ್. ಡಿಫ್ರೀಸ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಕೊಡಿ. ನಥಿಂಗ್ ಡೂಯಿಂಗ್, ಗಿವ್ ಇಟ್. ಎಲ್ಲ ಕೋರ್ಟ್ ಮುಗಿಸ್ಕೊಂಡು ಇಲ್ಲಿ ಬರ್ಬೇಡಿ, ಕೋರ್ಟೇ ಶುರು ಆಗಿಲ್ಲ ಬಿಡಿ. ಯಾವ್ದು? ಎಸ್
Lord,
ಕೊಡಿ ಎಲ್ಲ.
this matter, my lord, accused number 50.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 15
Accused number
ನೋಟಿಸ್.
15.
ಎಸ್.
No, my lord, only one
2
submission.
years ಇಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್?
No, my-
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕೂತಿದ್ದು ಅದನ್ನ ನಾನು ಲಿಸ್ಟ್ ಮಾಡಿಸಿದ್ದೀನಿ, ಈಗ ಅರ್ಜೆನ್ಸಿ.
ಅಲ್ಲ, ನನ್ಗೆ
ನಥಿಂಗ್ ಡೂಯಿಂಗ್.
ಇಲ್ಲ.
ಲಿಸ್ಟ್ ನೋಟಿಸ್ 1 HCGP, 2 emergent notice.
ನನಗೆ ಏನಂದ್ರೆ
You want to withdraw, I will permit you.
No, my lord,
Then.
only my humble submission. Kindly listen, only 1 minute.
No sir.
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ
2
ಅಂದ್ರೆ,
years ಇಂದ why did you keep quiet?
no, my lord, I have moved nearly 15 memo.
Thank you. sir.
50
ನನ್
memo
ಮುಂದೆ
ಮಾಡಿ-
ಒಂದ್ ಮೆಮೊನು ಬಂದಿಲ್ಲ.
ಅಲ್ಲ,
Yes.
ನನಗೆ ಮ್ಯಾಟ್ರೇ ಬೇಕಾಗಿಲ್ಲ. ಹರ್ಡ್ ಅಂದು ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ಬಿಡಿ, ನಮ್ಗೆ ಏನು ತೊಂದರೆನೇ ಇಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಏನು ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್.
ಆದ್ರೆ ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಮಾಡಿ ಅಲ್ಲಿ 2 ವರ್ಷದಿಂದ ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರೆ ಅದ್ರ ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಡಿಸ್ಚಾರ್ಜ್ ಅಪ್ಲಿಕೇಶನ್ ಡಿಸ್ಪೋಸಲ್ ಬೇಕಾ?
ಡಿಸ್ಪೋಸಲ್ ಮಾಡ್ತಾ ಇಲ್ಲ. ಹಾಗೇನೆ ಅದನ್ನ ಆಮೇಲೆ 482 ಪಿಟಿಷನ್ ಮಾಡಿದೀನಿ, ಅದರಲ್ಲಿ 50 ಮೆಮೊ ಹಾಕಿದೀನಿ, ಅದು ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ರು.
ವೆರಿ ಗುಡ್. ಆಮೇಲೆ ನಾನು ಕೂತ್ ಮೇಲೆ ಒಂದು ಮೆಮೊನು ಬಂದಿಲ್ಲ.
ಹಂಬಲ್ ಸಬ್ಮಿಷನ್.
Not a single memo. Office objections, it is lying for the last 15 months.
My humble
You don't have the time to go and comply with the office objections. Now will post ಮಾಡಿಸಿದ್ಮೇಲೆ ಏನೇನೋ urgency.
humble submission is very simple matter. ಏನಂದ್ರೆ
ಪರವಾಗಿಲ್ಲ. List after vacation. Next.
ಅಲ್ಲಿ ಒಂದು ಡೇಟ್ ರೀ
ಏನಿಲ್ಲ. Yes, next. ಮತ್ತೆ ಮೂವ್ ಮಾಡಿ.
Number 2.
Serial number 2, my lords, 3 to 6 have been acquitted.
Acquitted.
3 to 6
Split
have been
ಇದು?
acquitted. Split up. Split up.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಆಗಿದೆ.
ಆಮಾ ಆಗಿರೋದಕ್ಕೆ ಬಂದಿರೋದು ಈಗ. Yes. After vacation. No representation after vacation. Next.
Bill number 3.
Here for petitioner in this case, my lords.
302 ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ
That
ಸರ್?
matter was infectious, my lords.
Infectious.
This was the first petition filed by the petitioner.
The
my
learned
lords,
counsel for the petitioner
was
submits the
misplaced.
petition is rendered infructuous by efflux of time,
Which was
disposed as having become infructuous. Memo ಇದೆಯಾ?
No, my lords, it was later filed a second petition.
ಇದು
Which
ಫಸ್ಟ್
got
ಸೆಕೆಂಡ್ ಸರ್ ಇದು?
This is a first
First one, my
petition, my
lords,
lords.
Second ಇನ್ನೊಂದು ಹಾಕಿದ್ದೀರಾ?
Second ಹಾಕಿದ್ರೆ
Was
dismiss
dismissed
ಆಗಿದೆ.
and
Supreme Court ಮುಂದೆ ಹೋಗಿದ್ದಾರೆ, that's been stayed.
The petitioner files a memo submitting that the petition is rendered infructuous in view of the second petition filed on the same cause of action. Yes, next. Disposed as dismissed. ಏನಿದು ಕೊಟ್ರದ್ ನೀವು?
My lords, Supreme
Memo
Court.
ಬೇಡ. Counsel.
I'll file it
Counsel
in
for
the
the
registry, my
petitioner,
lords.
counsel for the petitioner submits that this is the first petition and on the same cause of action, second petition is preferred. In that light, petition is dismissed. Next.
Number 4.
Acha.
The criminal appeal ಇಲ್ಲ ಹಾಕಿದ್ದಾರೆ after vacation. Yes, next.
5.
Charge sheet has been filed in this case. my lords.
Charge sheet.
ಆಗಿದೆ.
Prefer new petition.
Yes.
6.
Correct. Charge sheet format.
Bill number 6.
Petitioner is accused number 7. ನೋಡಿದಿರಾ?
ನೋಡಿ.
ಏನ್ ನೋಡಿದಿರಾ?
DLF property law.
The petitioner is accused number 7. A perusal at the summary of the charge sheet would not indicate even a titter of offense against the said accused. In that light, there shall be an interim order of stay quo accused number 7 till the next date of hearing.
7.
Petitioner is accused number 3, finding no allegations that would touch upon the ingredients of the offences, shall be an interim order of stay.
The complaint is the court, my lords, false information.
ಬೇರೆಯವ್ರ ಮೇಲೆ ಅದಿರೋದು.
ಅಲ್ಲ, ಇವ್ರ ಮೇಲೂ ಇದೆ.
ಏತ್ರಿ ಮೇಲೂ ಇದೆಯಾ?
A3 ಮೇಲೂ ಇದೆ.
ಆಯ್ತು. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಏನು ಸ್ಟೇ ಬೇಡ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
8.
Petitioner is accused number 4. The offense alleged is section 490, offense punishable under section 498A inter alia, finding no so and so. State. Next.
9.
2 and 3, 498A.
10.
Petitioner is accused number 2, my lord. 1 and 3 is acquittal, my lord. Split up.
Acquitted, split up.
Split up, Church.
There shall be an interim order of stay of further proceedings quay the petitioner to the next date of hearing. List the matter on 11th June. Next.
11.
Lords, this is a prohibition of e-cigarettes act.
E-cigarettes, sir.
Yes,
Yes, sir.
this, accused number 2 is already stayed.
Kodi, tag along with so and so, the same order, list in the second week of June. Next.
12.
No, 1 HCGP 2 emergent notice. Next.
13.
In the meantime, all false is
14.
1, 3 and 4.
14%.
14%. I've been allotted High Court Legal Service Authority.
Ah?
For petition number 1,
Oh,
3.
ನೀವೇನಾ? ಹಾ. ನೀವು 14%, ಅವ್ರು partly in person.
ಇಲ್ಲ 1 2 ಮತ್ತೆ 4 ಗೆ
1 2 ಅವ್ರಿಗೆ ಮಧ್ಯದಲ್ಲಿ ನಿಮ್ದೇನು?
3 14.
Why? He will not put the case across properly. ಎಲ್ಲ ಮೆಂಬರ್ಸ್ ಆಫ್ ದ ಫ್ಯಾಮಿಲಿ ಒಬ್ಬೊಬ್ರು ಒಂದೊಂದು ಅಡ್ವೊಕೇಟ್, ಒಬ್ರು ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್. ಚೆನ್ನಾಗಿದೆ. ಐ ವಿಲ್ ನಾಟ್ ಗ್ರಾಂಟ್ ಎನಿ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಫ್ ದಿಸ್ ಇಸ್ ದ ಕೇಸ್. ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? P1, P2, P3 ಇನ್ನೊಂದ್ 3 ಜನ ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಡಿ. ಇದೇ ಆಗೋಯ್ತು. 2 to 4 entry order.
Petition 1.
No.
One is the father, my lords, not husband.
ಗೊತ್ತಾಯ್ತು. 1 to 4, sorry.
1 to 1 4.
15.
In the meantime, next,
16.
complainant,
Complainant, my lord. My lord, sir, the case of
will
the,
stay the order.
please.
Emergent notice to the respondent. Petitioner is also at liberty to serve on the counsel representing the respondent in the trial proceedings. The impugned order shall remain stayed till the next date. It is made clear that the trial is not stayed.
Please.
Yes, next.
17.
Case and counter case. 1 HCGP 2 emergent notice.
18.
For the petition. Second petition.
What is the role of A2, sir? Nothing.
Role of A2 is that
Nothing.
mobile in there.
In the meantime, accused number 2 finding no ingredient of the offense alleged against the petitioner. Next.
19.
In the meantime,
20.
Nagareddy. Huh? Agoit. Say it, sir. Yes.
20.
Relax. Sit down. Stay kottaito. Yes. 20.
Theft of construction
Huh?
material. Trespass and theft of
ಯಾವ
construction material.
trespass? Civil suit pending ಇದೆ, interim order ಇದೆ. The petitioners are before this court calling in question registration of a crime in crime number so and so. The petitioner files a suit in OS 188 of 2025 in which a temporary injunction is granted against the complainant not to interfere with the possession of the petitioner. Immediately thereafter springs the subject crime alleging the offense under section 447 of the IPC, 329(4) of the BNS stroke 447 of the IPC. The petitioners are in possession and there cannot be trespass into their own property. Therefore, there shall be an interim order stay. Next.
21.
The petitioners are before the court calling in question so and so. The parties to the list are before the civil court in OS 318 of 2024 on the same set of facts springs the impugned proceedings. In that light, there shall be an interim order stay for the proceedings investigation.
Submission, my lords, a government employee was been assaulted. The complaint is a government employee.
Assault.
Howd.
Yes. Amale. Next.
22.
Just after vacation. Yes.
20.
Bhagwan sir, company need not be made a party in Factories Act. 84 Pragar, I have myself taken that view. Adike will take it after vacation. Yes. List after vacation. Next.
23. 20.
A purely civil dispute is dressed with.
For 22.
You want to withdraw?
No, my lords, kindly pass it over.
Huh?
Pass over. my lords.
Sorry?
Pass over.
Oh, Passover, no Passover.
My lords, there's a connected matter at 164 serial.
No problem, madam. Yes. The petitioners are before. What's your name? Hey, where are you running away?
Sorry, my
You're not from the office?
lords. From the.
Then how can you run away like that?
Sorry, my lords.
Yes. Oh, where's the file?
That is good.
Open the file. What's the matter? You have not seen the file?
I have seen.
Then start.
Senior counsel.
Arre, start, madam. When do you start? Start.
My lords, this is with regard to that Udupi tollway matter, my
Huh?
lords. Udupi tollway matter.
Udupi?
Tollway.
Ah.
So the petitioners are former employees of the Udupi tollway, my lords. That is, so the second respondent met with an accident near the in the bridge that was on the highway, my lords. Thereafter, certain injuries were caused, my lords. Thereafter, they filed the FIR on 14/1, my lords. Charge sheet also has been filed, seeking for the stay of the proceedings, my lords. The own certificate is also there. It's the injuries are minor in nature, my lords. And they're simple in nature.
What's your name?
Preksha.
Third, the Learned Counsel Preksha appearing for the petitioner. 1 HCGP 2 emergent notice. There shall be an interim order of stay of further proceedings quay the petitioner till the next date of hearing.
Acha.
Yes. Next.
24.
Case and counter case.
Yes, my lord.
ಹಾ
There is a civil dispute.
ಅದಕ್ಕೆ ಹೊಡಿಬೇಕು ಅಂತ
ಇಲ್ಲ, page number 32 ಅಲ್ಲಿ.
ಹೊಡೆದಿಲ್ವಾ?
So-
Assault
ಇಲ್ಲ,
ಆಗಿಲ್ವಾ?
No, no assault.
In the meantime, yes, next.
25.
Straight, next. 25 ಇಲ್ಲ. 24 straight.
25.
25 notice, 109
109.
attempt to murder, yes.
26.
3 for the petition.
25 ಅಲ್ಲಿ 1 HCGP 2 emergent notice.
26, I believe.
26, petitioners are accused number 4 and 5. A perusal at the summary of the charge sheet would not indicate any offense any ingredients of the offense is so alleged. In that light, there shall be an interim order of stay of further proceedings, query petitioner to the next date of hearing.
498A, my lords, husband petition, my lords.
Husband notice, yes. Page 29, all allegations are there, yes. One HCGP to emergent notice.
28.
Sharana Basappa. Pudi matte list agadortala. The parties to the list are before the civil court and are before the division bench in an RFA. After losing the battle on the civil side, the subject crime is registered by the complainant on the very same set of facts. In that light, there shall be an interim order of stay of further proceedings by the petitioner to the next date of hearing. Pallava.
29.
Page 55, notice.
Really, they've filed they've lodged the FIR clearly as a counterblast, my lord, clearly malicious. I report the incident on the same day.
Yeredina is okay, but we'll see immediately after vacation. One HCGP 2 emergent notice immediately after vacation. In the meantime, next. Connected matter, tag along with sounds.
The crime number different is, my lord.
Here, Master.
Number different. 5 complaints have been filed.
The tag madi same beda. In a different crime number between the same parties, this court has granted an interim order of stay of further proceedings, finding the dispute purely civil in nature. The subject crime also shall remain state. Investigation. Subject crime also shall remain state. Next.
31.
Rangnath.
My lords, the petitioner, my lords, connected matter.
Kodi, tag sounds.
My lords, the judgment has been reserved, my lords. The judgment has been reserved, my lords.
Idralla? Oh, that matter is it. Anyway.
The impunged order.
Interim order. There shall be interim order of stay spread for to the next.
Obliged.
Andar bar. Jevai. Andar bar the judgment. Yes, next. Disposed.
33.
2013 crimes, sir. What are you doing in 26?
But notice not given, my lord.
No, sir.
Yes, my lord. The connected case has been.
Connected case and charge frame trial nadita ilva?
No, my lord.
No,
It's a private complaint, my lord.
So what? Trial nadibardu antidiya?
Criminal division petition, no notice was given to the petitioners, my lord. Your lordship has granted.
Yen 197 not complied anta iradu ashte
Yes, my
bere
lord.
enide?
Yes, my lord. In connected case, your lordship has.
Kodi aden connected. Yaar nanna order?
Yes, my lord.
Kodi. CC of 2025 idu.
Yes, my lord.
Nimdu?
You have not filed any.
Sir,
petition, my lord.
nimde CC ಹೇಳಿ.
You have not filed a private complaint, my lord. 20.
Idral
14, my lord.
you said connected matter.
Yes, my lord.
This is CC 1639 of 2025.
Yes, my lord.
ನಿಮ್ದ್ರಲ್ಲಿ ಏನು?
CC 1637 by 2025, my lord.
1637.
Yes, my lord.
ಯಾವತ್ ಕಾಗ್ನಿಸೆನ್ಸ್ ತಗೊಂಡ್ರದು?
No cognizance was taken by lord.
Yes.
For want of 197 CRPC has been rejected by the complaint.
Just after vacation. Tag along with sounds. Next.
Interim.
No. Next.
Serial number, sorry, my lord. Serial number 29, it's not page 55, my lord, it's page 83.
ಏನದು?
Charge sheet against me is at page 83. The charge sheet against the respondent number 2 is at page 55. Your lordship referred page 55.
Then 29 in the meantime. Next.
My lord, 34, my lord, 498A.
34.
Husband is first petitioner, mother-in-law, father-in-law, second petitioner. and third
Husband
petitioner.
again ಕೂಡ.
Husband is fine, my lord. Second, third petitioner, no allegations.
Husband ಮೇಲೂ ಏನು ಇಲ್ಲ sir. What is this? The petitioners are accused number 1, 2 and 3 A perusal at the charge sheet ಆಗಿದೆಯಾ?
Yes, my lord.
A perusal at the summary of the charge sheet would not indicate any offense against the husband or the in-laws accused 2 and 3. Permitting further proceedings against these petitioners would run foul of the judgment of the apex court in the case of Abhishek versus State of Uttar Pradesh 2023 SSC online SC page 1083. Therefore, there shall be an interim order of stay against all. Yes.
35,
Tag with page 34, same order. Please, next.
35,
The 30, allo ನಿಮಿಷ.
35 melons.
Correct.
35, correct.
35.
Tag. 35 ಮತ್ತೆ ಕರೆದ್ರೆ. 35, tag along with page 34. Yes.
Additional
Same order.
SPP Asma Kausar. Notice to additional SPP Asma Kausar.
ಓ ಅವ್ರಿಗ?
ಅವ್ರ.
ನೋಟಿಸ್ ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದೀವಿ ಅದೇ ಮಾಡಿ ಮಾಡಿ. Yes.
Order dated 4/7/25.
ಈ 30 page 34.
ಹೌದು, ಅದ್ರಲ್ಲಿ ಎರಡು ಆರ್ಡರ್ ಇದೆ.
Next. 36, ನಾಗೇಂದ್ರ.
64 to.
ರೇಪ್ ಕೇಸಲ್ಲಿ ಏನು
64 to.
after vacation. DV Act 2, 3, 4 stayed, no stay for 1.
Please.
Yes. ಗೊತ್ತಾಗುತ್ತೆ ಜವಾಯ್?
38,
109. 109 is there.
1 HCGP 2 emergent notice. Next.
39,
Yes, and count.
Page 29, same order.
Same.
Next.
Case number.
40,
Page 29 ಅಲ್ಲಿ ಹಾಕಿದಿರಲ್ಲ.
Please.
Next.
It's for reporting settlement, my lord, is a
When?
family.
What time?
She's in Dubai.
Ah.
That's point number 2. We are waiting.
ಯಾವಾಗ when do you want?
June first week, my lord.
First
I
week of
list the matter on 5th June at 4 PM to report settlement. In the light of the settlement arrived at between the parties, there shall be an interim order of stay of further proceedings by the petitioners to the next date of hearing.
41,
1 illa, 2 yes.
Appearing for petitioners, my lords.
For 2 interim order, offense 85, 1 husband, no interim order. Next.
Much appreciated.
42,
In the meantime,
43,
next.
4,
What MMDR?
They dropped all the sections of MMD.
ಮತ್ತೆ ಏನಿದೆ ಈಗ?
It's only
Why are you,
not-
Theft ಹಾಕಿದ್ರು, theft ಹಾಕಿದ್ರು.
why you can't without leaning stand, is it?
Your Lordship,
Ah,
the value of the stolen property is only 6,000 rupees.
the meantime. MMDR is dropped, huh?
No, draft.
1 HCGP 2 emergent notice. Next.
55,
Because the petition, my lord. Alleged to have husband has transferred the money to the wife.
Ah,
He is not the employee of the particular complainant firm. my lord.
ah.
So that amount has been transferred back to the husband, my lord.
Hmm.
I got the document to show that.
Sir, same interim order have refused in identical matter. You should say that first. 1 HCGP 2 emergent notice. I will not forget. Though it is refused a month ago.
Well,
is
obviously it is.
No, no, sir. That Pawan is the
Yes, yes. my lord.
petitioner?
Pawan
Yes.
Kashyap.
Yes, sir. Yes. Ah,
Plus his wife, my lord.
whatever. Yes. Next.
The settlement that's been arrived at, my lords, the money has
Medical
been,
seat.
apparently the money has been returned, my lords, on my
Yavat
instructions after vacation.
first week, 5th June.
Not, I'll file a joint.
Repeated offenses, my lord, sir.
Huh?
Multiple affairs, ಬೇರೆ ಬೇರೆ ಯಶವಂತಪುರ.
ನೋಡ್ಬಿಡಿ stay ಏನ್ ಕೊಡ್ತಾ ಇಲ್ವಲ್ಲ. List the matter on 5th June. Yes.
Obliged.
47,
All gone uncognizable. In the meantime, next.
48,
Petitioner words. I file an FIR first.
Instagram. Ah, yes, sir.
He files a case of 420 telling during relationship he had given certain items.
1 HCGP 2 emergent notice returnable by the 10th of June. List on 10th of June. Yes.
49,
Partner. Partnership firm ಏನು?
ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್
ಹಾ.
ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಆರ್ಬಿಟ್ರೇಷನ್ ಕ್ಲಾಸ್ ಇದೆ.
138 ಅದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಫರ್ಮ್ ಅಲ್ಲಿ ಎಲ್ಲರೂ ಲಯಬಲ್. ಇಟ್ಸ್ ನಾಟ್ ಲೈಕ್ ಕಂಪನಿ.
ಆರ್ಬಿಟ್ರೇಷನ್ ಕ್ಲಾಸ್ ಇದೆ ಮತ್ತೆ ಅವರು ಏನು ಅಲಿಗೇಷನ್ ಮಾಡಿದಾರೋ ಅವೆಲ್ಲ
ಅದೇ ಗೊತ್ತಿಲ್ಲ.
ಇದ್ದಿಲ್ಲ.
The counsel for the petitioner to serve on the counsel represents the respondent in the trial proceedings. List the matter in the fresh matters list on 4th June. Yes, next.
50,
Case and counter case. But there is no case on count in the meantime. Next. 85, husband gilla, 2, 3, 2 and 3 stayed. Yes, ಗೊತ್ತಾಗುತ್ತೆ ಜಯ ಭಾಯ್?
52.
Chit fund.
Petitioner, my lord.
ದುಡ್ಡೆಲ್ಲ ವಾಪಸ್
Petitioner
ಕೊಡಿ
of my.
sir. Give all the money
Petitioner-
back.
No, my lord. He
Oh.
not running cheats
No
fund.
money,
Iವ್ರು cheats
no
fund.
money, no interim order. Yes. Less the one HCGP 2 emergent notice. Next.
53.
Leela Raju. Sub-registrar is the complainant.
Yes, my lord. But thing is, RTC was not entered, my lord, when I entered into sale agreement. Subsequently, my lord, when the sale deed was executed, my lord, the seller who was, my lord, take due diligence. My
One
lord.
HCGP 2 emergent notice.
My lord,
Next.
even the acquisition proceedings, my lord, only 0.25 quintas is acquired.
Whatever
Mine
it
is 16 quintas of land, my lord, with the
It is
purchase.
the act of fraud and not the extent of land. Next.
The fraud has not been committed
No,
by my
no,
end, my lord.
we'll
Because
see.
it is by the my
We'll
vendor.
see, yes.
My vendor who has sold my property to me.
No,
I'm
no,
not
sir.
responsible.
We'll
I'm
see,
only a
sir.
purchaser, sir.
One HCGP 2 emergent notice. Next.
54.
Petitioner is the former manager and finding no allegations against him that would touch upon ingredients that are against the others, the permitting further proceedings would become an abuse of the process of the law, albeit prima facie. In that light, there shall be an interim order of stay of further proceedings. Next.
Please, ma'am.
55.
138. No ground. Petitioner to serve on the council who represents the respondent in the trial proceedings. 4th June, fresh matters. Next.
56.
The petitioners are said to be the purchasers of the property, which has now become the subject matter of the proceedings, subject matter of the subject list. The petitioners are themselves hoodwinked without knowing that it is the property could become the subject matter of crime. In that light, there shall be an interim order of stay away these petitioners till the next date of hearing. Next.
57.
85. 2 to 8 all stayed. No one. Husband gilla. Next.
58.
Promise to marry.
Yes, yes. Your lordship, in this, there was a consensual relationship for 2 months, your lordship.
2 months. ತುಂಬಾ ಕಮ್ಮಿ ಆಯ್ತು.
ಅಲ್ಲ ಸ್ವಾಮಿ, ಇದ್ರಲ್ಲಿ ಏನಿದೆ ಅಂದ್ರೆ, there in complaint itself it says the petitioner has agreed he will marry to the respondent number 2. The complaint itself says, your lordship, that is page number 21, your lordship. The complaint itself says, and there was a
ನೀವು
medical
ಕಂಪ್ಲೇಂಟ್
emergency.
ಇಟ್ಸೆಲ್ಫ್ ಸೇಸ್ ಆದ್ಮೇಲೆ ಏನು ಹೇಳ್ತಾನೆ ಇಲ್ಲ.
ಅದೇ ಸ್ವಾಮಿ, ಅದೇನಂದ್ರೆ, there is a medical emergency. Petitioner
ಮೆಡಿಕಲ್
father-
ಎಮರ್ಜೆನ್ಸಿ
ಅಲ್ಲ, ಪೆಟಿಷನರ್ ಫಾದರ್ಗೆ ಹುಷಾರಿಲ್ಲ ಸ್ವಾಮಿ.
ಆಯ್ತು.
ಹಂಗಾಗಿ ಅವ್ರು ಇದಕ್ಕೆ ಹೋಗಿರ್ತಾರೆ,
ಎಲ್ಲಿಗೆ ಹೋಗಿರ್ತಾರೆ?
ನೇಟಿವ್ ಚೆನ್ನೈಗೆ.
ಚೆನ್ನೈ.
Just because petitioner has not received the call of the respondent number 2, she has filed this case.
Why you did not receive?
Because ಬ್ಯಾಟ್ರಿ ಏನೋ ಇಶ್ಯೂ ಆಗಿರುತ್ತೆ.
ಬ್ಯಾಟ್ರಿ ವೀಕ್ ಆಗಿತ್ತಾ?
ಏನದು,
ಅಯ್ಯೋ.
there was a issue here.
ಇಶ್ಯೂ ಪ್ರಾಮಿಸ್ ಟು ಮ್ಯಾರಿ, ಬ್ಯಾಟ್ರಿ ವೀಕ್ ಆಗಿತ್ತು ಅಂತಿರಲ್ಲ.
Just because that is itself lordship case, just because petitioner has not received the call, she has filed this case, your lordship.
We should have received the call. Now you will receive the call. ಈಗ ಮದುವೆ ಆಗ್ತೀರಾ?
Husband,
ಈಗ ಮದುವೆ ಆಗ್ತೀರಾ?
he never said that that he will not marry, your lordship. In spite of that, she has not.
So I'll undertake that you never said that you will not marry, but you will marry.
It is mentioned, your lordship, in the complaint itself. He herself has mentioned in the complaint that petitioner has said that promise on the 4th February.
In the meantime,
that he will.
59.
Lordship. Much obliged.
That's a short password, Malad.
Why, sir?
Senior.
You are his colleague.
Please.
Where's the file? Open the file. Now, what's the matter?
That's the respondent number 2 has lodged.
Mike ತಗೊಳ್ಳಿ.
That's the respondent number 2 has lodged a complaint against petitioner Malad for forging a few documents. Malad, the suit, the complaint.
How many suits? Civil suit ಯಾವುದು?
RA.
Civil suit ಆಯ್ತು, RA ಆಯ್ತು. ಆಮೇಲೆ
There are no.
What's your name?
Dilip.
Heard the learned counsel Dilip appearing for the petitioner. The petitioner is before the court calling in question registration of a crime and crime. Charge sheet ಆಗಿದೆಯಾ?
No.
Registration of a crime and crime number so and so. The complainant, after having lost the civil suit and the regular appeal filed against the said civil suit, against the judgment and decree in the civil suit, has now set the criminal law into motion on the very same set of facts that that was urged before the civil court, i.e., cheating and forgery. In that light, there shall be an interim order of stay of further proceeding for investigation. Query petitioner to the next date of hearing. Next.
Petitioner offense is the 320, 326. ಅಲ್ಲಿ
324.
324 ಅದೇ ಫೈನ್ 354 ಇದೆ ಸ್ವಾಮಿ.
ಹೌದು ಸ್ವಾಮಿ.
ಬಟ್ ಈ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಪ್ರೆಸೆನ್ಸ್ ತೋರಿಸ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಯಾರು?
ನಮ್ ಪಿಟಿಷನರ್ಸ್, ಈ ಪಿಟಿಷನರ್ಸ್.
ಹ್ಮ್.
ಬಟ್ ಏನಕ್ಕೆ ಗಲಾಟೆ ಆಯ್ತು ಅನ್ನೋ ಅಲ್ಲಿ ಇದು ಕೂಡ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಏನಕ್ಕೋ ಗಲಾಟೆ ಆಗಿರುತ್ತೆ.
ಯಾವ ಪರ್ಪಸ್ ಗಲಾಟೆ ಆಯ್ತು ಅಂತ.
ಗಲಾಟೆಗೆ ಪರ್ಪಸ್ ಬೇಕಾಗೇ ಇಲ್ಲ. ಎಲ್ಲದಕ್ಕೂ ಗಲಾಟೆ ಆಗುತ್ತೆ.
ಅಲ್ಲ ಹೇಳ್ದಲ್ಲ ಈ ಪಿಟಿಷನ್ ಎಂಟೈರ್ ಎಲ್ಲ ಐ ವಿಟ್ನೆಸ್ ಇವ್ರ ಪ್ರೆಸೆನ್ಸ್ ತೋರಿಸ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಹೆಸರೇ ತೋರಿಸ್ತಾ ಇಲ್ವಾ?
ತೋರಿಸ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಅಲ್ಲ ಇವ್ರಿಲ್ಲ, ಇವ್ರು ರೋಲ್ ತೋರಿಸ್ತಾ ಇಲ್ಲ ಸ್ವಾಮಿ. ಏನ್ ಮಾಡಿದ್ರು ಅಂತಾನು ಈ ದಿಸ್ ಪಿಟಿಷನರ್ ಸ್ವಾಮಿ. ಓನ್ಲಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1, 2, 3 ಅಷ್ಟೇ ಮಾತ್ರ ಹೇಳ್ತಾರೆ.
ಪೇಜ್ 67 ಲೋನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ ನೋಡಿ.
ಇದು ನೋಡಿದೆ ಸ್ವಾಮಿ.
ನೋಡಿದ್ರಾ?
ಹೌದು ಸ್ವಾಮಿ. ಎಲ್ಲ ಈ ಪಿಟಿಷನರ್ ಸ್ವಾಮಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಆಗಿ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಮೊದಲೇ ಇನ್ನೊಂದು ಕೇಸ್ ಆಗಿದೆ, ಕ್ಲೋಸ್ ಆಗಿದೆ, ಕಾಂಪ್ರಮೈಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ.
ನೆಕ್ಸ್ಟ್ ಆಯ್ತು ಸ್ವಾಮಿ, ಕೊಟ್ಟಾಯ್ತು.
61.
In the meantime, next.
62.
Binu.
Yes, ma'am.
The petitioner is before the court calling in question. Charge sheet ಆಗಿದೆಯಾ? Calling in question the proceedings in so and so. The perusal at the wound certificate would indicate there are no external injuries at all. It is ununderstandable as to how an offence under section 118 is even laid against these petitioners in the case at hand. In that light, there shall be an interim order of stay of further proceedings. Query the petitioner to the next date of hearing. Yes.
63.
Meantime, next.
64.
Open the file.
The petitioner is for medical negligence, my lord.
Medical negligence. ಮತ್ತೆ doctor.
They
heard the learned counsel Dilip appearing for the petitioner. Have you read the papers? What is the cause of death? What's the cause of death?
He was booked for medical negligence.
Huh?
Case was registered before Karnataka Medical Council.
That is there. What has happened?
My lords, thereafter the petitioner had filed, appeared before this honorable court. My lords, this honorable court had granted interim order. Despite being an interim order, my lords, the police.
The petitioner is a medical practitioner. He is alleged of negligence, stroke medical negligence. The son of the patient, the complainant,
husband, my lord.
The husband of the complainant is said to have died allegedly due to the negligence of the petitioner. The negligence, the report would clearly indicate that that the husband has died due to coronary thrombus. Wife has died due to coronary thrombus and not due to the negligence of the petitioner. The learned counsel to further submit that the Karnataka Medical Council had passed an order against the petitioner, and the same is challenged before the coordinate bench, and there is an interim order of stay operating, and after the stay granted, the subject complaint is registered. In that light, there shall be an interim order of stay of further investigation. Query the petitioner till the next date of hearing.
65.
ಓದ್ಕೊಂಬರ್ಬೇಕಿನ್ ಮೇಲೆ. Yes.
Next 6. Let's appear for the petition, my lords.
Bail bond cancelled. Why? What is the next date? Next date.
My lord, next date in the June. This month. I'm sorry, my lords. I don't know, my lords. I have not verified.
Get to know the next date and come.
My lords, the day before yesterday there was a date, my lords. That is the problem, my lords. My lord,
Day after tomorrow. Day before yesterday itto. Day before yesterday. Saturday. All right. Day after tomorrow, I'll take it, you get to know the date.
My lords, I filed the EP, my lords, but it was not allowed, my lords. It was rejected, my lords. I was appearing before the court, my lord.
1 HCGP 2 emergent notice. There shall be an interim order of, ಏನillಲ್ಲ? Oh, bail bond cancelled, ಇಲ್ಲ.
Bail, ma'am.
List tomorrow, next.
Obliged, my lords.
Vinod Kumar.
My lord, in the civil matter, police are interfering.
Huh?
In civil matter, police are interfering.
They will interfere. What's the matter? Tell me.
My lord, first they have filed an police complaint, my lord. Then later it has been
Meantime,
stayed.
yes, next.
Much obliged.
67.
The petitioner shall serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement. List the matter on 10th June. Further proceedings before the concerned court shall remain stayed to the next date.
Please.
68.
Divorce granted. 68, 85.
Still, they have not filed the petition in spite of it, while talks were there and they had mediated to file the petition. This counter case has been filed, this case has been filed against the husband and the parents who are.
Husband stay ಕೊಟ್ಬಿಟ್ರೆ ನೀವು mediation ಹೋಗೋದೇ ಇಲ್ಲ. ಅದಕ್ಕೆ 2 and 3 husband ಗೆ ಆಮೇಲೆ ನೋಡೋಣ. mediation ಮುಗಿಸ್ಕೊಂಡು ಬಂದ್ಬಿಡಿ.
ಇನ್ನು ಕೇಸೇ ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ ಹಾಕ್ತಾರೆ ಈಗ. Yes.
69.
The petitioner is accused number 2. Was drawn as accused number 2 while filing the FIR. But after investigation had been dropped, ಬರ್ಕೊಂತ ಇದ್ರಲ್ಲ? And after investigation had been dropped from the array of accused while filing the charge sheet. The same statement is made by the complainant while in the course of the trial, and an application under 319 is filed by the prosecution, and the petitioner is brought back into the web of crime. Therefore, there shall be an interim order of stay, quae accused number 2 till the next date of hearing. Yes, next.
69.
Page 28. ನಿಮ್ದೆ ಬನ್ನಿ ಸರ್.
69.
16 ಆಯ್ತು. Yes.
70, my lord.
Yes. 70. Page 28. Absolute nonsense. In the meantime, next.
71.
I am for I am for petitioner, my lord. The petitioner is accused number
71.
7.
Accused number 7, sir.
Yes, my lord. 7, my
NDPS.
lord.
1 HCGP 2 emergent notice. We'll see list on 4th June. Next.
No, my lord. It is a covered by judgment of your lordship, my lord. Without issuing a
voluntary
notice.
statement,
Yes,
voluntary
my lord.
statement ತಾನೆ. ನೋಡೋಣ
Yes, my lord.
collaboration ಇದೆಯಾ ಇಲ್ವಾ? ಬೇರೆ accused ಕೊಟ್ಟಿದೀವಾ?
Yes, my lord. Co-accused ಗೆ this honorable court has granted bail, interim stay, my lord. Interim stay, my lord.
Page.
Stay of the proceedings.
Page.
We have not furnished the document, my lord.
Page ಕೊಡಿ ಸರ್. ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ ಕೊಟ್ಟರೋ ಆರ್ಡರ್?
They have not furnished along with the.
We have not produced, my lord.
ನೀವು ಅಲ್ಲಿ ವಿಸಿಲಿ ಸ್ಥಿತಪ್ರಜ್ಞೆ ತರ ಕೂತ್ಕೊಂಡ್ಬಿಟ್ರೆ ಏನಾಗಲ್ಲ.
No, I will come and
after vacation. Next.
Date may be fixed, my lord. Kindly date may be fixed.
ಹೇಳಿದ್ನಲ್ಲ 4th June. Yes, next.
72.
In the meantime, next.
73.
Yes. Meantime, next. ಯಾವ್ದು ಮೇಡಮ್?
73, my lords. My lord, he is the
73.
person who has damaged the police vehicle, my lord.
ಹೌದಾ?
Taking it, he has obstructed the police officials in taking one of the accused persons to the concerned police station.
Why?
My lords, he is being Mahesh Timmareddy, Mahesh Shetty, who happens to be have committed some offense, my lords. During the course while the police officials used to take him to the concerned police station, these
ಅದಕ್ಕೆ ಇವರೇ ಅಡ್ಡ ಮಾಡಿದ್ದಾರೆ.
ಇವ್ರು ಅಡ್ಡ ಮಾಡಿದ್ದಾರೆ. On the spot ಇವ್ರನ್ನ ಬಿಡಬೇಕು, ಸ್ಟೇಷನ್ ಗೆ ತಗೊಂಡ್ ಹೋಗ್ಬಾರ್ದು ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
ಅಡ್ಡ ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಕೊಂಡೋಗುವಾಗ ಕಾರ್ಗೆ ಟಚ್ ಆಗಿದೆ ಅಷ್ಟೇ.
ಟಚ್ ಆಗಿದೆಯಾ?
ಇವ್ರ ಕಾರು ಪೊಲೀಸ್ ಕಾರ್ಗೆ ಟಚ್ ಆಗಿದೆ.
ಏಕೆ ಟಚ್ ಆಯ್ತು?
ಡ್ಯೂರಿಂಗ್ ದ ಮೂವಿಂಗ್ ಟೈಮ್ ಅಲ್ಲಿ ಆಗಿದೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ.
ಮೂವಿಂಗ್ ಟೈಮ್ ಅಲ್ಲಿ ಟಚ್ ಆಯ್ತಾ?
ಹೌದು. ಅಬ್ಸ್ಟ್ರಕ್ಷನ್.
ಏನ್ ಮಾಡಿದ್ರಿ ಆಮೇಲೆ?
ಏನ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ನಾವು.
ಏನು ಮಾಡಿಲ್ವಾ? ಇವ್ರಿಗೂ ಮಹೇಶ್ ಶೆಟ್ಟಿಗೂ ಏನ್ ಸಂಬಂಧ ಮೇಡಮ್?
My lords, they are the followers.
Followers? ಅವ್ರು ಯಾರು ಪೊಲಿಟಿಕಲ್ ಲೀಡರ್?
Mahesh Shetty, please, my lords. My lords, when
Not
it
a
was
political
ordered, he should
leader,
not come and canvass any kind of a speech over there, my lords. Intentionally
that is a different
ಬಂದಿದ್ದಾನೆ.
case.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ.
ಒಂದ್ ನಿಮಿಷ ಅವ್ರು ಮಾಡಿ ವೇಟ್.
ಅವ್ರು ಇಂಟೆನ್ಷನಲಿ ಅಲ್ಲಿ ಬಂದಾಗ ಪೊಲೀಸ್ ಅಫಿಷಿಯಲ್ ಅಬ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡ್ತಾರೆ. ಇನ್ ಸ್ಪೈಟ್ ಆಫ್ ಯು ಬೀಯಿಂಗ್ ಟೋಲ್ಡ್ ನಾಟ್ ಟು ಕಮ್ ಇನ್ ದಟ್ ಪ್ಲೇಸ್.
ಓ, ಯು ಬೀಯಿಂಗ್ ಟೋಲ್ಡ್ ಅಂದ್ರೆ
ಯು ನೋ ಮಹೇಶ್ ಶೆಟ್ಟಿ
ನನಗೆ ಹೇಳ್ತೀರಿ ಅನ್ಕೊಂಡೆ.
ಮೈ ಲಾರ್ಡ್ಸ್ ಅವನಿಗೆ ಹೇಳಿದ್ರು ಕೂಡ ಸ್ಪಾಟ್ ನಲ್ಲಿ ಬಂದು ಮತ್ತೆ ಗಲಾಟೆ ಮಾಡ್ಲಿಕ್ಕೆ ಶುರು ಮಾಡ್ದ. ಸೊ ಪೊಲೀಸ್ ಅಫಿಷಿಯಲ್ ಅವ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ಬಿಟ್ಟು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಗೆ ತಗೊಂಡ್ ಹೋಗ್ಬೇಕಾದ್ರೆ ದೀಸ್ ಅಕ್ಯೂಸ್ಡ್ ಪರ್ಸನ್
ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕಾರೆ
ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕು.
ತಗೊಂಡು ಹೋಗೋದು ಮಟೀರಿಯಲ್ ಥಿಂಗ್ಸ್ ನ.
ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕಾದ್ರೆ ಇವನ್ ಅಬ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಪೊಲೀಸ್ ಅಫಿಷಿಯಲ್ ಅಬ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಕಾರ್ ನಲ್ಲಿ ಹೋಗ್ಬೇಕಾದ್ರೆ ಹಿಂದೆಯಿಂದ ಬಂದು ಓವರ್ಟೇಕ್ ಮಾಡಿದ್ದಾರೆ. ಓವರ್ಟೇಕ್ ಮಾಡಿ ಪೊಲೀಸ್ ಕಾರ್ ನ ಡ್ಯಾಶ್ ಮಾಡಿದ್ದಾರೆ. ಐ ವಿಲ್ ಪ್ಲೇಸ್ ಇಟ್ ಆನ್ ರೆಕಾರ್ಡ್ ದ IMV report and if any kind of an antecedents against him, my lord.
CCTV ಇಲ್ವಾ?
CCTV ಇಲ್ಲ ಇದ್ರಲ್ಲಿ.
ಅಂದಿವೆ ಹೈವೇ ರೋಡ್ಗೆ
ನೀವೇನ್ ಹಿಂದೆ ನಡ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರಾ?
ಇಲ್ಲ ಕಾರಲ್ಲಿ ಹೋಗ್ತೀವಿ.
ಇನ್ನೊಂದು ಕಾರ್ ನಲ್ಲಿ ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ, ಓವರ್ಟೇಕ್ ಮಾಡಿ
ನಂಬರ್ 1 and
ಮೇಡಮ್ ಚೇಸಿಂಗು ಫಾಲೋಯಿಂಗು ಡಿಫರೆನ್ಸ್ ಇದೆ. ಚೇಸ್ ಮಾಡ್ತಾ ಇದ್ರ ಫಾಲೋ ಮಾಡ್ತಾ ಇದ್ರ?
ಓವರ್ಟೇಕ್ ಮಾಡಿ ಡ್ಯಾಶ್
ಓವರ್ಟೇಕ್
ಎಲ್ಲರೂ ಯು ಫಾಲೋ ಮೀ ಅಂತಾರೆ, ಯು ಚೇಸ್ ಮೀ ಅನ್ನಲ್ಲ. ವೈ ಆರ್ ಯು ಚೇಸಿಂಗ್ ಹಿಮ್?
ವಿ ಆರ್ ನಾಟ್ ಚೇಸಿಂಗ್. ನಾವು ಅವರನ್ನು ನೋಟಿಸ್ ಮೇಲೆ ಕರ್ಕೊಂಡು ಹೋಗೋದಾಗ ಫಾಲೋ ಹೋಗಿದ್ದೀವಿ ಅವ್ರ ಜೊತೆ ಬಿಟ್ರೆ.
ವಿಂಡೋ ಗ್ಲಾಸ್ ಯಾವ್ದು? ಪೊಲೀಸ್ ವೆಹಿಕಲ್ ವಿಂಡೋ ಗ್ಲಾಸ್ ಹೊಡೆದಾಕಿದಾರ?
ಇಲ್ಲ ಇಲ್ಲ, ವಿಂಡೋ ಗ್ಲಾಸ್ ಬ್ಯಾಕ್ ಸೈಡ್ ಇಂದ ಹೆಂಗೆ ಹೊಡೆದಾಗತ್ತೆ?
ಬ್ಯಾಕ್ ಸೈಡ್ ಇಂದ ಫ್ರಂಟ್ ಗ್ಲಾಸ್ ಹೊಡೆದಾಕದ್ರ?
ಅದು ಹೆಂಗೆ ಆಗುತ್ತೆ?
ಮೈ ಲಾರ್ಡ್ಸ್ ಇವರು ಹಿಂದೆ ಬರ್ತಾ ಇದ್ರು, ಓವರ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡು ಹೋಗಿ
ಇಲ್ಲಿ
ಪೊಲೀಸ್
simple
ವೆಹಿಕಲ್ ನ ದೇ ಹ್ಯಾವ್
ಇರ್ಲಿ ಬಿಡಿ,
ಡ್ಯಾಮೇಜ್ಡ್ ಇಟ್.
ಇಷ್ಟೊಂದು ಅಪೋಸ್ ಮಾಡಲ್ಲ ಅವರು ಜನರಲಿ.
ಅಲ್ಲಲ್ಲ, ಸಿಂಪ್ಲಿ ಅಲ್ಲಿ ಮಹೇಶ್ ಶೆಟ್ಟಿ ತಿಮರೋಡಿ ಅಂತ ಒಂದು ವರ್ಡ್ ಬಂದ ತಕ್ಷಣ ಇವ್ರದ್ದು ಆರ್ಗ್ಯುಮೆಂಟ್
ಎಲ್ಲ ರಿಪೋರ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಪ್ಲೀಸ್
ಪ್ರೊಡ್ಯೂಸ್ ಆಲ್ ದಿ ಪೇಪರ್ಸ್ ಆಫ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
ಪ್ಲೀಸ್
ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ? ಹಾ ಸರಿ. 4th June.
Obliged.
74.
ಕ್ಯಾತ್.
Please, A2 Malach, no allegation.
ರೇಂಜ್ ರೋವರ್ ನೇ ಕದ್ದು ಬಿಟ್ಟಿದ್ದೀರಾ?
No, it's not me, Malach.
ಮತ್ತೆ
It is accused number 1, 5 and 3.
ವಾಟ್ ಎವರ್. ನೀವೇನ್ ಮಾಡ್ತೀರಿ? ಡ್ರೈವ್ ಮಾಡಿದ್ರ ಅದನ್ನ?
No, Malach, I was
ಮತ್ತೆ?
not involved in the entire transaction, Malach.
ಇಲ್ಲ, ಐ ಡೋಂಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. ರೇಂಜ್ ರೋವರ್ ಯು ಲಿಫ್ಟೆಡ್. ಮಸ್ಟ್ ಬಿ ಪ್ರೊಫೆಷನಲ್ಸ್.
Malach, in the entire charge sheet material, accused number 2 does not have any role, Malach.
1 HCGP2 emergent notice.
Malach.
ನಿಮ್ ರೇಂಜೇ ಬೇರೆ.
No, Malach.
Yes, yes.
Malach, in the entire charge sheet, Malach, the transaction, accused number 2 was not involved, Malach. If Malach may kindly peruse, Malach.
Belli, 1 HCGP2 emergent notice.
75.
138 proceedings.
Not a signatory to the check.
Please, my lords.
The petitioner, accused number?
Accused number 10, my lords.
The petitioner is accused number 10, who is neither involved in the transaction nor is a signatory to the check, is drawn into the web of proceedings and offense punishable under section 138. In that light,
Much of
1 emergent notice respond. That light, interim order. Next. 76, 85, 2, 3, 4, 5. Yes, next.
77.
I appear for the petitioner, my lord, subsequent purchaser.
The petitioner is accused number 8, who is said to be the bona fide purchaser from the hands of accused number 2, unknowingly that it would result in a crime, had purchased the documents appended to the petition. Prima facie demonstrate that the petitioner is a bona fide purchaser. Therefore, interim order print ಮಾಡಬೇಡಿ. No interim order. No interim order.
I'm sorry.
You can't appear from the car, sir.
I'm sorry, my lords.
No interim order. Yes, next.
I'm very sorry, my lords. Very sorry, my lords. Due to unforeseen circumstances, I had to.
Unforeseen?
There was some emergency, my lords. Otherwise, your lordships, I wouldn't have.
In that light, there shall be an interim order of stay. Yes, next.
Grateful, my lords.
Car ಅಲ್ಲಿ unforeseen circumstance ಏನು?
There was some emergency, my lords. I got late to the court. I'm on the way to the court, my lords.
All right. Yes.
Grateful.
ITP Act ಮೇಲೆ.
ITP accused number 1.
My lord, section 15 clause 2.
Not mandatory. ಆಮೇಲೆ.
My lord, she is the receptionist.
No problem. ಆಮೇಲೆ.
My lord, kindly peruse the column number 17, my lords.
Note ಆಗಿದೆ. Yes.
Victim has stated his name.
Yes. Anything else? Discharge ಹಾಕೊಂಡು. Best. Yes. Section 15 not mandatory at all. ಆ ಕೋರ್ಟ್ ಹೇಳಿದ್ರೆ ಕೇಳಬಹುದೇನೋ.
15 clause 2.
No, sir, not are Siguran sir, not mandatory.
As per that, there are 2 males panchas, my lords. It has conducted.
ಅದು not mandatory. 13-2 ನೀವು ಹೇಳ್ತಿರೋದು ಅದು not mandatory.
15-2,
15-2, 13-2, all not mandatory. The gone are those days. Yes. Supreme Court has now clarified. Next. File discharge. Yes.
79.
ಆಮೇಲೆ after that.
Complaint, my lord, the baseless complaint. Kindly complaint.
Baseless? What do you mean, sir?
It is a Corona time, my lord. Corona time, my lord. 33
How do
level.
you say it's baseless? In the meantime, next.
Already.
Meantime, next. Huh? ಯಾವ್ದ್ರಲ್ಲಿ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ವಾ
ಸ್ಟೇ ಕೇಳಿಲ್ಲ ಸ್ವಾಮಿ, ಬರೀ
ಮತ್ತೆ
ಲಾಂಗ್ ಡೇಟ್
ನೋಟಿಸ್ ಎಸ್
ಎಮರ್ಜೆಂಟ್.
emergent. Meantime, next. The petitioner is accused number 2 was accused number 2 while registering the crime had been dropped after investigation while filing the charge sheet. On the same evidence, the petitioner is again brought back into the web of proceedings on an application filed under section 319. In that light, there shall be an interim order of stay of further proceedings by the petitioner. Till the next date of hearing, it is made clear that the trial is not stayed. Yes, next.
82.
List after vacation. Next.
83.
For the petitioner, my lords.
A2 to A9, 80 to A9, 498A. Yes. Next.
My lords, page number 99. My lords.
I stay quoted, sir. Yes, next.
Grateful.
Lords, I'm appearing for the petitioner.
84, 69.
69 and
2 years.
238 minutes. 2 years, my lords.
80, 23 to 25.
Yes, my lords.
Very bad.
No, it is a consensual act, my lords.
Consensual actor. Illegal.
ಇಲ್ಲ, it is in her own statement.
In the meantime, Jevai. 100 ಮಾಡ್ಬೋಣ.
Grateful.
Jevai 100 ಪರ ಇಲ್ವಾ? Yes. PDO.
PDO, my
Arrest
lord.
ಮಾಡಿರ್ತಾರೆ. ಚಾನ್ಸ್
My lord,
ಇಲ್ಲ.
I've already secured a bail, my lord, but
So I should grant stay, is it, if you secured a bail? Seriously?
my lord, abatement to suicide, my lord. However, my lord, if I may say that the notice was issued,
Oh,
my lord, because
your name is
the-
Manasa, is it?
No, my name is Akshata, my lord.
Okay. Heard the learned counsel Akshata appearing for the petitioner, no case.
My lord, if I
One
may-
HCGP 2 emergent notice, the petitioner is a Panchayat Development Officer, is now alleged of offence punishable under section 306 of the IPC - abetment to suicide. A perusal at the summary of the charge sheet would not indicate even a titter of offence or ingredient as obtaining under section 107 for it to become an offence under
My lord, charge sheet is not filed.
complaint so and so would not indicate that any ingredient of offence. 306 or 108 is it?
108, my lord.
108/306 of the IPC, finding no ingredients that are necessary to be present for an abetment to suicide as obtaining under section 45 of the BNS. There shall be an interim order of stay of further investigation qua the petitioner, failing which it would run foul of.
Investigation.
ಗೊತ್ತಾಯ್ತು ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ failing which it would run foul of 2025 SSC online SC page 2332. There shall be an interim order. ಹೇಳಾಯ್ತಲ್ಲ?
My lord, I have another judgment.
Stayed.
86.
I appear for petition.
In the meantime, next.
87.
ಶ್ರೀರಾಮ್ ರೆಡ್ಡಿ ಯಾರು? ನೀವ್ ಯಾರು? ನೀವು ಶ್ರೀರಾಮ್ ರೆಡ್ಡಿ ಯಾವಾಗ? Yes. 86 in the meantime, next.
87.
Section
85 in the meantime, next.
88.
ಎಲ್ಲರಿಗೂ.
I appear for petitioner, my lord.
In the meantime, next.
89.
Leeladhar. The petitioner is accused number 3. A perusal at the complaint would not indicate any role of this petitioner in the alleged episode of crime, permitting further proceedings without there being any role. It would become an abuse of the process of the law, albeit prima facie. In that light, there shall be an interim order of stay.
90.
The metro.
Metro chicks.
Where, Lord,
What do you do, sir?
CCTV.
What CCTV? Metro, you
Lord, the
take the
photographs-
pictures of women from the backside and post them on that Metro chicks site? What nonsense is this?
Lord, the photos.
How
Lord,
can you do it? Metro nu safe ಆಗಿ ಬಿಡಲ್ಲ. ಏನ್ what nonsense? What kind of men you are?
Lord, the photos.
What? Click every picture from the back of the woman and post it on Metro chicks?
See the photographs, Lord, 28,
Nonsense.
27. Nothing is there.
What nothing is there?
Photographs, Lord, that doesn't speak that obscene photos are.
Why did you click, sir? Why did you click?
Photos.
And Instagram page Metro chicks.
Lord,
ಎಲ್ಲೋದ್ರೂ women ನ ಬಿಡಲ್ಲ.
Lord,
You don't leave women to be safe
cameras are-
anywhere.
Lord, CCTV cameras.
What
are
CCTV
installed.
camera is there?
CCTV cameras are there. Lord.
And Insta page ಬೇರೆ. ಅದ್ರಲ್ಲಿ reels, metro chicks.
Not a very investigating officer.
Not investigating.
He is the complainant.
No amount of technicality, sir, I will permit such things to happen. Technicality cannot override such acts of yours. Time has come that we should stop on technicality in certain things.
No offense is made.
What? No offense. Clicking the woman from back and posting it in
CCTV
metro chicks is not an offense?
So throughout CCTV is.
Oh, no, sir.
He has
Nothing.
not committed it.
Thanks. Oh, who has not committed?
He has not, the petitioner
Yes.
has not committed.
Dismissed. Next.
91,
In the meantime, next.
92, 91.
Stay application. No, sorry. 91 yaru? Aminullah. Yarilla. Emergent notice to the rest. 1 HCGP, 2 emergent notice. Next.
92,
In this, I appear for, I may be permitted.
Fresh
to appear.
crime, sir. No investigation by papers back. 25/3/26 is the crime registered.
Months delay in.
No,
filing the-
they are investors, sir. Nothing. 1 HCGP, 2 emergent notice, the learned HCGP to secure the entire investigation papers and place it before the court on the next date. Yes.
Any date is given.
No stay. Yes.
No, date is given.
No, date 10th June. Yes. Next.
93,
Petition.
In the meantime, next.
94,
I appear for petitions number 1 and 2 in this matter.
The, what
This
are
is
the civil suits pending?
Please, my lord, this is the 12th FIR that is being
Correct.
registered
The
against.
petitioner, the second respondent complainant has gone on registering crimes against this petitioner in a matter that is purely civil in nature. The present is the 12th. In that light, there shall be, and finding the issue purely civil in nature, which is being dressed with a color of crime repeatedly, there shall be an interim order of stay of further proceedings, further investigation.
Further proceedings.
Further
my lord.
proceedings
Charge sheet has
where the
also been
petitioner till the
filed.
next date of hearing.
Grateful, my lord.
95, Anusha. 1 HCGP, 2 emergent notice. Next.
96,
Offense
78/3.
APA identical, ma'am.
Quash, disposed.
Please.
97,
Lord, I appear for the petitioner in this case, my lord. False promise to marriage, my lord. Married woman makes an allegation of false promise to marriage.
Where are you?
She's having a kid.
Manalidira?
No, my lord. Due to unavoidable circumstances, my lord, I was not able to present before your lordship.
Unavoidable.
Brother's
Due to
marriage, my lord.
unavoidable circumstances, no interim order. Yes.
My lord, sorry, my lord. Sorry, my lord. Brother's marriage, my lord.
In the meantime, yes.
Grateful.
Mm.
98,
Happy for the petition in this matter, my lords.
Page 39. Outraging the modesty. 99 alva?
98.
Oh, no, sorry. ಇದು GM ಇಲ್ಲಿ 482 ಹೆಂಗಾಯ್ತು?
My lords, so basically it was applied for death certificate, my lords. And later-
GM ಹೋಗ್ಬೇಕದು. Post the
No,
matter
no.
before the bench having roster. Births and deaths ಅಲ್ಲಿ certificate ಕೊಟ್ಟಿಲ್ಲ ಅಂತಂದ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ಬೇಕು. Yes. Post the matter before the bench having roster hyphen general miscellaneous. Next.
99,
Omkar Basav Prabhu.
Petitioners are accused number 1 and 3.
Page 39, sir. Outraging the modesty. The petitioners are before this court seeking the following prayer. A perusal at the charge sheet ಆಗಿದೆಯಾ?
Yes, my lord.
Perusal at the summary of the charge sheet would not indicate any act of outraging the modesty of any person, much less a woman. What is alleged is the offense punishable under section 341, for which even the ingredients under section 339 is absent. Therefore, there shall be an interim order of stay of further proceedings by the petitioner to the next date.
Right.
Yes.
100,
Meantime.
For petition, my lordship.
Aito, next.
101,
There really, madam.
Appearing for petitioners in this matter. madam.
Wait, sir.
101. Please, madam.
11:10 ಅದೇನು? ಅಲ್ಲ ಆಯ್ತು 11:10 ಯಾಕೆ 11 ಅಲ್ವಾ? 10 1
101,
Petitioner is accused number 3, finding no role of no specific overt act or role against the petitioner accused number 3, permitting further proceedings would run, further proceedings become an abuse of the process of the law, albeit prima facie. In that light, next.
102.
Lords, appearing for the petitioner, my lords.
The 102 and 106 same.
Yes.
Ah.
Lords, page 44, your
ಅಲ್ಲ
lords.
ಈಗ ನೋಟಿಸ್ ಮಾಡ್ಬೇಕಷ್ಟೇ ಇನ್ನೇನು.
So I'll just only say this, my lords. Page 44, your lords will see. The appeal is, there are financial constraints which should have been considered by the court at the time of issuance of the fine levy warrant. Page 44, he doesn't challenge the appeal because it was a joint memo which was filed. Based on the joint memo, an order of conviction is passed. Now, conviction order cannot be challenged under 375, there is a bar. Now, the question is, the grounds raised in the appeal is, I have to pay the money, but the financial constraints are there, they should have been considered at the time of fine levy warrant. Lords, now kindly see.
You are the complainant.
I'm the complainant. Now, page 19, your lords will see what is the order passed.
Notice
It has to be stayed, my lord. The suspension of sentence is to be stayed. And 10%, my lords, you have been dodged despite admitting that this is the liability. Joint memo.
How do you stay suspension of sentence?
Lord, suspension of sentence is to be stayed only on the ground at page 20, my lords. Without condemnation of delay, the stay could not have been, suspension should not have been granted. Because unless the delay is condoned, it would not arise.
Yes, delay, sir.
80 days. That's the
Sentence
reason.
suspend ಮಾಡೋದು will be.
Lords,
So ಅದು without hearing
Lords, that's the reason why I said, my lords.
may not be correct.
Lords, if the
Because
suspension
if it, see, bail reject, cancel ಮಾಡೋದು ಅಥವಾ bail stay ಮಾಡೋದು.
it has to be heard before the other person. I understand.
Sentence suspend. You may have a case, correct. But without sentence suspend ಆಗೋಗಿದೆ ಈಗ.
The criminal appeal, there should be some application. The grounds
All
is,
that we may answer, but you tell me without hearing the person who has been set at liberty now to bring him back.
I just wanted to say one sentence, my lords, that appellant is having good grounds on the merits of the appeal. There is no merits which is, he has not challenged the merits at all.
Joint memo ಆಗಿರೋದು.
That's the reason why I said, this is the reason on which he says that.
Correct, I will accept total non-application
for
of mind.
cancellation of a bail, similar principles is to be applied for.
The problem, see, without
Take out
hearing,
notice, my lords.
sentence suspend ಆಗೋಗಿರೋದ್ರಿಂದ, without hearing.
Very well.
ಕಷ್ಟ. But what, we will definitely set it aside, not a problem. This should not be the way court should pass orders.
Please, my lords.
But how can you understand? By interim order sentence suspend stay ಮಾಡ್ಬಿಟ್ರೆ. ತೊಂದ್ರೆ ಆಗ.
I'll take out notice.
ಯಾದ್ ಮಾಡಿ. Heard the learned senior counsel, D.R. Ravishankar appearing for the petitioner. The petitioner is the complainant. The respondent, the accused. Several transactions between the two ends up in conviction of the accused. The matter reaches the appellate court. Before the appellate court, the conviction is set aside. So sentence is suspended on the joint memo filed by the two.
No. The conviction itself was based on the joint memo.
The conviction was on the basis of a joint memo. The appeal is preferred, and in the appeal, it is the averment that there is a good case on merits of the matter, while there was no merit in the, there was nothing to be considered on merit, as the conviction itself was based upon a joint memo. In that light, the concerned court has grossly erred in passing perfunctory order of this kind, that too suspending sentence on reasons that are found in thin air. But the sentence has remained suspended. Therefore, the hearing of the respondent would become imperative if any interjection of an order of suspension of sentence is to be passed. That light, ಅದಕ್ಕೆ ಎಲ್ಲ ಬರ್ದಾಗಿದೆ ಬಿಡಿ, ಇದು final order ಅಷ್ಟೇ. Yes. In that light, the petitioner to serve on the counsel who represents the respondent in the trial proceedings.
In the appellate court.
Before the appellate, in the appellate proceedings. List on 4th June, fresh matters.
Great.
103.
143A. D. Prabhakar.
The application was filed by the respondent under section 143A, and the trial court has directed to pay the interim compensation 15%.
What's wrong?
It is in contrary with the judgment rendered in Rakesh Ranjan Srivatsa versus
Why?
Jharkhand.
Why it is contrary?
The trial has not yet commenced, my lords. The accused was about to cross-examine the PW1.
What's your name?
Pooja S.
Pooja S. All right. Heard the learned counsel, so Pooja S. appearing for the petitioner. The petitioner is before the court calling in question an order directing payment of 15% of the check amount under section 143A. The law in this regard is well settled that if the accused would dodge the trial, it is only then under certain other circumstances or dodge the trial inter alia, an order can be passed under section 143A. In that light, there shall be an interim order of stay of the said order till the next date of hearing. Petitioner to serve on the counsel who represents the respondent in the trial proceedings.
Much obliged.
Next.
104,
Meantime, next.
105.
Accused number 1 to 4, my lordship. Petitioners as accused number 1 to 4. My lordship, alleged offences under section 379 of the IPC, my lordship. My lordship, the allegation is in the year of 2024, ಹಸುಗಳನ್ನ ಕದ್ಕೊಂಡು ಹೋಗಿದ್ರು ಅಂದ್ಬಿಟ್ಟು in the year of 2026 ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ against
Missing cows.
Yes, my entire family, my lordship. After lapse of 2 years.
Your ಅಷ್ಟೊಂದು ಕೌಸ್ ಇದ್ವಾ ಅಲ್ಲಿ?
ಅಲ್ಲ, 2 ಕೋಯ್ 2 ಹಸುಗಳನ್ನ ಕದ್ಕೊಂಡು ಹೋಗಿದ್ದಾರೆ.
The petitioner is before the court calling in question registration of a crime. In crime charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ, crimes.
ಅದಕ್ಕೂ ಹಾಕ್ಬಿಡ್ತಾರೆ, ಅದಕ್ಕೆ ಕೇಳಿದೆ. The petitioner is before the court calling in question registration of a crime and crime number so and so. In 2024, 2 cows go missing. The entire family is roped into the web of crime in a complaint registered in the year 2026 because the cows were not traced. Therefore, if this would be permitted, it would become an abuse of the process of the law on the face of it. Therefore, there shall be an interim order of stay of further proceedings, the petition, further investigation. ನೀವು ಹಸುಗಳನ್ನ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡೋದು ಬಿಡಿ ಸರ್, ನಿಜವಾದ ಕ್ರೈಮ್ ಇಂದ ಹೋಗಿ. ಯಾಕೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರೆ ಕ್ರೈಮ್ ಇದು?
ಪೇಜ್ ನಂಬರ್ 17 ಅಲ್ಲಿ
2 ವರ್ಷದಿಂದ 2 ಹಸು ಕಾಣೆ ಆಗಿದೆ ಅಂತ ಕೊಟ್ಟ ತಕ್ಷಣ ನೀವು ಆ ಕ್ರೈಮ್ ಏನ್ ಬೇಕಾದ್ರೆ ಮಾಡ್ಬಿಡ್ತೀರಾ? Real crimes you don't register. They have to knock at the police station 100 times to register a real crime. 2 cows are missing 2 years ago, crime registered. Yes, next. 106, same as 102.
107.
107, my lord, KP Act proceedings. Page number.
ಅಲ್ಲ ಸರ್, ಇದು ಲಿಯೋ ಕಾರ್ನೆಲ್ಲೋ, petitioner name. He runs a bakery.
No, my lord, no, my lord.
ಮುಂದ್ಗಡೆ ಬೇಕರಿ, ಹಿಂದ್ಗಡೆ ಮಟ್ಕ.
No, my lord, that is not the case. No, your lordship may kindly take.
ಈ ಲಿಯೋ ಕಾರ್ನೆಲ್ಲೋ ತುಂಬಾ ಕೇಸ್ಗಳಿದೆ.
ಪೇಜ್ ನಂಬರ್ 19 ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಲಮ್ ನಂಬರ್ 17 ಕ್ಲಿಯರ್ ಆಗಿದೆ ಮೇಡಮ್.
Yes, sir. I don't forget names, sir.
But he was only implicated based on the confession and statement.
No problem. ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ Halima madam has come in other cases. ಎಲ್ಲಾ ಕೇಸಲ್ಲೂ ಇದೇ ground.
Not aware of that case.
You are not aware, sir. I am aware. I told you I don't forget.
My lord, in this case,
month ago there are 3 cases of this Leo Carnello. He runs a bakery, correct?
Lord, as per this charge sheet, my lord, he doesn't run any bakery. My lord, it's completely covered by my lord's judgment.
I correct, sir. No, no.
My lord, only based on the confession and statement, my lord, he has been implicated.
HCGP 2 emergent notice list on 4 complainant ನೀವೇ ಅಲ್ವಾ? Yes. 2 HCGP accepts notice for the respondent list on 4th. Next.
My lord, apart from that, my lord, there is no materials in the charge sheet, my lord, to implicate the present petitioner.
No problem, sir. We'll see. Yes. Next.
108.
Binu. NDPS accused number 1. Yes. Notice.
Not another matter is the connected matter. Tag is better.
ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ಟಿದೀವಾ?
Stay ಕೊಟ್ಟಿಲ್ಲ.
Tag along with so and so 10th June.
On same course of action, my lord, 2 FIRs registered.
Sorry?
On same course of action, my lord, 2 FIRs registered.
We'll see. Yes. List on 4th June. Next.
My lord,
ಇವ್ರ ಮೇಲೆ ಇನ್ನೊಂದು ಕೇಸ್ ಇದೆ my lord. ಅದು ಸೇಮ್ my lord. NDPS.
Posted on 25/5, my lord.
ಎಲ್ಲಿ?
NPW's issue in that matter.
The warrant hanging on the head of the petitioner shall remain state till the next day.
Matter, another matter.
ಲಿಸ್ಟ್ ಆಗಿರಲ್ದ ಮ್ಯಾಟರ್ ಎಂಟ್ರಿ ಮಾಡ್ಕೊಡಕ್ಕಾಗತ್ತೆ. Yes. Tag the ನಾಳೆ. ಇದನ್ನ ಮಾತ್ರ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಹಾಕಿ, ಅದನ್ನ ನಾಳೆಗೆ ಹಾಕಿ. ನೆಕ್ಸ್ಟ್ ಗೊತ್ತಾಯ್ತಾ ಇದಕ್ಕೆ?
109.
My lords, petitioner, my lords. The petitioner, my lords, what has happened, my lords? My lords, he stays in US, my lords, the attorney there in US, my lords. Why I will sell my property with a false GPA? The question is that, my lord, I lodged a complaint, page 70, my lords. If your lordship go to page 70.
I don't know. Yes.
I reported to DIG, my lords. Or liberty with, after notice, my lord, I can press.
Correct, yes. 1 HCGP 2 emergent notice returnable by the 4th. consideration of interim prior would be after hearing the complainant.
Please.
Yes.
110.
I prefer the petitioner in this matter, madam. There were other criminal complaints before the, I produced along with the petition.
Stay ಇದೆ ಯಾವ್ದ್ರಲ್ಲಾರು?
All cases are disposed.
Correct.
ಇದ್ರಲ್ಲಿ
A3 and A4.
ಇದರಲ್ಲಿ notice, I was given notice to R2.
One HCGP2 emergent notice returnable by 10th June. The learned counsel submits in almost all the crimes between the parties. The proceedings have been quashed by the coordinate benches of this court. Therefore, there shall be an interim order of stay for the proceedings by the petitioner to the next date of hearing. Next.
11.
Then charge sheet ಆಗಿಲ್ಲ 2024 crime ನಿಮ್ದಲ್ಲ sir. Next matter.
ಆಗಿಲ್ಲ ಎಲ್ಲರೂ
Number 3 has been granted.
ರಿಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ ಒಂದು ಶಾರ್ಟ್ ಟೈಮ್
ಅಲ್ಲ 24 crime ಅಲ್ಲಿ charge sheet ಹಾಕಿಲ್ವಾ?
ಇನ್ನು ರಿಕಾರ್ಡ್ಸ್ ಬಂದಿಲ್ಲ ಅದಕ್ಕೆ.
ಅಲ್ಲ, one of the co-accused has been granted stay, my lord.
ಕೊಡಿ number.
Page number 22, my lord.
22.
Criminal petition number 1744 of 24.
Yes, same order.
Please.
112. 22.
112, my lord.
Under bar.
Covered by judgment, my lord, page number 84.
Madam? ಯಾವುದು? ಅದೇ ಮಾಡಿ ಅಷ್ಟೇ, ಟ್ಯಾಗ್ ಅಷ್ಟೇ. ಅಲ್ಲಿ ಏನಿದೆ ಅದು. ಇದ್ರೆ ಅಷ್ಟೇ ಇದೆ.
Page number 84.
112. Page number
84.
84 under bar quashed. Next.
113.
Okay, petition. Offense under section 318, 319.
Creation of documents.
Please.
Creation of documents. Yes. One HCGP2 emergent notice.
114.
20%.
10%.
ಯಾವಾಗ ಕಟ್ತೀರಾ?
10%.
ಟೈಮ್ ಪಾಸಾ?
ಅಲ್ಲ 10%.
10 ಬಾರ್ಗೇನ್ ಆಗಲ್ಲ.
2 months.
Anyway, we'll see. A list on 4th June, the counsel for the petitioner to secure instructions with regard to the timeline, regard to the date on which
2 months.
Demand draft would be produced. List on 4th June ಹೇಳಿದ್ನಲ್ಲ. Till such time, the order, the impugned proceedings shall remain stayed.
Connected matter 119.
ಎಲ್ಲ ಹೋಗ್ಬೇಕಾ?
ಇಲ್ಲ.
ಇರಿ. Yes.
115.
ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಊರಿಗೆ ಹೋಗಿದ್ದಾರೆ ಸರ್.
60 115 ಶಿವಶಂಕರ
Please, madam.
ಯಾರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂದ್ರು?
ಅಲ್ಲ, ನನಗೆ ಹೇಳಿದ್ದಾರೆ.
ನೀವು ಫಸ್ಟ್ ಕೇಸ್ ಯಾವ್ದೋ ಒಂದು ತೀರ್ಮಾನ ಮಾಡಿ, ಆಮೇಲೆ ಯಾರು ತೀರ್ಕೊಂಡಿದ್ದಾರೆ ಅಂತ ತೀರ್ಮಾನ ಮಾಡಿ.
115. Sorry. False promise to marry, my lord. There is a delay in filing the complaint.
ಯಾಕೆ?
ಅಲ್ಲ, incident occurred on 22/4/2025, my lord. But my lord, FIR has been registered on 1/8/2025, my lord. False promise to marry, my lord. But my lord, since 2 years back, my lord, they are well known.
Page number 34 ಅಲ್ಲಿ ಡೀಟೇಲ್ಸ್ ಆಗಿದೆ my lord. Page number 34, my lord.
ಏನಿದೆ?
17, my lord.
ಏನಿದೆ?
ಅಂದ್ರೆ 2022/4/2025.
ಅಲ್ಲ, ಅದು 2 ವರ್ಷ ಬಿಟ್ಟು ಬೇರೆ ಏನಾದ್ರು ಇದೆಯಾ?
ಸ್ನ್ಯಾಪ್ಚಾಟ್ ಮುಖಾಂತರ ಪರಿಚಯ ಆಗಿದೆ. 2 ವರ್ಷದ ಹಿಂದೆ.
In the meantime, yes.
Please, ma'am.
116. And for the petitioner, my lord.
Same identical order pass ಮಾಡಿದೀನಿ ಕೊಡಿ. Same order, tag and same order. Next.
117.
498. 498.
498. Sir.
D24 ಇದೆ.
ಇರ್ಲಿ.
Lord.
498 ಅಂದ ತಕ್ಷಣ ಸುಮ್ಮನೆ ಅಷ್ಟೇ ಕೊಟ್ಬಿಡ್ತೀವಿ ಅಲ್ವಾ? ಪೇಜ್ 28 ಹೋಗಿ, ಎಲ್ಲರ ಮೇಲೂ ಅಲಿಗೇಷನ್ ಇದೆ, ಎಲ್ಲ ಟಾರ್ಚರ್ ಮಾಡಕ್ ಬಿಟ್ಟಿದೆ.
ಅಲ್ಲ, ಅಲಿಗೇಷನ್
ನೋ ಸರ್, ಎನಿಥಿಂಗ್.
ಅಲ್ಲ,
per own certificate.
ಅಲ್ಲ, ಇವರೆಲ್ಲ ಎಲ್ಲೋ ಇರೋದು.
ಎಲ್ಲರೂ ಇರ್ಲಿ, ಪರವಾಗಿಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡಿ ಸರ್, ಪೇಜ್ 28 ಹೋಗಿ ಸರ್. ಎಲ್ಲರದ್ದು ಗುಣಗಾನ ಇದೆ ಸರ್.
We have got recordings. ಏನಂದ್ರೆ ಅವರೇ ಬಂದು ಗಲಾಟೆ.
ಎವಿಡೆನ್ಸ್, ರೆಕಾರ್ಡಿಂಗ್ಸ್ ಇದ್ರೆ ಎವಿಡೆನ್ಸ್ ವಿಲ್ ಪರ್ಮಿಟ್ ಟ್ರಯಲ್.
ಅಲ್ಲ, ಆತರ ಅಲ್ಲ, ಇವರೆಲ್ಲ ಎಲ್ಲೋ ಇರೋರ್ನ ತಂದು ಇದ್ ಮಾಡಿ.
ಎಲ್ಲಿಂದಲೋ ಬಂದವರು ಅಲ್ಲ ಇದು.
ಇವ್ರು ಯಾರು ಸೀನಲ್ಲೇ ಇರ್ಲಿಲ್ಲ.
ಅದೆಲ್ಲ ನೋಡ್.
ಅವತ್ತು
17 clearly makes out all the allegations. Yes.
ಅಲ್ಲ,
one HCGP, 2 emergent notice ಅಷ್ಟೇ. No stay for anybody. In-laws ಗೂ ಇಲ್ಲ, ಏನು ಇಲ್ಲ. Yes.
A date may.
List on 10th June. Yes.
118.
Petition. Allegation as against this petitioner, I introduced accused
Correct,
number
sir.
6 to one of the
Correct,
RTO.
sir. Page 31 ಅಲ್ಲಿ A8 ಗೆ ಲಾಸ್ಟ್ 4 ಲೈನ್ಸ್ ಅಲ್ಲಿ ಇದೆ. ಅಷ್ಟು ಸಾಕು. 1 HCGP to emergent notice.
Omnibus.
ಆಮ್ನೇನು ಇಲ್ಲ, ಬಸ್ಸು ಇಲ್ಲ, ಎಲ್ಲ ಕರೆಕ್ಟ್ ಆಗೇ ಇದೆ.
ನಮ್ದೇನ್ ರೋಲ್ ಇಲ್ಲ.
Nothing. Last 4 lines of page 31. Yes. Next.
119.
Notice.
120.
1 HCGP to emergent notice.
Serial number 14 connected.
14?
Connected, Swami.
14?
Yes, please.
ಬಂದಿರ್ಲಿಲ್ವಾ ನೀವು?
ಬಂದಿದೆ 114, Swami.
114?
Yes, please.
ಈಗ 20% ಅದು?
Yes, please.
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನ್ ಸಂಬಂಧ?
ಎರಡು ಒಂದೇ.
ಅದೇನ್ ಕನೆಕ್ಟೆಡ್? ಅದು 138 ಪ್ರೊಸೀಡಿಂಗ್.
Yes, please.
ಇದು ಯಾವ್ದು? ಇದು ಸ್ಟೇಟ್ ಇದೆ ಪಾರ್ಟಿ ಇದರಲ್ಲಿ? 119. Okay, same. Sorry. Yes. ರಾಜಶೇಖರ್.
Yes, please.
ಅದು ರಾಜಶೇಖರ್. ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ. ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದೀನಿ ಅದು 114 ಅಲ್ಲಿ.
120.
120.
Petitionable.
1 HCGP to emergent notice.
121.
420 my lord is already repaid.
No, ಅದ್ ನೋಡೋಣ, ಬಂದ್ ಹೇಳಿ ರಿಪೇಮೆಂಟ್ ಆಗಿದೆ ಅಂತ. Yes, next.
Meanwhile, my lord, other connected matters are stayed, my lord. Other.
ಪರವಾಗಿಲ್ಲ. Yes.
121.
For the petition, my lord.
In the meantime, next.
22.
DV Act notice. Husband ಗೆ stay.
Already permanent element is granted. Already permanent element is granted.
No
in the divorce petition.
No.
That amount is already paid.
No problems. ಅದು ಯಾವುದಕ್ಕೆ ಸಂಬಂಧ?
Permanent element is already paid.
Let the wife come and tell. Yes. Next.
Can date by kindly be fixed.
Emergent notice to the respondent returnable by 17th June. 16th June.
Permit me to serve a copy of the petition to the council.
Petitioner to serve on the council who represents the respondent in the trial proceedings. List on 18th June. Gopal Krishnamurthy.
123.
OS number.
OS number, my lord, 603 of 22.
603 of
22.
TI granted on?
Lord, the rejection of plaint is rejected by the respondent number 2, my lord.
His plaint is rejected.
Plaint, their application is rejected. Thereafter, they will lodge this complaint.
The petitioner is the defendant in OS 603 of 2022.
Plaintiff, my lord, plaintiff.
Plaintiff. TI reject ಆಯ್ತು ಅಂದ್ರೆ?
ಅಲ್ಲ. Rejection of plaint, their application is rejected.
The petitioner institutes suit in OS 603 of 2022.
Please.
An application is filed by the respondent complainant seeking rejection of plaint under Order 7 Rule 11 CPC. That comes to be rejected. The rejection immediately thereafter springs the subject crime. In that light, there shall be an interim order of stay of further proceedings, quay the petitioner till the next date of hearing.
124.
Grateful.
Hearing for the petitioner, my lords. That's the offense is
The meantime, next.
125.
Hearing for the petitioner in this matter. Case counter case. Complaint was given by me first on 25 to 26, which is resulted in a B report. Now, my case, which was registered first, is still pending. The same investigator had to investigate the
B report ಏನಾಗಿದೆ?
B report ಹಾಕಿದ್ದಾರೆ. RTC ಇರೋದು ತಂದೆ ಹೆಸರಲ್ಲಿ. It's a land dispute between.
That's all right. B report ಏನಾಗಿದೆ?
It had to be challenged, your lordship. It was filed on 7/4. 6/4, I appear before the IO and give all the CD and the pen drive which contains.
ಒಂದು ಟೈಮ್ ಮೇಲೆ ಕಾರ್ಸ್ ಬಂದಿಲ್ಲ ಸರ್.
ಇಲ್ಲ, B report ಒಂದರಲ್ಲಿ ಹಾಕಿ ಇದೇ ಪ್ರಾಬ್ಲಮ್ ಆಗೋದು. ಇದರಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್.
Investigation is
after your lordship's direction, series of direction. They again issued a circular and asking that there will be departmental action for violation of this.
ಹೌದಾ? ಇಲ್ಲ ಅಂದ್ರೆ ಆಗಲ್ಲ ಇದು.
My complaint was first.
In the meantime, yes, next.
126.
Meantime.
127.
Please.
Is there in this case? 108. 108 of.
That's a 306 IPC.
Yes, sir.
Fresh crime. Learned HCGP is directed to accept notice for the respondent to secure the investigation papers and place it before the court 4th June.
Kindly see page number.
Bail ತಗೊಂಡಿಲ್ವಾ?
No, man. The bail was rejected.
Take bail, sir. Prima facie there is a ground. Yes. Next.
128.
For the petitioner, my lords.
The petitioner is before the court calling in question proceedings in so and so. The petitioner registers the crime on 16/5/2025. As a counterblast, the impugned crime is registered on 10/9/2025. In that light, there shall be an
16 minutes. The complaint herself registers a complaint.
Petitioner's talva adu.
ಅಲ್ಲ, ಅವರು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ ಟು ಕಂಪ್ಲೇಂಟ್
files a first complaint, my lords, on 16/5. There's a conciliation proceedings, my lord. She agrees that I'll go with her husband. Statement is given.
The family ಇತ್ತಾನೆ ಇದು.
Please, please.
Yes, in the meantime, next.
Great.
129.
Hearing for petition this case, my lord. 498 E and 306. Petition is the husband of the deceased. Prior to the incident, prior to the incidents, there is no any allegations level at against
You are the
petitioner.
husband of the deceased.
Petition is the husband of the
Who else can abet, sir? Anything else, sir?
There is no any prior.
What any horrendous allegations are there? Anything else?
Even there, the petitioner was taking care of the entire family of the
no,
deceased,
sir.
my lordship. Still, they are taking care of the petition.
Who can abet other than the husband?
I say.
Oh, you are merely taking care of the children or parents after her death will
No,
not.
no, prior to from the date of marriage.
No
From the date of marriage.
No problem.
And the petitioner purchased a car for the father-in-law, my lordship. They are seeking their livelihood based on the car which purchased by the petitioner, my lordship. Even still, they are taking care of the family of the petitioner.
हो नहीं सकता. Discharge ಹಾಕೊಳ್ಳಿ.
Notice my brother, my lord.
No.
Charge sheet live witness ಇದಾರೆ my lord. As per CW.
Not a case for one moment's.
Petition
Pendants.
secured the deceased to
No,
the hospital. There is
no.
no any dying declaration of this
Hey,
case, my
want dying declaration? No problems. Anything else? You want me to write? I will write. That will pin you down completely.
Notice my bishop, let
No
them
notice.
for this
sir.
court.
Nothing. This husband should not be spared. Yes.
Apart from the after deceased, only the complaint raised against the petition, my lordship. Prior to that, from the date of marriage, there is no any single allegation leveled against the
That does
petitioner.
no problems. ಬೇರೆ ಏನಾದ್ರು ಇದೆಯಾ sir?
And while the incident, the husband was in same house, my lordship.
No.
There is an
Yes. Dismissed. You want to file discharge? File.
liberty
Yes.
file, sir.
Yes, next.
130.
Page 14 and 15. All allegations, nothing in the meantime. Next.
131.
85, except husband, all else. 7 ಜನ ಇದ್ದಾರೆ, except husband. 132.
1 and 2 granted stay recorded in each.
Breach of MOU, ಕೊಡಿ. Tag same order.
133.
Meantime.
134.
Difficult.
And their allegations.
The petitioner resigns from his post on 7/5/2021. 3 years later, the transaction happens on 2/4/2024. Notwithstanding this, the petitioner is now dragged into the web of proceeding. 134 ತಾನೇ ಇದು?
134.
Sir, web of proceeding, Muzaffar Ahmad. ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ facts. So and so in that light, there shall be an interim order of stay of further proceedings by the petition. Next date of here. Next. SPP notice.
135. 136.
In the meantime, delay. Identical matter and ಕೊಟ್ಟಿದ್ದೀನಾ?
Yes.
ಕೊಡಿ, number ಕೊಡಿ.
No, that is Lord in the same petition.
All right, in the meantime, next.
137.
Petitioner.
R2 ಗೆ ಮಾತ್ರ.
ಅಲ್ಲ ಒಬ್ಬರಿಗೆ ಆಯ್ತು.
Oh, thank you. Yes, DV Act R2. Yes.
Please.
138.
Paramara.
ಅವ್ರ ಪಾರ್ಟಿ ಮಾಡಿ.
ಆಯ್ತು, ಇರ್ಲಿ ಬಿಡಿ. Yes,
138.
in the meantime.
139.
78-3, 139. Rakshit.
OC ಮಟ್ಕ ಮಾಡೋದು.
OC ಮಟ್ಕ? OC ಮಟ್ಕ ಅಂದ್ರೆ ಏನು? ದುಡ್ಡು ಕೊಡದೆ ಆಡದ? ಕವರ್ಡ್ ಕೊಡಿ, ಅದು ಜಡ್ಮೆಂಟ್ ಕೊಡಿ.
This petitioner A2, my lord.
Our disposed. Next.
40.
140, Prasanna Kumar.
Allegations are, my lords,
Page 46, wound certificate, sir.
please, my lord.
Will not grant.
Wound
1
certificate,
HCGP, 2 emergent notice. Next.
wound certificate, after day, the wound certificate has been granted.
Let the complainant come.
ಅದು scratches ಆಗಿದೆ ಅಂತ ಮಾತ್ರ.
Scratches?
ಹೌದು.
ಇರ್ಲಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
Please.
ಏನ್ ಸ್ಕ್ರಾಚ್ ಮಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ?
It may be. There are series of matrimonial disputes between the.
ಒಂದೊಂದ್ಸರಿ ಉಗುರು ಜಾಸ್ತಿ ಇದ್ರೆ ಸ್ಕ್ರಾಚ್ ಆಗುತ್ತೆ. Yes.
Please, my lord.
141.
All right. On after 1 HGP to emergent notice. Next.
Date may be fixed.
10th June.
Please, my lord.
140
One lot.
For the petitioner.
in the meantime.
142.
Petitioner.
341.
Lots 224. Lots speaking loud voice.
Next matter.
Eh?
224. Threat ಮಾಡಿದ್ರು ಪೊಲೀಸಿಗೆ ಅಂತ.
In the meantime, yes, next.
143.
Petitioner, my lord.
Petitioner is accused number 3, finding no ingredients of any of the allegations, ingredients of all the offences so alleged against the petitioner. Further proceedings, if permitted, would become an abuse of the process of the law, albeit prima facie. Rajesha.
Madam, my colleague is on the way.
All right. So in that light, there shall be an interim order stay.
Great, my lord.
144.
A2 85, A2 only, A1 gilla.
145.
ರಮೇಶ.
ಕೇಸ್ ಕೌಂಟರ್ ಕೇಸ್ ಇಲ್ಲ
Correct, sir.
ಅವರು ಅದರೊಳಗೆ ಇನ್ನೊಂದು ಕಾಂಪ್ರಮೈಸ್ ಆಗ್ತಾ ಇದ್ದಾರೆ.
ಆಗ್ಲಿ ಬಿಡಿ.
ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಇಸ್ ಆಲ್ಸೋ ಫೈಲ್ಡ್ 5461/2020.
ಟ್ಯಾಗ್ ಮಾಡೋಣ ಬಿಡಿ.
5th
June
ಗೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನೊಳಗಿದೆ. 3rd June ಕೊಟ್ರೆ ಇಟ್ ವಿಲ್ ಬಿ ಕಾಂಪ್ರಮೈಸ್.
ಆಯ್ತು. List on 3rd June, tag along with so and so.
I am permitted to take out notice.
The petitioner shall also serve. Hand summons, huh?
ಅಲ್ಲ ಕಾಪಿ may be served.
The petitioner is also at liberty to serve on the counsel who represents the respondent in the trial proceedings. Next.
146.
108 MPNS and section 3(1) of the SC/ST Act, my lord, abusing over the phone. It is not amongst.
Not phone, sir.
Yes, my lord. Your lordship may kindly see the
The
complaint.
Atrocities Act stay ಮಾಡೋಣ ತೊಂದ್ರೆ ಇಲ್ಲ.
Even in respect of 306, my
No,
lord.
306, no, sir.
No, your lordship may kindly turn to the complaint.
306, I have to see the investigation papers.
My lord.
1 HCGP, 2 emergent
Not either
notice.
hearsay witness and even, my
In
lord,
so
if
far
their
as
case-
the offences under the Atrocities Act, the same shall remain stayed.
ಇಲ್ಲ,
In so
108
far as the
ಏನಿಲ್ಲ.
offence under section 108 of the BNS, the investigation papers would be required to be perused. List on 4th June, the learned.
Someday covered by judgment.
No problem, sir. The learned HCGP secure the investigation papers and place it before the court on the next date.
ಇಲ್ಲ, is 80 years, my lord, at least not to pursue with him ಅಂತ ಒಂದು.
ಯಾಕೆ ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ ಸರ್?
ಬೇಲ್
ಬೇಲ್ ಕೋರ್ಟ್, ಬೇಲ್ ಪಕ್ಕದಲ್ಲೇ ಇದೆ ಸರ್. ಗೋಲ್ ಕೋರ್ಟ್. Yes.
ಬೇಲ್
No.
ಮೂವ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ. ಅಲ್ಲ, is 80 years, my lord.
No,
senior
no, sir,
citizen.
nothing. Yes, next.
147.
Petitioner in this.
Who is A3?
A3 is the father of the one Shrikant Prabhakaran. He is the.
Who is that?
He is the proprietor of the Polyper Mercury mill.
In the meantime, next.
48.
Ketan, KPID.
Yes, my lords. Accused number 6, the brother of the accused number 2. My lords, he has appointed as a lab technical officer on 18/3/2017.
No,
He is no way connected to the business of the.
No, we'll see.
My lords, kindly appreciate, my lords.
Yes, well, I will, sir. ಹೇಳಿ ಏನ್ ಬೇಕಾರೆ.
My lords, accused number 1 company incorporated on 23/10/2017, my lord.
Yes, sir.
He has appointed as a lab technical officer on.
ಫೈನಲ್ ಆರ್ಡರ್ ಬರೆಯಕ್ಕೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
No, my lords. My lords, he is employed somewhere else. Is only because he's a brother of the accused number 2. He was deceased, died on 26/12/2019. Subsequent to that, these complaints are filed only because he's a brother of the deceased. He has implicated as the accused number 6, my lords.
Anything else?
My lords.
One additional SPP. Additional SPP accepts complaint ಯಾರು?
There were 3 complaints, my lords.
Private people, my lord, there are 500 victims in this.
ಯಾರು ಕೊಡಕ್ಕಾಗತ್ತೆ ಇದ್ರಲ್ಲಿ?
My lords, insofar as accused number
How
1
so far as ಇಲ್ಲ?
is employed in.
Maybe. Nothing doing.
He's implicated as a manager of the
No,
manager
no,
of
sir,
the
nothing.
accused number 1 company.
Additional SPP is directed.
Kindly see page number 125 for a
Sir,
moment.
ಏನಾದ್ರೂ ಇಲ್ಲ. This I am not granting at all. ಎಷ್ಟು victims ಇದಾರೆ?
400 plus, my lord.
ಸಾಕಾ? ಇಲ್ಲ ಆರ್ಗ್ಯೂ ಮಾಡಿ ಫೈನಲ್ ಆರ್ಡರ್ ಬರೀತೀನಿ, ತೊಂದರೆನೇ ಇಲ್ಲ. Yes, sir. It's up to you. Not a problem at all.
Please, my lords.
Additional SPP is directed to accept notice for the respondent list after vacation. Please.
149,
Who is in possession?
But I am in possession, but the
The main
interim
fact.
order is granted.
Next.
150,
NBW.
Yes, my
Why you
lords.
did not appear?
No, my lords, I had moved to Maharashtra in the year 2012. Now, once the proclamation
Next
comes,
date in.
next date is on 26th of June, my lords.
Appear on that date.
His petitioner surety, my lord.
I am only a guarantor to a mortgage
Whatever,
deal.
let
my
him
lords.
appear. Court proceedings, you can't evade like that.
No, I'll appear on the 26th,
Yes.
my lord. Until then, I may be protected.
I will state, I will
Yes.
dispose it only.
Yes, yes.
The petitioner is before the court inter alia calling in question the issuance of a non-bailable warrant against him on the score that he has failed to attend the court proceedings. The learned counsel submits at the next date of listing before the concerned court of the subject matter is 27/6/2020. 26/6/2020, 2026. In that light, the petitioner
22/6,
shall.
my lords. Apologies, 22/6.
22/6. In that light, the petitioner shall appear before the court on the next ensuing date. On the subject of the said condition, the bailable warrant hanging on the head of the petitioner shall stand suspended. In the event the petitioner would not appear on 22/6/2026, the concerned court shall treat this order as a revival of the NBW and take appropriate action against the petitioner. With the aforesaid observation, petition stands disposed.
Obliged.
Yes.
list number 2, fresh matter still number 1,
This case has come with NOC.
Huh?
This case has come to us with NOC.
NOC,
From the
we'll take it after vacation. Vacation ಎಲ್ಲ ಓದ್ಬಿಡಿ.
ಇಲ್ಲ, ಅದು number of objections are there, office objections to be complied.
ಅಯ್ಯೋ ಅದು ಮಾಡಿ ಸರ್, ಅದು ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ವರ್ಕ್. ದಿ petitioner seeks 30 days time to read and comply with the office objections. List the matter immediately after vacation. In the event office objections are complied. Yes, sir.
number 2,
Secret matters, 2 matters stayed.
List, kudi, tag along with so and so. Next after vacation. Next.
Entry ಮಾಡೋಣ.
Huh?
Entry ಮಾಡಿದ್ರೆ ಇದ್ರ ಎರಡರಲ್ಲೂ.
ಅದನ್ನೇ ಕೊಟ್ಟಿದ್ದು ಸರ್, ಬೇಡವಾ? Yes.
number 3,
There are no office objections complied.
ನಿಮ್ಗೂ 30 days ಟೈಮ್ ಬೇಕಾ?
No, it's
ಇಲ್ವಾ?
already complied.
Appearing for
Notice
respondent
may be
number
issued
ಯಾವ್ದಿದು?
to respond number 2.
ನೋಟಿಸ್ ಇಲ್ಲಿ ನೀವ್ ಯಾರಿಗೆ?
appearing for respondent number 2, my lords.
ಕಂಪ್ಲೇನೆಂಟ್.
Yes, my lords, filing, I'll take on.
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, my lords. ಇವತ್ತು ಬೆಳಗ್ಗೆ ಕೊಟ್ಟಿರೋದು
ಸಾರಿ?
legal aid ಇಂದ ಬೆಳಗ್ಗೆ
Legal aid
ಸಿಕ್ಕಿದೆ.
ಇಂದ.
Yes, my lords.
Yes. Notice ಆಗಿಲ್ಲ. The learned counsel, Yamini Muniraj, accepts notice for the second respondent complainant. The petitioner to serve set of papers upon the aforesaid counsel forthwith, 4th June. Objections if. 2 ವರ್ಷದಿಂದ ಈಗ. List the matter immediately after vacation.
Interim order is there.
ಇದೆಯಾ? Interim order ಇದೆಯಾ ನೋಡಿ? ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದು interim order ಇಲ್ಲಿದೆ.
No, my lord. Last
ಬಂದಿತ್ತಾ?
week appeared already.
ಬಂದು ಇದ್ರೆ
Interim order.
ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Oh, obliged.
Interim order, if any subsisting today, shall continue to the next date of hearing. If it is not subsisting, that also will continue to the next date of hearing.
Much obliged.
Grateful,
Yes.
my lords.
4,
9088 2 to 3.
23498A. Yes.
5,
Notice
For the petition. It's not for interim order. They are
after vacation.
purchasers.
Huh?
They are the purchasers.
No,
of the
no, sir.
property.
ಬರೀ ಅದೇ ಇದ್ದರೆ ತೊಂದರೆ ಇಲ್ಲ.
In fact, there was a private, there was a OS which was filed, which has been compromised, page number 181.
We'll see. One state illalla ಇದರಲ್ಲಿ.
Illa, some private
The
company.
meantime, yes, next.
Sisters, my lord, serial number
2
6.
and 4, 498A. Yes.
7,
379.
No, ಇದರಲ್ಲಿ ಏನು no question of stay after vacation. Yes, next.
8,
Petitioner is due promotion, my lord, on the previous occasion.
ಇದ್ರಲ್ಲಿ.
Sir passed an interim order.
ಗೊತ್ತು.
Allegation of misconduct.
Yes, sir.
My lordship, he is not keeping well. Arbati sir is not keeping well today.
Not well. We'll have it on 4th June. List the matter on 4th June for the hearing. Yes.
Please.
AVIO. Enter ಮಾಡಿದ್ಯಲ್ಲ.
Please kindly accept.
Yes. ಎಲ್ಲಿ ವಿನಾಯಕ್ ಏನ್ ಮಾಡಿದ್ರಪ್ಪ?
That's, I'm giving a check of 2 lakhs now.
Hmm.
Because we have paid 16 lakhs in lieu of 8 lakhs he had paid. I'm filing the affidavit.
My lord, I have one submission. I had requested my friend to appear, if my lord permits me.
ಪರವಾಗಿಲ್ಲ ಹೇಳಿ ಸರ್.
Really, there is one MBS Rao and Shantabai. MBS Rao, survivor of cancer.
ನಿಮ್ದು ಬಿಟ್ಬಿಡಿ ಸರ್.
ನಂದು ಆಮೇಲೆ ಒಂದ್ ವರ್ಷ
ಅವ್ರದ್ದು ಆಮೇಲೆ ಬರ್ಲಿ
ಅಲ್ಲ ನಂದು ಒಂದ್ ವರ್ಷ ಆದ್ಮೇಲೆ ಕೊಡ್ಲಿ. ನನ್ನ ವೈಫ್ ಬ್ಯಾಲೆನ್ಸ್ ಇರೋದು ಆಮೇಲೆ ಕೊಡ್ಲಿ. His wife is in death bed.
ಅದ್ ಯಾರು ಕ್ಯಾನ್ಸರ್?
ಅವ್ರಿಗೆ ನಾವು ಆಲ್ರೆಡಿ ಫೋನ್ ಮಾಡಿ ಮಾತಾಡಿ ಮಿಡಿಯೇಷನ್ ಇದೆ ಪ್ರಾಸೆಸ್ ಮಾಡಿ.
ಅವ್ರ ಒಬ್ರದ್ದು ಕೊಟ್ಬಿಡ್ಲಿ. ಅದಾದ್ಮೇಲೆ ಸತ್ಯಮೂರ್ತಿ ಅಂತ ಒಬ್ರು ಇದ್ದಾರೆ who is 80+, his wife is also
ಅವ್ರಿಗೆಲ್ಲ ಕೊಟ್ಬಿಡಿ.
ಫಸ್ಟ್ ಅವ್ರದ್ದು ಕ್ಲಿಯರ್ ಮಾಡಿ.
Process is ongoing, my lords. We have already.
Process ongoing ಅಲ್ಲ. ಯಾರಿಗೆ ನೀಡ್ ಇದೆ ಫಸ್ಟ್ ಕೊಟ್ಬಿಡಿ. ಇವ್ರಿಗೆ ಇಲ್ಲ ಅಂತಲ್ಲ, ಬಟ್ ಅರ್ಜೆಂಟ್ ನೀಡ್ ಯಾರಿಗೆ?
Urgent need ಇದೆ.
What is happening, my lords? Now he is simply taking the route the different way.
Yeah, Vinayak, see, act according to your conscience. I'm the client's conscience. I'm telling.
Absolutely.
See, if somebody is suffering from cancer, they will need the money most important. So first ಅದನ್ನ ಸೆಟಲ್ ಮಾಡಿ.
ಅದನ್ನ ಮಾತಾಡಿದೀವಿ ಆಲ್ರೆಡಿ.
ಪಾಸ್ ಓವರ್ ಎಂಡ್ ಆಫ್ ದಿ ಡೇ ತಗೊಂತೀನಿ.
ಏನಂದ್ರೆ 80 ಲಕ್ಷ ಇದೆ.
ಯಾರ್ಯಾರ್ದಿದೆ ಅದು ಸ್ವಲ್ಪ ಡೀಟೇಲ್ಸ್ ಕೊಡಿ.
ಇದೆ, it is here.
My lords, I have a difficulty. My instructions are there, my lords. ಇವ್ರಿಗೆ actually 8 lakhs he had paid. Now I may be permitted to pass on the affidavit. We have paid 16 lakhs. Now more 2 lakhs I'm paying because he thinks that remaining 8 lakhs is to be paid. Regarding that cancer patient, the mediation is ongoing. My lords, since we are going
ನೀವು ಯಾವಾಗ ಆಮೇಲೆ ಕೊಟ್ರೆ ಏನು ಉಪಯೋಗ ಆಗಲ್ಲ.
ಅಲ್ಲ ಈಗ at this moment of time I cannot, my lords.
7 lakhs that was given to my wife.
He is the only complainant. All of us are not.
I am returning 6 lakhs if I am willing. ಅವ್ರದ್ದು
ಕೊಡಲ್ಲ, ಕ್ಯಾನ್ಸರ್ ಪೇಷಂಟ್ ಇದ್ದಾರೆ.
ಅವ್ರಿಗೆ ಮಾಡ್ತೀನಿ.
He doesn't want to present, he will hold. Let them prioritize the ones
ಇದನ್ನೇ
who are
ಅಲ್ಲಿ
in
ಕೊಡಿ,
need.
ಅವ್ರಿಗೆ ಕೊಡಿ, ಅವರಿಬ್ಬರಿಗೆ ಕೊಡಿ. ಮಧ್ಯಾಹ್ನಕ್ಕೆ I'll take it at the end of the day.
Greatly
My lords, I have a check of now 2 lakhs.
No, whatever, I'll take it at the end of the day. I'll record that he will return his checks. Look at it.
We have in fact, my lord.
ಅವ್ರಿಗೆ ಯಾರಿಗೆ ನೀಡ್ ಇದೆ ಅವ್ರಿಗೆ ಕೊಡಿ.
Is in need, madam. We have in fact marked, my lord.
They are not the complainants in this case, my lord.
Shamsundar sir, I'll take it at the end of the day.
Greatly obliged. Greatly obliged.
One submission if I can make, my lord. In this matter, my lords, they are all not the complainant. He is the only complainant.
Complainant allappa.
Technically, I'm not going. My only humble request
See,
is that
complainant alla, he is wanting to give it back. Some cancer patient ಕೊಡಬೇಕು ಅಂತ ಅದು ತೊಂದರೆ ಮಾಡಿದ್ರೆ.
his money I can pay to him so that this case.
ನನಗೆ ಬೇಡ.
One ನಿಮಿಷ. My learned friend can't approach, can't adopt an approach that whoever cries foul, my lord, they have to be silenced.
They are not complaining. They are not at all in this case. They are not at all there in this case.
ಆಯ್ತು,
I'm ready to pay Anand sir. ಅವ್ರಿಗೇನು ತೊಂದರೆ ಇಲ್ಲ. ಅಲ್ಲಲ್ಲ
ಟ್ರಯಲ್ ಕಳಿಸ್ಬಿಡೋಣ ಬೇಕಾದ್ರೆ.
He can't take a truce, my lord.
ಅಲ್ಲಲ್ಲ ಈಗ ಅವರು
somebody who is suffering.
half part amount he has taken with the undertaking to this court that his amount will be settled. Now he is taking the route that ಅವ್ರದೆಲ್ಲ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ. My lord, they are not the complainants. And moreover, my lord, they have filed the civil suits. They have gone before the consumer courts, my lords. I can file there cannot be my lords legal recourse for them except for this. Now, my lords, if he puts up the criminal case against me, this mediation will be derailed. I am ready to pay. I am working on it, my lords. I am pursued the cancer patient when he told about the person in the mediation. I immediately on the same day we have approached them. We have made some sort of arrangements, my lords. That
ಏನ್ ಮಾಡಿದೀರಾ ಕೊಡಿ. ಅದನ್ನ ನೋಡ್ಬಿಟ್ಟು at the end of the day, not now.
I'll file an affidavit.
Come back, your lordship. We'll not
Pass over.
We'll come back.
Please.
4:30. Great.
6:30 ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ.
Oblige.
11.
Earlier order.
Yes, my lord. In the last date of hearing.
Literally, the direction to
No
file
progress, 17 months.
The direction to file an affidavit. Now the charge sheet has been filed.
ಆಗಿದೆಯಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ ಅಂತಲ್ಲ? ಚಾರ್ಜ್ ಶೀಟ್ ನಂಬರ್ CC ಇದೆಯಾ? ಚಾಲೆಂಜ್ ಮಾಡಿ ಚೇತನ್. ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್. ನೆಕ್ಸ್ಟ್.
12.
This is accusation of 52.
File your objections after vacation.
Interim order. No predicate offense, my lord.
No,
I am not named in the first information nor the charge sheet.
Predicate offense ಇಲ್ವಾ?
ಇಲ್ಲ, ನಮ್ಮೇಲೆ ಇಲ್ಲ.
ಹೆಂಗ್ ಮಾಡಿದ್ರಿ ಮತ್ತೆ?
ನಮ್ಮೇಲೆ ಇಲ್ಲ, ನಾವು ಅಕ್ಯೂಸ್ಡ್ ಅಲ್ಲ.
ಅಕ್ಯೂಸ್ ನಂಬರ್ 52 ಅಂತ ನಮ್ದಲ್ಲಿ ಮಾಡಿದೀವಿ. predicate offense ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. I
ಹಾ.
will see and come back, my lord.
I have produced the entire charge sheet and
The learned counsel for the list on 4th June.
Please, my lord.
Don't precipitate ಅಷ್ಟೇ ಅಲ್ಲಿ.
process is issued, my lord. The order of cognizance under challenge.
Oh, we'll see. Yes, 4th June. Next.
I will file my objections.
Lodge may say.
Objections, if any, by
Not
the next date. Till then, don't precipitate.
Please.
Next.
petition in the matter, your lordships.
Surface proceedings are instituted.
Yes, your lordship, but I am
Yes.
accused number 4 in the matter.
All right, surface is instituted.
Yes, your lordship.
In the
that is
meantime, next.
much of-
Surface ಮಾಡ್ಬಿಟ್ಟು 420 no ಮಾಡಿದ್ದಾರೆ. Yes, next.
Appear for petitioner. But this matter where, my lord, the police have registered suo motu case, my lord, only for protesting why the FIR has been registered against a civil, in a civil dispute. My lord, petitioner number 1 gave complaint. For that, my lord, a FIR has been registered. As a counter blast, one more FIR has been registered.
If every
They
FIR
only questioned it.
If every FIR results in protest outside the police station, and if there is no other alternative remedy for them apart from protesting in police station, my lord, then
FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಂತಾರೆ ಬಿಡಿ ನಿಮ್ಗೆ ಯಾಕೆ
ಇವ್ರ ಮೇಲೆನೆ ಮಾಡಿದ್ದಾರೆ. petitioner
Challenge
number
ಮಾಡಿ.
1 ಮೇಲೆ. and
Challenge
others
ಮಾಡಿ.
ಮೇಲೆ. Lord, only that there is no,
Challenge
there is no
ಮಾಡಿ.
unlawful assembly.
It's all right,
nothing.
ಚಾಲೆಂಜ್ ಮಾಡಿ.
Lord, that now they have filed C report.
That's all right, protest ಯಾಕೆ
But
ಮಾಡ್ತಾರೆ?
they, in the complaint which we gave, my lord, they filed B report. Now, my lord, only for protest they have filed charge sheet, my lord, only because, my lord, he was a defeated candidate.
Whatever it is, if FIR registered, why do you protest? There is no remedy in law?
That is there, my lord.
No, is there no remedy in law?
They only asked, my lord, what is the reason, my lord, and it is a politically
ಬರೀ
motivated.
ಹಂಗ್ ಕೇಳಿದ್ರೆ what is the
ಇಲ್ಲ,
reason
ಅಷ್ಟೇ
ಅಂತ
ಇರೋದು. Kindly come to, my lord, page
FIR
36.
also they can go and protest there only.
Lord, now, only this four lines, my lord, were
ಇದಕ್ಕೂ
observed.
ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿ ನಮ್ಮ ಮೇಲೆ ಯಾಕೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ಇಲ್ಲಿ ಯಾಕೆ ಬಂದ್ರಿ?
ಇಲ್ಲ, ಇಲ್ಲಿ- Now, my lord, no, charge sheet has
ಅಲ್ಲ
been
ಇಲ್ಲಿ
filed.
ಯಾಕೆ ಬಂದ್ರಿ?
Charge sheet has
ಚಾರ್ಜ್
been
ಶೀಟ್
filed.
ಹಾಕಿ ತಪ್ಪು ಅಂತ ಪ್ರೊಟೆಸ್ಟ್ ಮಾಡಿ. Why do you want courts now?
And now, what happened is, my lord,
No, sir.
they registered FIR, my lord, and against the petitioner who is a landlord.
Yes, that's
Lord,
all
on the
right.
basis
Why
of the
did you
complaint lodged by
protest? Why did you
counter complaint.
Why did you protest? for
Lord, there was
somebody's
already
FIR?
a FIR registered, my lord, on the basis of the complaint given by the petitioner number 1.
There was no warrant of protest at all.
My lord, except this, nothing has happened, my lord, no untoward incident, nothing. They only, my lord, asked why this FIR has been registered. It is
No,
totally
untoward incident, the
incorrect.
protest outside the police
There is
station.
no
neither untoward
other
incident.
ingredients of unlawful assembly. But they have not, my lord, created any law and order situation. Nothing has happened. It is covered by your lordship's judgment. my lord.
Yes, in the meantime, heard senior counsel.
Great.
AVIO.
Here for petitioner counsel.
3.
Colleague is appear, my lord, in VC.
ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ.
The complaint is not made as a party ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಕಂಪ್ಲೇಂಟ್ ಪಾರ್ಟಿ ಮಾಡಿದ್ರ ಈಗ?
Complaint has not made.
And not the state is directed to receive them.
ಬಸವರಾಜ್ ಒಂದ್ ನಿಮಿಷ.
Their claim is company is not made as a party.
ಹೌದು.
Your Lordship, you see petitioner accused number 3.
Manager.
Is also,
Page?
is also not company, please. Account number 3 is also not company. He is one among them, let's say, a senior manager.
Page.
ಪ್ರಧಾನ ವ್ಯವಸ್ಥಾಪಕರು ಅಷ್ಟೇ.
Senior manager, please.
That's the company, my lord. It's not been named
No,
as any.
After vacation. List the matter on 10th June.
ಅಲ್ಲ, covered, annexure C, my lords, it is covered by.
ಏ ಡಿಸ್ಪೋಸ್ ಮಾಡಲ್ಲ ಸರ್. 10th June. Yes.
ಇಲ್ಲ, ತಾವು ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ ಡೇಟ್ ಅದಕ್ಕಾಗಿ.
ಪರವಾಗಿಲ್ಲ. ನೆಕ್ಸ್ಟ್ ಗಿರೀಶ್.
Great. Entry.
After vacation.
Lordship is directed the government to call for records, my lordship.
Post him. Second respondent complaint.
Yes.
Bernard counsel so and so. Praveen Hegde na.
Praveen Hegde.
Registry to print the name of Praveen Hegde as appearing for the second respondent complainant in 16. List after vacation, objections if any by the next date. Next.
Other matter ಮೇಲೆ no
Entry ಮಾಡಿ ಒಂದರಲ್ಲಿ ಕೊಟ್ಬಿಟ್ಟಿದೆ.
ಎಲ್ಲದರಲ್ಲೇ ಇದೆ.
ಎಲ್ಲದರಲ್ಲೂ ಇಲ್ಲ.
ಇದರಲ್ಲಿ ಇಲ್ಲ.
ಎಲ್ಲದರಲ್ಲೇ ಇದೆ sir. ಇದರಲ್ಲೂ
16 ಅಲ್ಲಿ
ಕೊಟ್ಟಿಲ್ಲ.
ಇಲ್ಲ ಕೊಟ್ಟಿಲ್ಲ.
Interim order if any subsisting in any of these cases shall continue till the next date of hearing.
Last time
ಫಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ ಇಲ್ಲ.
16 ಅಲ್ಲಿ ಇಲ್ಲವೇ ಇಲ್ಲ. Yes.
ಎಲ್ಲಿದೆ? ಅದು ಹಳೆ ಮ್ಯಾಟರ್ ಇದ್ದು.
17.
16 ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ.
ಇಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಯಾವ್ದ್ರಲ್ಲಿ ಇಲ್ಲ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ. ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಅದು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
ಬಂದಾಗ ಎಂಟ್ರಿ ಮಾಡ್ರೋ ಕಂಟಿನ್ಯೂ ಆಗಿಲ್ಲ.
ಇವತ್ತಿಗೆ ಹಾಕಿದ್ದಷ್ಟೇ.
ಮೊನ್ನೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಾಗ ಓವರ್ ಟೈಮ್ ಕಂಟಿನ್ಯೂ ಆಗಿರಲಿಲ್ಲ.
ಇಂಟರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿಲ್ಲ ನಾ ಇದ್ರಲ್ಲಿ. ಎಸ್.
one submission.
ಎಂಟ್ರಿ ಮಾಡ್ರೋ ಕೊಟ್ಟಿದ್ದೀರಾ ಸರ್?
ನೋ
Grant liberty
ಕೊಟ್ಟಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಬಿಡಿ ಸರ್.
ಇಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್
ಕೊಟ್ಟಿದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
liberty to file the application for the gold ornaments ಇಲ್ಲ ಅದರಲ್ಲಿ
ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕೊಟ್ಟಿಲ್ಲ ಸರ್ ಅದರಲ್ಲಿ. ಕೊಟ್ಟಿದ್ರೆ ಈಗ ವೆಕೆಟ್ ಮಾಡ್ತೀನಿ ಕೊಡಿ.
ಅಲ್ಲ ಗೋಲ್ಡ್ ಆರ್ನಮೆಂಟ್ಸ್ ರಿಲೀಸ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದಾರೆ ಸರ್.
ಇಲ್ಲ ಅದರಲ್ಲಿ ನಾನು ಗೋಲ್ಡ್ ಕೊಟ್ಟಿದ್ದೆ, ಆ ಗೋಲ್ಡ್ ಮಾತ್ರ ನಾನು ರಿಲೀಸ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀನಿ. ನನ್ನ ದುಡ್ಡಿಂದ ತಗೊಂಡಿರೋದು ನಾನು ರಿಲೀಸ್ ಮಾಡಿಸಿಲ್ಲ.
ಆಯ್ತು, immediately after vacation will take file your objections or whatever. Yes, list the matter on 3rd June. 4th June.
And in one 5547, I make an application for recalling the order, my lord. Charge sheet agila. It is on basis of their submission.
ಅದು ಬಂದಿದ್ಯಾ ಅದು?
ಅದು ಬಂದಿದೆ, but put up ಆಗಿಲ್ಲ. 5547, I make an
ಇವತ್ತು
application.
ಲಿಸ್ಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ. DD ಅಂತ ಲಿಸ್ಟ್ ಆಗಿದೆ.
ಇವತ್ತು DD
ಕೆಳಗಡೆ 16 ಅಲ್ಲಿ DD
5547 ಏನದು?
47 ಅಲ್ಲಿ
and 6923 ಏನು?
6923 earlier on the FIR stage it has been filed, and after filing the charge sheet, now I filed 3251/2026.
ಅದು ಲಿಸ್ಟ್ let everything
5547.
come after vacation. Yes, next.
17.
AVIO, next.
Eitherly petitioner supposed to inform how much when he's going to
My lord,
return the
I
money.
have a memo of calculation, my lords. In fact, the complainant says that I've taken 9,01,444. I've paid more than 10 lakhs back to her.
ಆಯ್ತು, ರಿಜಿಸ್ಟ್ರಿ ಫೈಲ್ ಮಾಡಿ AVIO, next.
18.
Petitioner to serve on the council who represents the respondent in the trial proceedings and file an acknowledgement. List the matter after vacation. Interim order, there shall be an interim order of stay of further proceedings. Square the petitioner to the next date of hearing. Next.
So after the surface.
Earlier order, I have told if there is nothing, you're not indicating anything, I'm staying it.
Please, my lord. Lords, I have also discussed with the IO. Lords, all that, my lords, the allegation against him is that money has come to his account. He has traded with A1. Lords, without there actually being any transaction. Lords, so main allegation, the trust allegation would be 120B along with allied PC Act offences.
We'll see. Along with allied Elinda Bharat, if there is nothing against him. Heard the learned senior counsel, PP Hegde appearing for the petitioner. This court on last occasion had passed the following order. The learned counsel appearing for the respondent today submits that what at best the petitioner can be alleged of offence under section 120B of the IPC - criminal conspiracy. In that light, there shall be an interim order of stay of further proceedings square the petitioner till the next date of hearing. Stay ಬೇಡವಾ?
ಬೇಕು ಸ್ವಾಮಿ. ಅಲ್ಲ ಸರ್ಫೇಸ್ ಇದೆ ಅಂತ ಅವರು ಸರ್ಫೇಸ್ ಆಗಿ ಕ್ಲೋಸ್ ಆಗಿ ಇವರೊಳಗೆ ಸರ್ಫೇಸ್ ಆಗಿ IBC ಆಗಿ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ಕೇಸು.
ತೊಂದ್ರೆ ಇಲ್ಲ. ಈಗೇನು ಸ್ಟೇ ಬೇಡವೇ?
ಸ್ಟೇ ಬೇಕು.
ಕೊಟ್ಟಾಯ್ತಲ್ಲ ಬಿಡಿ.
ಗ್ರೇಟ್. This criminal case shall not come in the way of the passport renewal ಮಾಡ್ತಾ ಇಲ್ಲ ಅವರು.
ಮಾಡ್ಕೊಳ್ಳಿ, ಅದೇನ್ ಬಾರ. ಸ್ಟೇ ಮಾಡಿದೆಯಲ್ಲ ಈಗ.
Please. I'll file my objection. I'll file my objection.
7 ಏನಿದೆ?
ಅದು ಯಾವುದು ಇಲ್ಲ. Civil in nature, coordinate branch has already granted stay.
Civil in nature, ಯಾವುದಕ್ಕೆ?
Because an allegation is A2 has forged my signature. I'm a public servant and got the property of the case.
Coordinate bench ಯಾರಿಗೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ? ಯಾವುದಕ್ಕೆ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ?
A2.
ನೀವು A1
A1. ಅವ್ರು ನನ್ನ ಸಿಗ್ನೇಚರ್ ಅವರು ಫೋರ್ಜ್ ಮಾಡಿದ್ದಾರೆ. I have produced the original suit filed by me.
ಯಾರು ಫೋರ್ಜ್ ಮಾಡಿರೋದು?
A2. A2. Your lordship may kindly see the OS.
Wait, sir.
Lord, there is allegation of forgery, my lord, and 420. My lord, the petitioner herein being an official of KHB, without there being any order, my lord, allotment order, possession letter, my lord, he executed a say deed in favor of the A2. My lord, it is a matter of trial. And my lord,
list the matter on 5th June. Please. Objections, if any, by the respondent.
Your lordship may kindly see the OS.
And coordinate bench has specifically directed, my lord, to go on.
My department
to answer it will answer.
Your lordship may kindly see OS ನಲ್ಲಿ ನಮ್ಮ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಹೇಳಿದೆ no loss is conned and is not my signature ಅಂತ. Page number 112
ಕೊಡ್ಲೇಬೇಕು ಅಂತಿದ್ಯಾ? List immediately.
Already stay ಆಗಿದೆ. As far as A2 already stayed.
ಪರವಾಗಿಲ್ಲ.
A1
tag along with so and so ಕೊಡಿ. ಇದು A2 ಗೆ ಯಾಕೆ stay?
Parted matter.
Altered.
Other code. ಅಲ್ಲಲ್ಲ A2 ಗೆ my lord, when there is but there is
ಬಿಡಿ.
when there is
list on 5th June. Yes, next.
21.
Appeal for the petitioner in this case.
55 lakhs.
1 crore 10 lakhs ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ ಅವರಲ್ಲಿ. A1 ಅಕೌಂಟ್ ಕೊಡ್ತೀನಿ ಅಂತಾರೆ. ಅಲ್ಲಿ 600 ಪೀಸಸ್ ಚಾರ್ಜ್ ಶೀಟ್ ಇದೆ. ಅದರಲ್ಲಿ ಕೂಡ ಎಲ್ಲೂ ಅಷ್ಟು ಅಮೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿಲ್ಲ. ಇಟ್ಸ್ ಬರ್ಡನ್ ಟು A1 ಟು ಪೇ ದಟ್ ಅಮೌಂಟ್. ಬಟ್ A3 ಏನು ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಇಲ್ಲ.
A3 seems to have married to A1.
ಅದು ಇಯರ್ಸ್ ಎವಿಡೆನ್ಸ್
376 ಇದೆ.
ಅದೇ ಅದನ್ನ ಇಯರ್ಸ್ ಎವಿಡೆನ್ಸ್ ಅವ್ರು ಹೇಳಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. ದೇರ್ ಇಸ್ ನೋ ರಿಲೇಶನ್ಶಿಪ್ ಬಿಟ್ವೀನ್ ದೆಮ್.
1 HCGP 2 emergent notice. Next.
ಇದರಲ್ಲಿ ಸ್ಟೇ ಆಗ್ಬೇಕಿತ್ತು.
Post immediately after service of notice.
ಅರ್ಲಿಯರ್ ಸ್ಟೇ ಆಗ್ಬೇಕಿತ್ತು ಸ್ವಾಮಿ.
ಅರ್ಲಿಯರ್ ಸ್ಟೇ ಆಗ್ಬೇಕು.
ಅಲ್ಲ ಆಗ್ಬೇಕಿತ್ತು ಅರ್ಲಿಯರ್.
ಅರ್ಲಿಯರ್ ಆಗಿಲ್ಲ.
ಆಲ್ರೆಡಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಶಿ ಇಸ್ ಎ ಲೇಡಿ. ಮ್ಯಾಟರ್ ಇಸ್ ಕ್ಲೋಸರ್ ಫಾರ್ ಟುಮಾರೋ.
So what?
ನೋ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್
1 ಕೋಟಿ 10 ಲಕ್ಷ.
ಇಲ್ಲ ಸ್ವಾಮಿ, 1 ರೂಪಾಯಿ ಬಂದಿಲ್ಲ A3 ಗೆ. ಅದನ್ನೇ ನಾನು
We'll see. Yes. Bitumen.
Without intimation, road work has been done and then got injured.
No representation, list after vacation.
23,
AVIO,
24,
AVIO.
25.
Interim order ಇದೆ.
That's correct. Your lordship is directed. This is that bank matter, my lord, Mysore Bank. I mean, Mysore, ICICI Bank did not give document. Now we
Oh,
collected.
correct. ಅದೇ
Yes.
ಕೊಟ್ಟಿದ್ದಾರಾ?
Now we collected the document and sent it to FSL.
ಆಯ್ತು, ತೊಂದ್ರೆ ಇಲ್ಲ, ಕೊಟ್ಟಿದ್ದೀನಿ ನೀವೇ.
Only issue, my lord, is
ಅಲ್ಲ, ತೀರ್ಮಾನ ಮಾಡೋಣ. ಮೇಡಮ್, AVIOs ಲಿಸ್ಟ್ ಆನ್ 10th June. ಎರಡೂನು. ಈಗೇನು ಹೇಳಿದೆ ಎರಡು.
25,
Post immediately after service of notice upon the respondent, interim order continues 10th June. Next.
There's a clarification in this, your lordship.
What clarification?
This is a counterblast FIR case.
Hmm.
So in the previous day,
There's an interim order or not?
there is
Then
interim
what do you want?
clarification. and-
What clarification?
No, that ನಮ್ದು FIR ಗೆ ಏನ್
FIR ಮೇಲೂ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಆಗಿದೆ.
there's no
CC number,
communication from
CC number
The learned additional SPP submits that in the complaint registered by the petitioners also, the police after investigation have filed a charge sheet
CC number 1045/25.
in CC 1045 of 2025. So we'll dismiss the case.
No,
A list on 10th June. We'll dismiss that day. Yes.
interim order maybe.
26,
The guidelines of
188
this honorable
covered.
court.
188, 127.
ಬರೀ 188.
188 my lord, FIR has been registered initially.
127 ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
127 ಗೆ against other persons, not against me.
The same covered, same order. Disposed. Next.
27.
Huh?
Not 127 ಗೆ.
127 ಹೇಗೆ ಅದು? ಅದು 127 ಏನಿದೆ ಕೊಟ್ಟಿದ್ದೀಗ?
ಅಲ್ಲ 127 ಗೆ ಅದು 188 ಗೆ FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಅದರ್ ಅಕ್ಯೂಸ್ ಪರ್ಸನ್ಸ್ ಅನ್ನು ಬೈ ಮಿಸ್ಟೇಕ್ ಹಾಕಿದಾರೋ ಗೊತ್ತಿಲ್ಲ. ನಮ್ಮ FIR ಗೆ ಜಾಯಿಂಟ್ ಮಾಡಿದ್ದಾರೆ.
7A.
Demand by A1, acceptance by A3.
No problem, we'll see.
Nothing against A2, my lords. A1 is an inspector. He demands 2 lakhs for registering the case and searching out the accused.
No problem.
A3 is a mechanic who accepts the money. A2 is not there at all, my lords. Nothing
Learned
against
counsel B. Latif is directed to accept notice. What to do? I'm negative for 7A.
But idರಲ್ಲಿ ಏನಿಲ್ಲ, my lords. A1 and A3, person who demanded, person who accepted.
Learned counsel B. Latif is directed to accept notice for the respondent. I heard learned senior counsel and the respond objections, if any, by the next date list on 18th June.
Service conditions at least, my lords.
Same service conditions.
He's a sub-inspector.
13 ಮಾತ್ರ 7A service conditions order ಕೊಟ್ಟಿಲ್ಲ ನಾ ಯಾರು. Yes. ದುಡ್ಡು ತಗೊಂಡ್ಬಿಟ್ಟು service conditions.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ದುಡ್ಡು not A2.
Whatever.
Allegation ಇಲ್ಲ, my lords.
Yes.
A1 inspector demands.
ಕೊಟ್ಬಿಡಿ ಕಾಪಿ.
I'll give the copy to
Yes,
them, my
yes,
lords. At least in the
No,
afternoon.
no,
can
service.
take an answer.
13 ಅಲ್ಲಾದ್ರೆ okay, yes. Not in this, because 13 there's a circular, I told you.
Oh, the 13 there is circular, but
It's not 13, 7A.
7A ಅಲ್ಲಿ, my lords, he's been added without a role.
ಅಲ್ಲ ಏನ್ service conditions effect ಆಗುತ್ತೆ?
ಅಲ್ಲ, service condition ಅಲ್ಲ, my lords, he's been added without even a role. A1 is the inspector who demands. A3 is a mechanic who accepts. A2 is just like that name, my lord, sub-inspector. No role.
Let the objections come.
Latif sees it also. Let's.
Yes, Latif.
Demand is
ಈಗ
by
ಅಲ್ಲ,
A1, accepted
objections
by
ಹಾಕಿ,
A3.
please. Yes, yes. Next.
My lords,
7A becomes turn.
a shorter date, my lords, at least.
ಆಯ್ತು 10th June ಅಷ್ಟೇ.
Oblige.
28 is MMDR.
Notice.
The notice was already ordered, man.
Yes, Jagdish.
Got the record, but I think there are some officials of geologists have gone for a census, so there are some.
Then we don't precipitate till the next day. List the matter on 18th June. On 18th June, there shall be an interim order of stay for the proceedings by the petitioner to the next date.
29,
A2 NDPS.
NDPS.
List after vacation objections, if any, by the respondent by then. Next.
30,
Post immediately after service notice upon the respondent, interim order continues.
Notice issue ಆಗ್ಬೇಕು.
ಆಗಿದೆ. Notice.
31,
Offense under 63 and 65 of the
Copyright.
Copyright Act.
Ashirwad Pipes.
Ashirvad
31.
pipes. In this, they said that they have a counterfeit, they are manufacturing counterfeit pipes of the Ashirvad
The
pipes.
petitioners are before the court calling in question registration of a crime. Charge sheet ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿದೆ.
Proceedings in CC so and so registered for offences punishable under 63,
63 and 65
63 and
420.
65 of the Copyright Act. The fulcrum of the allegation is the pipes manufactured by the petitioner resembles Ashirvad pipes and not violation of copyright. Therefore, there shall be an interim order of stay of further proceedings by the petitioner to the next date of hearing. Next.
32.
353-34.
TD ಕೇಸ್ ಹಾಕಕ್ಕೆ ನಿಮಗೆ ಪವರ್ ಇಲ್ಲ. TD ಕೇಸ್ ಹಾಕಕ್ಕೆ ನಿಮಗೆ ಪವರ್ ಇಲ್ಲ.
Highway patrolling ಅವರು.
In the meantime, next.
33.
223 violated procedure is less the matter on 4th June, there shall be an interim order of stay of further proceedings by the petitioner to the next date of hearing. We'll dispose it on the next day.
34.
My lords.
Is the adult or?
It has to be tried as an adult matter because though the trial court also records it, last date of incident is May 2023, but May 2023 is above 18. If that is the case, my lord, it has to be tried as an adult.
My lord, one more submission, my lord. In the press meet, my lord, after the secure arrest of the accused, my lord, they conduct a press meet. And commissioner says that they recovered 80 lakh rupees of cash from the accused. But in the charge sheet, there is no 80 lakh rupees,
That's
my
not
lord.
the issue here.
I know,
The
my
issue
lord.
whether he has to be tried as an adult or a juvenile. Yes.
Page 438 ಅಲ್ಲಿ.
So there's nothing.
ಅಲ್ಲ, she's a
Andre, adult.
she's a victim.
Oh, she's the victim. Yes.
Notice has to go.
One additional SPP2 emergent
First
notice.
may have to stay this matter.
Yes.
There shall be an interim order of stay of further proceedings by the petitioner to the next date of hearing.
Your lordship
Further
may-
proceedings before the concerned court to the next date of hearing. Next.
35.
451, 457.
Your lordship may stay only if
Is it
this order.
cybercrime case, my lords?
ಅಲ್ಲಿ ಎಜೆಗೆ ಇದರಲ್ಲಿ 34 ಅಲ್ಲಿ there shall be an interim order of stay of the order impugned till the next date of hearing. Yes.
My lords, cybercrime case, my lords. Digital arrest. My lords, the complaint has been taken after 1 month, my lords. And 1.44 crores from my account has been transferred into the account of the complainant. In fact, this case has been taken up by the jurisdictional censor station, even when they did not have the pecuniary authority, my lords, to try this case, which is 11.8 crores, more than 3
Jagdish.
crores.
Yes.
My lords, I've got the.
ಇದರಲ್ಲಿ there are multiple one ನಿಮಿಷ. The petitioner, my lord, seems to have multiple in the petitioner's account have been used as by multiple fraudsters. So therefore, my lord, that the investigation let whatever freezing has been done and his contention is not been heard. Your lordship, in the first instance, Axis Bank has come. Your lordship has remanded back. At that time, trial court has issued a notice to him to appear. In spite of that, he doesn't appear. Therefore, now we cannot come and say I was not heard. Opportunity was given.
1.44 crores is from the Axis Bank, right?
Yes,
I have set it aside and sent it back.
And
my lords, we
thereafter,
were not
notice has been
heard
issued to
then.
him.
My lords, we were not party there. We were not heard even then.
No problem.
And, my lords,
Anyway, you are not, notice was issued to you?
No, my lords.
We'll see.
Lordship may see the
It's
order
gone to
sheet.
second. It's gone to second beneficiary, my lords. We have the third beneficiary.
We'll
as per
see,
the IO.
we'll hear Axis Bank now.
My lords, Axis Bank,
Page 59.
Axis Bank, who is the, from whose account to whose account?
it's gone from the account of the R2.
Ah.
From my account to the account of the R2. please,
So
my
we'll
lords.
hear the second respondent.
Your lordship, page
Allah, if
59.
it is not yet, it's already transferred.
Already transferred. It's already gone, my lords.
Yes.
And we have not been heard at all, my lords.
Emergent notice.
we have
to the-
been-
I will not commit the same mistake.
Notice was issued and in fact they did not.
ಇವ್ರಿಗಲ್ಲ ಇಲ್ಲಿ ಏನಾದ್ರು ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ R2 ನೋಟಿಸ್ ಬೇಡವೆ?
How they?
Yes.
Lords, we have the third beneficiary.
All right, madam,
Yes,
if
my
I have to send, give it back to you, notice ಬೇಡವೆ?
Please, my lords.
Yes. One additional SPP2 emergent notice returnable by the 4th of, 10th of June, yes.
They cannot come here and claim a lot notice was not issued. Notice
No,
was
no,
duly
let-
served.
The
Let
order very
the,
clearly records, my lords.
let the second respondent come,
Please, my lords. My lords, state, please.
10th June.
Grateful, my lords.
36.
Lordship, the petitioner was running a pre-nursery school. And then just because she had no registration certificate, actually initially she was given the registration certificate. And then due to the building bylaws violations, that was withdrawn. And then later she was charged under section 123.
Single bells. This court twice has
Yes, one, it's additional SPP, two emergent notice.
Your Lordship, interim order.
7.
Lordship, the cognizance was taken after 4 years.
That's exactly the point. Complaint, yeah, 2016 complaint?
Your Lordship, and then.
1 minute, 2016 incident, 2016 complaint? Cognizance is taken after 20 years also, no problem. That's not the law. 468, you have misread in the petition.
Your Lordship, and Your Lordship, one main.
Even
ground
after
is
20
that-
years, if cognizance is taken, that would not violate the
Lordship,
proceedings.
section-
Complaint yavat register agutte, avat 468 spring agadu.
Your Lordship, section 137 of the Karnataka Education Act may be.
No
looked into.
problem, we'll see, sir. Yes.
In fact, the reason was extracted in trial court order. It was filed with.
Whatever it is, his entire case in the pleading is 468 is applicable because cognizance is taken
Lordship,
after
that is
4.5
one of my
years.
grounds. My main ground is that section 137 of the
That
Karnataka
we'll see,
Education
sir.
Act.
Yes, one
The
additional.
court ought not to have taken cognizance. That's the.
We'll see, sir. One additional.
Lordship,
Who is the complainant?
PEO, Your Lordship.
Additional SPP accepts notice for both the respondents. List on 10th.
Lordship,
Next.
the interim order.
No, sir. Yes, next.
37.
Petitioner.
Who's in possession?
Lords, the petitioners, my lord, this,
I think the Lordship has stayed one of the orders.
my lord's batch,
Tag.
Joseph Chaco.
Oh, same.
The complainant is.
Number kodi bere. Tag matter number kotter number kodi next.
Lords,
38.
interim order.
Bharat Kumar.
Interim order.
ಅದ್ರಲ್ಲಿ ಇದೆಯಲ್ವಾ? ನಂಬರ್ ಕೊಡಿ, ಯಾವ್ದು ಟ್ಯಾಗ್ ಮಾಡೋದು?
It's a matter which was spilled over from Saturday to today, please.
Again, it will spill over from today after vacation. No case for interim order.
My lords, may kindly appreciate
64
69 and 88 is there. My lords, may kindly have the information for a moment, please.
Yes, sir. Really, sir.
The information states that from 2020, they were in a living relationship.
No problem.
Subsequently, on 10/11/2025, the engagement took place. Thereafter, it was broken down. It is her allegation that on 21/11/2025, the petitioner number 1 had issued threats to her and committed acts of, my lords, attempt to murder.
Yes.
Subsequently, please, my lords, page
Charge
number
sheet ಆಗಿದೆಯಾ ಈಗ?
31.
Charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ, 31.
Investigation papers ಬರಲಿ.
My lords, may kindly see 31 for a moment. I'll just take 30 seconds, sister.
You take 1 minute also, no problem.
Page 31 and 32, please, my lords. After she says that the threat was given to me and attempt to murder happened, an agreement was signed. 18 lakhs rupai na ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದೀವಿ in bank channel, because, my lords, we never had intention to cheat her. And subsequently, having received that 18 lakhs, she goes after about 18 days to the police and gives a complaint saying that he has committed section 16. That is, he had sexual intercourse with me with
That
an
we'll
intent to
see.
mislead.
Get the investigation.
164, my lord, speaks much more than what it is.
Correct.
Yes.
You get the investigation papers. Learned additional
And,
SPP to secure the investigation papers and place it before the court on the next date, 2nd June, fresh matters.
Magic, make one submission. Petitioner number 2 to 4 are mother, father and sister.
ಅವ್ರ ಮೇಲೂ ಇದೆ.
My lord, 69,
ಬೇಲ್
88.
ತಗೊಂಡಿಲ್ವಾ?
Bail ತಗೊಂಡಿದ್ದೀವಿ sir.
ಸರಿ ಬಿಡಿ. Yes,
But
2nd
if
June.
they prefer a charge sheet, then this petition will go in.
No, don't worry, sir. Yes.
They have arrested accused number 1, petitioner number 1. He has been in JC for 15 days.
ಈಗ ಬೇಲ್ ಆಗಿಲ್ವಾ ಅವ್ರಿಗೆ?
Bail ಆಗಿದೆ ಸ್ವಾಮಿ, but they may, my lords, to frustrate this petition, file a charge sheet.
Yes, don't file charge sheet without the leave of the court. The respondent state shall not file the charge sheet without the leave of the court. But will continue investigation and it is made clear that the petitioners would cooperate with the investigation. 2nd June. ಅಷ್ಟಲ್ಲೇ ನಾಕಲ್ಲ ಬಿಡಿ.
Fresh matters.
Fresh matters.
Obliged.
39.
ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್
ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ?
ಅರಿಯರ್ಸ್ ಕಟ್ಕೊಂತ ಬರ್ತಾ ಇದ್ದೀನಿ. ಅದು
ಎಷ್ಟಿದೆ?
arrears ಏನಿಲ್ಲ. ಇಲ್ಲ, ಕಟ್ತಾ ಇದ್ದೀನಿ.
ಕಟ್ತಾ ಇರೋದಲ್ಲ ಮತ್ತೆ ಏನಕ್ಕೆ FLW?
FLW ಆಗಿಲ್ಲ.
ಇಲ್ಲ,
ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಇದು.
125(3) ತಾನೆ ನಿಮ್ ಗ್ರೌಂಡ್?
125(3). ಬಟ್ 125(3) on present ಪೆಂಡಿಂಗ್ ಇದೆ. ಅನದರ್ ದೇ ಆರ್ ಫೈಲ್ ದಿ 144 ಕ್ಲಾಸ್ 3 ಕೆಳಗಡೆ BNSS ಕೆಳಗಡೆ ಫೈಲ್ ಮಾಡ್ತಾರೆ. ಅದು ಅದ್ರಲ್ಲಿ ಕಟ್ತಾ ಇದ್ದೀನಿ.
ಈಗ ಎಷ್ಟಿದೆ ಅರಿಯರ್ಸ್?
ಅರಿಯರ್ಸ್ ಇಲ್ಲ, ಕಟ್ತಾ ಇದ್ದೀನಿ.
ಬರ್ಲಿ ವೈಫ್. Learned HCGP, sorry, emergent notice to the respondent returnable by 10 June.
Kindly see my page number 73.
No sir.
73 5,000 ರೂಪಾಯಿ ಬ್ಯಾಲೆನ್ಸ್ ಅಂತ ತೋರಿಸ್ತಾ ಇದೆ.
Next.
ಅಲ್ಲ, ಒಂದ್ ಕೇಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದ್ರಲ್ಲಿ ಕಟ್ತಾ
ಪರವಾಗಿಲ್ಲ
ಇದೆ.
ಬಿಡಿ, ಬರ್ಲಿ, let the wife come. So what?
ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಇದೆ.
No, so what sir, let it come. Yes, next.
ಅರಿಯರ್ಸ್ ಇಲ್ಲ ನೋಡಿ.
ಪರವಾಗಿಲ್ಲ.
73 kindly
Yes.
see 5,000 ಅಂತ ಇದೆ.
List on 10th. Yes, next.
ಅಲ್ಲ, ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಇದೆ, ಹಾಗಾಗಿ
10th. Yes, next.
40.
in the meantime.
ಅಲ್ಲ ಇದರಲ್ಲಿ 14
Promise to marry.
No, 64 man.
64
Rape
allegation ಮಾತ್ರ.
ಕುಡಿಯಲ್ಲಿ
Allegation ಮಾತ್ರ.
one
ಅದೇ
ನಿಮಿಷ,
ಫಿಕ್ಸ್
one
ಆಗಿದೆ.
ನಿಮಿಷ, one ನಿಮಿಷ, one ನಿಮಿಷ.
64.
After 1 year, my lords.
One ನಿಮಿಷ.
Please.
Page 72 man.
64 and 318 ಇತ್ತಲ್ಲ, I thought promise to marry.
Takes her to Dharmasthala.
ಅಲ್ಲ ಅದು ಸರಿ, ಬಟ್
ಅಲ್ಲ, but it's not as 69.
69 ಅಲ್ಲ, 376 417.
But allegations, my lord, that
ಅಲ್ಲ ಬಟ್ ಅದೊಂದು we may
Threatened her
we may
saying
stay 64, but you have threatened her with photographs and videos.
After 1 year, she
ಏ
lost.
ಅದಕ್ಕೂ ಅದಕ್ಕೆ ತೊಂದರೆ ಇಲ್ಲ.
And ಮದುವೆ ಮನೆಯವರೆಲ್ಲ ಸೇರಿ ಮದುವೆ ಫಿಕ್ಸ್ ಆಗಿತ್ತು ಅಂತಾನೂ ಹೇಳ್ತಾರೆ
ಅಲ್ಲ
ಕಂಪ್ಲೇಂಟ್.
that we will stay.
SC/ST
And
lordship
SC/ST
can
also,
stay.
my lord, does not.
Atrocity.
Fellowship can stay, my lord, but not the
Atrocity and even rape. These all consensual acts. Other offenses we will not, because he has threatened with the videos and photos ಅಂತೆಲ್ಲ ಇದೆ. There shall be an interim order of stay of further proceedings. Que the offenses under section 64(2)M and the Atrocities Act. The remaining offenses should be considered on the appearance of the complainant.
So far as-
One additional SPP, 2 emergent.
So far as petition number 2 to 4, my lords, father,
Uh,
mother.
two,
and-
2 to 4, insofar as the petitioners 2 to 4 are concerned, the entire proceedings, charge sheet,
Proceedings.
entire proceedings shall remain stayed.
2 to
Yes.
5 minutes.
2 to 5, next.
Grateful.
41.
Petition number 2, 14%.
40?
Petition number 2,
41 now.
House.
ಏನಾಯ್ತಿದ್ದು?
My lord, the vehicle was parked.
You 14%.
Yes, my lord. Petition number 2, they have filed because in my office, the vehicle of mine was parked in the parking place. He came in a one way with the.
ಅದೆಲ್ಲ matter of evidence. How can we look into in 482?
Neither we are directly or indirectly, we have contributed to any accident.
That's all right, but that's a matter of evidence. I can't get into in 482.
It is for 304A, lorry driver who has driven the vehicle, we are not driven. It is we are no way connected.
14% ಎಲ್ಲ appear ಆಗ್ತಿದ್ದೀರಾ? ಯಾರು?
We have filed the application.
Huh?
I have filed the application. Petition number 2, I have filed.
But ಆದ್ರೂ evidence, sir. That fancy Devi ಅಂತ ಯಾರೋ
Yes,
ತಾನೇ
ma'am,
ಇದು?
yes.
He's opened the door and then because of that he fell down and then the truck came and.
No, these are things of evidence, sir. 482 I can't.
My lord, for a moment. my lord.
No, no, sir.
The my lord, the degree of punishment which is proportionately. The crime
Maybe
committed.
anything,
My
sir,
lord,
but
driver
these are
of the-
matters of evidence,
The vehicle
sir.
of the driver who has a BBMP who drove the vehicle, he died. He himself has stated, when one is vehicle, one driven by BBMP is responsible for that. What way we are responsible for that?
Take chance after vacation, just immediately after vacation.
Till such time.
No,
my lord,
no, sir.
The matter was posted for NBW has been
No,
issued.
no, sir.
For my, for no fault.
NBW will stay vacant, but
Yes.
not the proceeding.
Yes.
The sword of NBW hanging on the head of the petitioner shall remain stayed. ಬೇರೆ ಎಲ್ಲ evidence, I will not interfere.
ಅಲ್ಲ,
at all.
much obliged, my lord. I will demonstrate with the document evidence.
ಇಲ್ಲಲ್ಲ ಸರ್, ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಮಾಡಿ, ಅಲ್ಲಿ ಡೆಮಾನ್ಸ್ಟ್ರೇಟ್ ಮಾಡಿ.
It amounts to the abuse of process.
482 ಅಲ್ಲಿ ಯಾವ ಡೆಮಾನ್ಸ್ಟ್ರೇಷನ್ ಎವಿಡೆನ್ಸ್ ಬಗ್ಗೆ? ಎಸ್, ನೆಕ್ಸ್ಟ್.
42.
Money lenders.
Yes, my lord. This is with regard to earlier we have filed a complaint. My lord, it's purely question of loan repayment. My lord, we have paid the entire amount. My lord, there is no due as such.
Let
We
the
have filed
complainant
the
come.
bank statement as well. And my lord,
One
added to that,
additional
my lord,
SPP
he
to
has also
emergent
filed
notice.
138 proceedings, my lord, that is going on.
Barley, let the complainant come.
My question is, my lord, since it's a loan repayment, it's purely civil dispute
see.
and we have paid the entire amount, we have
We'll see,
filed
we'll
the
see. Yes.
bank statement as well. There is no due as such.
One additional SPP to emergent notice.
My lord,
written.
so far as A2 is concerned, my lord, she is a wife. She has been roped in
No
unnecessarily.
problem. Yes.
The transaction is
Wow.
between accused number 1
10
and
June.
the, my lord,
10.
even according to them, my lord, the transaction is between A1 and the complainant. A2, my lord, wife. My lord, there is absolutely no role at all, my lord, A2. At
After
least for
vacation.
A2, my lord.
Barley, complainant, yes.
No, so far the A2 wife, my lord, only because she is wife, she has been dragged in.
That's not the only
Even
thing.
if the
Yes.
entire charge sheet, my lord, there is no mentioning of the A2
Yes,
name.
yes, Jagdish.
Our discharge has been rejected.
ಅದಕ್ಕೆ yes,
Plus,
next.
so far as the A2, my lord.
No, sir, nobody.
43.
After vacation, yes.
43.
Complainant, notice. Next.
44.
44, Sheshgiri Rao.
302.
Notes.
offences for 323, 350.
Maybe, sir, 2023 order you are challenging today.
Now kindly see, Milords. Cognizance, Milords, few lists of, only two lists.
Ella
of-
2023 order is under challenge.
Not only that, Milords.
Not only alla.
Not-
Bere ella adar hinದಿಂದು.
Yes, Milords. The cognizance, Milords, is dated 2019,
No
September. Thereafter, Milords, Milords, the trial was supposed to commence in 2022. Milords, they file an application, Milords, stating that I will prosecute through my own counsel. Milords, that is in 2023.
All right.
Now, Milords, from that day, kindly see, Milords, till today, Milords, not even the complainant has tendered herself for, Milords, examination,
We'll see.
forget cross-examination. Milords.
Then
Now,
additional
this is,
SPP
Milords,
is directed to accept notice for the
your
response.
dilation of trial, Milords. The person cannot even get married. That's the problem.
We'll see, sir. 3 years in the end ಮಾಡ್ತಾ ಇದ್ರಿ sir.
Because we've been waiting that she'll at
Very
least
good.
tender.
Yes.
Milords,
It is
prima
covered by
facie,
your
Milords,
lordship judgment for respondent.
Huh?
This covered by your lordship judgment for respondent,
Oh,
which is
correct.
confirmed by Supreme Court.
Milords,
Just after vacation. Yes.
Milords, insofar as 302, Milords, Milords, I'm not saying that they don't have a right, but there is also a concept of pecuniary bias, Milords, in these prosecutions. Of course, Milords, that will be, that can be taken note of. The second aspect, Milords, is only with respect to, Milords, even the order of cognizance, if your lordship will see for a moment, order of cognizance for a moment,
ಏನು
Milords, absolutely unreasoned.
7 ವರ್ಷದಿಂದ ಆಗಿರೋದು 2019.
Absolutely unreasoned.
No problem.
And if your lordship looks
7
at
years in the reasons
Milords,
build
if
up
your
ಆಗ್ತಾ
lordship
ಇದೆ.
looks at the complaint,
No, sir.
Milords, Milords, that is lodged after 3
Absolutely
years.
still. If you are staying criminal cases on the ground of it being still, this also we can't.
Very well, Milords. May I request this indulgence? If your lordships could fix a date, we will serve the counsel appearing before the trial.
Well, that will be granted.
And Milords, a date be fixed so that, Milords, I think this
Charge
is not,
frame
if your lordship
302 ಬೇರೆ ಏನಿದೆ?
302 is covered by your lordship judgment.
against him.
Against him.
Yes, sir.
Milords, that's right.
ಅದೊಂದೇ ಆರ್ಡರ್ ಬೇರೆ ಯಾವ್ದು ಕಾಗ್ನಿಸೆನ್ಸ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ? ಕಾಗ್ನಿಸೆನ್ಸ್ ಆರ್ಡರ್ ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ರಿ ಈಗ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ?
2021 ಅಲ್ಲಿ charge.
All other,
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
all other prayers have also been sought for.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್?
A date be fixed.
ನೋ ಸರ್, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ಅದನ್ನ.
Milords, that is,
No, sir.
that is your lordship. Milords,
No,
I'm
sir.
not saying there is no hard and fast rule. Kindly
No,
see.
no, sir.
Now, if your
So
lordship will
in
see-
this court, it's only a hard rule, fast till well.
Milords, kindly
Yes.
see, my, Milords, if may I just submit two things. The incident, Milords, is said to have occurred, Milords.
No
prior to
problem. You want me to answer? I'll answer. Kudi.
2017. Your lordship may have a look at it.
The petitioner
May I just, there are two
is
facts.
before the court.
Only two facts, Milords.
Absolutely, sir.
Only
Yes,
two facts.
yes.
Now, Milords, your lordship will see who is the complainant for a moment.
Ah.
Complainant, Milords, was an employee under the petitioner. Milords, she, Milords,
You're wasting
resigned.
the time because charges have already been framed and trial is on. What is challenged is 3022 at the stage of trial. I am not going to interfere.
Post trial.
So exactly, that's why I'm not going to interfere.
Now-
I'm not going to interfere, seriously.
Fair enough, Milords.
Yes.
Look at the other prayers, Milords, in the petition.
What other prayer? No other prayer. Ella 2019, the cognizance order ಇವಾಗ ನೋಡಕ್ಕಾಗತ್ತೆ after charges are framed?
All right, Milords. Now,
Yes, sir.
now since the charges have been framed,
Yes, sir.
Milords, now since the charges have been
Hmm.
is it, Milords, would it not be available for me to at least seek that?
No 482, sir.
Fair enough, Milords,
Yes,
fair
sir.
enough. May I only request this, Milords? Your lordships are also exercising in pari materia jurisdiction under 227.
No,
Now-
sir, not at all.
Yeah, Milords,
No, sir.
Milords, kindly look at 483.
This is
Milords,
criminal
for a moment.
petition, sir. Yes.
483 for a moment, Milords.
No, sir, 483 superintendents, sir. Superintendents like CPC 227, yes.
483, your lordship
That
have
I
that
am not,
power.
anything
Your
else?
lordship have that power. Your lordship may
Anything
actually say,
else,
Milords,
sir?
in 6 months the trial can be concluded.
That I will do, no problem at all. ಆವಾಗ್ಲೇ ಕೊಡ್ತಾ ಇದ್ದೆ.
Or yes, Milords, a time frame be fixed. 4-5 months, Milords, I am ready for
ಅಷ್ಟೇ,
the trial.
6 in 4-5 ಯಾಕೆ?
ಕಮ್ಮಿ ಆಗ್ಲಿ ಸ್ವಾಮಿ. I have been, Milords, I have been languishing for the past 8 years now.
Oh, no problem, sir, we'll do
8
it
years
now.
now.
Yes.
8 years.
Hmm.
She is
6
not
months.
coming before the court.
6 months.
Fair enough.
Yes.
I am all right.
The petitioner is before the court seeking a spade of prayers, all of which on the face of it have become stale, as either they are 6 years old or 2-3 years old, as the case would be. The learned additional SPP submits that 5-6 years prior to the filing of the subject petition, charges have been framed and the trial is on. Obviously so, as the petitioner calls in question an order of the year 2023 passed under section 3022 of the CRPC. The learned counsel Sunil Rao now would restrict his submission to a direction to the concerned court to conclude the proceedings within a time frame that this court would fix. The case is of the year 2018, 17 or 18, first
The FIR
is of the year 2017. as the complaint is registered in the year 2017 and the case is pending before the concerned court for the last 9 years. In that light, I deem it appropriate to infuse finality into the proceedings with a direction to the concerned court to conclude the proceedings in an outer limit of 6 months in accordance with law. It is needless to observe that parties to the list would cooperate to the direction of conclusion of the proceedings, failing which it is open to the concerned court to pass necessary orders in accordance with law, ordered accordingly.
Within October, if it is of that.
ಅದು 6 months and within October.
The problem is.
ನಾನು 6 months ಅಂತ ಬರೆದ್ಬಿಟ್ಟು within October ಅಂತ ಬರೆಯಕ್ಕೆ
ಆದ್ಮೇಲೆ all those things.
ಇಲ್ಲ ಆಯ್ತು 6 months ಅಂತ ಬರೆದು within October ಅಂತಾನು ಬರಿಬೋದಾ?
I have not seen it. It's your lordship. A date be fixed not before
ಡೇಟ್
October.
ಫಿಕ್ಸ್ ಮಾಡಕ್ಕೆ ಅಪಿಯರೆನ್ಸ್ ಅದು 6 months ಆಯ್ತಲ್ಲ. ಎಸ್
Not anyway, I'm deeply.
45.
Lords, I appear for the petition.
196.
Lords,
352.
How the correct, but
The meantime, yes.
Lords, all the three matters,
All three same.
much of it.
48.
Dates for counter blast.
Counter blast charge sheet was filed on
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಮಾಡಿದಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಡೇಟ್ ಹೇಳಿ ಸರ್ ಕೌಂಟರ್ ಬ್ಲಾಸ್ಟ್ಗೆ.
counter blast complaint your worships is on ನಮ್ಮ
ಡೇಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಆಫ್ಟರ್ ವೆಕೇಶನ್.
ಅಲ್ಲ ಇದೆ
ಹೇಳಿ ಮತ್ತೆ.
16/5/2018 the complaint filed as counter blast.
16/5/2018 ಯಾರ್ದು?
ನಮ್ಮ ಕಂಪ್ಲೇಂಟ್.
ಹಾ ಅವರದ್ದು ಯಾವತ್ತು?
ನಾವು ಕೊಟ್ಟ ಕಂಪ್ಲೇಂಟ್ is
ನೀವು ಕೊಟ್ಟ ಕಂಪ್ಲೇಂಟ್ ಏನಾಯ್ತು?
ನಾವು ಕೊಟ್ಟ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ.
ಆಯ್ತು ಅವರದ್ದು ಏನಾಯ್ತು?
ಅವರದ್ದು ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದಾರೆ.
In the
ಬಿ ರಿಪೋರ್ಟ್
meantime.
ಹಾಕಿ
Yes. ಹ್ಮ್.
ಇದು ನಾವು ಕೊಟ್ಟದ್ದು ಕಂಪ್ಲೇಂಟ್
ಈಗ ಆಯ್ತಲ್ಲ ಕೊಟ್ಟಾಯ್ತು. ನೆಕ್ಸ್ಟ್. ಎಸ್.
49.
ಬಡ್ಸ್ ಆಕ್ಟ್.
No, your lordship, it is not there in the charge. It is being.
ಬಡ್ಸ್ ಆಕ್ಟ್ ಡ್ರಾಪ್ ಮಾಡಿದ್ರಾ?
Yes, your lordships.
ಎಸ್ ಜಗದೀಶ್.
that's file ಇಲ್ಲ.
Your lordships, initially, the bank employees were the parties to the said case, your lordships.
ಕೊಡಿ ಮೇಡಮ್ ಒಂದು ನಿಮಿಷ.
Petition.
ಹ್ಮ್. ಒಂದು ನಿಮಿಷ ಮೇಡಮ್. Come to page 83, madam.
It's very short point, Manoj. Initially, they have initiated proceeding in the Butts Act against the bank officials. Thereof the charge sheet is filed. Present petition is A3.
No question of stay.
Stay.
One additional SPP to emergent notice. Next.
50.
Complainant and petitioner were living together for.
Living
10 years.
together. Page 20 and 21 ನೋಡಿ ಸ್ವಲ್ಪ. Complaint ಅಲ್ಲಿ. What have you done while living together ಅಂತ.
10 ವರ್ಷದಿಂದ ಅವರಿಗೆ ಡಿವೋರ್ಸ್ ಆಗಿ after that she was living together with the petitioner for 10 years with her household ಗೆ ಎಕ್ಸ್ಪೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳಿ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು.
Yes.
Later he stated in the complaint that
No license for all that you have done.
accused number 2 and 3 are granted state.
You are accused number 1. Correct. 2 and 3 ತೊಂದರೆ ಇಲ್ಲ ಕೊಟ್ಟದ್ದು ಕರೆಕ್ಟ್ ಆಗಿದೆ. Tag along with so and so. Stay. Next.
ಅವರ household
No sir. Accused number 2 and 3 ಕೊಟ್ಟದ್ದು ಕರೆಕ್ಟ್ ಆಗಿದೆ. Yes, next.
There was a orally agreement, your lordship, in the early stage, your lordship. For 10 years they were.
No
living
problem,
together.
sir.
He was a, your lordship is there.
No interim.
Issued, your
No
lordship.
interim orders. NBW, why did you not go to the court?
Your lordship, he is in Dubai, your lordship.
ಮತ್ತೆ ಎಸ್ ದುಬೈಯಿಂದ ಹೆಂಗೂ ಬರಲ್ವಲ್ಲ ಬಿಡಿ.
ಬರ್ತಾ ಇದ್ದಾರೆ, your lordship. The next
ಯಾಕೆ ಬರ್ತಾ ಇದ್ದೀರಾ?
the petitioner.
Okay.
On
Yes.
3rd, your lordship.
The next date ಏನು? Next date. Next date court ಅಲ್ಲಿ ಯಾವಾಗ?
Totally next date, the last date was 22, your lordship.
Next, I'm not asking last date. What is the next date?
June, your lordship.
ಯಾವಾಗ?
Next June 5.
June,
June 5, I guess, your lordship.
The petitioner shall appear before the concerned court on 5th June 2026. Subject to the said condition, the non-bailable warrant shall remain stayed, failing which the concerned court shall pass necessary orders upon the said non-appearance of the petitioner. Husband.
mere rejection of visa to pursue education in Germany, my lord, leads to this complaint. My lord, it is a
One
case where,
additional SPP, two emergent notice.
not for a moment, my lord, it is a case where, my lord, they are married on 4th of August. He flies back to Germany on 9th, my lord. In the complaint throughout, my lord, she states that husband is not responding to my message, nor is answering my call. My lord, only on the ground that, my lord, her visa gets rejected. She can't pursue her education in Germany, my lord, which leads to
Let's
this
see.
complaint.
Let's
My lord,
let's
married
matter
for
on
son.
4th June returnable. Yes, next.
My lord, for a moment, my lord, if my lordship looks at the fact, charge sheet is already filed in this matter, my lord. It is clearly admitted in the complaint. She clearly states the fact that, my lord, she applies for visa, it
No
gets
problem.
rejected.
Yes,
Husband
immediate.
lives in
4th June. Yes, next.
52. Obliged.
Andar bar judgment. Early judgment.
Annexa K, my lords.
Okay, page
94.
covered GJM. Your estimated GJM. Yes, covered. Page 84. Next. 53. Santosh, home buyers complaint.
My lord, RERA complaint.
That's all
dismissed.
right. Home buyers, have you have you sold the property to someone else?
No, my lord.
In the meantime, yes, next.
54.
Uday Kumar, after vacation.
55.
My lord, appealing for the petitioner, my lord, application was filed under section 436.
55.
Yes, my lord.
Pururaghavendra Bank.
Yes, my lord. My lord,
I'll take
it-
notice.
Huh?
I'll take.
Of course, you'll take notice.
my lord, it
Yes.
is covered by judgment, my lord.
Covered?
Yes, my
Yake sir?
lord. In Vijay Madan Lal Chaudhary case. If the-
ಎಲ್ಲ ಇಡಿ ಕೇಸು ವಿಜಯ ಮಲ್ಯ ಚೌಧರಿ ಕವರ್ಡ್.
My lord, it has been clearly held. He has undergone more than the maximum punishment is 7 years, my lord. He is
ಈಗ
in
ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು?
4 years, 2 months, my lord.
ಈಗ ಎಲ್ಲಿದೆ? We are still in custody.
Yes, my lord, I am in
Apply
custody.
for bail.
It was rejected, my lord,
Ah,
under
then?
436. Therefore, I am
No, ಅದಕ್ಕೆ 482 na. Yes. Learned Council Anuparna so and so accepts notice for the Enforcement Directorate. Lists the matter on 2nd June. Objections, if any, by the next date, failing which this court would be constrained to set the petitioner at liberty. Yes, next. Avat nodu. Next.
56.
Not in the entire complaint, not on 3 instances, not the petitioner's name has been mentioned.
ಏನಿಲ್ಲ ಎಲ್ಲ ಇನ್ಸ್ಟೆನ್ಸ್ 306.
Husband has died.
Correct, but ಇವರು not the wife.
She's
Wife
married- ಅಲ್ಲ, ಅಲ್ಲ. She is married 5 years prior to the.
She's some other relative. Accused number 3. That Bhargavi.
Please.
Yes. No, accused number 3.
Yes.
The petitioner is accused number 3 is caught in the web of proceedings for offence punishable under section 306 of the IPC. A perusal at the summary of the charge sheet would not indicate any of perusal at the complaint even ಹೇಳ್ಬೇಕು ತಾನೆ. Perusal at the complaint would not indicate any ingredient of the offence offence punishable under offence punishable under section 108 of the BNS stroke 306 of the IPC. In that light, there shall be an interim order of stay of further investigation qua the petitioner only accused number 3 till the next date of hearing. Next.
The only civil
In
case.
the meantime is next. Gotagamma? GJM, meantime is next.
58.
I am for the petitioner, my lord.
69 in the meantime, next.
59.
I'm appealing
The
for
petitioner is before the court calling it. Consideration delay application ಹಾಕಿಲ್ವಾ?
ಹಾಕಿದ್ದಾರೆ my lord.
ಹಾಕಿದ್ಮೇಲೆ ಆಯ್ತು ಏನು 11
Cognizance
days delay ಏನು
ತಗೊಂಡಿಲ್ಲ,
ಬರಲ್ಲ.
it's- My lord, there is a Supreme Court judgment, my lord.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ 11 days
11 days
application
delay
ಹಾಕಿದಾರಾ?
Application ಹಾಕಿದ್ದಾರೆ without.
ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡಿಲ್ವಾ?
Order has been passed without issuing the notice, my lord. Straight away magistrate.
11 days ಡಿಲೇಗೆ ಆರ್ಡರ್ ಮಾಡಿದಾರಾ ಇಲ್ವಾ ಅದು?
Well, straight away without issuing the
Cognizance
notice.
ತಗೊಂಡಿದ್ದಾರಾ?
Cognizance has been taken, my lord. Hence I.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. 10th June, there shall be an interim order of stay of further proceedings where the petitioner proceedings before the concerned court. Next.
Much of this.
60.
Please, this case, the requirement of compliance of erstwhile 155(2) and the present 174 as.
174 2. At the learned senior counsel, so and so is appearing for the petitioner. 60, 61, 62 in the meantime. Next.
Grateful.
63, 64, 65 notice.
63. This is at.
What I guessed.
Oh, Jargold ಇದು. Sorry, yes sir. Sorry, 63. Stop at 62 madam. 63 ಆಮೇಲೆ.
Not, I filed a detailed statement of objections with the documents made available by the IO to the court. I'll just not take the not take more than a minute.
Yes, sir.
But your lordship may kindly have a look at, but your lordship's earlier ordered page 347. Submission of the IO was not that there is no gold and there is no cash.
ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ ಅದಿರ್ಲಿ.
Oh, by then, not your lordship will find, by then, not the memo filed, not by the IO himself indicates, not that.
230.
Pass.
Again. Now I produce all the documents produced by the IO. Let him just
Pass.
have a look at it. Please.
66.
2 to 4.
But I'm
85
sorry. Not,
in the meantime.
not that.
ಯಾವ್ದು 66.
Not, I'm sorry. Instead of 230, can I request for tomorrow? 230 ಇನ್ನೊಂದು ಎರಡು ಕಡೆ possible.
ನಾಳೆ ಬೇಡ. ಕಮ್ at 4:30 ತೊಂದ್ರೆ ಇಲ್ಲ. ಇವತ್ತೇ ಮುಗಿಸ್ಬೋಣ.
Please.
66 my lord is 498.
ಆಯ್ತು ಕೊಟ್ಟಾಯ್ತು. ಬರ್ಕೊಂಡ್ರಾ? 2 to 4.
ಅಲ್ಲ.
85.
Accused number is not party my lord. Husband is not party. Husband na party ಮಾಡಿಲ್ಲ. Only in-laws.
ಅದೇ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್.
ಅಲ್ಲ 2 to 4 and.
ಎಷ್ಟು ಜನ ಇದ್ದೀರಾ?
Number 2
2 to 4. ಅದೇ ವೆಹಿಕಲ್ ನೋಡ್ learned additional SPP is directed to accept notice of the respondent. Next.
C8.
Lordship, date me, it's been 1 year, your lordship.
ಯಾವ ವೆಹಿಕಲ್?
Vehicle is car, your lordship.
ಕಾರ್ ಹಳ್ಳಿ ಕೌ ತಗೊಂಡ್ ಹೋಗ್ತಾ ಇದ್ರಾ?
At the time of
ರಿಲೀಸ್ ಮಾಡೋಣ. ಡಿಸ್ಪೋಸ್ಡ್.
and 69 also. 69 ಅಲ್ಲಿ
Wait,
ತಗೊಂಡು ಹೋಗಿ.
ಇರಿಸ್. ಡಿಸ್ಪೋಸ್ಡ್ ಅಂತ ಹೇಳಿ. 68 ಚಿನ್ಮಯ್. In the meantime 74.
Case and counter.
ಏನಿ 74 ಕಂತ ಏನಿಲ್ವೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ. Yes, next. Yes, next.
9.
ಇದು ವೆಹಿಕಲ್ ರಿಲೀಸ್.
The vehicle release.
ಇದು ಅದೇನಾ?
Yes, your lordship.
ಇದು
full
ಕೆಲಸ
bank
ಮಾಡಿ.
guarantee ಕೊಡಬೇಕು ಅಂತ ಇಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆ.
65 and 67 and 69 ಪಾಸ್ ಓವರ್ ಮಾಡಿ by the end of the day ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. ಇನ್ನು ತಗೊಂಡ್ರೆ ನನಗೆ ಬರುತ್ತೆ ಆಮೇಲೆ.
Great, your lordship.
Next. Joshua. ಎಷ್ಟು ಮಾಡ್ತೆ?
406 and 420 my lord.
ಕರೆಕ್ಟ್ ಆಗಿದೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
No, my
The
lord.
petitioners are before this court calling in question proceedings in so and so registered for offence punishable under section 406 and 420 of the IPC. A perusal at the complaint would clearly indicate the criminal law is set into motion for the purpose of recovery of money. In that light, there shall be an interim order of stay of further proceedings where the petitioner investigation.
ಇಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
Further proceedings where the petitioners to the next date of hearing. Next.
71.
For the petitioner, my lord.
Yes, sir.
I'm the engineer by profession.
Very good. ಅದಕ್ಕೆ ಹೊಡಿಬೇಕು ಅಂತಿಲ್ಲ. 118. Yes.
My lord. It is arising out of the civil matter.
Very good, sir.
There is a attached neighboring lands, my lord. The complainant purposefully is bringing her cattle into my field too.
Oh, that doesn't mean that you should beat her, sir. You're engineer by profession.
Oh, my
You should
lord,
have
I
been
have
that.
never beaten. They have created all the sceneries.
Sceneries?
Because, yes, my lord.
What scenery?
No. So I invited this page number 16, my lord. What the materials they collected, the police. ಕಲ್ಲು ಅಂತ ಜಮೀನಲ್ಲಿ
ಯಾಕೆ
ಎಲ್ಲ
ಸರ್
ಕಡೆ ಕಲ್ಲು ಸಿಗತ್ತೆ, my
ನೀವು
lord.
ಸೀನರಿ ಕಲೆಕ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
No, my lord. In page number 16, the police collected only ಎಲ್ಲ ಜಮೀನುಗಳು ಕಲ್ಲು ಬಿದ್ದಿದೆ ಅಂತ 90.
Police collected only scenery.
So, my lord, see, there is a OS before the civil court at Chikkanahalli.
ಚಿಕ್ಕನಾಕ್ನಹಳ್ಳಿ.
Chikkanahalli.
All right.
So between the parties arising out of the civil, ಅಲ್ಲಿ ಆ ಕೇಸನ್ನ ವಾಪಸ್ ತೆಗಿಬೇಕು ಅಂತ ನಮ್ಮನ್ನು ಒತ್ತಾಯ ಮಾಡ್ತಾ ಇದ್ರು, ನಾವು ತೆಗಿಲಿಲ್ಲ. It is a partition suit, my lord. This complainant, the complainant and my relative both are colluded each other and they have created this.
ಅಲ್ಲಿರೋದು offense 324.
ಅಲ್ಲ,
No. 1189, my lord.
Page 20 Mother
petitioner
on stones. ಅಲ್ಲಿ 90 ಮತ್ತೆ ಬಟ್ಟೆನೆಲ್ಲ ತಂದಿದ್ದಾರೆ, ಅದರಲ್ಲಿ ಬ್ಲಡ್ ಇದೆ ಅಂತಾನು ಬರೆದಿದ್ದಾರೆ.
ಅದೇ ಡೌಟೇ ಇಲ್ಲ.
The incident happened, what they said, the incident happened on 6th. They said that complaint given on 7th. See, before that day, 5th evening, my lord, when they are coming with the cattle near to my house, ನೋಡಿ ಅಲ್ಲಿ ಹಸುಗಳು ಬರ್ತಾ ಇದೆ ನಮ್ಮ ಜಮೀನ್ ಅಂತ ಹೇಳಿದ್ರೆ, ನೀನೇ ಕೂತಿದ್ಯಾ, ನೀನೇ ಅವ್ರ ದನಗಳನ್ನ ನಾನು ಹೊಡೆದು ಹಾಕ್ಬೇಕಂತ, ಯಾಕಮ್ಮ ಹಾಗೆ ಮಾಡ್ತಾ ಇದ್ದೆ ಅಂದ್ರೆ, ಇದಿಷ್ಟೇ ಇದನ್ನ ಕೋಪ ತಗೊಂಡು ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇ ದೇ ಕ್ರಿಯೇಟೆಡ್ ಆಲ್ ದಿ ಸೀನರಿ. Scenery means they have created all ಯಾವ ತರ ಮಾಡಬೇಕು, ಸಾಯಂಕಾಲ ಬಂದಾಗ 4 ಜನರನ್ನು ಸೇರಿಸೋದು, ಸೊ ಪ್ರವೋಕ್ ಮಾಡೋದು, ಬೈಯುವುದು. ಸಿ ಐ ಆಮ್ ಇಂಜಿನಿಯರ್ ಮೈ ಲಾರ್ಡ್.
Engineer,
ಐ ಆಮ್ ಇಂಜಿನಿಯರ್ ಬೈ ಪ್ರೊಫೆಷನ್.
profession.
ನಮ್ಮ ಸಿ ಟು ಪ್ರೊಟೆಕ್ಟಿಂಗ್ ಮೈ ಪ್ರಾಪರ್ಟಿ, ಜಸ್ಟ್ ಐ ಅಡ್ವೈಸ್ಡ್. ನೋಡಿ,
So you are an engineer to protect your property.
ಮೈ ಪ್ರಾಪರ್ಟಿ, ಅವ್ರ ಹಸುಗಳು ನನ್ನ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಬರ್ತಾ ಇದೆ. ಸಿ ಅವ್ರ ಜೊತೆ ನಾನು ಕಲ್ತ್ಕೊಂಡು ಅವರಿಗೆ ಒಂದು ಮಾಡೆಸ್ಟಿ ಆಫ್ ದಿ ವುಮೆನ್ ಅದನ್ನ ಮಾಡಕ್ ನಮ್ ಕಡೆ ಸಾಧ್ಯ ಇಲ್ಲ.
ಯಾಕೆ?
No, my lord.
Because you are engineer by
No,
profession.
that I am educated as well as it is my property, my lord. ಹಸುಗಳನ್ನ ತಂದು ನನ್ನ ಜಮೀನಲ್ಲಿ ಬೆಳೆ ಬಯಸಿದ್ರೆ ನಾನು ಸುಮ್ನೆ ಕುತ್ಕೋಬೇಕಾ?
ಅರೆ,
ನಾನು ಹೇಳಿದ್ದು ನೋಡಿ, ನಿಮ್ಮ
ಅದಕ್ಕೆ
ಹಸುಗಳನ್ನು ತೆಗೆದುಕೊಂಡು ಹೋಗಿ
ಪ್ರಾಬ್ಲಮ್
ಅಂತ
ಏನ್ ಗೊತ್ತಾ? ಸುಮ್ನೆ ಕುತ್ಕೋಬೇಕಾದ್ರೆ ನೀವು ಕೂತಿಲ್ಲ ಅಂತಾನೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು.
No, my lord, this is all created scenery by others. Who is a person involved in my civil case?
Sir, you are an engineer. You should not have started battle for a cattle.
No.
So,
This is, my lord, I pray to this honorable to stay this proceeding.
No, sir. Crime is very fresh.
No, my lord. See,
March 7th, sir.
my lord, in this case, the one Shivananda, who is very close to the complainant, very previous day, he has told her, ನೀನು ಈ ತರ ಹೋಗು, ನಾವು ಈಗ ಬಂದಿರ್ತೀವಿ, ಅವನು ಪ್ರವೋಕ್ ಮಾಡು, ನೀನು ಬೈದಂಗ್ ಮಾಡು, ಅವನು ಏನೋ ಅಂದ್ ಬಿಡ್ತಾನೆ, ಇದನ್ನ ಸೀನರಿ ಇದೆಲ್ಲ ಮಾಡ್ಕೊಂಡು they have created the scenery, my lord.
Very good screenplay.
No, my lord, there is no incident happened at all.
ಅಯ್ಯೋ, ಹೌದಾ?
They have came to my property.
ಇದೇ ಬಾಕಿ ಇದ್ದಿದ್ದು, ಇನ್ಸಿಡೆಂಟೇ ಆಗಿಲ್ಲ.
I pray to my lord, the incident, what they have explained and given the color of this in the FIR.
Color?
There is no scenery of in that way. ಅಲ್ಲಿ ಬೈದಾಡಿದಾಗಿದೆ, ಯಾಕಮ್ಮ ನಮ್ಮಲ್ಲಿ ತಗೊಂಡ್ಬರ್ತೀವಿ ಅಂತ ಅವರು ಒಂದು ಬೈದಿದ್ರು, ಬೈದಾಡಿದಾಗಿದೆ. These all 118, 74, 351, 352, these all are the sections. ಅದು ಕುತ್ಕೊಂಡು ಮಾತಾಡ್ಕೊಂಡು ಈ ತರ ಮಾಡೋಣ ಅಂತ they have did purposefully, my lord.
ಕುತ್ಕೊಂಡು ಮಾತಾಡಿ, ಪರವಾಗಿಲ್ಲ. One additional SPP to emergent notice. ನೋಟಿಸ್ ಇಷ್ಟೊಂದು ಮಾಡಿದ್ರ, ಇರ್ಲಿ ಬಿಡಿ, ಪರವಾಗಿಲ್ಲ.
72.
138. Petitioner to serve on the council who represents the respondent in the trial proceedings. List on 10th June. Interim on the further proceedings shall remain state till the next date. Next.
73.
Appearing for the petitioners, my lordship. My lordship, in the FIR, my lordship, they have alleged against 3 people, my lordship. 1 vehicle and 3 people. Suddenly in the charge sheet.
Page 32, sir.
Page 32.
Yes, sir.
My lordship, the allegation, the entire case is based on the confession statement of this number 4 and 5, 4 and 6, my lord. That is number 4 and 6.
307, sir.
307, 4 arm injury agide anta
Oh,
state.
ನೋಡೋಣ.
There is no injury at all.
ಬೇರೆ ಎಲ್ಲ ಇದೆ, sir.
Accused,
One additional SPP to emergent notice 18th June. Next. Returnable by 18. Next.
74.
The
353.
353, of course, ingredients are not made out, but what they have done is, they have taken him to the police station. We do not know what has happened, but the version is that he locks the Innova and then sits inside because they come. Innova car glass is broken, backside glass is broken, they take him out and then they have thrashed him. And realizing that this person is likely to
ಅದಕ್ಕೆ
give a
ಹಾಕಿರೋದು
complaint.
ಕಂಪ್ಲೇಂಟ್. ಅದು ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ
ಅದಷ್ಟೇ.
ಯಾವ ingredient ಇದೆ. 351. Heard the learned senior counsel R. Ravishankar appearing for the petitioner. A perusal at the complaint would clearly indicate that it is registered only to harass the petitioner, as there is not even a speck of ingredient that is necessary as obtaining under section 351 of the as obtaining under 132(1) of the BNS for it to become an offense under 132(2) of the BNS. In that light, there shall be an interim order of stay of further investigation, quay the petitioner to the next date of hearing.
Great.
Next.
25.
Same. Meantime.
I'm grateful.
Next.
76.
85, 2 and 3, no stay for husband.
ಹಸ್ಬೆಂಡ್ ಕೇಳಿಲ್ಲ ಸರ್.
ಕೇಳಿಲ್ವಾ? ಹಸ್ಬೆಂಡ್ ಇಲ್ವಾ?
ಫಾದರ್ ಹಸ್ಬೆಂಡ್ ಇದ್ದಾರೆ, ಫಾದರ್ ಇಲ್ಲ, ಮದರ್ ಇಲ್ಲ, ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ಆಫ್ ದಿ ಹಸ್ಬೆಂಡ್.
ನೀವು ಸ್ಟೇನೇ ಕೇಳಿಲ್ವಾ ಅವ್ರಿಗೆ? ಕೇಳಿದ್ದೀರಾ?
ನಾಟ್ ಸಾಟ್ ಮೆಲೋಡ್, ಐ ಆಮ್ ನಾಟ್ 76 ಮೆಲೋಡ್, ಐ ಆಮ್ ನಾಟ್ ಸಾಟ್.
76 ಅಲ್ಲೇ ಇದೀನಿ ನಾನು.
Not party. He's not party. Husband is not party.
ಹಸ್ಬೆಂಡ್ ಇಸ್ ನಾಟ್
not a part. Then 2 and 3. 2 and 3 ಇಬ್ರೇನ ಯಾರಿದ್ದಾರೆ?
ಅಲ್ಲ, ಫಾದರ್ ಇನ್ ಲಾ, ಮದರ್ ಇನ್ ಲಾ, ಗ್ರ್ಯಾಂಡ್ ಮದರ್ ಆಫ್ ದಿ ಹಸ್ಬೆಂಡ್.
ಆಯ್ತು, ಸ್ಟೇಡ್ 2 to 4. 2 to 4, 85. ಜಿಜೆ ಗೊತ್ತಾಗುತ್ತಾನೆ. 85. ಇಲ್ಲರ ಎಜ್ಜಕ್ಕೆ ಕೇಳಿ ಹೇಳ್ತಾರೆ.
77.
A7.
Yes,
A7.
allegation is that I am a paramour.
Paramour, yes. The petitioner is accused number 7 in a proceeding under section 85 of the BNS. The petitioner is said to be a paramour of the husband of the complainant. Paramour cannot be a member of the family for her to be dragged into the proceedings under section 85. In that light, further proceedings, que the petitioner, Chashita. Further investigation, que the petitioner shall remain state till the next date.
78.
Husband.
The notice was, divorce notice was issued in the
No
2024,
problem.
after 26 of years of relationship.
So what?
Lord, the children are settled and they are pursuing education in Singapore. And now, Lord, the divorce notice in 24, now they after 2 years filed a complaint of 498A.
ಎಷ್ಟು ವರ್ಷ ನಿಮಗೆ?
50 years.
All right. In the meantime.
ನಾಳೆ ಕೇಸ್ ಇದೆ.
ಮಾಡ್ಕೊಳ್ಳಿ. ನಾಟ್ ಎ ಗ್ರಾಸ್ ಕೇಸ್, ಸುಮ್ಮನೆ ಇವೆಲ್ಲ. 85 2 to 5. 85 2 to 5. ಅದೇ ಇನ್ಲಾಸ್ ಎಲ್ಲರೂ. ಹಸ್ಬೆಂಡ್ ಇಲ್ಲ.
Husband.
ಗೊತ್ತು. ಎಲ್ಲರಿಗೂ 85 ಸ್ಟೇಟ್. ಎಸ್ ನೆಕ್ಸ್ಟ್. 118.
Serial number 80.
80. 118.
Treated in the hospital. He was treated in the hospital.
ಇಲ್ಲ ಸ್ವಾಮಿ, kindly see the complaint.
No.
ಇಲ್ಲ ಅವರು
ಅದನ್ನ ಓದ್ಬಿಟ್ಟು ನೀವೇ ಅಲಿಗೇಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಡಿ.
ಹೌದು ಸ್ವಾಮಿ, ಹೇಳ್ತೀನಿ.
ಇಲ್ವಾ?
ಹೇಳ್ತೀನಿ. ಇದ್ರಲ್ಲಿ ಅವರು ಕುಡ್ದಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅವರೇ ಒಪ್ಕೊಂತ ಇದಾರೆ. ನಾವು ಕುಡ್ದ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಬಂದು ಗಲಾಟೆ ಮಾಡಿದೀವಿ ಅಂತ ಆಗ್ಬಿಟ್ಟು.
ಕರೆಕ್ಟ್. ನೀವು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿಲ್ವಾ? ನೀವು ಕೇಸ್ ಹಾಕಿಲ್ವಾ ಅವ್ರ ಮೇಲೆ?
ಇದ್ರ ಮೇಲೆ ಹಾಕಿಲ್ಲ ಸ್ವಾಮಿ.
ಹಾಕ್ಬೇಕಲ್ಲ, ಮತ್ತೆ ಹಾಕ್ಬೇಕು ಫಸ್ಟ್ ನೀವು.
ಇದ್ರ ಮೇಲೆ ನಾವು
ಯಾಕಂದ್ರೆ ನೀವು ಹೊಡೆದಿದ್ದು ಇದಕ್ಕೆ ಅವ್ರ ಹಾಸ್ಪಿಟಲ್ ಎಲ್ಲ ಇದಾರೆ.
ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಅವರೇ ಬಂದು ಕುಡ್ದ್ಬಿಟ್ಟು ಗಲಾಟೆ ಮಾಡ್ಕೊಂಡಿರೋದು ಸ್ವಾಮಿ.
ಪರವಾಗಿಲ್ಲ.
ಅದು SC/ST ಆಕ್ಟ್, ಅಟ್ರಾಸಿಟಿ ಆಕ್ಟ್ ಇದ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಅದ್ರ ಅಲ್ಲದೆ ಇದೇ ಇದರಲ್ಲಿ ಅಲಿಗೇಷನ್ ಮೇಲೆ ಅವ್ರ ನಮ್ಗೆ ಇನ್ನೊಂದು FIR ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಮೆಡಿಕಲ್
ಹಾಕ್ಲಿ ಬಿಡಿ ಸರ್, ತೊಂದ್ರೆ.
ಒಂದೇ ಅಲಿಗೇಷನ್ ಮೇಲೆ ಎರಡು FIR ಹಾಕಿದ್ದಾರೆ
ನೋಡ್.
ಅಲ್ಲ, ಅದು ಅಲ್ಲದೆ ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಎಲ್ಲ ಅವ್ರು ಕುಡ್ದಿದ್ದಾರೆ ಅಂತ ಸಬ್ಮಿಟ್.
One additional SPP to emergent notice. Yes, next.
81.
The incident petitioners are before this court calling in question charge sheet. Registration of a crime and crime number so and so. Incidents of 2018 are projected to become a crime in the year 2026. It's solely on the score that it is full of embellishments on the ground of delay. There shall be an interim order of stay of further investigation qua the petitioners to the next date of hearing.
52.
So I appeal for respondent number 2, my lords. Matter has been settled, my lords.
Settled, hangar parayilla.
At 4 o'clock, my lords. Clients are on their way, my lords. Can I take at 4 o'clock?
Password.
Please. Great.
83.
Misappropriation.
Misappropriation by accused number 1 only, my lord, not by other.
But they claim
accused
that
person.
they claim that she is a lawyer, not an accounts officer. May I place their accounts?
Assistant
She was
account.
working as an accounts officer.
Para 10
After
of,
vacation.
para 10 of the complaint,
No,
please, my
sir.
lord.
One additional misappropriation will not.
Please.
One additional SPP to emergent notice.
Okay.
Two yaru?
Complaint-
Private.
Private company.
Emergent notice.
24.
Next.
NDPS. Take a passport.
After vacation. Notice after vacation.
85.
Axis Bank closed, disposed.
86.
74. Yes, in the meantime.
87.
You are the driver?
PMTC bus driver. No, there are possibilities of settlement, my lord. We are in
I
talks with
noticed.
the.
This is that PMTC bus conductor.
No, notice madu.
Them, they only brought the complainant also, where she claims that, my lord, we don't want a compensation.
Now they are in talks for some settlement on basis
and
of monetary terms.
One additional SPP to emergent notice. Yes, next.
Grateful.
88.
Disposed.
89.
Non-CTC. Saturday's remand, right?
Yes, ma'am.
Ah,
We have served the council also on
ಎಲ್ಲಿದ್ದಾರೆ?
not entered appearance, but my lord, there's an acute delay, my lord. Page number 23.
What
my lord.
delay?
In both issuing the notice and as well as presenting the complaint. The mandatory under 138B requires 30 days within.
10th, awaiting the appearance of the respondent. 10th. In the meantime, further proceedings shall remain state. Yes.
Grateful, ma'am.
90 disposed, 91 disposed.
92.
92.
Nagesh Vinay.
92. Together.
Oh. Early, you come out of the car?
Very sorry, my lords.
Yes, don't worry, yes. You never do that, I know, yes.
I couldn't have avoided.
In the meantime,
Grateful.
next.
93,
304A, L 93, Rajat.
ಅಲ್ಲ ಇದು blade was left inside
The cause of death and my lords, my act have no connection whatsoever.
Hospital is the accused.
Hospital is the-
Doctor is not the accused?
They are all accused, my lords, but I have no control on what they may do.
Doctor, hospital ಮಾಡಬಾರ್ದ, not necessary.
tomorrow they come up and
Company is not made a party, the hospital is not made a party.
ಆತರ ಇಲ್ಲ my lords. But 3 years later, after 3 years.
Maybe, that is doctor leaving the blade,
Please.
You can't pardon him at all.
I have no control, my lords, on what they are able to do.
let them come back my lord, after charge sheet being.
ಇವ್ರಿಗೆ ಯಾಕೆ, hospital ಯಾಕೆ? The petitioner is the hospital in which a co-accused, the doctor, was a practitioner. On certain medical negligence on the part of the doctor for having conducted a surgery or leaving a blade inside the place where surgery was conducted, the hospital is dragged into the proceedings. The hospital or the managing director, ಯಾರಿದು?
ಇಲ್ಲ, hospital.
The hospital would obviously have no control on the performance of the doctor. Therefore, on this score, there shall be an interim order of stay of further proceedings where the petitioner, hospital alone till the next date of hearing.
For the investigation.
Investigation, sorry.
Let them cooperate with the investigation.
Allah, in it is made clear, despite the grant of this interim order, the hospital authorities shall not, hospital authorities shall cooperate with the investigation with the investigating officer. ಇಲ್ಲದ್ರೆ ಏನು ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡಲ್ಲ ನೀವು ಅಂತಂದ್ರೆ ಕಷ್ಟ ಆಗುತ್ತೆ. Meantime, next. Theft, sir.
Lords, ingredients, my lords, does not affect because here, my lords, it's only a recovery, my lords, it is not theft, my lords.
ಅದು ಗೊತ್ತಿಲ್ಲ.
My lords, here, they say, my lords.
ಇದನ್ನ ಬ್ಲಾಕ್ಸ್ ನೇ ತಗೊಂಡು ಹೋಗ್ಬಿಟ್ಟು
ಇಲ್ಲ ಇದ್ರಲ್ಲಿ
ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ಇದನ್ನು ಸೇಲ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ.
ತಗೊಂಡು ಹೋಗಿದ್ದೆ ಯಾಕೆ?
My lords, it's a part of they have said, my lords, in their complaint itself they have said, my lords.
Scrap dealer has given a statement and the JCB where the transporter has given a statement.
No, sir, nothing.
Yes.
Accused number 1.
Yes, my lord.
My lords, accused number 1, my lords, yes, ಅವ್ರ ಮೇಲೆ ಇರುವಂತದ್ದು ಅರೌಂಡ್ ಈ ವಿಚಾರ ಪ್ರಶ್ನಿಸಿದ್ದಾರೆ. ಬಾಕಿ 3 ಗೇಟ್ ಮತ್ತು 3 ಗೇಟ್ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
3 ಕೊಟ್ಟಿದ್ದಾರೆ.
ನಾನು ಒಂದು ಭೀಮ್ ಅನ್ನೋ ಸಂಸ್ಥೆ ಇನ್ನು ಮತ್ತೊಬ್ಬ ಉದ್ಯೋಗಿ ಇದೆ ಸುರೇಶ್ ಅವರು ಕೊಂಡೊಯ್ದು ಗುಜರಿಗೆ.
ನೀವು ಕೊಂಡೋಗಿದ್ದು ಯಾಕೆ?
ಇಟ್ಸ್ ಅ ಪರ್ಪಸ್ ಆಫ್
ನಥಿಂಗ್. ಎಸ್
Lords, it's mentioned here.
Pure theft ಸಿಗಾಕೊಂಡಿದ್ದೀರಾ ಆಮೇಲೆ ಅಂತ ಅಷ್ಟೇ.
ಎಲ್ಲ ಗೇಟ್ ಗಳನ್ನು ಮುಳ್ಳಿಗೆ ಡ್ಯಾಮ್ ನ ಗುತ್ತಿಗೆದಾರರಿಗೆ ನೀಡಿರುವುದು. ಅಲ್ಲಿ the dam construction was going on, my lords, there.
Yes.
So it was
after one additional SPP. ನೀವೇ ಇದಾ ಕಂಪ್ಲೇಂಟ್?
ಅಲ್ಲ, I think that dam authority.
Emergent notice to the second respondent returnable 18th June.
He states, my lords, it is
no stay in this.
96.
MMDR. HS Shankar. Anyway.
Lord, MMDR is
ನೀವು ಸಬ್ಜೆಕ್ಟ್ಸ್ ಪ್ರಕಾರ ಬೈಫರ್ಕೇಟ್ ಮಾಡ್ಕೊಂಡು. ಹುಷಾರಿಲ್ಲ. All right.
Lord, what has happened? The Swamiji was on Kumbh Mela.
Swamiji was on Kumbh Mela.
They produced the photographs. And what has happened, Lord? Beam Army has given a complaint. That basis, somebody has done.
ಇವಾಗ ಸ್ಯಾಂಡ್ ಮೈನಿಂಗ್ ಎಲ್ಲ ಸ್ಯಾಂಡ್ ತಗೊಂಡೋಗಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕುಂಭ ಮೇಳಕ್ಕೆ ಹೋಗ್ಬಿಟ್ರೆ?
ಇಲ್ಲ, ಅವರೆಲ್ಲ ಮಾಡಿದ್ದಾರೆ. ಬೇರೆ ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆ. ಅದನ್ನೇ ಸೇಮ್ ಇದನ್ನ ಕಾಪಿ ಅಂಡ್ ಪೇಸ್ಟ್ ಮಾಡಿ ಇವ್ರ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ.
ಪರವಾಗಿಲ್ಲ. One additional, ನೀವೇ ಅಲ್ಲ, additional SPP accepts notice for the respondent 18 June. ನಿಮ್ಗೆ ಹುಷಾರಿಲ್ಲ, ಸುಮ್ಮನೆ ರೀ.
ಸಾರಿ.
ಎಸ್.
ಅವ್ರದ್ದೇನು ನೋ ಇಂಗ್ರೀಡಿಯೆಂಟ್ಸ್.
ಪರವಾಗಿಲ್ಲ ಸರ್.
ಅಲ್ಲ, ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಏನಾಗುತ್ತೆ? ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
ಅಲ್ಲ, ಅಫೆನ್ಸ್ ಡೇಟು ಇಲ್ಲ ಅದರಲ್ಲಿ.
ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
ಅಲ್ಲ, ಬೇಲ್ ತಗೊಂಡ್, ಬಟ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅಲ್ಲ NBW ಇಶ್ಯೂ ಆಗಿದೆ.
ಯಾಕೆ ಹೋಗಿಲ್ಲ? ಕುಂಭ ಮೇಳದಲ್ಲೇ ಇದ್ದೀರಾ ಇನ್ನು?
ಇಲ್ಲ, ಬಂದಿದ್ದಾರೆ.
ಮತ್ತೆ ಬಂದ್ಮೇಲೆ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಕಲ್ವಾ?
ಅಲ್ಲ, ಸಮ್ ಮಾಲಿಫೈಡ್ ಇಂಟೆನ್ಷನ್ಸ್ ಇದೆ.
ಮಾಲಿಫೈಡ್ ಇಲ್ಲ ಇದೆ.
ಇಟ್ ಈಸ್ ಅಲ್ಲ 9 ಒಂದ್ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವ್ರ ಮಠದ ಇದ್ರಲ್ಲಿ ಬುಷಿಸ್ ನ ಕಿತ್ತು ಕಳಿಸಿದ್ದಾರೆ.
ಏನ್ನ
ಆ 9 ಗುಂಟೆ ಜಮೀನಲ್ಲಿ ಅದು ಮಠದ ಜಾಗ.
ಅದು ಡಿಸ್ಪ್ಯೂಟ್ ಇದೆ ಇನ್ನು.
ಅಲ್ಲ ಏನಿಲ್ಲ, ಅದೇನಂದ್ರೆ ಅವರು ನಮ್ಮ ಮಠದೊಳಗಡೆ 9 ಗುಂಟೆ ಜಾಗದಲ್ಲಿ 3,500
ತೊಂದ್ರೆ ಇಲ್ಲ ತಗೊಳ್ಳಿ.
ಲೋಡ್ ಆಫ್
Non-bailable warrant hanging on the head of the petitioner shall remain state till the next date, subject to the condition. Next date yavattu? Court al next date yavattu?
35
Subject to the condition that the petitioner would appear before the concerned court on the 30th of May 2026, which is said to be the next date of listing. In the event the petitioner would not appear, the NBW that has now stood suspended would get revived. List after vacation.
See, Swamiji is innocent, Lord. I have produced the document.
Swamiji is innocent?
Innocent, my lord.
Because he went to Kumbh Mela?
No, my lord.
Then?
No, my lord. This is some Beam Army ಅವರು ಏನೋ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಆಯ್ತಾಯ್ತು, ತೊಂದರೆ
ಅಲ್ಲ
ಇಲ್ಲ.
ಅದಕ್ಕೋಸ್ಕರ ಅಲ್ಲ ಈಗ ಏನಾಗುತ್ತೆ ಇಟ್ ಇಸ್ ರೆಪ್ಯುಟೇಷನ್, ದ ಮಠದ ರೆಪ್ಯುಟೇಷನ್ ಹೋಗುತ್ತೆ.
ಇಲ್ಲಿವರೆಗೆ ಏನ್
ಆಮೇಲೆ
ಮಾಡ್ತಾರೆ?
ಇಲ್ಲ, ಭೀಮ್ ಆರ್ಮಿ ಅವ್ರಿಗೆ ಸುಮ್ನೆ ಒಂದ ಇದಕ್ಕೋಸ್ಕರ ಮಾಡಿರೋದು.
ಅಂದ್ರೆ
ಆಮೇಲೆ ಏನಂದ್ರೆ ಸ್ವಾಮೀಜಿ ಆ ಟೈಮ್ ಅಲ್ಲಿ
ನೀವು ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, 30ನೇ ತಾರೀಕು ಕೋರ್ಟ್ಗೆ ಹೋಗಿ ಬಂದ್ಬಿಡಿ, ಆಮೇಲೆ ಇದು ಮಾಡುವ.
ಏನಾಗುತ್ತಂದ್ರೆ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಏನಂದ್ರೆ ಇವ್ರು ಹೋದ್ರೆ ಅಲ್ಲಿ ಸ್ವಾಮೀಜಿಗೆ ರೆಪ್ಯುಟೇಷನ್ ಇದೆ, ಒಳ್ಳೆ ರೆಪ್ಯುಟೇಷನ್ ಇದೆ. ಆ ರೆಪ್ಯುಟೇಷನ್ ಹಾಳು ಮಾಡ್ಬೇಕು ಅಂತ ಹರಾಸ್ಮೆಂಟ್ ಮಾಡೋಸಲ ಮಾಡಿರೋದು.
ಅದೆಲ್ಲ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲ
ಯಾರೇ ಇದ್ರು ಕೋರ್ಟ್ ಮುಂದೆ ಬರಲ್ಲ ಅಂತ ಹೇಳಂಗೆ ಇಲ್ಲ.
ಇಲ್ಲ ಬರ್ತೀವಿ ನಾವು.
ಹೋಗಿ ಮತ್ತೆ.
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇವ್ರು ಅಲ್ಲಿ ಲೋಕಲ್ ಕೋರ್ಟ್ ಅದು ಅಂದ್ರೆ ಇದು ಚನ್ನರಾಯಪಟ್ಟಣ ಕೋರ್ಟ್ ಇದೆ, ನುಗ್ಗೇಹಳ್ಳಿ ಅಂತ ಅಲ್ಲೇ 15 ಕಿಲೋಮೀಟರ್.
ಸರಿ ಬಿಡಿ.
ಅಲ್ಲ ಇದಕ್ಕೋಸ್ಕರ ಇವ್ರು ಅಪಿಯರ್ ಆದ್ರೆ ಏನಾಗುತ್ತೆ,
you should majesty of law you should protect nothing.
MMDR ಅಲ್ಲಿ ಇಂಗ್ರೀಡಿಯೆಂಟ್ಸ್ ಇಲ್ಲ.
ನೆಕ್ಸ್ಟ್
ಅಲ್ಲ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
ಏನು ಆಗಲ್ಲ,
ಹರಾಸ್ಮೆಂಟ್
ಕೋರ್ಟ್ ಗೆ ಹೋಗಿ ಬನ್ನಿ, ಏನು ಆಗಲ್ಲ.
ಅಲ್ಲ ಹರಾಸ್ಮೆಂಟ್ ಗೋಸ್ಕರ
ಏನಿಲ್ಲ, ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆನ್ 2nd June itself. First go and come on 30th.
ಟಿಲ್ ದೆನ್ ಅಲ್ಲ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್
ಟಿಲ್ ದೆನ್ ಏನು ಇಲ್ಲ.
ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ
ಅಯ್ಯೋ ಮತ್ತೆ ಏನಾಗುತ್ತೆ ಅಂತ ನನಗೆ ಏನು ಆಗ್ತಾನೆ ಇಲ್ಲ.
ಅಲ್ಲ
ಎಸ್ ನೆಕ್ಸ್ಟ್
97
can be connected with serial number 95.
95
97.
95 ಆಯ್ತು. 97 in the meantime ಎರಡು ಸೂಟ್ ನಂಬರ್ಸ್.
My lord,
the petitioners are before the court, the parties to the list are before the civil court in 2 suits, numbers 25.
OS 1570 of 2024.
ಇನ್ನೊಂದು.
And my lord, another is OS 103 of 24.
ಬರ್ಕೊಂಡ್ರೆ ಮೇಡಮ್. So on the same set of facts springs the subject crime. Therefore the criminal law is set into motion on the proceeding. Criminal law is set into motion in a proceeding which is seemingly civil in nature. Please. In that light, there shall be an interim order of stay of further investigation, quay the petitioner to the next date of hearing. Next.
98
It has to be connected with 95.
95 same order.
Just one paragraph I'll read.
No sir, yes, same theft adunu.
ಅವ್ರು theft ಅಂತ ಹೇಳಿಲ್ಲ ಎಲ್ಲರೂ.
ಇರ್ಲಿ.
ಈ ವಿಚಾರದಲ್ಲಿ ಸಂಸ್ಥೆ ಆಂತರಿಕ ವಿಚಾರ
Next. Tag with 95 same ಅದ್ರಲ್ಲಿ ಏನ್ ಮಾಡಿದೀನಿ. Next.
Date
99
ಕೊಟ್ನ ಅದ್ರ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ.
Petitioner.
The learned counsel Madhu and Rao is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel forthwith. Objections, if any, by the next date, list on 18th June. Yes.
My lord, serial number 12 is by the co-accused. The
So
date
what?
is fixed for 4/6.
Same
date may be.
4/6, all right.
100
What is the peculiar case, my lord, for sending a WhatsApp to the Facebook?
103 sir.
ಹೌದು,
Murder?
ಮೆಸೇಜ್ ಸೆಂಡ್ ಮಾಡಿದ್ದಕ್ಕೆ 103 ಪೋಸ್ಟ್ ಮಾಡಿದ್ದಕ್ಕೆ
ಸ್ಪೆಷಲ್ ಕೌನ್ಸಿಲ್ ಬರ್ತಿದೆ ಪಾಸ್ವರ್ಡ್.
ಅಲ್ಲ ಮರ್ಡರ್. ಅದು ಯಾವ್ದಕ್ಕೆ ಏನ್ ಹಾಕ್ಬೇಕು? ವಾಟ್ಸ್ಆಪ್ ಮೆಸೇಜ್ ಮರ್ಡರ್.
ಅವರೇ ಬಂದು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿ.
ಇಲ್ಲ ಇದರಲ್ಲಿ ರೆಕ್ಲೆಸ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಫ್ ಕ್ರೈಮ್ ಅಂತ ಐ ವಿಲ್ ಡೈರೆಕ್ಟ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಟು ಬಿ ಇನಿಷಿಯೇಟೆಡ್ ಅಗೇನ್ಸ್ಟ್ ದೀಸ್ ಫೆಲೋಸ್. ಕಳಿಸಿರೋ ಯಾರು ಡೆತ್ ಆಗಿದೆ?
ಡೆತ್ ಯಾವ್ದು ಆಗಿದೆ, ಅದನ್ನ ಅಕ್ಯೂಸ್ ನನ್ನ ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ಲ, ಇವನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ಬೇಕು ಅಂತ ಪೋಸ್ಟ್ ಮಾಡಿರೋದು.
ಅದಕ್ಕೆ ಮರ್ಡರ್ ಏನು? ಪಾಸ್ ಓವರ್ ಬರಲಿ, ಬರಕ್ ಹೇಳಿ. ಅಷ್ಟೇ ಕೊಡ್ತೀನಿ, ಸ್ವಲ್ಪ ಅವ್ರು ಕೇಳ್ಬಿಟ್ಟು ಕೊಡೋಣ. ಯಾರ್ಯಾರ ಮೇಲೆ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಎನ್ಕ್ವೈರಿ ಮಾಡಕ್ ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ ಕೊಡೋಣ. ಎಸ್
101 access
disposed.
102
The petitioner accused number 4.
Accused number 4, my lord, the allegation is attempt to murder and
Literally, no, the issue of charge sheet has been filed.
ಯಾರ ಮೇಲೆ?
Accused number 1 ಮೇಲೆ.
1 ಮೇಲೆ?
ಅಲ್ಲ, accused number 2 and 3, this court has granted anticipatory bail. They have not even appeared.
ಯಾರು? 2 and 3 ಅಲ್ಲ, ಇದು 4.
ಇವ್ರನ್ನು sir.
I've also been
Not
granted
appeared. Your lordship is a bail order, my lord. It's a
You go to the summary of the charge sheet.
ಅಲ್ಲ, charge sheet.
Not one akshara
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಇವ್ರು ಹಾಕಿಲ್ಲ.
ಅಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಕಂಪ್ಲೇಂಟ್.
Now the charge sheet has been filed and the bail, this
Charge
court
sheet
has
is
granted a bail. Yes, madam, charge sheet has been filed.
ಕೊಡಿ ಯಾವ ಚಾರ್ಜ್ ಶೀಟ್ ಎಲ್ಲಿದೆ?
I'll ತರಿಸ್ತೀನಿ. I've been told my charge sheet has been filed. But though there is an order of bail, these people have not appeared.
Before the investigating
Yes.
officer. Why?
The direction to appear within 1 month. Page 24, man.
Use Kirti, secure instructions and come. I'll pass it over. Yes.
Hundred and three.
Counter blast. Tag same order. Next. ಯಾವ್ದ್ರಲ್ಲಿ ಇದ್ರಲ್ಲ?
104.
104 ಅಲ್ಲ? 104 PPE kit. ಅದು ಕೇಳ್ತಾ ಇದೀನಲ್ಲ ಇನ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಕೇಳ್ತಾ ಇದೀನಿ.
That is a writ petition which is separately filed.
ಹ್ಮ್.
This one is a criminal case.
ಅಲ್ಲ ಆಯ್ತು ಅದು it depends on that. How can I?
This is a case of misappropriation.
Misappropriation ಯಾವ್ದಕ್ಕೆ ಯಾರ ಮೇಲೆ?
Misappropriation.
ಇವರೇ ಲಾರ್ಜ್ ಎಕ್ಸ್ಪರ್ಟ್ಸ್ ಅದ್ರಲ್ಲೂ ಇರೋದು ಪೆಟಿಷನರ್.
Yes, madam. Yeah, no
Pradeep
doubt,
sir,
madam.
will that not be frustrated if I continue with this? Tomorrow I accept all their submission in that and hold they are entitled to the refund of that amount. What happens to this?
But where kits have not been supplied,
ಅದು
money has
ನೋಡೋಣ.
been taken.
I'm hearing that there also.
True, my lord, but the investigation, my lord, if the investigation is curtailed, my
No,
lord, now
the
at this
moment
stage,
I will tag this also with that. Anyway, that is also by special orders before me.
Yes,
We will tag it.
Yes.
ಅದಕ್ಕೆ what happens to that will happen to this.
Yes, but here, my lord, the offense is clear. They have not supplied the kits, they have
See,
received money.
ಅಲ್ಲಿ refund ಕೇಳಿದ್ದಾರೆ or amount ಕೇಳಿದ್ದಾರೆ. ಅಲ್ಲಿ amount ಕೊಡ್ಬೇಕು ಅಂತ ನಾನು ಬರೆದ್ರೆ ಇಲ್ಲಿ ನಾನ್ ಸಪ್ಲೈ ಆಫ್ ಕಿಟ್ಸ್ ಹೋಗ್ಬಿಡುತ್ತೆ. Because there is a detailed report, Justice Kunna ಅವ್ರದಲ್ವಾ?
ರಿಪೋರ್ಟ್ ಇಲ್ಲ. ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ದಾರೆ? ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಟಿಲ್ಲ. ತಮ್ಮ ಮುಂದೆ ಎಲ್ಲ ಡೆಲಿವರಿ ಚಾಲನೆ
ಹೌದು.
ಅಲ್ಲ ಇಲ್ಲಿ ಯಾವ್ದು ನೋಟ್ ಬಂದ ಕೊಡದೇನೆ ಈ ಸೇಸ್
ಅದು ಯಾವತ್ತು ಹಾಕಿದ್ದೀನಿ ಸರ್ ಅದು?
ಅದು ತಾವು 2ನೇ ತಾರೀಕು.
2 second we'll post this also on 2nd.
But we'll file the charge sheet, my lord. Investigation is almost complete. Offense is almost made out.
I will not permit my proceedings itself to get frustrated. That's not yes. Heard the learned senior counsel Uday Holla appearing for the petitioner and the learned additional special prosecutor CS Pradeep representing the respondent. The issue arises out of supply of PPE kits pursuant to a tender. The learned the special prosecutor would submit that kits were not even supplied. In an analogous proceedings in writ, which is that writ petition number, Naman?
6875 of 2023.
In an analogous proceeding 6875 of 2023, this court had directed refund of the amount of close to 3 crores. So close to 38 crores. The matter was tossed before the division bench and the division bench had set it aside and remitted the matter back to the hands of this court for a fresh consideration on a material that had sprang after the closure of the proceedings in the writ petition. Therefore, the matter is being heard and is posted to June the 2nd, 2026. In the event this court would permit the subject proceedings to continue or filing of the charge sheet, it would undoubtedly frustrate the pending proceedings in writ petition 6875 of 2023. In that light, there is no question of vacation of the interim order today. They tag this petition along with writ petition 6875 of 2023, list them both on June the 2nd, 2026. ಅದೇ allowed ಗೊತ್ತಾಯ್ತು.
ಎಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ ಅದು
ಇದು ಬರ್ದಿರೋದು.
ಸ್ಟೇ ಇಲ್ಲ. ರಿಟ್ ಪಿಟಿಷನ್ ಸ್ಟೇ, ರಿಟ್ ಅಪೀಲ್ ಸ್ಟೇ
ಇರಲಿಲ್ಲ.
ಅಂಡ್ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿದ್ವಿ. ಕೂಡಲೇ ಒಂದು ರಿಜಿಸ್ಟ್ರೇಷನ್. ಎನಿವೆ
State also sometimes should act as a litigant ಅಲ್ಲ ಅದಕ್ಕೆ. Yes sir.
105.
Depositors amount. Moment, additional SPP is directed to accept notice for the respondents after vacation. Yes. Bonded labor.
106.
Preparing for the
after vacation. Objections haki. Framing of charge. ಅದು A1 ತಾನೆ.
This is a petition by A4.
You file your objections.
Yes, Your Honor.
The respondent impleading Febanisha.
Yes, Your
Not accompanied by an affidavit.
Huh?
Not accompanied by an affidavit. The advocate's affidavit, not the
Uh,
parties.
Your
Where
Honor,
is the
because the
affidavit?
victims are
Where are they?
in Orissa, Your Honor.
Or they were working here, is it?
They were working here, Your Honor.
Anyway, will not permit, allow the application. The petitioners are A4 to? If, where is? ಆಗೋಗಿದೆ, ಇರ್ಲಿ ಬಿಡಿ.
Yeah, but the wakalat is signed by the
The
victim, Your Honor.
concerned court shall not defer the act of framing of charges against the present accused only till the next date.
Your Honor, the wakalat is signed by the victim only, Your Honor. Only that.
Affidavit, madam. Yes.
Only issue, my lord, that even the investigation,
It's
my lord,
very
I don't think so.
Huh?
Investigation also, I don't think so it's been properly.
Not at all proper, but let's see, bonded labor ಅಂತ ಅಷ್ಟೇನೆ. We'll take it on 18th June, objections if any by the next date. Yes, next. ಅದು application allow ಆಗ್ಬಿಟ್ಟಿದೆ. Amend, cost amend ಮಾಡಿ. Yes, next.
107.
Digging government road, why?
My land, there is no government road.
Wind time, yes, next.
108.
Accepting the submission of the counsel appearing for the petitioner of his objections overruled. Atreya. One additional SPP, 2 emergent notice in the meantime. Next. 109. One.
That POCSO matter.
ಗೊತ್ತಾಯ್ತು. Additional SPP is directed to accept notice for the respondent after vacation. Next. Registry file ಮಾಡಿ. Yes, next.
110.
After vacation? List after vacation. Yes, next. Interim order continues. Yes, next.
111.
352 and 74 matters. Case and
Counter blast. Nim crime 19/12/24. Yes. The petitioners register a crime against the complainant on 19/12/2024. 3 months thereafter, on 13/3/2025, comes the crime against these petitioners, which is clearly a counterblast to what the petitioners had registered. In that light, there shall 31/3, sorry, 13 ಅಲ್ಲ 31/3. In that light, there shall be an interim order of stay for the proceedings. Charge sheet ಆಗಿದೆ. For the proceedings with the petitioners to the next date of hearing. 2 accounts.
Apart from this, they have 5 accounts, but the gold pledge is mine. There are 348.
2 accounts ಎಲ್ಲಿದೆ ಅಲ್ಲಿರುತ್ತೆ. ಬೇರೆ ಅಕೌಂಟ್ ನಿಮಗೆ ಯಾಕೆ?
ಬೇರೆ ಅಕೌಂಟಿಂಗ್ ನಂಗೆ ಏನು ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ. Apart from that, this gold should not be released. That's the only objection.
ನಿಮ್ಮ ಅಕೌಂಟ್ ಇಂದ ಏನು ರಿಲೀಸ್ ಆಗಲ್ಲ ಸರ್.
Please, man, that is the only apprehension.
The learned counsel Mayuri Banu submits that 5 accounts have been frozen, while the complainant alleges 2 accounts only in which gold is there.
Alert. There are multiple gold articles, my lord.
ನಿಮ್ಮ ಅಕೌಂಟ್ ಏನಿದೆ ಸರ್?
ಅಲ್ಲ, ನನ್ನ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಇದೆ. This is joint account.
Just to summarize, my lords, there is one locker.
Last time I kindly
maintained
take
by the
this
mother
objection.
and
I have
daughter.
given the
Sampath, one ನಿಮಿಷ.
There is a gold loan. There is a locker maintained by the mother and daughter. My lords. Some gold which is existent in the locker has been pledged by the daughter. Around 5, my lords, 5 loan accounts totally. My lord, this is secured only for the purpose of a marriage. My lord, subsequent to that, there is some rift in the family. The mother goes on filing complaints after complaints. First complaint is an Ulimao police station. The second complaint is this. On the basis of an LPT, my lord, they issue a notice saying freeze all 2 accounts. The other 3 accounts give clarification. This is the facts, my lords. And until the PCR is filed 3 months post this notice of my lord freezing. I do not understand.
ಈಗ ಅದಿರ್ಲಿ, ಅದು ಕಂಟಿನ್ಯೂ ಆಗ್ಲಿ.
Yes, my lords.
ಮೂರ್ ಲೋನ್ ಅಕೌಂಟ್ ಇವ್ರದ್ದು ಅಲ್ಲದೆ ಇರೋದು ರೀಫ್ರೀಸ್ ಮಾಡಕ್ಕೆ.
There is no allegation in so far as that is concerned.
What is
which are the loan
important.
accounts, Mayur?
What?
ಅದು ಯಾವ್ದು ಲೋನ್ ಅಕೌಂಟ್ಸ್ ಕೊಡಿ?
Page number 57.
Given the account number, what is pledged is not disclosed in that.
The
The
complainant
account, my lord, I have given the inventory of what are the golds which belongs
inventory
to.
ಎಲ್ಲ ಇಲ್ಲ.
Alla,
The
this should
complainant
not be given released to him. That is
that
the only.
won't be, sir.
That won't be released. That's all.
Are you seeking that release of that?
I'm just only seeking defreezing so I may regularize my account.
Yes. The complaint in the case at hand has two accounts in which there are several gold items in the locker of those two accounts. Accounts of the petitioner, totally 5 in number, is frozen, notwithstanding the complaint being only two accounts. Therefore, barring those two accounts, the investigating officer shall direct the concerned bank to defreeze the said accounts. The investigating officer shall oversee that the accounts of the complainant or the items that are in the locker of the complainant shall not be permitted to be defrozen.
Straightforward. So that's interim order maybe.
Interim order earlier granted stands extended to the next date.
Straightforward.
Then 13.
Learned counsel Madhu and Rao ಆಗಿದೆಯಲ್ಲ ಆಗ್ಲೇ is directed to accept or ಹಾಕಿರ್ತಾರೆ ಮುಂಚೆ directed to accept notice for the respondent. Objections if any by the next date 4th June.
My lords, the predicate offences have been stayed, my
No
lords.
problems. Yes,
May
4th
also
June.
be stayed, my lord.
4th June, yes. Whatever protection continues to the next date.
114.
Yes, Pramod, defreezement.
Yes, Your Lordship have protected us, my lords. We maintain the lien in the account for the amount that is mentioned in the notice, my lords.
What is the amount?
My lords, there are two accounts, my lords. One, the Lordships will find.
Yes, Jagdish. ಅವೇ ಬರೋದೇ ಇಲ್ಲ ಯಾಕೆ ಮತ್ತೆ ಅವರು ಇರಲ್ಲ ಅವರು ಇರಲ್ಲ. Yes.
Annexure A, my lords. One account is, my lords, 2,86,264. And the second is 6,36,394. We maintain that lien.
Yes. The learned senior counsel, heard the learned senior counsel Pramod Nair appearing for the petitioner. The learned additional SPP is directed to accept notice for the respondent. The relief sought is with regard to debit freezement of the accounts. The learned senior counsel submits the amount that is claimed by the complainants. Lien may be permitted to be marked and the account be permitted to be operated in the normal course. In the light of the said submission, the bank shall mark a lien on amounts
Of 2,86,264. And 6,36,394.
so in the respective accounts and permit defreezement till the next date of hearing. Next.
One issue with respect to petitioner. Petitioner seems to be having, petitioner's account seems to be used by multiple.
No, correct. The coordinate bench is held. You can't freeze at all.
That's correct.
Yes. Next.
Your Lordship is saying in with respect to present case, because the
No,
one more
the
melody.
defreezement
38 is
concerning the subject proceedings. Yes. Next.
Then 15.
Day after tomorrow, Becca.
Please.
Day after tomorrow. Yes.
116.
My lords, relaxation of bail condition number 7. Passport, my lords, has been ordered to be surrendered. My lords, the passport has expired.
You have to seek renewal of it.
Renewal. Therefore, that
The
condition-
petitioner is before this court seeking relaxation of a particular bail condition which directs surrender of the passport. The learned counsel Nishant AV appearing for the petitioner submits that the passport has since expired and it has to be renewed. In that light, for the purpose of the renewal of the passport, the bail condition stands relaxed. The petitioner is permitted to apply for the renewal of the passport, which would be considered by the passport authorities in accordance with law. ಆಮೇಲೆ ಕೊಡ್ಬೇಕಾ? And the learned counsel further undertakes that once the passport is renewed, he would surrender the same as is directed by the concerned court. Therefore, the temporary reprieve is as directed.
Dispose.
ಅಷ್ಟೇನಾ ಕೇಳಿರೋದು? With the aforesaid observations, petition stands disposed. Yes, next.
117.
This my lord, he is accused number 3 based on
MMDR.
confession.
He is transported from Mangalore to Chamarajanagar.
Transportation is by A1 and
One
A2.
additional SPP to emergent notice. Next.
No, transportation not by him.
ಪರವಾಗಿಲ್ಲ.
A1 and 2 transported.
No problem.
A3 allegation is confession of A2, my lord.
If any, by the next date.
Confession of A2, name of A3 is taken.
No, next we'll see. Yes, next.
Transportation alone. Please. As fresh matter.
Fresh matter. ಇದ್ಯಾಕೆ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಇಲ್ಲಿ ಬಂದಿದೆ?
Disposed by this lordship. For the reason, my lord, it has been assigned for before lordship. Last again, it has been heard, my lord.
and post.
ರೆಸ್ಪಾಂಡ್ ಸರ್ವ್ ಮಾಡಿ.
ಸರ್ ಮಾಡಿದೀನಿ ಸರ್. ಅದನ್ನ ಅಕ್ಲನ್ ಕೂಡ
ಬರ್ಲಿ ಬರ್ಲಿ.
ಇಲ್ಲ ತಾವ್ ಇವತ್ತು ಫೈನಲ್ ಅಂತ ಹಾಕೊಂಡಿದ್ರೆ
ರಿಜಿಸ್ಟ್ರಿ ಟು ಪ್ರಿಂಟ್ ದಿ ನೇಮ್ ಆಫ್ ಯಾರು ರೆಸ್ಪಾಂಡ್ ಯಾರಿಗೆ ಸರ್ವ್ ಮಾಡಿದೀರಾ?
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್ ತಾವ್ ಸರ್ವ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ಸರ್ವ್ ಮಾಡಿದೀವಿ. ಅಕ್ಲನ್ ಕೂಡ
ಯಾರಿಗೆ ಮಾಡಿದೀರಾ ಹೇಳಿ ಸರ್.
ಶಿವಸ್ವಾಮಿ ಅಂತ ಹೇಳಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಡ್ವೊಕೇಟ್.
Registry to print the name of Shivaswamy as appearing for the respondent list day after tomorrow. Next.
Last cases.
Day after tomorrow, sir. Yes, next.
190.
2007 crime.
Yes, my lord.
Is the doctor issued a fake wound certificate?
ಅಲ್ಲ 2007 crime. ಇಲ್ಲಿವರೆಗೆ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿಲ್ವಾ?
ಆಗಿದೆ ಸ್ವಾಮಿ, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ. We had even approached this honorable court and the honorable court had quashed the proceedings.
ಮತ್ತೆ ಈಗ?
Even worst is they have approached the Supreme Court. The matter got remanded back in 2013. From 2013 till 2024, no proceedings were conducted. The matter was like a forgotten case left over. It's only on the petitioner's accused number 5 petitioner. It's only on his instance the matter was taken up in 2024.
So he is the doctor who issued a fake certificate to MEC claims.
There is no material, even a single material produced.
No,
on the
let
court order.
again stay in ಪ್ರಶ್ನೆ ಇದೆ.
Stay ಬೇಕಾಗಿಲ್ಲ ಸ್ವಾಮಿ. He may be, the entire charge sheet may be quashed against him.
After learned additional SPP is directed to accept notice for the respondent list on 10th June. 10th ಅಲ್ಲ 14th June 14th ಬೇಡ.
My lord,
16th
the
June.
matter is already been dragged on for
No
almost
problem.
2000.
No problem. Yes.
My lord, he has not got his retirement benefits as well.
No
my lord.
problem.
Till
Yes, no issues. Yes.
120.
Additional Director of Agriculture. On the date of the alleged incident, 2012-11, he was at his duty in Davangere Millets, page 61.
The main time. Yes, next.
Page.
121.
Organ transplant.
But I have precisely only two submissions. Single case, two separate cases were registered with respect to a single
2016 sir.
I'll not take more than 2 minutes.
ಅಲ್ಲ ಪರವಾಗಿಲ್ಲ 16 ಅಂದ ತಕ್ಷಣ ನೀವು ಟೈಮ್ ತಗೋಬೇಕು ಅಂತಲ್ಲ ಹೇಳ್ತಾರೆ.
Bangalore case was with respect to, my lord, allegation of forging and, my lord, using the forged documents for the purpose of, my lord, doing the documentation pertaining to transplantation. Alsur police registered a case, my lord, precisely for 468.
ಅಲ್ಲ ಈಗ 10 ವರ್ಷ ಆದ್ಮೇಲೆ ಏನ್ ಮಾಡ್ತಾ ಇದೀರಾ ಇಲ್ಲಿ ಅಂತ.
ಅಲ್ಲ ಇನ್ನೊಂದು ನಿಮಿಷದಲ್ಲಿ ಹೇಳ್ಬಿಡ್ತೀನಿ. Alsur police registered and I am acquitted in Bangalore. For the same matter, Magadi police also registered a case for the offence punishable under the Transplantation Act. Alli, my lord, the court went through and found that the incorporation of offence under the Transplantation Act is without basis, because it is not, the complaint is not filed by the proper, my lord, authority. So in respect of, my lord, the cognizance taken for the offences under the TOHO, my lord, was set aside. And the court, my lord, now proceeds to take cognizance of the offences for the fabrication of documents, my lord, which is already, in which case I am already acquitted.
I'll go through it, my lord. Lordship, have it some other time.
After vacation. Heard the learned ಸ್ವಲ್ಪ ಇರಿ ಆರ್ಡರ್ ಮಾಡೋರು. Heard the learned senior counsel M.S. Shamsundar appearing for the petitioner at the request of the learned additional SPP list the matter on 18 June. Objections, if any, by the next date. In the interregnum, the learned senior counsel submits that two crimes come to be registered by two different police stations on the same cause of action. In one of the crimes, the petitioner has been acquitted.
Yes.
Petitioner have been acquitted. But in the different police station now, though the offences under the Organ Transplantation Act is dropped, other offences of fabrication of documents is taken cognizance of. The matter would require consideration. Therefore, there shall be an interim order of stay of further proceedings square the petitioner to the next date of hearing. Yes.
122.
The complainant's petition, Lord, in spite of the order of the trial court.
Yes, sir. Yeah, an Axis Bank is behaving like this.
No notice was given and order was passed to learned magistrate.
No notice was ಇಲ್ಲ ಇದೊಂದರಲ್ಲೇ ಅಲ್ಲ ಏನ್ ಎಲ್ಲಾದ್ರಲ್ಲೂ
ಎಲ್ಲ ಕೇಸಲ್ಲಿ they don't issue notice to us.
ಕಾರ್ಪೆಟ್ ಕೊಟ್ಟು ಕರೆಸ್ಬೇಕಾ? ಕಾರ್ಪೆಟ್ ಹಾಸಿ
ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ the other way, the victim has now filed this petition saying that bank is not complying with the order. ನಮ್ಗೆ ಗೊತ್ತೇ ಇರಲಿಲ್ಲ ಈ ಆರ್ಡರ್ ಬಗ್ಗೆ. We are not
ಈಗ ಕೊಡ್ತಿರಲ್ಲ ಎಲ್ಲ.
In fact, ಇವಾಗೆಲ್ಲ we are filing our objections in many cases. Matters are getting settled. There are other judicial orders as well, multiple freezing.
We'll take it after vacation.
Nice one.
Learned counsel Unni Krishnan undertakes to enter appearance for. Oh, ideal already. Yes, list the matter on 7th June. Sorry, 9th June. Yes, next. In fresh matters list.
And 23?
Earlier order.
That's the disproportionate asset. Source report vague. In the source report, you take the assets of the wife and the mother who are income tax assessees. No PE done.
Objection. Copy, judgment copy.
ಬಂದಿಲ್ಲ, ಇನ್ನು ಸಿಕ್ಕಿಲ್ಲ,
ಬರ್ಲಿ.
my lords. And there,
I have protected you anyway. Yes. ಯಾರು ನೋಟಿಸೇ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ, notice last time ಮಾಡಿದಿರಿ, my lords. We have served it also.
Venkatesh Arbatti, registry to print the name of Venkatesh Arbatti as appearing for the respondent Lokayukta. The interim protection granted earlier shall stand extended till the next date of hearing.
PST, my lords. Now
We'll quash it, copy ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ ಮುಗಿಸ್ಕೋಣ. Yes.
Since an order now has been passed, my lords, if the source report
We
is
don't know the
scripted-
reason. Yes, we'll see.
If the source report is scripted, desirability of a PE, my
We'll
lords.
quash everything whole hog. Yes. Problem ಏನ್ ಗೊತ್ತಾ? Last time this is what happened. Just Hemant ಅವರದ್ದು order follow ಮಾಡಿ ಎಲ್ಲ ಆಯ್ತು. Everything came back.
The whole batch came
The
back,
whole
my
batch
lords,
came
because of
back.
Sudhakar Reddy's case.
Whatever.
Sudhakar Reddy's case and Chennakeshava, in that case, my lord, source report was complete. Court goes through the entire source report and they say, in case where it is complete. they
Because I
need not-
wrote this in Gangadhar, PE is necessary.
ಅಲ್ಲ, ಅದ್ರಲ್ಲಿ that came as a batch, it came back, my lords.
No, ಇದ್ರ desirability ಎಲ್ಲ mandatory ಅಂತ ಬರ್ದಿದ್ದೆ PE ಅದು.
That they said is not mandatory, my lords, because they say desirability. Vijay Lakshmi's case, my
Correct,
lords,
but I had
uses the word of
gone a step further saying it was mandatory.
So now, my lords, on it coming back, what the court has held is, this source report, if it is cryptic in any manner, there's a desirability of a PE. Do the PE, only then come up with the FIR because it has its consequences.
Immediately after vacation we'll take it. 4th June ಗೆ ಹಾಕಿದ್ದೀನಿ ಎಲ್ಲ 13th ಅವತ್ತೇ. ಅಷ್ಟು
Meanwhile,
ಕಾಪಿ
we'll
ಕಾಪಿ
get-
ಬಂದಿರುತ್ತೆ ಅಷ್ಟೇ.
Please.
125, got 75(1) and 75(2) of Lord BNS. But the petition number 1 is a my lord health inspector, who is a my lord supervisor.
Not a
Your lordship
healthy,
kindly see
not
the-
a healthy allegation.
ಅಲ್ಲ, allegation my lord, ಮಾನಸಿಕವಾಗಿ ಗಿರಿಗಿರಿ. Your lordship see the complaint, on the bus complaint. ಅಲ್ಲ,
Additional SPP is
Lord,
directed to accept notice, secure the investigation papers and place it before the court.
Lord, what
2nd
had I-
June, fresh matters.
Till then, my lord, what had happened, my lord? Your lordship may kindly see the complaint allegation may kindly be seen, my lord. And my lord, your lordship, it is omnibus complaint. ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ, ಈ ತರ ಮಹಿಳೆಯರಿಗೆ ಒಂದು ನ್ಯಾಯವೇ, ನಮ್ಗೆ ಕಿರಿಕಿರಿ ಮಾನಸಿಕವಾಗಿ ಕಿರಿಕಿರಿ ಮಾಡ್ತಿದ್ದಾರೆ. And my lord, now
ಅಷ್ಟೇ ಇದೆ
ಇಲ್ಲ,
ನಿಮಗೆ ಏನ್ ಬೇಕು ಅದು ಹೇಳ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲಲ್ಲ, my lord, other allegations are there, but however, ಅಲ್ಲಿ date ಇಲ್ಲ, there is no specific date.
ಪರವಾಗಿಲ್ಲ.
Since the last 6 months ಅಂತ ಹೇಳ್ತಾರೆ. Government officials, my lord, they are
ಅದಕ್ಕೇನೆ ಸ್ಟೇ ಕೊಡ್ತಾ ಇಲ್ಲ, ಬೇರೆ ಯಾರಾಗಿದ್ರೆ ಕೊಡ್ತಾ ಇದ್ದೆ.
ಅಲ್ಲಲ್ಲ, ಏನಾಗಿದೆ?
You should behave, ಅದು ಹೆಲ್ತ್ ಇನ್ಸ್ಪೆಕ್ಟರ್.
ಇಲ್ಲ, my lord, what had happened? ನಂದು ಕಾಯಂ ಮಾಡ್ಲಿಲ್ಲ ನೌಕರಿ, ಹೊರಗುತ್ತಿಗೆ ಆಧಾರ ಅಂತ ಹೇಳಿ my lord, she is making allegations.
All possibilities of what you have done. ಡೌಟೇ ಇಲ್ಲ ಸರ್.
In fact, my lord, this is a false
ಇವಾಗ
complaint.
ಅಷ್ಟೊಂದು ಬೇಕಾಗಲ್ಲ ಸರ್, ನೋಡಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ ಯಾವ್ದು ನಿಜ ಯಾವ್ದು ಸುಳ್ಳು.
ಬಟ್ ಇದರಲ್ಲಿ ಅವರೇ ಹೇಳ್ತಾರೆ, ನಮ್ಗೆ ಹೊರಗುತ್ತಿಗೆ ಆಧಾರದಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ದೀನಿ, ಬೇರೆಯವರಿಗೆ ಹೆಲ್ಪ್
ಅದಕ್ಕೆ ಕಾಟ ಕೊಟ್ಟಿರೋದು.
And my lord, she states in the complaint, insofar as permanent employees, my lord, they are not harassing.
Obviously,
ಅಲ್ಲ,
you have a reason to harass
harass
here.
ಇರ್ಬೋದು, but sexual harassment is not there.
ವುಮನ್ ಗೆ ಹರಾಸ್ಮೆಂಟ್ ಇನ್ನೇನು ಸರ್?
She is a, my lord, they are all married, even she is a, my lord, lady, married lady.
So what, harass ಮಾಡಬಾರ್ದು ಅಂತಿದ್ಯಾ?
ಆತರ ಇಲ್ಲ, but in fact, this is all in sexual in Kannada.
No, sir. List after vacation.
Till then, my lord.
Not till then, nothing.
Not to take any specific action. Bail
Bail
ತಗೊಂಡಿದ್ದಾರೆ,
ತಗೊಂಡಿಲ್ವಾ?
bail ತಗೊಂಡಿದ್ದಾರೆ. Bail has been granted.
Bail cancel ಮಾಡಕ್ಕೆ ಹೇಳಿ. Yes.
Fresh matters, please.
125?
Please, my lords, I beg to appear virtually, my lords, for the petitioners in 125 and 126. Your lordships would recollect that there is that matter.
ಇದು ಯಾರು ಅಪೇರ್ ಆಗ್ತಾರೆ? ನೀವೇ ಅಪೇರ್ ಆಗ್ತಾರೆ.
ED matter.
Learned additional SPP is directed to accept notice for the respondent. Yes.
Lordships may kindly
Objections, if any, by the next date.
Lordships may
Just
kindly
on,
consider
no interim orders are in this. List the matter on 10th.
My lords, in terms of the circulars issued by the central government as well as state of Karnataka, the circumstances mentioned in the FIR, they relate to circular trading. Both the central government as well as the state government are ad idem about the fact that there is no incidence of GST in these kind of transactions. Your lordships may kindly have those circulars if my learned friend could
We'll
kindly.
see, sir. Yes, let him come up with his objections. Yes. Next.
So grateful.
Same, 126, same. Same.
On behalf of the petitioner, my lords, in 127,
My lords, the matter pertains to a section 12 application filed by the respondent number 2. All the allegations made
Section 12 application?
under protection of domestic violence, my lords.
Why is the state party?
The respondent number 2 has also been made a party to this. my
No,
lords.
why is the government a party in that?
All these, my lords, that must have.
Yes, emergent notice to
My
the
lords,
respondent.
an humble request, the arguing counsel in the matter is just on his way for.
No problem. Emergent
may
notice
kindly
to
be
the
passed
respondent.
over or a date may
Registry
be
to
listed.
the petitioner to delete the state as a party respondent to the proceedings.
My lords, if a date may kindly be fixed,
Ah,
kindly. my lords.
Put up immediately after service of notice upon the respondent. Next.
128.
Sorry for the petition in this case.
138.
Of enact, my lords. Petitioner is convicted. 20% of amount is directed to be paid.
40%.
20%.
Ah,
To be paid.
sentence suspension. Yan Jammu Bandar ittkondiddira.
No, my lords orders, my lords, where matters.
When will you pay? I will not waive off. When will you pay?
Well, this matter may be remanded for first consideration on my application, my lords. Good grounds.
Anyway, list the matter on 18th June. Interim order subsisting will continue to the next date of hearing. 128, 129, 130, more same. Please.
131.
Showed on my learned.
7 and 13.
13.
I'll file my objection, my lord.
There is one interim
Objection
protection.
ಹಾಕ್ಲಿ.
ಮಾಡ್ತಾರೆ.
Yes.
Service on interim protection ಇದೆ.
ಏನೋ?
With reference to service my lord condition.
ಏನಾಗಿದೆ?
Like interim protection, your lordship was pleased to grant.
ಕೊಟ್ಟಿದ್ದಾರೆ ಕಂಟಿನ್ಯೂ
That
ಆಗುತ್ತೆ
will
ಅಷ್ಟೇ.
continue.
18th June, objections if any by the next date, interim protection of any kind granted shall continue to the next date of hearing.
Please.
132.
For the petitioner, my lords, offense under 812 of PC Act and 61, my lords. Lords, the offense invoked, allegedly I have offered bribe to a private person, my lords, not a public
Now we'll
servant.
see, sir. List counsel BB Patil is directed to accept notice for the respondent. The complainant yaru?
My lords, private party, my lords.
Emergent notice to the complainant 4th June. Yes, next.
My lords, till then, no court
No,
step.
sir.
My lords, I'll
Secure
cooperate
bail.
with the, I'll cooperate with
Secure
the-
bail, sir.
My lords,
Yes.
he's 59 years old, on the verge of retirement, my lords.
Secure bail, sir.
My lords,
Bail
this is-
ತಗೊಂಡಿಲ್ವಾ?
My lords, this is another
Bail
complaint.
ತಗೊಂಡಿದ್ದೀರಾ ಇಲ್ವಾ?
ತಗೊಳ್ಳಿ.
Yes. Next.
Alleged is criminal breach of trust. Accused number 1 and 3 and no relationship whatsoever with the complainant.
One additional SPP to emergent notice in the meantime. Next.
134.
Seeking for speedy disposal.
The petitioner is before this court. ಯಾವ ವರ್ಷದ್ದು?
My lords, B report is set aside in, P report is filed in 23, 24 it is set aside. My lord, till now, evidence.
The petitioner is before the court seeking the following prayer. The petitioners are accused to get embroiled in a crime in which the police conduct investigation and file a B report. The protest petition being filed, it is the concerned court rejects the B report and takes cognizance of the offense, and the matter is pending before the concerned court since then. In the light of the prayer being innocuous, I deem it appropriate to infuse prayer being innocuous, and a perusal at the odd sheet would indicate that the court has adjourned the matter from time to time without any rhyme or reason. In that light, the concerned court shall endeavor to conclude the proceedings in outer limit of 6 months from the date of receipt.
A lot of shorter time.
That's 6 months from the ಮತ್ತೆ extension ಬರುತ್ತಿಲ್ಲ.
Employment, my lords, that's the reason.
6 months if not earlier in accordance with law. Next.
Obliged.
135.
6 months may not.
Huh?
6 months may be too short because B report has been rejected and cognizant.
12 months. ಇಲ್ಲ 6 months ಮಾಡ್ಲಿ ಬಿಡಿ ಸಾಕು. Yes, next.
135.
The petitioner is saying that it is
ಹೇಳಿದೆ
through
ಅಷ್ಟೇನಾ?
WhatsApp group.
ಮುಗಿಸ್ಕೊಂಡು.
The message has gone through the petitioner's WhatsApp. The allegation is under section 67.
Correct. ಮೆಸೇಜ್ ಯಾರಿಗ ಹೋಗಿದೆ?
It is to the group. It has gone. Your Lord.
ಹೌದು, correct.
The group. No, I am not from that group. It has been transferred to.
That's a different thing. Second respondent is extramarital affair with several persons ಅಂತಂದ್ರೆ.
Father and son relationship.
Anything else, madam?
That's all. I'm just only seeking that it's not gone from him. It's come out. It is through the group, WhatsApp group. It is.
How
gone.
can you paint some lady black like this? Yes.
Lordship, sir.
One HCG additional SPP to emergent notice.
136.
Mahadev. Huh? NDPS.
EC Act.
Section 11 is not followed. Private complaint FIR
To take cognizance, not the investigation.
Investigation ಮಾಡಕ್ಕೆ ಬರ private complaint.
ಏನಿದ
EC Act, essential commodities, private complaint before the London.
EC Act ಅಂತ
Yes,
ಹೇಳಿ.
madam.
ಹಾ. Yes.
No, is cognizance, my lord, it's for a court, the prohibition for taking cognizance.
Accused number 1.
Yes.
ಹಾ, ಏನು?
The other offenses are cognizable offenses are there, investigation can be done. After investigation, we may file a complaint, my lord.
ಅಲ್ಲಿ ಬರಲ್ಲ ಸ್ವಾಮಿ.
Yeah.
Private complaint ಹಾಕ್ಬೇಕು section 11 ಪ್ರಕಾರ.
Pass
Private-
over. Yes, next. ಅದು same.
ಇಲ್ಲ,
137.
Forest Act,
37,
all the documents.
137 pass over. Yes. Next.
138,
Same order. Pramod Nair, sir. Serial number 114, same order. Next.
It could be tagged along with the other matter.
114 tag along, same order. Next.
It could be fixed. I'm so sorry. It could be fixed.
After vacation, move it. Yes, next.
139,
Which of this? The second respond knowingly full well that manner I have constructed the building in question, 95%. There is a civil suits are pending before the arbitrator and the
Additional SPP 1, 2 in the meantime. Next. Swarup,
140,
states.
State.
Barkondra Jj. In the meantime, 140. Hello, 139.
140,
140 appeal for petition. Case and counter case, my lords. There's already 2 affairs pending between the parties. The day on which I allege an incident, they've registered one more affair. May I just point out, my lords? Kindly see page number 100, my lords.
Notice. Yes.
My lords, may I point out, my lords? There's an incident which happens on 10th. Now there's an affair registered at their instance. Then I file a complaint along with an MLC stating that there's an incident. The local police does not register a complaint because she is a Gram Panchayat member. Then after that, I write several representations, after which on the 4th FIR is registered. On the same day, another FIR is registered, my lord. I produced CCTV footage to
So
show.
what, sir? So what?
My lords, I've produced CCTV footage to show that I was around the house at that point of time.
No.
My lords, I kindly see page number 113, my lords. At the
One
time-
additional SPP to emergent notice. Yes,
My
next.
lords, at the time of incident, I was at the
No,
house,
sir,
my
that's a
lords.
matter of evidence. Yes, next.
My lords,
Yes,
some
Bipin.
protection until then, my lords, because
Bail ತಗೊಳ್ಳಿ, sir.
no, bail is already taken.
Then Indian protection ಬೇಕು immediately after vacation. Next.
Some date may be fixed, my lords.
It will come. Yes.
141,
The medical examination, seat
Medical
blocking scam.
My lordship, in this case, my lordship, accused, colleges are not made party, my lordship.
We'll see.
Colleges
not-
were
One, ಅಯ್ಯೋ ನನ್ ಮುಂದೆನೆ ತುಂಬಾ ಇತ್ತು. Yes.
No, my lordship,
Street blocking ನನ್ನ ಹತ್ರನೇ ಇದೆ. Yes. No,
my
sir.
lordship,
Yes.
there.
One additional SPP to emergent notice.
One,
No stay in this, sir.
my lordship,
Yes.
kindly see, my lordship.
No, sir. Seat blocking, I have not granted stay in any case.
My lordship,
Yes.
he's an only agent by.
Only agent.
He claims that.
Very good, sir.
My lordship, IVO claims that he's.
Yes, yes. Anything else, sir?
My lordship.
Hmm.
Accused number 9 and 10, who is on the same footing, has got a
No,
stay
sir.
out, my lordship.
Nothing. ಅಯ್ಯೋ 9 ಕೊಟ್ಟಿದಾರಾ?
9 and 10 ಇದೆ.
ನೀವ್ ಯಾರು?
I am accused number 12, my lordship.
9 ಕೊಟ್ಟರೆ ಇದೆ ಕೊಡಿ.
I have produced, my
Page?
lordship. Page 301, my lordship.
My order?
Not, my lordship. Hemant sir.
No, your lordship, in fact, heard
Oh,
this
I have
matter,
not
my lord.
stayed. I have not stayed those thing at all.
My
Nothing.
lordship, he's on same footing.
We'll see. ಅದ್ ಕೊಡಿ tag along with so and so ಅಷ್ಟೇ. List after vacation.
It has to come before your lordship because your lordship.
Exactly. I have order ಮಾಡಿದ್ದೀನಿ ನಾನು ಅದು.
No, my lordship. No order.
I have passed an order dismissing it.
No, my lordship. Not in the respect of this.
HCGP accepts notice. Yes, next. ಅದ ಟ್ಯಾಗ್ ಮಾಡಿ ಅಷ್ಟೇ. ಇಲ್ಲ ಅದು ಮುಂಚೆನೆ ಮಾಡಿದೆ. Yes.
No,
No.
in respect of same crime, no order is passed.
Blocking of seats I have not stayed. It's not. Yes, next.
142,
Please, my lords, I'm for the petitioner, my lords. There's a private complaint case, my lords, against me. My lords, the commercial transactions are between me and the complainant from 2017, my lords.
In the meantime, yes, next.
Grateful.
ಸಾಕಷ್ಟು. Admission matters, none of them I'm taking. ಎಲ್ಲ after vacation ಹೋಗುತ್ತೆ.
That's one submission, my lord.
All submissions.
Lords, a memo for being spoken to, my lord.
ಯಾರು ಏನ್ ಹೇಳಿದ್ರು ಇಲ್ಲ interim orders will continue ಅಷ್ಟೇ.
Memo for being spoken to, my lord.
Wherever interim orders are there, they'll continue.
Lords, I have a memo for being spoken. My lord, the memo for being spoken to, my lord.
What, why?
My lord, in that TDR matter, my lord, in the operative portion of the order, my lord, the typographical error with regard to the direction needs to be corrected, my lord. I've set it out in the memo, my lord. Serial number
My lord, this is a case for senior citizen.
Huh? Wait, sir. Whatever office objections you comply.
Milords.
No
Milords.
admission matters will be
Milords,
taken.
Milords, this is.
Orders will continue.
Milords,
Compromise,
Milords,
please, my lord.
Milords.
Parties are present.
Mi-
Compromise.
My lords, one mention in, my lords, one fresh matter.
Hello, court officer. Hello. Hello. Hello, court officer. Hello, court officer. Court officer. Excuse me, court officer, admission matter ತಗೊಳಲ್ವಾ? Excuse me, court officer.
husband is petitioner number 1. 2 to 6 had to happen, this happened 2 to 5 years.
Sorry?
Interim order, petitioner number 1 is the husband, others are family members. Instead of 2 to 6 year lordships, it has happened 2 to 5 year lordships.
ಆಯ್ತು 6, 2 to 6, no problem.
Lord, serial number 90, Lord, morning it was dismissed. Observation should not influence the trial.
Of course, sir, that is always.
Adon line madku.
ಆಯ್ತು ಆಗ್ತೀನಿ.
Please.
Move tomorrow. Move tomorrow, sir. ಆಯ್ತು move tomorrow. ಏನಕ್ಕೆ ಮೆಮೋ? ಯಾವತ್ತಾಗಿರೋದು ಅದು? ಕೊಡಿ. ಸಾರಿ. ಕರೆಕ್ಟ್. ಆಯ್ತು ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ. ಯಾರು ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ? ಎಲ್ಲಿ? ಹಾ ತೊಂದರೆ ಇಲ್ಲ. ಆಯ್ತು ಕೊಡಿ. ಕೊಡಿ ಮೆಮೋ ಕೊಡೋದು ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಆಯ್ತಾಯ್ತು. ಹಾ ಯಾವತ್ತು ಬೇಕು? ವೈ? Give it. Yes. Withdrawn the wrong petition now. Whose mistake is that? You have filed a memo withdrawing the wrong petition? Then whose mistake is that? What being spoken to there? Yes. Wait. Iri. We'll take it, wait. Yes. ಏನು ತಗೊಂತೇನೆ ಅಂತ ಹೇಳಿದೆ ತಾನೆ? ಈಗ ತಗೊಂತೇನೆ ಅಂತ ಹೇಳಿದೆ ತಾನೆ? ವಾಟ್ಸ್ ಯೋರ್ ಪ್ರಾಬ್ಲಮ್ ದೆನ್? ವೇಟ್. ಎಸ್. Oh, it should go before that bench only. No. Wherever it is withdrawn, it will go there only. Oh, whatever it is, sir, it should go there only. Yes. ಆಯ್ತು ಕೊಡಿ ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಿ. We'll see tomorrow, madam. Today we can't, madam. Tomorrow we'll see. No, wait. ಏನ್ ನಿಮ್ದೇನು? ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಕ್ಕಾಗಲ್ವಾ? ಸಾರಿ? ಬೆಳಗ್ಗೆ ಯಾವ ಮೆಮೋನು ತಗೊಂಡಿಲ್ಲ ನಾನು. ಎಲ್ಲ ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ. ಎಸ್. ಎಲ್ಲ tomorrow morning you move, sir. Yes. ಆಯ್ತು ಕೊಡಿ. ಮೆಮೋ ಕೊಡಿ. ಆಯ್ತು ಕೊಡಿ ಮೆಮೋ. Tomorrow you move it, yes. Yes, attorney sir. The password ಎಷ್ಟಿದೆ? The moment this is over, I will take the password.
Matters pertaining to Dharwad bench, serial number 2.
Yes.
I have prepared an additional.
Yes.
That additional note.
Yes.
That additional note.
I think the phone there.
Somebody's device.
I think you can. Yes, sir. Now you can.
It's all right. Before I read that additional note, let me, in one goes again and again into the depths of a matter like this. So, to be able to say one as objective and fair as possible. One. That's well understand AG for India and all that. It's pleasing to hear that, but
yes, sir.
I try to structure it in the following way. We begin with one of the basic documents, namely the application on which the other say
we found we have some disagreement. So the application which formed the basis for all further contractual proposals and acceptance and transactions is the document at page 2 in our convenience compilation.
Yes, sir.
Which is at page 2. And when you talk of design capacity, we take into account the production capacity of kiloliters per day, multiply the number of days
Yes.
somebody proposes to work. Therefore, at page 2, we have these figures, that is 300 multiplied by 205. Even though the application which is shown to the court and form part of the petition is 300 multiplied by 305, but this is a reckoning document. Therefore, if you go by that, as I was trying to point out the other day, the production capacity design would be 6.15. So based on that, as I told your lordship the other day, so the total number of applicants in the state of Karnataka, like any other state, there's a marking system. And the marking system for 6.15, you got so-and-so 1.44 as the quantum allocated. Kindly also now keep in mind one more statement. When you come later to the question of whether estoppel or legitimate expectation, or put them all together in a nice kaleidoscope, say reasonableness, fairness, put them all together. So we have a notification which was issued on 2nd of June 2021. Presently, I'll hand over those. We have a Petroleum Act of 1934. And the 1934 Act in Section 5 talks about petroleum will, subject to blending, will be subject to central government's rules and all that. So in 2021, when government began to contemplate ethanol as a blending dimension of selling petrol, these notifications issued directing, mandating all the oil manufacturing companies to act in terms of a mandate. Which means there is a statutory basis for the oil manufacturing companies to enter into the domain.
Madam, sorry.
Give me a copy and give me the other side a copy. Give me a copy. Yeah. This is how this notification reads. In exercise of the powers conferred by Section 3, the Essential Commodities Act, read with Section Para 6 of the Motor Spirit and High Speed
20%.
Order, supersession of so and so, except as respecting the omitted within so and so, the central government hereby directs that oil companies shall sell ethanol blended petrol with percentage of ethanol up to 20% as per the Bureau of Indian Standards specification in the whole of the states and union territories. Given this mandate, now the next question is, how do I discharge this mandate? How do you have an operational system to have this mandate discharged? Therefore, there is something called a statutory basis for the OMCs to enter into the whole area of a contract inviting, which so on and so forth. At a later point of time, we'll probably try to pitch in this statutory basis for a reason that if a power to do a certain thing is traceable to a statute, and that statute mandates me to act in a particular way. I'm not talking about Taylor and all that.
Taylor versus Taylor.
I'm not talking about that. I'm talking about in the context of legitimate expectations and promises. So if there is a statutory power which mandates me to do a certain thing, I can probably have a certain plan of action in order that I comply with a mandate. A plan of action may have certain specifications to begin with. I may not have the entire 10-year period contemplation fully placed dot by dot, mile by mile, etc. So I have a plan, a specification, and I want to start with that. That's how the whole expression of interest and then in letters of interest, and thereafter long-term offtake agreement. I must say at this point of time, prior to 2021, but as soon as this came, there were people who were already distilleries who were already making ethanol and supplying ethanol to private oil manufacturing companies as well as public sector companies. So when we went into the 2021 regime, then we had the second class of invite those like the petitioners. There were about 75 in number with whom we entered into contracts. Then in 2024, 2023, 24, 25, we had a third set of people who we further invite because the invitation for entering into ethanol manufacturing was not closed at any given point of time. People can always see the portal and say, I'm willing to supply. Therefore, the whole field of supply was kept open. It was not confined to a certain dedicated class of people, even though dedication is a different part of the contract. But given that, therefore, there are more than one class of suppliers in this field. The pre-2021, the 2021-23, and the post-23, with whom there is a certain modified term of the contract. Given this set of factors, the court will probably ultimately understand how will oil manufacturing companies discharge, plan ahead for a certain period, reasonably will all probably precision, and then in the course of that, how will it discharge to selling ethanol blended petrol? If somebody, as one of the old English cases, they said if there is one, besides the equitable interpretation of a contract, there are multiple readings of a contract. And in an early, then what is that? The court will say there is no equitable interpretation. We'll arrive at a right interpretation, unlike where between Dworkin talking about hard cases make bad law, etc. So, and then there is an early judgment in 1954, where we were in the essential commodities era. People are asked to sell their entire surplus of grain beyond their personal consumption. And that was challenged in the Supreme Court. Sir, I'm really telling observations in the judgment I would like to read with the Tulia. Is it before the court? Okay, let me. I'll hand over a copy of the judgment in a short while. And that was the situation when we had some different states shortage and some states at surplus. Therefore, equitable distribution of the food grains. This is what the court had to say at that point of time. Though it may not directly be applicable, but I'm looking at the logic. How will court look at it when conflicting interests come before the court in collision, and how to look at it? I'll just read 2 paragraphs. The stark reality confronts us that there is not enough food to go around, and parts of the country are constantly verging in conditions of acute shortage and even famine. Under such emergent circumstances, would it be unreasonable for the legislature to vest the government with wide powers of regulating or prohibiting the production, supply, or distribution of essential commodities, insofar as it appears to it to be necessary or expedient for maintaining or increasing such supplies, or for securing their equitable distribution availability at fair prices? Though it is in the context of essential commodities, I look at the logic. Why would the court look at it like that? Then in the subsequent paragraph, this is what the court says. To expect that the state will not take from anyone and yet give it to all. That it should procure at the highest price and distribute at the lowest. That it should nurse, clothe, and feed the multitude without the least executive interference or without the least encroachment upon any of the fundamental rights guaranteed by the Constitution, is, to my mind, a counsel of perfection not likely to be attained. These are words of wise import. Therefore, you can always apply it appropriately in any given circumstance where the counsel of perfection is likely to be attained or not will be the question that's being asked to the before the court. So having said that, this is AR 1953 Calcutta 548. I was reading at pages paragraphs 37 and 38.
Yes, sir. Yes.
Having said that, yes. Give me the Excel sheet. May I request the Lordships to read with me the additional brief note which I have prepared. The more I look at it, a contract like this, and we have so many in our armory, so many things to persuade the court the way we want to think. So if I call this contract a sui generis contract, and how you read a sui generis contract, may read it a lot to this note. Point A, fettering discretion is opposed to public good. It's a well-settled principle that public policy can always be reviewed, altered, or changed. There's nothing like an immutable public policy. The sequitur of this principle is that a public authority, even though could lay down rules, principles, or norms for the exercise of its power or authority, it cannot be said to have fettered its power to review or alter its policy, principles, or rules. A blanket fetter and exercise of discretion that can be suggested to be exercised for any reason whatsoever will be opposed to public interest. What is being argued is a suggestion that the LTOA contains injunctions against possible future discretionary exercise for compelling reasons on the ground that clauses such as clause 6.8 impose a fetter. This proposition is thus opposed to the above stated well-settled principle. Clause 6.8 of the LTOA itself contemplates a multi-factor balancing exercise. It is not a fetter on the exercise of any discretion in the course of managing the multi-factor balancing. The ethanol blending and supply policy is dependent upon factors which may change or emerge in due course. In such circumstances, a stipulation such as clause 6.8 conceived to be desirable at a given time will not be elevated to the status of a complete fetter on the need, necessity, and the discretion therefore to act in pursuance of changing or emerging factors. I read a few paragraphs of judgment here so that the perspective is can I read this paragraph? So page 10 onwards. Having analyzed the provisions of section 49, we may now turn to consider the argument advanced before the board that the stipulation binding the board not to charge anything more than the specific rate would be void as to the effect of divesting the board of the power to fix and refix charges enters to it under section so or rendering or fettering its future exercise. Now, the one principle more well settled than any other, it is that when a public authority is entrusted by a statute with a discretionary power to be exercised for the public good, it cannot, when making a private contract in general terms, fetter itself in the use of that power or in the exercise of such discretion. There are a number of decisions which would establish this principle beyond doubt. We may refer to a few of them in order to appreciate the true scope and so on. So I skip paragraph 11 to the number of English judgments which are noted here. How the court looks at them, kindly turn to the next page, paragraph 14, then 15 and 16. At the top of page 3, before just ahead of paragraph 14, what was said in Lord Parker CJ in Finlay's case, there's a long line of cases to which you have not been specifically referred to, which lay down that a public authority cannot by contract fetter the exercise of its discretion. The principles laid down in these cases are unacceptable and cannot be doubted. But the question is, does it apply to the present case? We do not think so on the facts of the case they were said. The principle so attract when an attempt is made to fetter in advance the future exercise of a statutory power, otherwise than by the valid exercise of statutory power. Then kindly turn to paragraph 15. At paragraph 14, the last line in paragraph 14, sentence beginning, the discussion of these two cases shows that the principle that a public authority cannot by a contract fetter the exercise of the statutory power which is conferred upon the public good is limited in application to those cases where the attempt to do so is otherwise than by the statutory power. Therefore, we come talk about bona fides, malifies, etc. Then we kindly turn to the next paragraph. I'll probably read paragraph 15, the fifth line from the top at page 4. To put it differently, where a stipulation in a contract entered into by a public authority in exercise of a statutory power, then even though The stipulation fetters subsequent exercise of the same statutory power or future exercise of another statutory power. It would be valid and the exercise statutory power would pro tanto stand restricted. That would follow on the principle of harmonious construction. The public authority would not in such a case be free to denounce the stipulation as a nullity and claim to exercise statutory power in disregard of it. If that were permissible, it would mean the stipulation has no binding force and the public authority has no statutory power to enter the stipulation. But that would be plainly contradictory of the premise on which the argument is based. The distinction must always therefore be borne in mind. Whether the stipulation by which the public authority is alleged to have fettered in advance the future exercise of statutory power is one which is entered into as a part of a private contract in general terms or in exercise of a statutory power. If it is the former, the stipulation would be bad on the principle that a public authority cannot by contract fetter the exercise of a statutory power which is conferred upon it for the public good. But if it is the latter, the stipulation being an exercise of a statutory power would be valid and it won't be open to the public authority disregarded also. Next, this last statement must, however, be qualified by making it clear that a case may conceivably arise where there may be an overriding statutory provision which expressly or by necessary implication authorizes the public authority to set at naught in certain given circumstances a stipulation though made in exercise of a statutory power. Where there is as a statutory provision, the stipulation would certainly be binding. But when the specified circumstances arise, the public authority would have the power to override the stipulation and act in derogation of it. But that again would be a matter of construction. If this is one of the classic cases where we are confronted with the situation. So that's why I refer to the mandate where OMCs have been asked by the central government to sell ethanol blended petrol and left it to their discretion as to how the plan will be formalized. Now, let me read the next paragraph. On an instrumental understanding of the logic that can be derived from the above said paragraph, it is submitted that the desirable and public purpose oriented reading of clause 6 point so and so will be that it shall not be a fetter in the OMCs to act relevantly in future. Next, the principle of legitimate expectation arose from the insistence on continuing with or not departing from a consistent course of conduct. This principle has been extended to cover cases of withdrawal of benefits or concessions given or exemptions granted prematurely or otherwise. Even in such instances, courts have declined the expectation principle on grounds of public interest. For this principle operates in the context of a dealing, a transaction, or a measure taken between the state and a select class of citizens. So no third-party interests or concerns other than the select class of citizens will ordinarily enter into this domain. The moment the state is called upon on felt necessities, I place emphasis on felt necessities, they are to reckon or take into consideration any third-party concerns which may enter the domain at a given point of time, the expectation principle will come to a halt. In other words, as long as the transaction and dealing remain exclusively between the state and the select class, and as long as no other concerns do not arise, the expectation principle can be invoked. If it's otherwise, it cannot be. Next, the core commitment in the long-term offtake agreement is only towards the minimum guaranteed annual offtake quantity. I want to place the emphasis on how do you read the entirety of the contract. So in any contract, for instance, there will be the core commitment. There are other peripheral commitments or non-core commitments, which may be only for the purpose of exercising the contract. Therefore, the core contract here is only towards the minimum guaranteed annual offtake quantity. Any other part of the agreement, including so-and-so, is a non-core element. I say 6.8 is a non-core element. If the OMCs have defaulted vis-a-vis the annual offtake quantity of 1.44, the legitimate expectation can be seen as a facet of binding contractual element can arise. In other words, anything beyond the annual offtake quantity that will lie in the field of consideration alone is a non-core aspect. In this non-core aspect, there is room for legitimate expectation. There is no room for legitimate expectation. The features of clause 6.8, hedging by several factors, the overall context of the ethanol policy, the public policy requirement of giving sufficient room for multiple players in the field, all will suggest that the non-core elements do not have a binding aspect and cannot be specifically enforced. In the facts of the present case, the well-recognized principle of the doctrine of legitimate expectations are not applicable for the following reason. Legitimate expectation must be based on a right as opposed to a mere hope, a wish, or anticipation. I'll read the judgment presently. Clause 6.8 is a case of anticipation that the OMCs will act in the best endeavor basis. Whether you call it a right or give it any other name, the result is the same. In the present case, there is no specific quantity as per its design capacity. Under clause 6.8 is clarified. The additional annual offtake quantity beyond that offered under 6.2 would be given through preferential allocation in the ethanol procurement process followed by OMCs on the best endeavor basis. It is a discretion exercisable only by the respondents, dependent on its annual requirement, and to maintain a level playing field for meeting the objective of National Ethanol Blending Program. This discretionary right cannot give rise to legitimate expectation. I stop here for a minute. For instance, in the year 25-26, but for the state of Karnataka, this gives a figure of when you said wood. The demand from the OMCs at the bottom, you'll find the total figure 1,050, and the offer came out to 1,759. Now, as far as Karnataka was concerned, the demand was 8651, but the offer supply was multifold beyond that. Therefore, I should now ask myself a question. Now, how will I now allocate 86.51? That's why the core, I'm talking about the core element. I'll go to the core element. 1.44, certainly I'm bound. Compared to 6.15, if I'm able to offer a little more, I'll certainly offer that. But how do you go about doing that? Can I do it whimsically, giving something to somebody more, somebody else some less? So I think I cannot do that. Therefore, when you go back to the marking principle, 6.15 and then 1.44, I keep that 6.15 in mind. And if there is more surplus that can be made available within 8651, and then one is a surplus state, the other less surplus states. Therefore, what I take into account is I spend a lot of time in understanding the dynamics of how they went around it. So, I also found that the OMCs had not worked in idle space. They have spent a lot of time in understanding how do we moderate everything. So they didn't want to be told that you were acting malafide or for other extraneous reasons. Because after all, oil manufacturing companies acting under the statutory mandate I said about. So they have to probably report at some point of time in their annual working program to a central government, how have you managed this entire program? Therefore, when they look at this more than 86.51, what they did is by the time in 24-25, we had so many players in the field. As I said, 3 classes of players. So in the class of 3 classes of players, people who have been offering earlier, people who now come and offer later. So as I said, the field is never closed. So because the field is never closed, I try to find out what is my best endeavor. So therefore, the best endeavor meaning to be given in that context, not the best endeavor to offer it to only one person alone.
Of course, to all.
Correct. Therefore, your best endeavor means given a particular context, how do I exercise in a fair way the distribution of the ethanol supply? So how do I distribute it? Therefore, it ultimately came to this, that even though it's 1.44, at the end of the day, they got an additional offer, supply of 2.48. Therefore, that's also to 3.9.
3.32.
That's right. Therefore, we could have said, I am confining to 1.44. We did not do that. Therefore, that's the way one could understand clause 6.8. That's why I thought the best way of looking at it is, what is my core commitment under the contract? Beyond the core commitment, everything has become discretionary, but even within discretion, I suppose OMC should act fairly. So in order to act fairly, they put everything in a pool and find out how do I distribute it. Today, if therefore the court were to say, no, you could not have done it at all. You could still go by beyond 1.44. There is some expectation that I will have under 6.8 only to meet 1 or 2 or 3 people's interest. Therefore, the policy hinges on several other factors. Therefore, that's why they went into an equitable distribution, put it into a common pool, and then distribute it equitably. Now, then let me read the next paragraph here. I want to place also for your lordship's consideration. Page 4 of this note. Just a few factors. These are facts which probably, can I read this?
Page 4, is it?
It is a title, EOI floated for signing. You lordships have that last page, I think.
Ah, yes.
Just quickly read that. A, B, C, D, E, F, G, H, L, I think.
No, are you referring to this note?
That,
The chart.
this one, the one with the chart.
Ah, yes, yes.
That's right. As per the report on the roadmap for ethanol blending in India 2025, published in Niti Aayog, the estimated ethanol requirement to achieve 20% blending. We started with 5, 10, 15, 20 now. In ESI was 1,016 crore litre. The statewide shortfall of ethanol was calculated basis. The estimated ethanol requirement in so-and-so for achieving 20% blending and the current availability offers in ethanol supply year 2021. Accordingly, EOI 1 for signing long-term offtake agreement with upcoming dedicated ethanol plants in ethanol deficit state was floated in 27/8/2021 for a requirement of 648.5 crore litre of ethanol. Then for the state of Karnataka, the requirement floated was 18 crore litre. Out of it, the total requirement of national requirement of 648. Karnataka was not a deficit state, and the requirement was calculated under. All these are purely mathematically worked out, and there's no other way of looking at it. Therefore, the estimated bulk sales in ESI was 37.26 crores litre. Ethanol requirement for E20 is 74.85. Ethanol available in 2021 is 57.22. Therefore, tender requirement floated is 18 crore litre. That's what the figure that I read. Then E, although OMCs received offers in excess of the requirement in several states, no offers were received from major ethanol deficit states, Tamil Nadu, Kerala, Rajasthan, Gujarat, Telangana, and Andhra Pradesh. Therefore, how do I therefore manage deficit versus non-deficit states? Next,
So
post-evaluation,
Karnataka was not a
OMCs
deficit state.
So there's a question.
Karnataka was not a deficit state.
That's right. Not at all. It's a post-evaluation. OMCs have signed long-term octave agreements with 132 DEPs for an annual offtake quantity of 435 crore litre against an offered design capacity of 764 crore litre. Therefore, nowhere the design capacity ultimately figured in the quantum which was offered for everybody. For the state of Karnataka, against a published requirement to achieve 20% blending 25-26, OMC signed long-term offtake agreement with 9 numbers of upcoming dedicated ethanol plants for an annual offtake quantity of 24.3 crore litres against an offered design capacity of 59.3 crore litres. Next, as on date, out of nine out of LTOA holders for the state of Karnataka, 6 numbers have been commissioned. So people came and then there is a slackness on their part. Therefore, how do I know that at a given point of time, the promised quantity, the assured quantity will be available, or I'll require more? Is there a magic way of saying that I'll be able to see what is that? Yeah, some visionary with a long-term 10-year visionary, I don't know it's possible. That's why I read that other judgment saying it's an ideal situation. Now, let me read the next paragraph. As subsequently, as on 15/5/2023, OMCs floated another EOI2 for signing long-term offtake agreement with upcoming dedicated ethanol plants in selected states, so-and-so, so-and-so, so-and-so. Then with the EOI2, that's the second one. OMCs have signed LTOA with 101 DEPs with annual offtake quantity of 361 crore litre. So I asked myself a question, because there is deficit states and non-deficit states. Some people volunteer to offer more. Why can't I pick it up here and transfer it to non-deficit states? That's not how the system should work. So as on date, 31 plants with annual offtake quantity of 106.5 crore litre and design capacity of so-and-so have been commissioned. Therefore, this is how the what was envisioned and what is happening on the field. And therefore, given those factors, how will OMCs work on an equitable basis is the only question to be asked. Now, may I continue reading from a note? Paragraph 4 at page 6. The doctrine of legitimate expectation cannot be invoked to fetter valid exercise of discretion. Generally speaking, a public authority cannot contract, fetter the exercise of any power which is conferred upon it, where the need to exercise discretion is warranted by public good in this regard. Please see Aluminium Company, I read those paragraphs. Now, though this is so and so, the public authority has the discretion to exercise the full range of choices available within its power. The public authority often has to take into consideration diverse factors, concerns, and interests before arriving at a particularly policy decision. Legitimate expectation must arise either from an express or an implied promise, or a consistent past practice or custom followed by an authority in its dealings. Under the LTOA, there is no express or implied promise to allocate additional annual offtake quantity. Additional annual offtake quantity, if required, could be allocated on best endeavor basis, keeping the entire EBP program in perspective. Therefore, if when I say 6.8 is non-core, but still, how will you operate this non-core element? The best endeavor, I asked the highest level of officers in OMCs, how do you conceive will exercise best endeavor basis? So they say it's very difficult in 2021 to have what will happen 1 or 2 years later. How many people volunteer to come forward to set up dedicated plans or will divert their already existing distilleries to offer more? Therefore, we said best endeavor is a guide for us to internally work out the emerging situation from time to time. Then they said, have we not acted in the best endeavor basis to equitably distribute for everyone? So clause 6.8, when it goes beyond the annual offtake capacity 1.44, that means if there is a possibility, if there is a good scope, then that good scope will be explored on the basis of best endeavor. If the possibility is not there, best endeavor recedes to the background. Therefore, suppose there was a possibility, then of course best endeavor. Now let me take further.
No, in
Any
this case,
expectations?
owing to that possibility,
Yes.
you have increased it to 3.2.
That's right.
That is the best endeavor.
That's right. That's right. Therefore, there is an answer to it saying that I did that. If you've not done that at all, then I have closed my eyes to some and opened my ears to somebody else.
That is not the case
That's
here.
not the
So
case. That's not even
you
what
have
done.
invoked or executed clause 6.8 to a limited extent,
What
not
it
to the
says-
extent of the intake capacity.
My expectation is my design capacity. So that's where the problem lies.
Yes.
Now let me read further. Any expectation which is based on sporadic or casual or random acts, or which is unreasonable, illogical, or invalid, cannot be treated as legitimate expectation. The petitioner, since entering into the LTOA, has never offered to supply the quantities of ethanol as per its claimed planned design capacity of 9.9 crore liters. Because over a period of time, they said different offers have been made beyond 1.44, and they have been taken into consideration. However, in the current PSY, being aware of the surplus supply situation, has offered to supply 9.27 crore liters. Such a course of action based on voluntary choices cannot be the basis for the application of the doctrine of legitimate expectation. Now, this is not a case of any past practice or conduct leading to the expectation that such practice or conduct will be pursued in future. And secondly, I've given those list of cases which are noticed in a recent judgment, the state of Maharashtra versus Reliance Industries, Court Master. Before I read this judgment, I just quickly complete reading this paragraph. The 11th paragraph judgment I have set out here. What happened, we go back in point of time to a little bit of the history of legitimate expectations. We have all those classic cases where a free electricity is offered for a particular period. Then you have a tax holiday for a particular period. Then you have other benefits or concessions or exemptions for a particular period. So cases arose when before the period expired, you prematurely withdrew an exemption or said no more benefit. It's on those contexts in our country, by and large, the principle of expectation were applied. This is one such case. Here is a case where Lordship will notice the payment, exemption payment of electricity duty. For kindly turn to paragraph 6. Paragraph. No, paragraph 11. Paragraph 11, the petitioner's appellant submissions are noticed. I would like to read that. Then a senior counsel for the appellant, while inviting so-and-so and the several notifications, submitted that withdrawal of exemption was neither premature nor was the same withdrawn with retrospective effect. It's urged that the argumentation of revenue is in public interest as budgetary deficit is a valid ground to withdraw the exemption. It's contended the High Court ought to appreciate it. Doctrines of legitimate expectation, promissory estoppel, do not apply to the obtaining of actual matters. It's argued that the power to grant exemption is a statutory power. It's coupled with the power to withdraw the same. Contended the captive power producers have no statutory or fundamental right to claim exemption from payment of electricity duty. The third reduction so cannot be a reason to quash the notification. In support of the aforesaid submission, reliance has been placed on the decisions of the following decisions of the court. At the bottom, we have the footnote number 1. Then,
Oh, please. No, where?
and in paragraph 2, paragraph 12, in the next page, about 10 lines in the course of the paragraph, the sentence beginning, it's contended that acting on the solemn representation of the state government, the captive power producers have made huge investments and have set up the captive power plant, and the state government is therefore bound by the doctrine of promissory estoppel.
Paragraph 20, last 9 lines.
I'll just come to that. And I'm going to probably little moderate it. I know.
Yes.
I would have probably avoided reading the judgment, but I thought it's important.
No, it's paragraph 20, last 9 lines.
Yes.
Whether it amounts to arbitrariness or otherwise, change in policy, legitimate expectation, if it is in public interest, cannot be claimed at
That's
all.
right. That's right.
Neither promissory estoppel.
Absolutely. Now, can I go back to my
Yes.
note at page 6? At page 6, in the next page, I have set out about a couple of paragraphs from the state of Jharkhand versus Brahmaputra Metallic.
Yes.
So at page 7 of the note, those extracted paragraphs can be seen.
Yes, sir.
Can I hand over a copy of the entire judgment?
It's here. That's okay. I'll read this. These are the paragraphs spelled out which you are placing reliance upon.
There are a long line of paragraphs looking
I
at
know,
other
that's-
judgments. I thought what's relevant is probably available.
This Kamadhenu Kettlefield is a celebrated judgment where, with regard to contract vis-a-vis the legitimate expectation or the interplay between the two.
No, let me, Raju, you allowed to put it to me. So it's open to the state without entering into a contractual domain to have policy decisions, granting. That's why we talk of Electricity Act or sales tax or income tax or any one of those acts where exemptions are granted. There are decisions taken in exercise of either executive power or statutory power. Many statutes grant authority to the state to grant an exemption. So there's statutory power or other executive power. Now, Union of India versus so-and-so, the court discussed the decision in monetary part and noted reliance on the judgment in attorney for so-and-so. This court went on to hold that if denial of legitimate expectation in a given case amounts to a denial of a right, that is a guarantee or is arbitrary, discriminatory, unfair, or biased, gross abuse of power in violation of so-and-so, the same can be questioned on the well-known grounds of attracting Article 14, but a claim based on mere expectation without anything more cannot ipso facto give a right to invoke this principle. That the court held, doctrine of legitimate expectation cannot be claimed as a right in itself, but can be used only when the denial of expectation leads to the violation of Article 14 of the Constitution, as stated in the previous paragraph. Those are the dimensions of Article 14. Now, as regards the relationship between 14 and the doctrine of so-and-so, in Food Corporation of India, this is Verma's judgment, in contractual sphere, as in all other state action, the state and its instrumentalities are to conform to Article 14 of the Constitution, of which non-arbitrariness is a significant facet. This Verma was in fact having in mind Srilekha Vidyaja's case, which was cited a little earlier. There is no unfettered discretion in public law. A public authority possesses powers only to use them for public good. This imposes the duty to act fairly, adopt a procedure which is
That is Srilekha Vidyarthi. That is quote from Srilekha Vidyarthi.
That's right.
1991.
I appeared in that matter. Trust is the the more mere reasonable, I am talking paragraph 8, or legitimate expectation of the citizens in such a situation may not by itself be a distinct enforceable right, but failure consider and give due way treatment render the decision arbitrary. Now, turning to the next page. This is page 8. This is also not a case of conferment of an unconditional benefit granted in unequivocal terms. So if you read 6.8 as unconditional, unequivocal, a different consideration follows. The subject of quantum of supply of ethanol is hedged in by several considerations. In such circumstances, invocation of expectation is misconceived. If it is so, to invoke it indirectly through recourse to reasonableness or arbitrariness would also be misconceived. In state of Jharkhand, court looks at it, the overplay between promissory estoppel and legitimate expectation. I think very often we weave them together so that we have a good basket of foods and for consumption. So it is not a case of arbitrariness. It is not a case of promissory estoppel. We are bound either by the contract or, I said, the principle that can be read into the contract by recourse to public good and public interest. Because no contract like this can keep away public interest and public good being read into them. The concept of preferential allocation under LTOA is not absolute and must operate within reasonable limits to ensure equitable distribution among all stakeholders, including DEPs as well as non-DEPs, many of whom were established significantly prior to the LTOA regime. Without prejudice to the above, any expectation that a person may not be exposed to any loss or injury, particularly economic and financial losses, must be dealt with in reference to larger public interest that may be legitimately invoked. In the instant case, whichever way one may designate the expectation or anticipation element in para 6.8, it will be subject to the larger public interest of operating the ethanol supply policy without disruption, uncertainties, and informed by equitable considerations. Beyond this, there is no other room for any argument either on anticipation or expectation. I would have probably said, I would very strongly use the word only anticipation. Since you are using expectation, I think interchangeably, in the facts of this case, perhaps there was an anticipation, not even an expectation. Then the C, conduct to the appellant and the bona fides of the OMCs will inform the scope or assess it necessary for judicial review. Differences in clauses 6.2 and 6.8. The clauses differ in respect of commitments. In clause 6.2, OMCs have offered annual offtake quantity and the petitioner is committed to supply the same. So both parties have in a way bound themselves into this part of the conduct subject to the conditions in this clause. Before I go further, if in clause 6.2, if it has been worded differently, beyond 1.44, the OMCs oblige themselves on their own without any other consideration to keep in mind the annual intake design capacity and then therefore offer, it would have been a different thing altogether. But then having regard to the design capacity, if I fix the quantum, then that is what's called a commitment there. So therefore, anything beyond that, I would probably use the word again, anticipation and not even expectation. So in clause 6.8, the commitment as expressed in 6.2 is not there. Then petitioner's conduct. There is no vested right available with the petitioner under clause 6.8 to seek a commitment from the ONC to receive ethanol up to its annual design capacity. This is also evident from the conduct and understanding of the petitioner based on the offer for supply that they have made in the past less than the design capacity. The petitioner stated before the Honorable Court that it completed the installation and commissioning of its plant on 9/1/2023 with an annual design capacity of 9.9 crores liters. Despite this, in the ethanol supply year 22-23, the petitioner offered 3.4 crore liters, and going forward, they made offers of 4.0 crore liters and so on and so forth, and then 6.4 crore liters. None of these offers are in line with their claimed annual design capacity of so and so. So do they have the liberty and the freedom to offer less than this? If they do so, then I must say, look here, all right, you give me less, but I have to hunt for it elsewhere for the balance.
Less than 1.44 can't envisage that situation. If that happens, then you'll have to take it from him.
That's right. That's what they were trying to do from time to time, and I've honored them. If they say, no, I'm going to ask you to go up to the highest and insisted on that, then probably I would go to Section 7 of the Contract Act. I'll just read it for a minute. This is how section 7 of the Contract Act reads.
Yes.
And in order to convert a proposal into a promise, the acceptance must, one, be absolute and unqualified. The moment there are factors which qualify the acceptance, then there is a different way of looking at it. And B, be expressed in some usual and reasonable manner, unless the proposal prescribes the manner in which it is to be accepted. If the proposal prescribes the manner in which it is to be accepted, and the acceptance is not made in such a manner, the proposer may, within a reasonable time after the acceptance is communicated to him, insist that his proposal shall be accepted in the prescribed manner and not otherwise. But if he fails to do so, he accepts the acceptance. What I mean to take up, what I mean to take out from this, that once you have 6.2, there is an acceptance of the acceptance, and then rest of it is all qualified.
So you can't base your right on 6.8 now.
Right.
After 6.2 becoming absolute.
Therefore, I say 6.2 is unqualified, 6.8 is qualified.
Right flows from only, a right would flow only from an acceptance which has become absolute in terms of 6.2.
That's right.
So that is unqualified.
That's right.
That's accepted. Now this is qualified on so many circumstances.
It's qualified. So if he says, no, I don't want 6.8 because it's so qualified, I do not know what's in store for me, then why should I accept it? Correct. That's where section 7 will come in. I was reading at page 9, paragraph 3. I said, how much did they offer during this 2-3 years? So, however, paragraph 4, however, in the ESY 25-26, they've offered 9.27 crore liters. The onus is on the petitioner to show and explain his conduct. The conduct of the petition does not corroborate its understanding of clause 6.8, in that always committing annual design capacity to OMCs to enable them to achieve the national ethanol blending program.
But 6.8 does not envisage a separate contract to be drawn. On certain circumstances, 6.8 can be operated by grant of the need, whatever demand is there for you by you,
yes,
from their hands, you can take it under 6.8.
Correct.
So now if anything is sought to be projected as a right under 6.8, it would amount to alteration of the contract itself.
That's perhaps they would object to that. I would say, I would put it slightly
No,
different.
what is running in my mind.
I understand. I understand. Let me put it like this. Let me
No,
put it
if
both ways.
6.8, which is a clause which is
Right.
qualified,
Right.
then if they want to base their right on a qualified clause of a contract, which had not become absolute or cannot become absolute.
That's right.
Then
That's
it
why
is-
I refer to section 7. Therefore, if 6.8 is so qualified with many factors, as I say, hedged by many factors. So you can't say my reading of the contract should prevail with you. That
Correct.
means every
Whether the
time,
contracting party is a state or a private party, whatever it is, a clause which is unqualified cannot draw a right to a particular
Absolutely.
person and take it
Absolutely.
forward. So,
that's how probably we should look. That's why I started saying there's no question of equitable interpretation of a
Yes.
contract, even though there are multiple meanings that a word or an expression can give rise to them. So OMCs have allocated quantities. I'm reading paragraph 6.
yes.
As per the prevalent allocation criteria applicable to the respective tenders for quantity bidding, and in consideration of the offered quantity by the petitioner, not only in the past, but also in the current ethanol supply year, including what is offered beyond annual offtake quantity as per clause 6.2. This can again be seen from the allocations made by OMCs to the petitioner, all of which exceeds the annual offtake quantity of 1.44. Para 7. So even though the offer for supplies given by the petitioner in the past till current ESY was as per their so-called annual design capacity, OMCs neither compelled them nor sought any mandatory commitment from them to supply additional annual offtake quantity, and the petitioner could offer anything beyond so and so under clause 6.2. Similarly, OMCs also have an unfettered right to accept what is offered, particularly if it has an element of larger public interest involved. OMCs, being stated under Article 12, cannot close their eyes to the other suppliers of ethanol, which are much more in numbers than the LTOA holders also. If petitioner's interpretation of clause 6.8 is followed, it may result in a situation where there shall not be any allocation to any non-DEPs, leading to their financial death. So you say, sir, that's why I think I also referred to a 1970s judgment where giving a no objection certificate to a theatre being set up in a locality, because the one has a theatre says, my commercial, you can't have it at all. So then, para 10, yeah, that judgment, just give the reference, Lord Smith. In fact, in 1976, one SEC, page 671. There, the court went on to the extent of saying, in cases of competition, you don't have a locus even to come to High Court. Because you can't say competition is bad, there can't be a competitor in your locality because it will affect your commercial interests, etc. But I'm not going to the extent of locus. I only say that all those considerations have weighed in our mind. That's why understanding and conduct of the petitioner, with the understanding of the conduct of the petitioner under clause 6.8 was always driven by individual pursuits. So far as the OMs are concerned, they acted in a manner which is driven by inclusivity, protecting the interests of a large number of bidders. Having done that, yes, can I quickly invite your Lord's attention to our additional objections filed on 3rd of April 2026. In fact, it virtually incorporates some parts of the ethanol policy, Niti Aayog statement, etc. Can you make a note of that? A couple of paragraphs there. It's part of, where is that? 3rd April 2026.
Yes.
The ethanol blended petrol program is being, I'm beginning the first page, sir.
I'm there.
Is being implemented by the government of India and has evolved significantly since inception, growing from a limited pilot initiative into a nationwide strategy. And the EBP program has been supported by distilleries before the advent of long-term offtake agreement mechanism. Today, the EBP programs represents a key component of India's clean energy transition, with multiple objectives of crude oil substitution, savings in foreign exchange, related environmental benefits, and boost to domestic agricultural sector, thus fostering a more sustainable biofuel ecosystem. Since ethanol supply at 2014-15, ethanol blending in petrol by public sector OMCs has resulted in expeditious payment to farmers to the tune of rupees 143 crores, foreign exchange saving 1,43,000 crores, foreign exchange saving of more than rupees 160 crores, net COT reduction of 830 lakh metric ton, and crude oil substitution of so-and-so LMTs. It's a national program to promote greening of fossil fuels and in public interest. Here too is produced a copy of the roadmap and so on. So the paragraph 6. In fact, before we reach paragraph 5 and 6 in 2021, the groundwork had to be prepared by various departments of the government to issue notification facilitating the movement towards ethanol blending. That all that is noticed in paragraphs 3 and 4. Now kindly turn to paragraph 6. Ethanol procurement for blending in public sector has thus increased from 38 crore liters in 2013 to 1,040 liters in ESY 24-25. The EBP program has grown over the years, carefully taking into consideration the technical constraint former interest ethanol capacity required for the purpose. In this regard, the requisite information provided by the so-and-so written reply so-and-so. In the above background, it noted that an expression of interest noted. That's how the history is shown here. And in paragraph 7, we say how he participated with the capacity of 6.1 crore liter.
Objections, we'll look into it. I'll go through the
Just
objections.
pick up one page in the note which I gave in the chart. There is a this is the second I think sheet, which begins like this: ethanol allocation methodology at the top. Methodology so and so offers received is more than the requirement. Now we kindly just pick up quickly a few statements here. Ethanol requirement of each state is calculated for each ESY quarter. It can't be fixed in advance on an annual basis. So, and then projected sale and ethanol blending percentage. The state-wise total requirement is aggregated and published in the quantity in a bid tender document. Then tender is floated to vendors registered with OMCs on long-term basis. Then number C, currently there are 6 different feedstocks from which OMCs are seeking offers from vendors for supply of ethanol. That is sugar, sugarcane juice, sugar syrup, heavy molasses, then B and C, damaged food grains, then surplus rice source and so and so, and maize. Therefore, different distilleries, different plants may have more than one set of these resources for making ethanol. So this particular petitioner, I think, has both the sugar as well as the other. That's right. Maize. Therefore, then for each vendor, the following backend data is available in the OMC's online IMS portal, which is used for allocation: geographical state of the bidder's distillery, cooperative sugar mills marker, DEP with marker, annual offtake quantity for the DEP, maximum ethanol production capacity, and so and so, then number of days of operation distillery. So we keep all that. Then bid evaluation, excess bids, if any, above the maximum ethanol production capacity are truncated to arrive at the vendor-wise eligible bids to be consolidated for allocation. If a consolidation takes place. In the next page we have, I'm sorry, this page is like this. I'm so sorry about
I've taken
it. After the first vendor-wise allocation of ethanol quantities is carried out quarter-wise, then just below that, preferential allocation. Eligible offers of cooperative sugar mills are accepted in totality under preferential allocation. LTOA so-and-so is accepted under preferential allocation as per clause 6.2. Non-preferential allocation along within state feedstock priority logic. For the balance requirement of the state zone after considering the preferential allocation quantity, allocation is then as per the following feedstock priority, that is sugar, sugar syrup, sugarcane juice plus heavy molasses, then heavy molasses plus all other feedstock. Therefore, all this which goes into reckoning, then you say no, don't do that at all. That my investments will probably tell you how to go about it. So that's where the figure and the plan and the working and operations, I think, happen. Now, yes. Maybe it's here. It's here. Maybe it's here.
Oh, that's Calcutta.
Yes, the first.
Which one? I read out paragraph 37.
Yes,
That's right. I would have confined myself to Swadeshi jurisprudence, but
oh, this is nice.
permit me to go to a little beyond in point of time. And US during that recession period, maybe I was in New York and New York Ice Company. Those two cases, I got a book from, yes, let me open it. At the 517 of this report, Libya versus New York. There's a question of fixing the distribution, product distribution of milk and fixing.
This
prices.
is US Supreme Court.
Correct. Is a kindly turn to page 517 of the report. The production and distribution of milk. We'll have that page. 517 of the report.
Yes,
the
sir.
top right hand side we have the page number.
The production and distribution of milk.
That's right. If milk is a paramount industry of the state and largely affects the health and prosperity of people. Dairying yields fully 1/2 total income. Dairy farm amongst approximately so and so. Curtailment and destruction of the dairy industry would cause a serious economic loss to the people of the state. In addition, general price decline and other causes for the low price milk include periodic increase in the number of cows and in milk production, the prevalence of unfair and destructive trade practices in the distribution of milk, leading to demoralization of prices in the metropolitan area and other markets, and the failure of transportation and distribution of charges to be reduced in proportion to the reduction in retail price of milk and cream. So all those imponderables, and which may change over a period of time. The fluid milk industry is affected by the factors of instability peculiar to itself, which call for special methods of control. Under the best practical adjustment of supply to demand, the industry must carry a surplus of so-and-so, because milk, essential food, must be available as demanded by the consumers every day, and demand and supply vary from day to day and according to the season. And so on. So then, close adjustment of supply to demand is hindered by several factors difficult to control. The surplus milk presents a serious problem, and the price which can be realized for it for other users are much less than those obtainable for milk sold in consumption in fluid form or as a cream. Then at page 520 of the report, first the appellant urges that the order of Milk Control Board denies him the equal protection. It is shown that the order requires him, if he purchase supply from a dealer, to pay 8 cents per quart and 5 cents per pin, and to resell at not less than 9 and 6, whereas the same dealer will buy his supply from a farmer at lower prices and deliver milk to consumers at 10 cents a quart and 6 cents a pin. We think that the contention, discrimination deprives the appellant of equal protection, is not well founded. For aught that appears, the appellant purchased supply of milk from a farmer, distributors, or could have procured a farmer if so desired. There is therefore no showing that the order placed him at a disadvantage, or in fact affected him adversely, and this alone is fatal to the claim of denial of equal protection. But if it were shown, the appellant is compelled to buy from a distributor, the difference in the retail price is required to charge his customers from that prescribed of sales by distributors is not on its face arbitrary and unreasonable. There are obvious distinctions between the two sorts of merchant, which may well justify a difference of treatment if the legislature possesses the power to control the prices to be charged for fluid milk. Then it goes further. Page 523. Under a form of government, the use of property and the making of contracts normally matters of private and not a public concern. The general rule is that both shall be free from governmental interference, but neither property rights nor contract rights are absolute, for government cannot exist if the citizen may at will use his property to the detriment of his fellows or exercise his freedom of contract to work them harm. Equally fundamental with the private right is that the public to regulate it in the common interest. So-and-so said specifically inspection laws, a portion of that minimum mass of immense mass of legislation, which embrace everything within the territory of a state, all which can be most advantageously exercised by the state themselves. Inspection laws, quarantine laws, health laws, so and so, are components of this mass. And so that's therefore it's. I don't propose to read this further. Then the NBCC. Which paragraph? No, give me this. This is forgivable. Give me Army.
Legitimate expectation.
Yes, I picked up in my note.
This is past practice. Deviation from past practice.
That's right. But I picked up from this in my note a statement which
62, 63, 64.
paragraph 62. Where is that? Conclusions. Why? Yeah. Paragraph 62 at page 651 of the report. This court, while differentiating between legitimate expectation on the one hand and anticipation, wishes and desire on the other, observed thus. A legitimate expectation is not the same thing as an anticipation. It is distinct and different from a desire and hope. It is based on a right. Now, therefore, then the conclusions are drawn here. So paragraph 63.
63 is the conclusions. About 5 conclusions.
But how do I say it is not an expectation, merely an anticipation? That depends on how the reading of the most objective reading of clause 6.8 will yield that result. So if it is stronger, one can say it is expectation. If it is very, very at the lower side, they say it's only an anticipation. Therefore, the anticipation, because I use the word very deliberately, so if there is something, a clear road between two parties, then one can say it is expectation. That's why all those cases where court gives an exemption, a grant, a benefit, or a concession, so on and so forth, it's between the state and the citizen. The state knows what it can do. The citizen knows what the state ought to do. But when you can't know it finally and fully and conclusively, the question of expectation will have no room at all.
So here it is.
Show that in contracts like this, as I said, is a sui generis contract, not comparable to a building contract, not comparable to a road laying contract, not even comparable to a medicine buying contract. At the benefit of lordship judgment in that Karnataka case, probably if the state of Karnataka had come with a proposition that we want to have a long list of waiting passenger people who would like to offer their services for selling generic medicine in terms of the central government plan. They are waiting since long. I need to give a room to them. Perhaps the case could have turned a little different chapter. But they said, no, we want to sell privy medicines. Therefore, the lordship had a choice to make that. So cases where of this nature,
You can just read this of CT7
I know, I'm sure CT7 has been quoted extensively in the judgment. Merit friends always, when they instruct, I think I should avoid with instruction. Paragraph 38 of CT7 and then. That's why I looked at the Indian Aluminium, the Kerala Electricity Board case, fettering the discretion. Paragraph 38, this is...
You have given the judgment?
Given. 2024 3 SCC 719. You see the compilation?
Yes. Oh, that's again on legitimate expectation.
I don't propose to read it. I just make a note of that. Therefore, I think it's important for the court to have a clear. I don't say the lordships will not have the clarity. All that I say is, since we tend to put into an Article 14 basket too many things which ought to be distinct. And so that's why just Venkatachari, one of the judgments, the hotel case, is that reasonableness word is used freely in administrative law, in constitutional law, in tort law. So for look at the result which follows, which is not the appropriate result. Para 38 at page 69 of this compilation.
Paragraphs are marked here, we'll check. You already indicated the paragraphs, right?
That's
no problem. Yes. Attorney or the separator.
In the list of dates, please show from the list of dates. Our list. List of dates. The 17th of October 25 was the allocation.
Yes. Yes.
Which is page number? 15 of dispensation.
Our convenience compilation.
Our convenience compilation.
Is
1-5. There are few dates, and maybe that whether one can take a strict view of that or not, but I think it's important. So 17th of October 2025, the allocation is made.
Oh, the dates and events.
The dates and events.
That's so that will know.
17th of October 2025, the allocation is made. Then 27th of October 2025, there is that is on 27th of October. On 27th of October, this allocation is accepted. That's why I went to section 7 of the Contract Act.
Absolute.
So
makes it absolute.
That's right. Therefore, there is no resiling from it. You may say that, well, I am asked to sign on the dotted line, and then there being so I must depend on the continued,
Resume the 25th April note reading.
Very much right.
Yes.
Just make some.
Yes.
Just show me that. In fact, when we tried to persuade the Supreme Court saying that what will be the effect of unsettling everything, you can have 2 points of view. When you say you went on a wrong basis, why do you talk about unsettling? So the question is, did I actually go on a wrong basis? That begs the question. I say, no, I've not gone on a wrong basis. You understood 6.8 correctly, having regard to many factors. Therefore, if the clock has to be turned back or to reverse, then what will happen? The Supreme Court looks into it, what we place before the court in paragraph 19 and of its order, para 19.
The Supreme Court.
26th February.
The one which sends it back here, 26-2.
That's which remitted the matter back to
Yes, yes.
Paragraph 19.
19.
19.
Yes.
The learned so-and-so argued that additional supply would result in increase of allocations for some and DEP, decrease of supply for the non-DEPs. He also pointed out that if clause so-and-so is interpreted as mandatory, as argued so-and-so, then the DEP1 category suppliers who in total offered 585.3 crore liters would alone account for approximately 56% of the total published requirement of 1,050 crore liters, which would necessitate appropriate reduction from other categories, thereby displacing the non-LTOA suppliers extensively, affecting their business viability. Therefore, the court says the same will have its own cascading effect. Now, why should it can be argued from the other side? I am concerned about my effect. You went on a wrong reading of 6.8. So therefore, you can't have the argument at all.
But that's
So
the
my only
submission is-
submission is,
That's the submission that was made there.
made there and made here.
Made here also.
So I can kindly paragraph
But
23.
Apex Code does not consider para 22 onwards. It only goes on
That's right, paragraph
the
23. Your Lordship, that's it.
unsustainability of the order.
So tender allocation should completed on 17th of October. Then 2 supplies are only for ESY 25-26. And then 15th of February, 281 liters have been supplied. Then ESY 25-26 is for the period November 2025 to October 26 only. Hence, Q1 of the ESY so-and-so should completed and the petitioners have entered Q2. Therefore, 473.4 liters stand supplied today. 473 crore liters have been supplied as of today. Now, therefore, I come back to the basics of this case. Will the court read the entirety of the contract like this as subject to rigidity, which will not leave any room for an appropriate understanding and the working of the contract from time to time? If the contract admits of such rigid reading, then of course I have no legs to stand upon. But given the nature of the contract, and therefore, I again asked them why 6.8 at all. Said we do not know how much offer will come. How do we manage it? Therefore, I think they had to spend a lot of time to understanding the dynamics of an emerging market. So in the dynamics of an emerging market, if there are too many imponderables, and if somebody may suffer a little setback, will that probably a reason for the court entering into a microscopic, examination of the contractual process or the working of the contract? My respectful submission, this is not a case for a microscopic examination, and therefore the matter, as in one case where parties understand they are the masters of the contractual fate. So if parties they are the masters of the contractual fate, and if they understand, and the loss should lie where it lies. So if government suffered a loss, it will suffer a loss. Somebody suffers a loss, it should lie where it is. That's the best principle in any interpretation of a contract. I would have probably concluded with that. In my earlier note, I just make a note of these pages. 25th April note. At paragraph, the whole of paragraph 4, it's a fairly explanational statement given by me. So it runs into several sub-paragraphs. And then that's okay. I'm grateful for a lot.
Yes. So submissions are concluded.
Yes.
Yes. Then we'll hear the others.
Yeah.
I'll just run through the list and hear. Hold on, sir. 30 minutes. We'll. Dhyanchinaba, sir. Only.
Well, I'm
Oh,
here, Manoj.
sorry, yes,
Yes.
yes. I didn't see you here, so.
Yes, Manoj, I'm sorry, Manoj. Manoj, I was
No
waiting to
problem, no
have it.
problem.
I'm not there, sorry.
So we'll conclude this today.
Yes, please.
We'll conclude this today, sir.
Yes.
Yes. So half an hour's time, we'll get back. Submissions ಏನಿದೆ? All you're ready ಅಲ್ಲ? Nice.
He's finishing some other work and then take up.
Madam, pronouncement.
Announcement of order, list number 4, seal number 1, S.T. Rajendra Reddy.
Anticipatory bail. ಎಲ್ಲಿದ್ದೀರಾ ಈಗ? ಅಲ್ಲೇ ಇದ್ದೀರಾ? ಇನ್ನೂ ಅರೆಸ್ಟ್ ಮಾಡಿಲ್ವಾ? Huh? ಒಂದೇ ತಾನೇ ಇದೆ. Criminal petition is allowed. The impugned order dated 18/3/2026 passed by so and so stands quashed. The order dated 29/9/2025 granting anticipatory bail to the petitioner stands restored. Liberty is reserved to the respondent's prosecution of the state or the respondent to file application seeking cancellation of bail only if there is breach or violation of the conditions of bail order dated 29/9/2025 in its strict sense.
Serial number 2.
The writ petition is disposed. Respondent 1 and 2 are directed to carry out joint inspection of scheduled property to ascertain who is presently in possession of the property, bearing in mind the observations made in the course of the order. The said exercise shall be undertaken independently without being influenced by the observations made in the course of the order. In the event the petitioner is found to be in possession of the property, the acquisition notifications dated 25/3/92 and 96, where the scheduled land would stand lapsed in the light of the law as laid down by the apex court in the judgments quoted supra. The aforesaid joint inspection shall be carried out by the respondent 1 and 2 within a period of 8 weeks from the date of receipt of the copy of the order of due notice to the petitioner. Dharwad.
Dharwad bench pronouncement of order. Still number 3.
Allowed quashed.
Number 4.
Writ petitions 105,448 of 2019, 104,730 of 2018, and 111,440 of 2019 are allowed. Writ petition 107583 of 2018 is allowed in part. The impugned order dated 24/9/2018 passed by the government and the Department of Endowment, notifying the temple under section 23B of the Act and orders passed thereon by the Deputy Commissioner Koppal stands quashed. Writ petition 147680 is allowed in part. Now come to password count. List ಅಲ್ಲಿ
Password matter.
policy. Wait, sir. Yes. Electricity policy. Alla. Let it get dark. Oh, all right. Yes. 6 o'clock.
Still number 10.
List number 1. One ಅಲ್ಲಿ ಯಾವುದಿಲ್ಲ ಅಲ್ಲ 2 ಅಲ್ಲಿ ನಂದೆಲ್ಲೋ ನಿಮ್ಮ ಹತ್ರ ಬಂದಿದೆ ಲಿಸ್ಟ್ ಎಸ್ಕೇಪ್ ಕೊಡಿ. ನಾನೊಂದು ಬರ್ದು ಇಟ್ಕೊಂಡಿದ್ದೆ, ನಾನು ಲಿಸ್ಟ್ ಇತ್ತು ಇಲ್ಲಿ. ಸೀರಿಯಲ್ ನಂಬರ್ ಹೇಳಿ. ವಿನಾಯಕ್ ಏನ್ ಮಾಡಿದ್ರು ಅವರು ಫಾರ್ ದ ಪಾಸ್ವರ್ಡ್? ನೆಕ್ಸ್ಟ್
63.
ಜಾರ್ ಗೋಲ್ಡ್.
Yes, ma'am.
Online. He was offline. Password? He's there. Short password. He'll come here or?
57.
Then Jagdish sir, we can hear it after vacation. So what? Jar gold. Huh? Yes, that will be released. Salary will be released.
The file give the details for
You
salary.
just give the details if they will release.
May I just see the password?
You want gold also to be released, then.
That's not gold, my lords. What happens, my lords, is when the customer
Hmm.
says he will sell the, they want money. If my account today is blocked, my lords, we are creating the very victims, my lords, the butts and the other acts intended to protect. In fact, the designated court finds that absolutely no victims are there till today.
What designated court finds? It's totally wrong. Designated court finds that there is confusion in my order.
But the investigation officer is confused. That is the
On.
very, so, confusion on the lord's order. That is the, that will be not the.
Yes, Prasanna Kumar sir. The case has a legal glitch. This has a technical glitch. Yeah, nothing will happen. Password. Ask him to come to a different location.
67. 67.
ಬೆಳಗ್ಗೆ ಇರಲಿಲ್ಲ.
Vehicle. Release of the vehicle.
ಇದೆರಡು ರಿಲೀಸ್ 67, 65, 4 ಇದು ಮೇಡಮ್.
7 and 69.
67 and 69 ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ರಿ ಕೊನೆಗೆ ನೋಡೋಣ.
82.
ಸೆಟಲ್ಮೆಂಟ್ ಒಫೆನ್ಸ್
338.
ಮೈಕ್ ಆನ್ ಆಗಿಲ್ವಾ? What have you what have you paid now? That's settled? Yes, Jagdish, you close it. Oh, ಬಂದಿದ್ದೀರಲ್ಲ. Parties are there? All right. Close ma'am. Next.
Order sheet signatures. $100.
Latif. Jagdish, murder. ಎಲ್ಲ ಈಗೆಲ್ಲ ಸರಿಯಾಗಿ ಬರೆಯಕ್ಕೆ ಟೈಮ್ ಇಲ್ಲ ತಾಳಿ. ಸ್ಟೇ ಮಾಡ್ರಣ್ಣ ಸದ್ಯಕ್ಕೆ.
The justification is that instigation to murder.
ಅದಕ್ಕೆ 103 ಎಲ್ಲಿ ಬರುತ್ತೆ? 103 is murder, sir. Instigation to murder ಎಲ್ಲಿ ಬಂತು? Anyway, we'll take care of this investigating officer after vacation. ಇಲ್ಲ ನಾಳೆ ಹಾಕ್ಲಾ?
After vacation.
Yes. List the matter on 5th. For further hearing, there shall be an interim order of stay of further proceedings, square the petitioners to the next date of hearing.
But I'm sorry, the previous matter not, the voice was not audible.
ಈಗ ಬಂತಲ್ಲ.
ಈಗ ಅದಕ್ಕೆ ಮತ್ತೆ ಲಾಗ್ ಔಟ್ ಆಗಲಾಗಿನ ಅದು.
Wait, ತಾಳಿ.
Please,
Yes.
I shall wait.
102.
Filed, charge sheet is filed. Then you will challenge the charge sheet. Heard the learned counsel, Srimati Kirti Reddy, appearing for the petitioner. The petitioner is accused number 4. A learned additional SPP on instructions and verification of the records. So would submit the charge sheet as filed. The learned counsel for the petitioner also would admit that charge sheet has been filed, including accused number 4. Even again.
They've shown as an absconding because they have not appeared. Your lordship had one sentence. That I believe, my lord, that anticipatory bail order was not available for them.
Correct. Maten.
Your lordships had one word, my lord.
ಇಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ನಂಬರ್ ಆಗಿದೆಯಾ?
228 of 26.
ನಂಬರ್ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. ಇಲ್ಲ ನಂಬರ್ ಆಗಿ ಬಿಡ್ತಾ ಇರಲಿಲ್ಲ.
ಅಲ್ಲ, your lordship give them protect them to appear before I want.
Yes, so charge sheet is found, so including the accused number 4. While filing the charge sheet, the accused number 4 is said to have shown as absconding. The petitioners were not aware, the petitioner accused number 4 was not aware of the anticipatory conditions ordained in the order of anticipatory bail, and therefore had not appeared before the concerned investigating officer. Therefore, the petitioner shall now appear before the concerned investigating officer within
Week.
Huh?
1 week.
1 week ಬೇಡ ಜಾಸ್ತಿ ಆಗಲಿ.
ಬೇಗ ಮುಗಿಯುತ್ತೆ ಅಂತ ಅಷ್ಟೇ.
Within ಮುಂಚೆ 4 weeks ತಾನೇ ಕೊಟ್ಟಿದ್ದು. Within 4 weeks from today, from the date of receipt of the copy of the order. Insofar as the charge sheet is concerned, liberty is reserved to the petitioner to call in question the registration of the charge sheet, filing of the charge sheet against the petitioner hyphen accused number 4 as well. Yes, so that you won't be arrested now. Yes. No, ordered accordingly.
137, 136.
ಮೈಕ್ ಆನ್ ಮಾಡಿ.
ಆನ್ ಮಾಡಿ ಸರ್.
My lordship, EC Act, section 11 is mandatory to file the private complaint before the concerned magistrate. But concerned authorities file the complaint before the police. It's invalid. Page number 21.
No, that we have invoked 420. No problem for investigating this matter. Only at the time of filing a charge. Recently, my lord, the Supreme Court clarified this issue and said that the prohibition is only at the time of taking cognizance, not for investigation.
No. The complaint itself cannot be filed.
No,
that cuts at the root of the matter.
No. It's the at the time of taking cognizance, after investigation, we will file a complaint.
No, where does the investigation spring from? A faulty complaint that is registered? Complaint itself could not have been done. Where is the question of investigation?
420 is invoked.
420 is invoked. That should have been before as a complaint itself, not before the jurisdictional police.
No. Supreme Court, my lord, while interpreting 195.
195 ಬೇರೆ.
195 CRPC is interpreting 195
CRPC. That's different.
Supreme Court said that there is no restriction for investigation even where complaint has to be filed by authorized person before the magistrate. That is only for magistrate. Recent Supreme Court judge dealt with this issue extensively.
Magistrate ಮುಂದೆ police ನವರು ಮುಂದೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು.
ಅದನ್ನೇ ಅವರು ಹೇಳಿ ಇಷ್ಟೊತ್ತು ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡಿದ್ದು ಅದನ್ನೇ. ಆಗತ್ತೆ ಅಂತ. Doubtful. We'll take it 5th, 4th or we'll take it on 10th. ಇದು ಎರಡು ಮಾದೇವ್ ನಿಮ್ದು ಎರಡಲ್ಲ?
ಎರಡನೇದು
ಬೇರೆನಾ?
ಬೇರೆದು your lordship may see, may request your lordship to page number.
ಇದು ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಇದು?
ಫಸ್ಟ್
137 second. First ಅಲ್ಲಿ 136 ಅಲ್ಲಿ list the matter on 10th. Further proceedings shall remain stayed. Further investigation shall remain stayed till the next date.
Next matter forest offense. All license ಇದೆ FIR ಹಾಕದ ಫೋನ್ ಮಾಡಿದ್ರೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಡ್ಲಿಲ್ಲ. All document issued by the forest officials.
ನೀವ್ ಯಾಕೆ ಮೈಕ್ ತಳ್ತಾ ಇದ್ದೀರಾ ಅವಾಗಿಂದ ಆ ಕಡೆ?
My lordship, at the time of registration of the case, the respondent police called the petitioner but not produce the documents. Documents ಕೊಟ್ಟಿರಂತೆ FIR, all the documents produced. In page number 2, forest official issue the NOC. All the document license concerned Gram Panchayat. Small industry.
ಏನ್ ನಡೆಸ್ತಾ ಇದ್ದೀರಾ?
Small scale industry.
Small scale industry.
ಮರದ ಕಟ್ ಪೀಸ್
ಕಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಸಿಲ್ವರ್ ಪೀಸ್ ಅಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ.
May request your lordship to page 25. May request your lordship.
ಬೇಕಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿರೋದು ಅವರು. ಲೈಸೆನ್ಸ್ ಬೇಕಾಗಿಲ್ಲ.
ಅದೇ ತೋರಿಸ್ತೀನಿ ಸರ್.
Page
25 annexure F. Your lordship may see the date, 31/3/2012.
12
ಲೈಸೆನ್ಸ್ ಅವಾಗಿಂದ?
No. Your lordship may see inside that ನಿರೀಕ್ಷಣಾ ಪತ್ರ reference is 25/2013. A letter dated
ಆದೇಶ ನಿಯಮ ಮತ್ತು ಸೆಕೆಂಡರಿ ವುಡ್ ಇಂಡಸ್ಟ್ರೀಸ್
ಹೌದು
5 HP ಸಣ್ಣ ಕೈಗಾರಿಕೆ ಪರವಾನಿಗೆ ಬೇಕಾಗುವುದಿಲ್ಲ ಎಂಬುದಾಗಿ ನಿರೀಕ್ಷಣಾ ಪತ್ರ ನೀಡಿದೆ.
NOC ಅವರೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, the letter dated
ಇಲ್ಲ 31/3/2012ಕ್ಕೆ ಒಂದು ವರ್ಷ ಮುಂದೆ ಬರೋದು ಡೇಟ್ ಹಾಕ್ಬಿಟ್ಟು ಕೊಟ್ಬಿಟ್ಟಿದಾರಲ್ಲ, ಏನಿದೆ?
ಗವರ್ನಮೆಂಟ್ ವಿಲ್ ಬಿ ಇಶ್ಯೂ.
ಫೋರ್ಜರಿ ಇದು.
ಫೋರ್ಜರಿ
ಡೌಟೇ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಎಂಕ್ವೈರಿ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
ಮಾಡ್ತಾರೆ, ಅಲ್ಲಿವರೆಗೆ ನಿಮ್ಗೇನ್ ಬಿಡಲ್ಲ.
ಇದು ನೋಡಿ, ಲೈಸೆನ್ಸ್ ಇಶ್ಯೂಡ್ ಬೈ ದ ಗ್ರಾಮ ಪಂಚಾಯತ್ 13ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
List the matter on 10th June. The learned additional SPP to secure instructions as to how the document dated 31 document rendered to the petitioner on 31/3/2012 is on a notification dated 20th May 2013.
Yes, our department will be issued.
Nostradamus.
And the notification, my lord, is exemption up to 5 HP motors. And that too because beyond 10 kilometers.
Yes.
He's less than 10 kilometers.
No stay in this, yes. ಇದು ಯಾರು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಲ್ಪ
I
ಗೊತ್ತಾಗ್ತದೆ.
will get it.
RFI will be issued, ಅಲ್ಲೇ ಇದೆ.
ಕರೆಕ್ಟ್ ಅದು.
RFI will be issued. 5 HP ಬೇಕಾಗಿ license is not required. Notification is there.
ಆಯ್ತು ನೋಡೋಣ. ನೆಕ್ಸ್ಟ್. ವಿನಾಯಕ್ ಏನ್ ಮಾಡಿದ್ರಿ?
That is sir, in the meantime move the vacation court.
ಯಾಕೆ ಸರ್?
Urgent ಇದೆ.
ಅಲ್ಲೇನ್ ಬಂದಿರಲ್ಲ ಇನ್ಫಾರ್ಮೇಶನ್ ಸಾಕು ಸುಮ್ನೆ ಇರಿ. ಎಸ್. ಏನ್ ಮಾಡಿದ್ರಿ ವಿನಾಯಕ್? ಕ್ಯಾನ್ಸರ್ ಪೇಷಂಟ್ ಏನ್ ಮಾಡಿದ್ರಿ?
My instructions are that cancer patient is not at all part of the PCR as well as complaint.
ಅಲ್ಲಿ ಈ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಪ್ಪ.
How complaint allu illa. My lords, in fact, after my lordships directed, we voluntarily, though she was not there in that, we sent her a notice seeking that you come down, we'll sit together, we'll settle. And she has come, she has spoken. Now at this juncture, my lords, they are taking that stand.
ಆಯ್ತು ಬಿಡಿ, ಅವ್ರಿಗೇನ್ ಕೊಡೋದಿದೆ ಕೊಟ್ಬಿಡಿ.
ಅದು ಕೊಡ್ತೀನಿ.
ಆನಂದ್ಗೆ ಏನಿದೆ ಕೊಟ್ಬಿಡಿ. ಅವ್ರು ಬಂದ್ಮೇಲೆ ನೋಡೋಣ ಆಮೇಲೆ.
My lords, in the meantime, if limited protection that no coercive action against me would be grateful because.
ಯಾವ ಕೋರ್ಸಿವ್ ಆಕ್ಷನ್ ಯಾರು ತಗೊಂತಾ ಇದ್ದಾರೆ?
ACP concerned, my lords, Buds Act ಇದೆ ಅದಕ್ಕೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು my lords, we have recorded our statement before him also.
In the Buds Act, we need not go only into the complaint filed by the complainant.
No, Buds Act ಯಾರು ಬೇಕಾಗುತ್ತೆ? Any investor.
Victims has to be there and.
Any investor, ಅದು ಕಂಪ್ಲೇಂಟ್ ಇದ್ರೆ ಮಾತ್ರ ಇಲ್ಲ.
In so far as me, I have complied with all the requisites, my lords. I may be.
We'll see, wait.
My learned friend need not go into technicality whether they filed a complaint.
I'm not going.
They have deposited the money and then you should
I'm in the right spirit that my lordships had, my lords, taken the view. My lords, it is very much clear. Only thing is that he is batting for the ones who are not at all concerned to this.
Don't worry about the game.
Please.
Now you pay. A cancer patient ಯಾರಿದಾರೆ ಅವರು ಫಸ್ಟ್ ಕೊಟ್ಬಿಡಿ, ಅವರು ದುಡ್ಡು ಬೇಕಾಗಿರೋದು.
ಅಲ್ಲ, he is, if he is asking for the complainant, now the one who is not there inside the complaint
You
itself.
forget it, sir. ಕಂಪ್ಲೇಂಟ್ ಹೌದು ಅಲ್ವೋ, ಕ್ಯಾನ್ಸರ್ ಪೇಷಂಟ್ ಯಾರಿದಾರೆ ಅವ್ರಿಗೆ ಫಸ್ಟ್ ಕೊಟ್ಬಿಡಿ.
We don't know when she paid, how much she paid, how much we have to pay.
Information ಅವರೇ ಕೊಡ್ತಾ ಇದ್ರಲ್ಲ, ಕೊಡಿ.
ಅವ್ರು ಕೊಟ್ಟಿದ್ದ information is not at all sufficient. What one line, one page he has prepared is not at all disclosing that what is the amount.
ನಿಮ್ಮ ಹತ್ರ ಗೊತ್ತಿಲ್ವಾ ಯಾರ್ಯಾರು ಇನ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ?
ನಮ್ಮ ಹತ್ರ ಇದ್ದಿದ್ದು my lords.
ಅಂದ್ರೆ ಅಷ್ಟೊಂದು ಜನ ಹತ್ರ ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡು ಅಷ್ಟೇನಾ?
ಅಲ್ಲ, my lords, I may be permitted to submit this in ನಿಶ್ಚಯ
ದೀಪಂ ಸಿಲ್ಕ್ಸ್ ಈ ಸ್ಥಿತಿಗೆ ಯಾಕೆ ಬಂತು?
ಇಲ್ಲ ಬಂದಿದೆ. My lords, my only respectful submission is this, that if at all he is pursuing the criminal complaint, my lords, I would stick to the, my lords, basics that he should sue only for him. My lords, the unparticularized items.
He will pursue it for him, it's a different thing. But if there is a cancer patient in that investment, first give the money, release the money to them. If you are not understanding, then I will no protective order I will grant. This is not correct.
My lords, in the right
ಎಲ್ಲ
spirit, my
ದುಡ್ಡು
lords,
ರೈಟ್ ಸ್ಪಿರಿಟ್, ನೀವು ರಾಂಗ್ ಸ್ಪಿರಿಟ್ ಅಲ್ಲಿ ಹೋದ್ರೂ ಆಗಲ್ಲ ಅವೆಲ್ಲ.
ಅಲ್ಲ, ಅವರು ಯಾರ ಹೆಸರು
ಅವ್ರು ಏನಾದ್ರು ಬಿಡಿ ಸರ್.
My lords,
If there is a cancer patient, first clear that amount.
and what he says is on the pro note that I have to pay. What is that pro note? He has not produced in the complaint in PCR court also and today here also. That is
Sorry,
what is my difficulty, my lord.
No
Even if I am ready to pay, how I will be able to pay? That is the difficulty, my lords.
Anyway, you have decided not to pay. I have decided not to give you interim order. Yes.
My lords, my lords, whatever my lordships had, my lords, in the meantime, my lords,
ಆಯ್ತು, ಅವ್ರದ್ದು ಏನಿದೆ ಕೊಟ್ಬಿಡಿ.
ಅವ್ರು ಕೊಡ್ತೀನಿ.
ಅವ್ರದ್ದು ಪೂರ್ತಿ ಕೊಡಿ. ಅವ್ರಿಲ್ಲ ಈಗ, ಯಾರಿಗೆ ಕೊಡ್ತೀರಾ? ಇರಿ. Yes.
ಸಾರಿ my lords. ಇಶ್ಯೂ ಮಾಡೋದು ನಮ್ಗೆ 23/5/19 ಸರ್. 23/5/19.
ಸ್ವಾಮಿ, ಅದು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಕೊಟ್ಟಿರೋದು 19
ಅಲ್ಲ 12 ನಾವು
12 ಅಲ್ಲ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ 19 ಅದು.
19 ಇಸ್ವಿ ಆಗಿರೋದು.
ಅದು ನೋಡೇ ಮಾಡಿದ್ ನಾನು. ಅದು ನೋಡ್ಲಿಲ್ವಾ ನಾನು? ಎಸ್. ಇದು ಅಡ್ಮಿಷನ್ ಮುಗಿಸ್ಕೊಂಡು ಕರೆದು ಬೇಡ.
Admission 143.
After vacation.
144.
Same. ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡರ್ಸ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ. ಎಸ್.
ಸೆಟ್ಲ್ ಆಗಿದೆ ಸರ್.
ಯಾವುದು?
140.
ಯಾರು ಇದಾರೆ ಪಾರ್ಟೀಸ್?
ಇದು ಸೆಟಲ್ಮೆಂಟ್ ರಿಪೋರ್ಟ್ ಇದೆ.
ಏನಿದು ಒಫೆನ್ಸ್ ಏನು?
490.
ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
ಫ್ಯಾಮಿಲಿ.
ಹಾ, ಕೊಡಿ. 143 ಶಿವರಾಮ್ ಅವ್ರ ಸೆಟ್ಲ್ ಆಗಿದ್ಯಾ? ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ? 140. ಹಾ, ಬನ್ನಿ. 143 ಆಫ್ಟರ್ ವೆಕೇಶನ್. ಎಸ್.
144 ಕೌಂಟರ್ ಎಫ್ಐಆರ್ ಇದೆ ಸ್ವಾಮಿ, ಸಿವಿಲ್ ನೇಚರ್.
ಏನ್ ಸೆಟ್ಲ್ ಆಗಿದೆ? ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
145 Swami.
ಅಯ್ಯೋ
144 settle actually. Family code.
ಕೊಡಿ sir.
Family.
140? 144 settled. ಪರವಾಗಿಲ್ಲ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಆಗಿದ್ರೆ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಡಿ. ಎಸ್ 145
ಇದು ಕೂಡ
ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ
ಇಲ್ಲ ಸರ್.
ಆಫ್ಟರ್ ವೆಕೇಶನ್?
ಸ್ವಾಮಿ ಇದು ಒಂದು ಸಬ್ಮಿಷನ್ ಇದೆ.
ಏನು ಸ್ವಾಮಿ?
ಇದ್ರಲ್ಲಿ ಏನಂದ್ರೆ ಲಾಸ್ಟ್ 30 years ಇಂದ ಇದು ಅಣ್ಣ ತಮ್ಮನಿ ಕಂಪ್ಲೇಂಟ್ ನಾವು 482 ಬಂದಿದ್ವಿ ಕೋರ್ಟ್
482 ಬಂದಿದ್ರಾ?
ಲಾಸ್ಟ್ ವೆಕೇಶನ್ ಬಂದಿದ್ವಿ. ಅವಾಗ ಅವ್ರು ಬಂದು ಕೌಂಟರ್ ನಮ್ದು 86 FIR ಅವ್ರು 88 ಅಲ್ಲಿ ಬಂದು ಸ್ಟೇ ತಗೊಂಡು ಹೋದ್ರು.
ಅದೆಲ್ಲಿದೆ? ಯಾವ್ದದು
ಇದೆ
ನಂಬರ್ ಕೊಡಿ. ಪೇಜ್ ಎಲ್ಲ ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ? ನೀವಿದ್ದೀರಾ? 88 ನಿಮ್ದೇನಾ?
88
ಸ್ಟೇ ಆಗಿದೆಯಾ? ಸೇಮ್ ಆರ್ಡರ್. ಎಸ್
146.
There's a stay in the matter.
AVIO after vacation.
Date may be fixed, please.
Immediately after vacation.
147 interim order.
AVIO.
148 settlement.
148 and 149
Settlement.
settled.
ಎಲ್ಲಿ? Offense ಏನು?
Offense is 115 cross 2, 118 cross 1.
ಕೊಡಿ. ಇಲ್ಲಿದಾರಾ?
Either parties are there.
Settlement. Respondent?
In civil matter also it is settled.
Correspondent number 2, please. Complaint is present.
ಆಯ್ತು ಕೊಡಿ ಎಲ್ಲ.
2 offenses,
All right,
118
yes.
being
Next.
on compound offense application is a file.
Next.
149, 149 also.
Madam?
49 also.
149 also.
149.
Same.
Please.
Let serial number 230 is also settled.
ಇದು ಕನೆಕ್ಟೆಡ್?
It is not connected.
ಬರ್ತಾ ಇದ್ದೀನಿ ತಾಳಿ ಸರ್.
150.
Petitioner, please. This matter, there's no stay. It's a DV matter which is challenged. There's a delay in filing of the petition. However, my lords, the 498A stayed by my lords. The order is also annexed. Same, the complaint and the petition are one and the same. The order is also annexed, my lords, at page number 53. And page number 57. The 498A proceedings have been stayed. This is a domestic violence petition that has been filed by the wife.
Husband, no.
Well, the husband has also been stayed by my lords. The order is also annexed.
My order.
Please.
Where is
page
the
number
rest?
53 and page number 57, two separate petitions were filed. Page number 57 is the husband's petition, please.
Same order in the meantime. Next. ಬಟ್ ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಆಗಲ್ಲ, ಅದಾಗಿದ್ರೆ ಪರವಾಗಿಲ್ಲ. ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಹಸ್ಬೆಂಡ್ ಮೇಲೆ ಇನ್ ಯಾರ ಮೇಲೆ ಇರಕ್ಕಾಗತ್ತೆ?
It's also against the parents, my lords.
ಇನ್ಲಾಸ್ ಐ ವಿಲ್ ಸ್ಟೇ. ಇದರಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರೆ serial number 150 ಅಲ್ಲಿ ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ವಿತ್ ಪೇಜ್ ಏನದು?
53 and 57.
Tag along with that, there shall be an interim order of stay insofar as petitioners 2, 3 and
4.
2, 3 and 4. Insofar as the first petitioner is concerned, we considered on the appearance on the next date of hearing. Yes.
151.
138 positive marks. 391 application has been rejected by the
Appeal alli.
appellate court. Apply now. The exhibit P13
ಈಗೇನ್ ಮುಗ್ದೋಗಿರುತ್ತೆ ಅಪೀಲ್?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಇದು 65 ಪೆಂಡಿಂಗ್ ಇದೆ ಸರ್.
ಪರವಾಗಿಲ್ಲ. ಎಸ್. Petitioner to serve on the counsel who represents the respondent in the appeal proceedings. List immediately after vacation. Next.
152.
Petitioner, party shoot pending and partition of 341, 504, 506 male.
341 na?
341. Is position me man. Now a position.
ಏನ್ ಪ್ರೊಫೆಷನ್?
Position.
ಪೊಸೆಷನ್ ಯಾರಿದ್ದಾರೆ?
ನಾವೇ ಇದೆ.
341 ಗೂ ಪೊಸೆಷನ್ ಗೂ ಏನ್ ಸಂಬಂಧ?
ಅಲ್ಲ, ನಾವು ಟ್ರೆಸ್ಪಾಸ್ ಮಾಡಿದೀವಿ ಅಂತ ಅಲಿಗೇಷನ್.
341 ಅಲ್ಲ, ಅದು 447.
504 and 506.
Wound certificate ಇದೆ. Wound certificate ಇದೆ.
Simple in nature, Malash.
Simple in nature. Yes.
Building.
ಕೈಗಳಿಗೆ ಹೊಡೆದು ಮೂಗೇಟು ಮಾಡಿದ್ದಾರೆ. ಯಾಕೆ ಹೊಡೆದ್ರಿ?
ಇಲ್ಲ some civil dispute Malaysia.
ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಹೊಡಿಬೇಕು ಅಂತಿದ್ಯಾ? Meantime, yes, in the meantime, next.
My lords, in this case, the DV Act proceedings, my lords, 498A is not filed. And also, it's because of the properties are in question. The sale, the gift deed was in question because I got a stay order. They admit that they from 2024 they're living separately, my lords. There were no contact at all for a long period of time. After I obtained a status quo order, my lords.
Mic off ಮಾಡ್ಬಿಡಿ.
Hello, my lords. After I obtained a status quo order on the property, then there comes a domestic violence. Till then, there was no complaint, there was no FIR, not even a single case was filed. Now the claim is that ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅದನ್ನ ನನ್ನ ಹೆಸರು ಗಿಫ್ಟ್ ಡೀಡ್ ಮಾಡಿ ಈಗ 75 lakhs plus 6 lakhs ಅವ್ರ ಅಕೌಂಟ್ ಕಳಿಸಿ ಆಮೇಲೆ ಬರ್ತೀನಿ ಅಂದ್ರು ಮನೆಗೆ
ಎಲ್ಲಿಗೆ
ವಾಪಸ್ ರಿಟರ್ನ್ ಆಗ್ತೀನಿ ಅಂದ್ರು 75 plus 6 lakhs ಎಲ್ಲ ಅಕೌಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್
ರಿಟರ್ನ್ ಆಗ್ಲೇ ಇಲ್ವಾ
ನಾವು ಇದು ಡಿಮ್ಯಾಂಡ್ ಇಸ್ ದಟ್ ಒನ್ ಮೋರ್ ಪ್ರಾಪರ್ಟಿ ಇದೆ ನಂಗೆ ನನ್ನ ಹೆಸರಲ್ಲಿ ಗಿಫ್ಟ್ ಡೀಡ್ ಮಾಡ್ಕೊಡಿ ಆಲ್ ನೋ ಪ್ರಾಪರ್ಟೀಸ್ ಆರ್ ಇನ್ ಗಿಫ್ಟ್ ಡೀಡ್ ಈಗ ಆ ಡಿಮ್ಯಾಂಡ್ ಫುಲ್ಫಿಲ್ ಮಾಡದಿರೋದಕ್ಕೆ ಡೊಮೆಸ್ಟಿಕ್ ವೈಲೆನ್ಸ್ ಕೇಸ್ ಕಮ್ಸ್ ಇನ್ ಟು ದ ಪ್ಲೇ ಮೈ ಲಾರ್ಡ್ಸ್ they are all the residents of Chandigarh. If she was really aggrieved back in those days, she had to file one complaint, not even a single case. We had also filed a pre-litigation conciliation before the Punjab High Court, my lords.
ನೀವು 2 days ಮುಂಚೆ ಇದನ್ನೇ ಆರ್ಗ್ಯೂ ಮಾಡಿದೀರಾ ಸ್ವಲ್ಪ ಇರಿ
I would like to
like to what sir
file 2 documents, my lords.
ಕೊಡಿ heard the learned counsel appearing for the petitioner and the respondent.
Stay may not be granted, my lords. May kindly look at the documents, my lords.
No, may not be illa. I am granting stay. You file vacating stay, no problem.
My lords,
There should be some limit to misuse.
my lords, we have not.
You should file everything in Chandigarh. Why did you come here and file?
My lords, I am residing here. They tried to choke me, my lords.
Choke you?
Yes, my lords.
Not even a single complaint.
Where?
My
Where?
lords,
In
in Chandigarh, it's. My lords, in Chandigarh, it's.
Chandigarh, they tried to choke you.
Yes, my lords.
Why did you come to Bangalore to register a crime?
My brother is residing here. My mother is residing.
So the
here.
choke, effect of choke did not come there, is it? Bangalore orgo it traveled.
Just to try to save myself, I came
That's,
back to
sir,
Bangalore.
what do you mean? Yes, we'll hear it anyway.
My lords, transferring the amount from the joint account which is there in the name of the wife also, my lords.
No, that they will not do.
My lords, joint account, one
That
clarification.
you
my lords.
don't
My lords, one
frustrate and don't
clarification.
empty the coffers.
That's a salary account of mine, my lords.
Oh, that's all right, no problem. You don't need. No, sir.
My lords, they are
They
deliberately
list the matter on 10th June. 498 proceedings are stayed.
No, my lords, there is no 498 proceedings at all, my lords.
The petitioner is said to be, the petitioner and the respondent are husband and wife.
My lords, just one submission, if your lordship may permit, I would like to make. My lords, they are questioning the jurisdiction that I am not residing here. My lords, I have filed the documents.
We'll see, we'll consider it. The petitioner is before the court calling in question the institution of the proceedings invoking section 12 of the domestic the respondent wife was choked in Chandigarh but did not register a crime there, came down to Bangalore because her brother is residing here and then decided to register the crime. The petitioner has a different story altogether. When in property dispute,
My lords, now gift deed with the certain properties of my parents who was transferred to me, I have
the
transferred
learned
the
counsel for
certain
the
properties
petitioner.
into her name.
Wait, sir. Interim order, wait. The counsel for the petitioner has a different story to narrate. That the moment all financial transactions froze between the two, it is then the complainant did not register any complaint before the jurisdiction at Chandigarh, but comes down to Bangalore and registers the crime. The matter would require consideration qua the jurisdiction or otherwise. Therefore, there shall be an interim order of stay of further proceedings before the court, in the impugned proceedings till the next date of hearing. List the matter on 10th March. The learned counsel for the respondent submits that if an interim order of stay is granted, all the amount in the account, joint account of both the husband and the wife would be taken away. Therefore, the husband shall not utilize the amount that is there in the account, particularly in the joint account between the two, till the next date of hearing. Yes, next.
Much obliged, my
My
lords.
lords, there is a connected matter in which we have filed vacating IM.
My lords,
Which is that, sir?
that is in respect to in-laws, my lords. It has already been stayed.
Which number, sir?
131.1.
Alleged offence under 323, 324, 504, 506. Admittedly, there is a civil dispute pending between the parties from the year 2024. My lord. The crime is of the year 2025.
324 ಇದೆ.
Own certificate, my lord. May kindly find it
ಎಲ್ಲಿದೆ?
page number 42, my lord.
Page
42, my lord. 42 and 44, my lord.
aberration, tenderness, aberration. ಇದು 323, not 24.
Chest ಕೊಡಿದೆ.
Lady, huh?
Chest ಕೊಡಿದೆ.
Even a lady is there. Allegation of assault on the chest is towards the uncle of the petitioner.
63 years. There shall be an interim order of stay, quae, accused number 2 only till the next date of hearing. Yes, next.
Please.
AVIO.
Petitioner, my lord.
After vacation, interim order continues.
Interim order may kindly wait.
157.
For the petitioner, this case will 156.
156 ಆಯ್ತು after vacation. ನೀವು ರೆಸ್ಪಾಂಡೆಂಟ್ ಹಸ್ಬೆಂಡ್ಗೂ ಆಗೋಗ್ಬಿಟ್ಟಿದ್ಯಾ? ಯಾರು ಅವರು? 156 ಆಫ್ಟರ್ HC ಶಿವರಾಮ್ದ. ಇದು ಹಸ್ಬೆಂಡ್ಗೂ ಸ್ಟೇ ಆಗಿದೆಯಲ್ಲ, ಹೆಂಗೆ?
Husband, my lord, is a government doctor, my lord, working.
ಗವರ್ಮೆಂಟ್ ಅವ್ರು ಸ್ಟೇ ಕೊಡ್ಬೇಕು ಅಂತಿದ್ಯಾ?
That is not the case, my lord. After giving a notice, my lord, she files a
ಬೇರೆ
complaint.
ಸರ್, ಒಂದ್ ನಿಮಿಷ, ಅವ್ರದ್ದು ಕೇಸು.
My lord, I was appointed as a government doctor, your lordship, at the Uchangi village, Sakleshpura Taluk, which is a remote village, my lord, where she did not wish to leave, my lord. She left the matrimonial home within a month, my lordship. Then, my lord, I gave a notice to her, come and stay with me. Thereafterwards, she is the daughter of DYSP, my lord, and she lodges a complaint
ಓ,
subsequently.
ಇದು ನವಾಜ್ ಸಾಹೇಬ್ರ ಸ್ಟೇ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗ್ಲೇಬೇಕು.
Yes.
Yes, next.
157.
After vacation, yes.
58.
157, my lord, 157.
ಏನು ಸರ್? ಹಾ,
Sorry.
ಇಂಟರ್ ಮಾಡ್ರಿ ಇದೆಯಾ ಸರ್?
ಇಲ್ಲ ಇಲ್ಲ. 108 ಇದು ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿದ್ರೆ, in 2019 a check bounce case was filed against the deceased. In 2025 he makes a video on his phone. He says that it is because of the petitioners he committed suicide.
What is the date of filing of the case, check bounce case?
2019 law.
ಅರೆ ಡೇಟ್ ಹೇಳಿ ಸರ್, ಇಯರ್ ಅಲ್ಲ.
Date was 17/1/2019.
17/1/2019. Date of death.
Date of death is 18/9/2025.
Date of death 18/9/2025.
Right. And not in page number 72.
ವಿಡಿಯೋ ಮಾಡಿದ್ಯಾ ಯಾವಾಗ?
On the day he passed.
All right. ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ?
What he says is this. Main reason
Admission
for my
ನಾನು ಯಾವುದು ಓದಿಲ್ಲ, ನೀವೇ ಹೇಳ್ಬೇಕು.
The reason for my suicide is Jairam Reddy and his son Pratap Reddy. Because of them, I lost my entire life. Please don't leave them. They will try to create problems to my mom and sister. When what they already did, please do support my mom and sister. Kindly find the death note video in the phone album. That is what. Lord, in
ಹೇಗಾಗಿದ್ರು ಅಂತ.
Also, the accused one is absconding, my lord, till date. I am for respondent to complainant.
enlarge on bail, my lord.
Accused 2 has procured bail, accused 1 is still absconding.
Where are you absconding, sir?
No, my lord, they are saying the same place.
Same place.
ಕೋಲಾರ ಮನ್ಲೆ ಇದ್ದಾರೆ.
ಕೋಲಾರ ಮನ್ಲೆ ಇದ್ದಾರೆ.
ಕೋಲಾರಲ್ಲಿ ಅವ್ರು they are still living in their own house.
ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಬೇಲ್ ತಗೊಂಡಿದ್ದೀವಿ.
ಮತ್ತೆ ಯಾಕೆ?
ಅಲ್ಲ ಇಲ್ಲಿ
We will see, my lord, anyway. Then bail, nothing will happen.
If it's 138, nothing.
138 was pending against him. It is not that it's been disposed of.
My lord, ಅಲ್ಲಿ even the cross examination of the deceased also was done. Next date of hearing ಅಲ್ಲಿ he passed away.
The petitioners are accused 1 and 2. Stand at the doors of this court calling in question registration of 108 or 306.
108.
Registration of a crime for offence punishable under section 108 of the BNS/306 of the IPC. The learned counsel for the petitioner submits that the deceased recorded a video on his phone, which is now construed to be a death note, and the petitioners are dragged into the web of crime. The complaint clearly indicates that the complainant, Satid yaru?
Accused.
Satid yaru, sir.
Accused in the
complainants ge relation ಏನು?
Maga sir, Maga son.
The complainant's son commits suicide. ಓದ್ಕೊಂಡು ಬರಲ್ಲ.
ಓದ್ಕೊಂಡು
Yes sir. The complainant's son commits suicide. The backdrop of the suicide is institution of the proceedings under section 138 of the Negotiable Instruments Act. The complainant is cross-examined by the petitioners in the said proceeding. The next day he commits suicide.
A month later.
A month later he commits next day month later he commits suicide. In the light of the said, if the dates and events are noticed, goading, instigation or proximity to the death cannot be established prima facie against these petitioners. In that light, further proceedings shall remain stayed till the next date of hearing. List the matter on 18th June. The 17th June. Next. Next.
58.
After vacation, yes.
159.
Chetan.
In this case, a for petitioners, my lordship. Case and counter case, my lordship.
After vacation.
A date may be. Stay agila in notice.
Stay agila alla.
In agila. Date may be fresh.
10th, ಯಾವ ವರ್ಷದ 25 9th June, yes. 9 June.
Fresh matter.
9 June, yes.
160.
AVIO, next.
61.
AVIO.
In this matter.
After vacation ಕೇಳೋಣ. ಈಗ ಎಲ್ಲಿ ಕೇಳೋದು?
ಅಲ್ಲ, ಸೆಟಲ್ಮೆಂಟ್ ಆಗೋಗಿದೆ.
ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದ್ರೆ ಕೊಡಿ.
No, your lordship, ಈಗ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದಾರೆ. ಅಲ್ಲಿ there are some mistakes are there. ಇಲ್ಲಿ ಕ್ವಾಶ್ ಮಾಡಬೇಕು, ಚಾರ್ಜ್ ಶೀಟ್ ಕ್ವಾಶ್ ಮಾಡಬೇಕು. ಚಾರ್ಜ್ ಶೀಟ್ ಕ್ವಾಶ್ ಮಾಡಿದ್ರೆ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅದು ಸಪರೇಟ್ ಡೈವರ್ಸ್ ಮಾಡ್ತಿರೋದು. ಇಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಸುಮಾರು ಅಲಿಗೇಷನ್ಸ್ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ.
ಅದು ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆದ್ರೆ ಇಲ್ಲಿ ಕ್ವಾಶ್ ಮಾಡ್ತಿರೋದೆ.
ಅನ್ನ ಸೆಟ್ಲ್ ಆಗಿಲ್ಲ, ಅದು ಸೆಟ್ಲ್ ಆಗ್ಬಿಟ್ಟು ಬಗ್ಗೆ ಕ್ವಾಶ್ ಮಾಡಲಿ.
ಆಗ್ತಿಲ್ಲ. Let me make Leonard friend, let him not get offended. Petitioner is none other than an advocate. He had approached me to see that the things work out in his favor. Then the lady came. Then I said, what to do about it? He said, let us get it divorced. I said, do it. Then now she agreed for the mutual consent. Mutual consent ಆಗಿ agreement sign ಮಾಡಿದ್ದಾರೆ.
ಎಲ್ಲಿದೆ?
ಇಲ್ಲಿ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಒಂದು ನಿಮಿಷ ಅಗ್ರಿಮೆಂಟ್ ಅಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 9
ಏನು
ನನಗೆ ಗೊತ್ತಾಗಿಲ್ಲ.
ಯಾರು ಸೈನ್ ಮಾಡಿದ್ದಾರೆ?
ಇವರು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಸೈನ್ ಮಾಡಿದ್ದಾರೆ.
ಸೈನ್ ಮಾಡಿದ ಪೆಟಿಷನರ್ ಏನ್ ಅಡ್ವೊಕೇಟಾ?
ಅಡ್ವೊಕೇಟ್.
ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ವ ಏನು ಅಂತ?
ನಾನು ಹೇಳಿದೆ ಇದು
ಚೆನ್ನಾಗಿದೆ, ನಿಮಗ್ ಗೊತ್ತಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿ.
ಕೈಲಿ ಸೈ ಮೈ ಲಾರ್ಡ್.
Both the petitioner state that no other case pending against ಆಯ್ತು ಸರಿ.
ಅಲ್ಲ ಪ್ಯಾರಾ ನಂಬರ್ 9 the petitioner have agreed that their children have complete and absolute right over self-acquired properties of both petitioners. ಇಲ್ವೇ ಇಲ್ಲ ಅದು. ಇನ್ನೊಂದು
ಏನ್ ಪ್ರಾಪರ್ಟಿ ಇಲ್ವಾ?
ಏನ್ ಅಲ್ಲ, ಚಿಲ್ಡ್ರನ್ನೇ ಇಲ್ಲ, ಮಕ್ಕಳೇ ಇಲ್ಲ.
ಸರಿ ತೆಗೆದ್ಬಿಡೋಣ ಬಿಡಿ.
ಆಮೇಲೆ ಪ್ಯಾರಾ ನಂಬರ್ 6 in view of this settlement first petitioner have agreed to cooperate in closing and quashing the criminal case.
ಕರೆಕ್ಟ್, ಅದೇ ಹಂಗೆ ಇರ್ಬೇಕು.
ಅವ್ರು ಏನು ಸಿಗ್ನೇಚರ್ ಅಲ್ಲಿ ಮಾಡ್ಬೇಕಾದ್ರೆ they should have given consent, they will cooperate ಅಂತ ಇದೆ.
ಎಲ್ಲ ಹಂಗೆ ಇರೋದು. ನೀವು ನೋಡಿ DRT ಪ್ರೊಸೀಡಿಂಗ್ ಅಲ್ಲ ಇದು.
Make one submission. If they are not interested, let them not. I also withdrew from.
ಹಾಗಾದ್ರೆ ಇದು ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ ಬಿಡಿ, ಟ್ರಯಲ್ ಆಗ್ಲಿ.
My own colleague brother, they are
ಅಲ್ಲ ಪ್ರವೀಣ್ ಗೌಡ್ರೆ, ಟ್ರಯಲ್ ಆಗ್ಲಿ, ಡಿಸ್ಮಿಸ್ ಮಾಡೋಣ. ಸೆಟಲ್ಮೆಂಟ್ ಇಲ್ವಾ?
ಸೆಟಲ್ಮೆಂಟ್ ರೆಡಿ ಇದಾರೆ, ಬಟ್ ಇವೆರಡು ಪ್ಯಾರಾಗ್ರಾಫ್ ಇದೆ.
ಈ ಕೋಆಪರೇಷನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ಇರ್ಲೇಬೇಕು. ಅದ್ಯಾವ್ದೋ ಇದಿಲ್ಲ ಅಂದ್ರಲ್ಲ, ಈ ಪ್ಯಾರಾಗ್ರಾಫ್ ಬೇಕಾದ್ರೆ ತೆಗಿಯೋಣ.
9
I have also not seen it.
ಪ್ಯಾರಾಗ್ರಾಫ್ 9 ತೆಗಿಯೋಣ.
ಆಮೇಲೆ
ಯಾಕಂದ್ರೆ ಮಕ್ಳಿಲ್ವಲ್ಲ. ಮತ್ತೆ ಇನ್ನೇನು?
ಅದೇ ಕ್ವಾಶ್ ಆದ್ರೆ ನಮ್ಗೆ ಇಲ್ಲ ಸರ್, ಚಾರ್ಜ್ ಶೀಟ್
ಆಗೋದು ಮತ್ತೆ.
Yes. Squash ಆದ್ಮೇಲೆ now he says that after getting the copy of the order, ಸ್ಕ್ವಾಶ್ ಆಗಿರೋ ಆರ್ಡರ್ ಸಿಕ್ಕ ಆದ್ಮೇಲೆ ನಾನು ಬಂದು ಅಲ್ಲಿ ಸೈನ್ ಮಾಡ್ತೀನಿ ಅಂತಾರೆ. ಇರೋದಿಲ್ಲ.
I will record everything now. The petitioners are before the court so and so. The parties to the list are before the family court in MC 1790 of 2026. Where they have drawn certain terms of settlement and have agreed upon them. The terms of settlement so drawn reads as follows. Learned counsel M. A. Rajendra submits that clause 9 is erroneously included, as there is no there are no children born from the wedlock, and they have applied for divorce on mutual consent. In that light, the said clause stands deleted from the agreement. All other clauses remain intact. In the light of the clause which records cooperation for the purpose of closure of the present proceedings, the petition is, the settlement is accepted, crime quashed.
May I make one submission? If they fail to come and appear before the family court tomorrow,
The
then this-
learned counsel appearing for the respondent submits that if the petitioners would not come before the family court and cooperate for its closure, certain conditions must be imposed. Therefore, the petitioner shall cooperate with the closure of the proceedings before the concerned court, failing which the subject proceedings would stand revived.
Yes. Before Saturday.
ಅದು ಯಾವತ್ತಿದೆ ನೆಕ್ಸ್ಟ್?
ಇವತ್ತಿತ್ತು.
ಶನಿವಾರ ಹೋಗಿ
ಆಗ್ಬೋದು.
ನಾಳೆ ಶನಿವಾರ before
ಯಾಕಂದ್ರೆ ಅಕ್ಯೂಸ್ ಅವರ ಸರ್ಜನ್ಗೆಲ್ಲ ಪಾರ್ಟಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವರ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡಿ ಸರ್ಜನ್ಸ್.
ಈಗ ಕ್ಲೋಸ್ ಆಗ್ತಾ ಇದೆ ಅಂದ್ಮೇಲೆ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗ್ಬೇಕು. ನೀವು ಕ್ಲೋಸ್ ಆಗಕ್ ಬಿಡಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ?
ಇಲ್ಲ ಕ್ಲೋಸ್ ಆಗಿ
ಮತ್ತೆ
ಕ್ವಾಶ್ ಆದ್ರೆ
ಅದಾಯ್ತು, ಇಲ್ಲ ಆಯ್ತು ಬಿಡಿ, ಅಲ್ಲೂ ಹೋಗಿ ಕ್ಲೋಸ್ ಆಗ್ತಾನೆ, ಕ್ಲೋಸ್ ಆಗಿ ಬಿಡಿ. ಲಿಟಿಗೇಷನ್ ವೈ ಡು ಯು ವಾಂಟ್ ಟು ಕೀಪ್ ಇಟ್ ಅಲೈವ್?
ಪ್ಯಾರಾ ನಂಬರ್ 9 ಇಂದ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ.
ಈಗ ಹೇಳಿಲ್ವ ಪ್ರವೀಣ್ ಗೌಡ್ರು ಹೇಳಿಲ್ವ ಅಲ್ಲಿ ಪ್ಯಾರಾ ನಂಬರ್ 9 ನೋಡಿಲ್ಲ ಆಯ್ತು ಅಂತ? ಎಸ್
162
125 B.
after vacation.
163
For petitioner, my lord. Accused number 2 already granted stay, my lord.
Offense ಏನು?
Accused number 5. 395, my lord.
395?
Yes, ma'am.
ಡಕಾಟಿ ಸ್ಟೇ ಯಾರ್ದು? ಅಪಿಯರ್ ಆಗಿದ್ದೀರಾ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Bail move ಮಾಡಿದ್ದೇವೆ, my lord. Bail move ಮಾಡಿದ್ದೇವೆ already. Anticipated bail.
First appear before the court on the next date, ಆಮೇಲೆ
After date, my lord. Date, my lord.
164
after vacation you move, appear and move.
For the petitioner, your lordships. Initially, case was registered against petitioner and others for offence under section 78(3) of the Police Act, your lordships. And it is now, that case has been quashed, your lordships. Now the
ಈಗೇನು?
complaint is, allegation is that after registering the complaint, during the course of investigation, when they went to arrest the accused persons, around 20 to 30 persons obstructed their, from their duty.
ಅರೆಸ್ಟ್ ಯಾಕೆ ಮಾಡಕ್ ಬಂದ್ರು ನಿಮ್ನ?
ಅದು ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದಕ್ಕೆ.
ಯಾವ ಕೇಸ್?
ಪೊಲೀಸ್ ಆಕ್ಟ್ ಕೆಳಗೆ ಇಂಕ್ ಪೇಜ್.
ಪೊಲೀಸ್ ಆಕ್ಟ್ ಕೆಳಗೆ ಕ್ವಾಶ್ ಆಗಿದೆಯಲ್ಲ ಅದು?
ಅದು ಕ್ವಾಶ್ ಆಗಿದೆ.
ಅರೆಸ್ಟ್ ಮಾಡಕ್ಕೆ ಯಾಕೆ ಬರ್ತಾರೆ?
2021 ನಲ್ಲಿ
ಅವಾಗ ಅರೆಸ್ಟ್ ಮಾಡಕ್ಕೆ?
ಆವಾಗ ಅರೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದ.
ಕ್ವಾಶ್ ಆಗೋ ಮುಂಚೆ ಅದು?
ಕ್ವಾಶ್ ಆಗೋ ಮುಂಚೆ, ಕೇಸ್ ಕ್ವಾಶ್ ಆಗೋ ಮುಂಚೆ, ಸೇಮ್ ಡೇಟ್ ಕಂಪ್ಲೇಂಟ್.
ಅರ್ಲಿಯರ್ ಕ್ರೈಮ್.
ಅರ್ಲಿಯರ್ ಕ್ರೈಮ್.
In the meantime, next.
165
85 of BNS petitioner husband and in-laws. page 20 my lord. Divorce petition file ಮಾಡಿದ್ಮೇಲೆ
ಪರವಾಗಿಲ್ಲ, ಅದು ಸೇಮ್ ಸ್ವಾನ್ ಸಾಂಗ್. ಒನ್ ಹಸ್ಬೆಂಡ್ ಇಲ್ಲ ಎನ್ವಿಜೆ. 85 ನೋ ಹಸ್ಬೆಂಡ್. ಅಲ್ಲ ಹಸ್ಬೆಂಡ್ ಇದಾರೆ, ಹಸ್ಬೆಂಡ್ಗೆ ಸ್ಟೇ ಇಲ್ಲ, ನೋ ಹಸ್ಬೆಂಡ್ ಅಂತ. Next.
166
My lords, kindly have it after vacation, my lords.
After vacation, yes.
67
Lords, appear for the petition, my lords. Offense is under
Enter ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ sir.
ಏನು offense under?
420. Petitioner is a builder, my lords. So respondent number 2 is a purchaser, where I have sold the flat of flat number 402. Now, my lords, after 4 years, my lords, he comes and says, my lords, instead of 103, you have sold me flat number 402.
ಅವ್ರಿಗ?
Please, my lords. He's staying in the same flat. He's enjoying the property. My lords, thereafter, my lords.
Dimension difference ಏನು?
No dimension difference, my lords. Everything is same. Thereafter, my lords, police, my lords, one step ahead, they goes and they freeze my bank accounts, my all current accounts and saving bank accounts. Everything is frozen, my lords.
Meantime. Yes,
Lords, I have sought for the prayer to defreeze my.
ಆಮೇಲೆ ಅದು take advantage of the stay order. Yes. Next.
My lords, I'm unable to pay.
Take advantage of the stay order, sir. I have stayed it. Yes.
Please, my lords.
168
For the petitioner, my lords, complainant is working as a Gram Panchayati president, my lords. For that, the scams I have exposed, my lords. For that, she files a
Scam expose
to my lords. 2 government officials were suspended for that. I am an RTI activist, my lords.
ಹೌದು ಸರ್. Page 37 ಬನ್ನಿ. 74 clearly made out.
My lords, in complaint ಅಲ್ಲಿ ಯಾರು
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
ನೋಟಿಸ್ ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
One additional SPP2 emergent notice. Next.
169
Great.
Applicability of the
Coca, my lord, they are in custody. Now because
Who
of
is
this-
in custody?
The petitioners, my lords.
Sorry.
Because of the, at the 90th day, my lord, they invoke the provisions of Coca. As far as invocation of Coca is concerned, my lord, there should be more than one charge sheet in the preceding 10 years.
1 or 3 na?
More than one.
More than one.
More than one.
More
Idರಲ್ಲಿ
than
more
one,
than
my
one
lord.
ಇದೆಯಾ?
More than one only against petition number 2 and 3.
That's sufficient.
Petition number.
Sir, Coca is organized crime.
That's true, but-
ಒಬ್ಬೊಬ್ರ ಮೇಲೂ ಮೂರ್ ಇರ್ಬೇಕು ಅಂತ ಇಲ್ಲ.
Whereas, my lord,
ಜೊತೆಗೆ 3 ಇದ್ರೆ ಸಾಕು.
they should be a group, my lords.
Correct.
They form a group. No such allegations, my lords. So against 2 and 3, I have myself set out, my lords. There are more than 2 criminal cases pending, my lords. But I have set out the details. Now, my lord, they should also indicate, my lords, that they were the form of that group. Not connected to this, my lords.
Let them file. Let them file something.
And in the meanwhile, what happens, my lords? Because the stringent provision of this law, my lords, even the bail petition, my lords.
ಅದನ್ನ ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಬೇಲ್ ರಿಜೆಕ್ಟ್ ಆಗಿದೆ 482 ಕೊಡಿ ಅಂದೆ.
ರಿಜೆಕ್ಟ್ ಆಗಿಲ್ಲ. ರಿಜೆಕ್ಟ್ ಆಗದಾಗ
ಆಗುತ್ತೆ. ಆಗುವುದು ಖಚಿತ.
Petition number 4 is a lady, my
Then
lord.
it
Against whom there is no criminal case at all.
Petition number 4 is
a lady.
You are also a part of the crime, huh?
That allegation is that she has conspired with others. And that allegation is
Covered by
based on
Kavita Lankesh.
Absolutely. Anything else?
Now, my lord, there should be an application of mind, my lords, by before invoking
Coca.
Coca, my lords. And it doesn't show anything. And what has happened is, my lord, they have submitted a requisition to the learned session judge. That's how we come to know.
ಮತ್ತೆ ಇನ್ನೆಂಗ್ ಮಾಡ್ತಾರೆ ಕೋಕಾನ?
73, my lords.
Yes, sir.
Stating that now we have invoked. Stage at which invoked is also an important
Stage at ಹೌದಾ?
stage at which last they wanted the extension of the time for filing
Invest ಅದೇ ಕರೆಕ್ಟ್. ಅವಾಗಲೇ ಕೋಕಾ ಇನ್ವೋಕ್ ಮಾಡೋದು.
charge sheet, my lords. And
60 ಬದಲು 90 ಆಗುತ್ತೆ ಅವಾಗ. ಅಷ್ಟೇ.
90 ಇದು 180 ಆಗುತ್ತೆ.
90 ಇದು 180 ಆಗುತ್ತೆ, ಡಬಲ್ ಆಗುತ್ತೆ ಅದು. Yes.
Please, my lords. And my lord,
UAPA ಕೋಕಾಗೆಲ್ಲ ಡಬಲ್.
as far as continuing unlawful activity, there should be a material also, my lords. No such material is there.
Material full ಇದೆ.
ಅಲ್ಲ ಕಾಣ್ತದೆ ನೋಡಿ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಲೆಫ್ಟ್ ಗೆ ತಿರುಗಿ ನೋಡಿ.
I will
ನೋಡ್ತಾ
only see
ಆ
my
ಕಡೆ
lord.
ನೋಡಲ್ಲ.
No, I will
ನೋಡಿದ್ರೆ
always-
ಗೊತ್ತಾಗುತ್ತೆ. ಮೆಟೀರಿಯಲ್ ತುಂಬಾ ಇದೆ ನಿಮ್ ಸಬ್ಮಿಷನ್ ಇಮ್ಮೆಟೀರಿಯಲ್. After vacation, yes. No.
Any one specific date, my lords.
9th ಅಲ್ಲ 10th June. 9th June, yes.
Please.
170, 13%, Pradeep ji.
Additional. So offense is for criminal trespass, my lord. I am the lawful owner of that property, my lord.
ಲಾಫುಲ್ ಓನರ್ ಅಂದ್ರೆ ಪೊಸಿಷನ್ ಇದ್ದೀರಾ?
Possession ಇಲ್ಲ. I have been evicted unlawfully.
ಯಾವಾಗ?
2018 ಅಲ್ಲಿ, my lord.
18 ಅಲ್ಲಿ?
Yes, my lord. But
ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು ಯಾವಾಗ? 19 ಅಲ್ಲ. ಮತ್ತೆ ಒಳಗೆ ಹೋದ್ರಾ?
ಇಲ್ಲ.
ಮತ್ತೆ
ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಆಗಿದೆ, ತುಂಬಾ ಇದೆ.
ಗೊತ್ತು, ಸಿವಿಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಆಗಿರುತ್ತೆ.
Kindly peruse 107, my lord. ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ even till today I am the lawful owner ಅಂತ ECE ಅಲ್ಲಿ.
ಎಲ್ಲಿ ಮೈಸೂರ ಇದು?
Yes, my lord.
ಮೈಸೂರಲ್ಲ?
ಮತ್ತೆ ಈವನ್ ಅವರು ಏನ್ ಲೋನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ವಿತೌಟ್ ಎನಿ
ಒನ್ ಅಡಿಷನಲ್ SPP to emergent note
33 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಇದೆ ಫೋಟೋಗ್ರಾಫ್
ಇದೆ, ಅದೇ ನೋಡಿದ್ ನಾನು.
ಈವನ್ ವಿತೌಟ್ ಎನಿ ನೋಟಿಸ್ ದೇ ಹ್ಯಾವ್ ಎವಿಕ್ಟೆಡ್ ಅಸ್. ಒನ್ ಯಾವುದೇ ತರ ನೋಟಿಸ್ ಇಲ್ಲದೆ.
ಏನ್ ನೋಟಿಸ್?
ಅವರು ನಮಗೆ ಸರ್ಫೇಸ್ ಆಕ್ಟ್ ಇನಿಶಿಯೇಟ್ ಮಾಡಿದಾಗ.
ಸರ್ಫೇಸ್ ಆಕ್ಟ್?
ಹೌದು ಮೇಡಮ್.
ಯಾರು ಕಂಪ್ಲೇಂಟ್? ಯಾರು? ಬ್ಯಾಂಕ್?
ಕಂಪ್ಲೇಂಟ್
ಬ್ಯಾಂಕ್ ಗಾಯತ್ರಿ ಬ್ಯಾಂಕ್. Yes, even otherwise 447 requires 441 notice. In the meantime, yes. Next.
171.
Case and counter case, 109. But my FR even is not registered. Not page 47, may kindly see.
Where is your complaint?
Was my complaint?
In fact,
I have filed a private complaint notes.
Sorry, buddy.
Page 47, may kindly be seen.
They have,
These are my injuries. And the day I got injury notes, I immediately took
These are
treatment.
your injuries. How many injuries have you caused?
The allegation against me is I shot with the revolver. Now, my complaint on the same day, I'd even filed a complaint notes, page 51.
Arms Act ilva?
Arms Act, there's a charge sheet filed against me. But as far as my complaint is concerned, even the FIR is not registered. Now, I was compelled to file a private complaint.
ಆಯ್ತು, ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಆಗಿದೆಯಲ್ಲ?
ಹೌದು, ಈಗ ಪ್ರೆಸೆಂಟ್ಲಿ
ಅದು ರೆಫರ್ ಆಗಿದೆಯಲ್ಲ?
in fact,
ಆಗಿಲ್ಲ. But for a moment, page 51 may kindly be seen. That's my medical record. So what I'm presently seeking is investigation may have to go on in both. It has to be by the same investigating officer. In
Correct.
addition, it has to happen simultaneously as well.
No, your lordship may see. the
Case
photo-
and counter case, huh?
Your lordship is the photograph which is showing head injury, blood. This is the photograph which you taken at the day of arrest. Look
The
at
day of the incident and arrest. That's the day of the incident.
ಯಾವತ್ತು
as well.
ಅರೆಸ್ಟ್ ಆಗಿದ್ದು?
Because I was arrested the same evening.
3-4 hours.
This happened in this happened in the afternoon.
And medical records, my lord, when he was arrested, he was produced before the magistrate, to the doctor. And the doctor is, because mandatory, my lord, you have to produce the doctor for examination. Doctor examined and no injuries were found. And your
ಅಲ್ಲ
lordship,
ಇದ್ಯಾವ್ದು ಫೋಟೋ ತೋರಿಸಿದ್ರಲ್ಲ ಇಲ್ಲಿ?
Page 47. My injury as on even before I shot.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಒಂದ್ ನಿಮಿಷ. ಇದು ನಿಮ್ದಾ?
ಇದು ನಂದು. Even before I was shot, this was the photograph taken.
ಎಲ್ಲಿ ಇಂಜರಿ ಆಗಿದೆ ಇಲ್ಲಿ?
But the head injury, my lords.
ತಲೆ ಮೇಲೆ ಕೈ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಅಷ್ಟೇ?
There is blood as well indicated, my lords. Even the next photograph, my lords.
ಅದು ಕೊಡಿ ಜಗದೀಶ್.
I immediately go to the
ಆಮೇಲೆ
hospital. There is a medical record.
ಡಾಕ್ಟರ್ಸ್ ಮೆಡಿಕಲ್ ರೆಕಾರ್ಡ್. ಯಾವ ಆಪ್ ಯೂಸ್ ಮಾಡಿದ್ರಿ ಇದಕ್ಕೆ? ಈ ಫೋಟೋಗೆ ಯಾವ ಆಪ್ ಯೂಸ್ ಮಾಡಿದ್ರಿ?
Photographs were taken as on the date of the incident, as the incident was taking place. There are videos also, my lords.
Correct. Incident was taking place. Which app did you use for these photographs?
Page 51 is my medical record.
Correct. ಅದೇ ಇಲ್ಲಿದೆ.
Page 51. But
Page
this may
51.
kindly be seen, my lords. My injuries are there. I have a gunshot injury on my left foot. In addition to that,
When was he examined ಇದು?
same day after arrest, my lord, it was the same day he was arrested. He was examined.
Wound
and
over left head.
injuries on the legs are there because that's a different. That is
Whether
his
I
own,
had injury or not, my lord, the order sheet of the trial court may kindly be seen, my lords. Page number 81. The learned magistrate observes, it is found that the accused number 1 has sustained injuries on the right side of head and left ankle. Must page 81. So injury is found as far as I am concerned. In fact, I immediately even file an email complaint. Must kindly see page
ಈಗ
number 72.
ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ಕೆ ಏನಂತೆ ಜಗದೀಶ್?
Page
ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ಕೆ ಏನು ಇವ್ರದ್ದು?
now magistrate is under 175.
He has referred it.
Sought a report from the police.
ಬಿಡು,
And we had given
ಮಾಡುತ್ತೆ.
a report to the police, to the magistrate.
Page 170, sorry, page 76 may kindly be seen. But there was a necessity for the police to register my complaint.
ಈಗ ಪ್ರೈವೇಟ್
I have
ಕಂಪ್ಲೇಂಟ್
said-
ರೆಫರ್ ಆಗಿದೆಯಾ ಈಗ?
But what happened then was I was arrested, I was in prison. But about 4 months later, I filed a private complaint. My FIR was not taken. But presently what's happened is the learned magistrate has referred the matter under 175(3) for an inquiry by a different investigating officer.
No, we'll direct this
He has to take
by
a report
the
from the,
SHO,
he has to take a
necessity-
report from the jurisdictional police.
and refer it to
Report. We have given a report. Once the refers it, then we will.
same IO.
It has to be the necessity.
IO, sir.
The necessity.
I will
would be-
direct same IO.
Not only same IO, but kindly appreciate. Now there is a conclusion by the present investigating officer as far as the charge sheet against me is concerned. But he cannot, but if I am relying on my lord's judgment one, not.
ಏನಕ್ಕೆ ಡಿಫರೆಂಟ್ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್?
It is the same. In fact, not even the rulings would as well say that the investigation has to happen simultaneously.
We will direct investigate. ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗೋಗಿದೆಯಲ್ಲ ಈಗ?
ಈಗ charge sheet ಆದ್ರಿಂದ, but I will now, there is a prejudice as far as I am concerned. But what I am only seeking is.
But ಎಲ್ಲ ಅಬ್ಸಲ್ಯೂಟ್ ಫಾಲ್ಸ್ಹುಡ್.
But there is, in fact, not this injury is prior to my, there are video recordings I gave before the police of the injuries caused
ಆಯ್ತು,
to me.
ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ತಾರೆ ಬಿಡಿ.
We will investigate, my lord. If
But
you
it
want
has to be
direct, only-
essentially by the same IO simultaneously.
ನೋ ಸೈಮಲ್ಟೇನಿಯಸ್ ಏನ್ ಬೇಕಾಗಿಲ್ಲ, ಮಾಡ್ತಾರೆ. See, a private complaint registered later will not stall these proceedings.
This is not a counter case, but it's a
What
counter blast case
happens,
he's making.
Lord,
He's trying to make a counter blast case against them. It cannot be.
ಕೌಂಟರ್ ಬ್ಲಾಸ್ಟ್ ಅಲ್ಲ ಇದು.
This is not a counter blast. My submission is, my injury that is caused to me is even prior to my shooting. And the photographs that I am relying on, there are videos as well, my lords.
Sir,
Page 76.
you are
my
on
kindly-
the day of arrest. On the same day you were arrested.
I was arrested at night, my lords, on the same
ಅಲ್ವಾ?
day around 7.
ಯಾವ ಇಂಜುರಿನೂ ಇಲ್ಲ.
And same
The
shirt, my lord, your lordship,
learned,
is the
the learned
photograph.
magistrate makes an observation, my lords.
Where?
First page, I pointed out, my lords, page number 56, my lords. I'm sorry, my lords, order sheet is at page number 81. It is found that the accused number 1 has sustained injuries on the right side head and left ankle. And in the police station, I even sent a mail to the official email ID of the police.
So that is self-injury.
They
my
do
lord.
not register there for self-injury. How do there is a gunshot injury on my ankle? But once the learned magistrate observe this, in addition, my lords, the medical.
ಗನ್ಶಾಟ್ ಇಂಜುರಿ ಹೆಂಗಾಯ್ತು?
ಅವ್ರದ್ದೇ.
I was,
ನೀವೇ ಹೊಡ್ಕೊಂಡಿದ್ದೀರಾ?
while I was leaving, my lords, I was keeping the revolver back.
ಅವಾಗ
That time there was an accident, there was an accidental injury.
ಸೊ ಅದ್ ಬಿಡಿ.
So the medical report at page number 51.
You forget that injury, self-inflicted.
Please, lords, page number 51 may kindly be seen. Page 51, assault by group of people while he was in house at Machanhalli on 23 first so and so at 1:30 PM. Now there is indication self-injury.
ನಾವು ಈಗ
and on the head.
175 ರಿಪೋರ್ಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ.
If it is
According to
referred
us-
now by same investigating officer.
According to us, it's a false case because they have produced all these things.
Whatever.
According to us, false case.
My submission is.
No, will not state, sir.
But there is a necessity that simultaneous investigation, may kindly rely on this judgment, lords.
Your Lordship, is a photograph.
The-
Same.
The necessity
in fact,
in law,
the
my lords,
same,
is that
clothes which
the
we have.
investigation has to get completed in one and the second one, and
ಇದು ಗೊತ್ತು
thereafter.
ಬಿಡಿ. This is case and counter case.
But this also is
Case
the
is not registered only today.
But that is the failure of the
That
police.
we'll see,
But
yes.
my complaint, I have filed, my email may kindly be seen, my brother
Now
sent
it is
an email.
better in this case if a different investigating officer investigates.
But now either
Same
way, my lord,
investigating
there is-
officer andre obviously he will not he will find you false.
my lords, either way, for a moment, my lords, whether not duty bound to register the FIR when the mail was sent, when there is an injury on me. but
We'll
as
see,
specifically-
let the investigation go on. We'll see what is to be done later.
But
No
now,
question of
my-
staying this.
My submission is, but it could be disposed of immediately.
I won't
after
dispose
vacation.
it. I won't dispose it.
Immediately after vacation, lords, it could kindly be disposed of. My submission is there is a prejudice cause against me. That's what this,
We want to move the vacation bench.
absolutely, it may kindly be taken up immediately after vacation. None may the charge sheet, lords, it is coming up for hearing before charge now.
ಅಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
But you can get non private company
ಮಾಡ್ತಾ
file
ಇರಿ,
ಮಾಡಿದ
yes.
ನಂತರ it has gone for.
You finish the investigation and place it before the court.
But that we have already
ಅದು
filed a
before
charge
the
sheet.
concerned court.
We already filed a charge sheet.
ಯಾವ್ದ್ರಲ್ಲಿ? ಇವ್ರದಲ್ಲ, ಇವ್ರ ಕಂಪ್ಲೇಂಟ್.
And ಇನ್ನು reference ಆಗಿಲ್ಲ.
ಬರೀ ರಿಪೋರ್ಟ್ ಅಲ್ಲಿ
Report,
ಇದೆಯಾ?
my lords.
Now that it is before the court, I cannot pass any supervening order there, yes.
I have anyway suffered, my lords, till now by the police not registering my FIR.
In
The
fact,
learned members, I will as well submit. It was even contended and even heard before the learned magistrate
Yes,
that
yes.
it is a case and counter
Lest
case.
immediately after vacation, the stage of the proceedings be placed on record by the next date.
Please,
Yes,
any date, first week of June,
first week of June,
please,
yes.
any date.
First, 7th, 8th of June.
Please.
9th of June. Next.
I am the CEO of the company, my lordships will recall. Company had taken a loan. Now, my lords.
Recall, why?
No. The last occasion we had assisted your lordships, my lords. I was a CEO of the company. Company had taken loan from the KSFC, my lords, for purchase of land by KID from KIDP. I was only, my lords, an employee of the company. Absolutely no nexus, my lords, in the provisional attachment order insofar as what my role was, my lords, insofar as the proceeds of crime. Two predicate offences, both the predicate offence I have a clean sheet.
Stay na.
No, my lords, the investigating
Quashta.
officer, no, investigating officer files a B report in my favor, my lords. That there is no.
What, a
mechanism.
B report has become final?
One B report, my lords, the ED has challenged.
My lords, prosecution complaint has already been filed.
Complaint is already filed.
Filed, my lords. I have filed objections along with the objections.
ಹಾಕಿದ್ದೀರಾ ಈಗ?
Please, my lords.
ಎಲ್ಲಿದೆ objection?
My lords.
Copy ಕೊಟ್ಟಿದ್ದಾರಾ?
Copy is given.
Based on 2nd June, fresh matters.
No, until such time, lordships may direct them.
ಏನಾಗಲ್ಲ. Next.
ಅಲ್ಲ, at least not to
ಯಾವ
confirm,
ಪೇಸಲ್ಲಿ ಮಾಡ್ತಾರೆ ಗೊತ್ತು, ಏನೂ ಆಗಲ್ಲ.
not to confirm, my lord, this attachment on that list.
They will not confirm. Complaint file ಆಗಿದೆ ಆಗಲ್ಲ already. Confirm ಆದ್ರೆ will take care, don't worry.
Obliged.
Orders 173 withdrawal.
Withdrawal, 174 withdrawal.
175.
2 weeks time is granted to comply, do the needful.
175, I have one submission, my lords.
Yes, sir.
The malpractice of medical PGET of 2006, my lords.
Correct, sir.
Insofar as other accused.
I have myself passed the orders.
Exemptions, my lords. Before the trial court is granted by your lordship.
Hmm.
In fact, this is accused number 14.
Exemption ಕೊಟ್ಟಿದ್ದೀನಲ್ವಾ?
Idlal ಕೊಟ್ಟಿಲ್ಲ, madam. That's why I am seeking.
In the light of exemption being granted to every other accused in these proceedings, in these proceedings or the other accused in revision petitions, the petitioners are exempted from appearance before the concerned court unless the court would specifically warrant their appearance. Next, after vacation.
Much of.
176.
Supreme Court transfer petition where marriage stands dissolved. ಏನಿದು? ಸೆಟ್ಲ್ ಆಗೋಗಿದ್ಯಾ? Close
Settle before the
ಮಾಡಂಗ.
Supreme Court, please.
The parties to the list have settled the dispute between them before the apex court. The apex court has closed the proceedings recording the said dispute. Illide idea?
It's been received directly with the registry, please.
Illide. Settlement agreement between the parties. Inuje, illide. In that light, the petition stands disposed, the crime stands quashed. Flag hakil. Next.
177.
Petitioner, please, Lordship.
Non-compliance of office objections. After vacation, interim order. Next.
178.
Office objections be complied with in the meantime, failing which interim order would stand automatically vacated. Next.
178. Withdrawal.
In terms of. No, non-amendment of cost rate.
We have filed, we have already given NOC, we will file.
Very good.
more of
After
it.
vacation. Next.
180. Withdrawal.
Yes, in terms of 181 withdrawal. 182.
As a CEO of the company.
Very good.
And my lords, the allegation is that his.
Post immediately after service of notice upon the respondent.
Lordships, consider staying the matter, my lords. It's affecting my professional pursuits. I was not involved. The only allegation is that.
It's my order.
Please,
Let's
your lordship.
post immediately after service of notice upon the
For a
respondent.
date,
Next.
my lord. I've
It will
taken
come
steps.
immediately after vacation. Next.
Please.
183.
Only small objection, my lord, I will comply the course of the day.
Hmm.
Offense under section 441, 447, 323, please, my lord.
First time ಬರ್ತಾ ಇರೋದಾ?
ಇಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದಿತ್ತು
ಮುಂಚೆ ನನ್ ಮುಂದೆ ಬಂದಿದ್ಯಾ?
ಇಲ್ಲ ತಾವು ಟೈಮ್ ಕೊಟ್ರಿ ಕಂಪ್ಲೈ ಮಾಡೋದಕ್ಕೆ ಅಂತ, ಬಟ್ ಅಲ್ಲಿ ಫೈಲ್ ಲೇಟ್ ಆಗಿ ಬಂತು ಅಂತ ಕಂಪ್ಲೈ ಮಾಡೋಕ್ಕಾಗಿ.
Complied ಆ?
Suit was registered in.
ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೀರಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ.
then dismiss ಆಗ್ಬೇಕಿದ್ದು.
Blood, I'll comply course of the day, please.
No, sir. ಯಾವ ಡೇ ಮುಗಿದ್ಮೇಲೆ in course of the day.
Blood, charge sheet ಅಷ್ಟೇ ಹಾಕ್ಬೇಕು.
No, ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಇಷ್ಟೊತ್ತಿಗೆ. List on 2nd June in the event office objections would be complied. Next. ಅದೇ ನೋಡ್ಕೊಳ್ಳೋದೇ ಇಲ್ವಾ? Yes. Busy. ಯಾವತ್ತಿಂದು? Yes, sir.
184. My lord.
ತಾಳಿ ಅದೇನೋ ಫೈಲ್ ಲೇಟ್ ಆಗೋಯ್ತು ಅಂತ ಕೊಡು. ಒಂದು ನಿಮಿಷ ವೇಟ್. Office objections to be positively complied with by the 2nd of June. There shall be an interim order of stay of further proceedings qua the petitioner to the next date of hearing in the teeth of the fact that several civil suits are pending between them. One additional SPP, 2 emergent notice. In the event office objections would not be complied, the interim order would stand automatically vacated. Yes, next.
184. On the last date, the office objection were overruled, my lord, on the grounds that not approved proceedings were not filed and typed copy was not produced, my lord.
It is not overruled, madam.
Submission were
2 weeks
made
time
with
to
respect
comply with the office objections. Next.
185.
Office objections.
Completed.
Huh?
Complete earlier it was. It was complained on the first occasion itself, my lord.
Comply ಮಾಡಿಲ್ಲ ಈಗಲೂ?
ಆಗಿದೆ ಸುಮ್ಮನೆ.
ಯಾರು ಹೇಳಿ?
First
ಹಿಂಗೆ ಇದೆ?
the order sheet was the
Office objections
first occasion it
are complied with. One additional SPP, 2 emergent notice. Is surety ಇದು?
Your lordship, in this case, accused number 3. Allegations ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ಪ್ರಾಪರ್ಟಿನ accused number 3 ಗೆ ಕಂಪ್ಲೈನೆಂಟ್ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ ಇಂಪರ್ಸನೇಷನ್ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ. Either the accused number 3 that the petitioner has never claimed the ownership of the said property, and moreover a loan of 95 lakhs has been taken in the name of the accused, that is the petitioner.
In the name of the petitioner.
Yes, your lordship.
One additional SPP, 2 emergent notice immediately after vacation. Next.
186. Await service.
Post immediately after service of notice upon the respondent.
Interim order in this matter.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ.
ಅಲ್ಲ interim order ಇಲ್ಲ ಸೊ.
ಅದಕ್ಕೆ post ನನ್ ಮುಂದೆ ಬಂದಿತ್ತ after vacation. Next.
187.
Date may be fixed in 186.
Immediately after vacation ಬರ್ತಾವೆ ಇವೆಲ್ಲ.
187.
Office objections regarding 7 and 8. Already a certified copy of the annexure C and D is produced. The office objection raised is there is no seal in every page.
Office objections overruled. ಏನಿದೆ?
regarding 7.
ಅಯ್ಯೋ ಅದೊಂದೇ ಅಲ್ಲ ಸರ್,
Sir.
9 objection
yes,
ಇದೆ. Office objections to be complied with by the next date. Next. Dismissal.
Liberty may be given to proceed with this during vacations, Your Lordship. I shall comply with the objections by tomorrow day after tomorrow. Please. I'll comply
In the event office objections are complied with, liberty is reserved to the petitioner to move the vacation bench.
Yes.
188.
Please, ma'am, for the petitioner.
Post immediately after service
That's-
notice upon the respondent.
In this matter, please, my lord, I would like to make one submission. My lords were inclined to grant stay with offences punishable under 69 and 3184, please, my lord. On the very same day, the matter was posted before the court below for on bail application, my lord. And the bail application came to be rejected on the score that offences are made out under offences punishable under section 69, please, my lord. Though there is a stay granted, the court below observes that a memo along with the stay order was produced before the court below.
My lord, one small submission.
Section 69 and 318, 4 was stayed by my lord.
69 stay ಆಗಿದೆಯಲ್ಲ.
Please, my lord. Even then, the sessions judge has dismissed the bail application on the score that the offences are made out under the offences punishable under 69, please, my lord. This is the bail order.
This court was very clear from the beginning that this court is not going to come in between the merits of the bail while deciding the bail application.
ಅದಕ್ಕೆ ಬೇಲ್ ಹೆಂಗ್ ಬೇಕಾದ್ರೆ ಡಿಸೈಡ್ ಮಾಡಬಹುದು, ಕಾಂಟ್ರಾರಿ ಟು ಮೈ ಆರ್ಡರ್.
And my lord,
is that what the order meant?
Lords, and
Where
the
is it?
complaint, lords, may kindly find at page number 6, my lord. Page number 6, there's a reference to stay being granted by this honorable court, my lord, in criminal petition, and at para 12, my lord. Para 12, fourth line from the bottom, my lord.
This court on 7/4/2026 ಇವರು ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿದಾರೆ ಅಲ್ಲಿ.
They have objected. In fact, surprisingly, they made a submission that my lords have not granted stay, and also the said order.
ಯಾಕೆ ಆರ್ಡರ್ ಇರಲಿಲ್ವಾ?
Order it had produced the same. I literally took 3 hearing dates only to
Petitioner,
convince the court below.
this court on 7/4/2026 had passed the following order. This court was clear that offences under 69 and 3184 had been stayed. What remained was offence under section 1152, 1181, 351(2) and 351(3) of the BNS. The bail application is said to have been listed on the next day, on the same day before the concerned court. The interim order granted was produced before the concerned court. The concerned court deliberately, after referring to the interim order that is granted where section 69 was stayed, again passes an order invoking section 69 and rejects the bail application. Be that as it may, the learned counsel for the petitioner submits that the respondent complainant has objected to before the concerned court even with regard to section 69 in the teeth of the interim order. Therefore, there shall be an interim order of stay of all the offences so alleged against the petitioner till the next date of hearing. The respondent complainant is, you entered appearance?
No, my lord.
Learned counsel so and so undertakes to enter appearance for the complainant. List the matter on 17th June.
The petitioner is in
Objections,
custody,
if any, by then.
and the petitioner is in custody as on date.
My lords, the matter may be listed.
He should be released immediately.
Please, problem
How
is-
can the court do that?
That's maybe not correct. That may not be correct, my lord. That court should not have done that.
Yes.
The only issue, my lord,
It is 118 ಮಿಕ್ಕಿದ್ದು.
correct, but there is injuries also that
How custody ಹಂಗೆ ಹೇಳಿ?
trial court should have granted.
Bail is entitled to bail. Injuries, yes.
Injuries, the medical certificate was produced, my lord.
Ah,
Please,
you-
my lord.
you
That would be a matter of
don't behave as though you're a paragon of virtue.
No.
Yes.
Please.
Yes, now we'll direct the court to reconsider the bail application. If you file a bail application, now we'll see what
Be
they.
considered in a couple of days, please. A direction, because it
Ah,
almost took a
ಮಾಡಲ್ಲ,
month's
ಮತ್ತೆ ಅದೇ
time, my
ಮಾಡಲ್ಲ.
lord.
Lordship, direct, my lord.
In the light of the aforesaid order rejecting the bail, the petitioner in an offence under section 69 has been in custody. ಯಾವಾಗಿಂದ?
From 24th of March, please.
From 24th of March. in the light of the order passed by the concerned court and the offence being under section 69 and the offence under section 69 being stayed at the hands of this court, the concerned court ought to have granted bail to the petitioner. It having failed on the erroneous score that section 69 has not been stayed, while it was, the only corollary is the release of the petitioner from the prison. Therefore, the petitioner shall now be set at liberty. The petitioner shall be released from prison, however, with a condition that he would not create any problem to the complainant or ಅಲ್ಲಿ ಬೇರೆ offenses ಇದೆಯಲ್ಲ ಅದಕ್ಕೊಂದು condition ಹಾಕಿ madam, those bail conditions are, yes. So and so, yes, registry is directed to communicate this order to the prison authorities to enable the release of the petitioner.
189.
Your Lordship directed to connect the matter, stay there.
ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಬಂದಿಲ್ಲ, ಅದಕ್ಕೆ ಮತ್ತೆ ಮೂವ್ ಮಾಡಿದ್ದು ಸರ್.
ಏನ್ ಬಂದಿಲ್ಲ?
ಅದು ಸ್ಟೇ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಅಫೆನ್ಸ್ ಏನು?
420 ಅಷ್ಟೇ.
420 ಕಾರಣ?
ಅದು ದುಡ್ಡು ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ನಂಬರ್ ಕೊಡಿ, ಕನೆಕ್ಟೆಡ್ ಮಾಡಿ.
ಸೇಮ್ ಆರ್ಡರ್.
ಟ್ಯಾಗ್ ಅಲಾಂಗ್ ವಿತ್ ಸೋ ಅಂಡ್ ಸೋ, ಸೇಮ್ ಆರ್ಡರ್. ನೆಕ್ಸ್ಟ್ 190.
My lords, the prosecution case, my lords, is based on,
Ah.
but my lords, this thing, my lords, took place in the year 2012. And the
2012.
complaint is filed in the year 2023.
2012 or 23 na sir?
Complaint is filed in the year 2023, charge sheet is filed now. 2012, the incident occurs.
2012, what is that?
That
2012, our incident,
That 2012 is the incident.
2012 one. Yes. In the meantime, yes, next. Office objections overruled.
191.
Saturday, my lords, had asked for the issues, my lords, copy of the issues. This pertains to the will matter, my lords, where I'm just furnishing the copies of the will.
What are the issues?
My lords, here, my lords, the will, issue of the will, whether the plaintiff's is complainant's husband, whether he proves the will dated so and so, please in the name of defendant is null and void and tanmut hakida. The suit got dismissed. And in that suit, my lords, the accused number 1 and complainant's husband, both were the plaintiffs.
ಅದು ಒಂದು ಮೆಮೊ ಹಾಕ್ಬಿಟ್ಟು ಹಾಕಿ. The counsel for the petitioner places on record the issues framed in OS
3448 of 2013.
3448 of 2013, which is identical to what is alleged in the case at hand. The suit filed by the complainant is dismissed and later the subject crime emerges. In that light, there shall be an interim order of stay of further proceedings, square the petition to the next date of hearing. Next.
My lord, I have submission, my lord. Serial number 184, my lord.
Don't go back, wait. Yes. Next.
192.
For the petitioner in this matter, my lords. Case and counter case, my lord. In fact, it's with respect to voluntary causing 118, 352, 351.
Correct.
The same allegations have been made against me. I mean, I've also filed a FIR against them, and my FIR is the first FIR which is filed at 1:30 PM. The facts of the case is this: ರಂಗೋಲಿ ಹಾಕ್ತಾ ಇದ್ರು ಪಕ್ಕದ ಮನೆಯವರು, ನಾನು ಮನೆ ಕಟ್ತಾ ಇದ್ದೆ, ನೀರ್ ಹಾಕಕ್ ಹೋದಾಗ ಅಲ್ಲಿ ರಂಗೋಲಿ ಹಾಕ್ಬೇಡಿ ಅಂತ ಹೇಳಿದ್ರು. But my complaint clearly says that they have used to dump debris next to my, in and around the locality. We asked them not to dump the debris. For that reason, they have started and assaulted me. Then subsequently at 1:33 PM, I have gone to medical, I got a medical examination.
ಏನಾಗಿದೆ? ಏನೋ ಆಗಿಲ್ವಲ್ಲ?
Charge sheet.
Simple in nature.
ಹೌದು.
118 ಗೆ ಏನಿದೆ? ಏನಿಲ್ಲ ಇಲ್ಲಿ. ನಿಮ್ದು ಅಷ್ಟೇ, ಅವ್ರದ್ದು ಅಷ್ಟೇ.
ಅಲ್ಲ, ನಮ್ಮಲ್ಲಿ ಸ್ವಲ್ಪ ಗ್ರೀವಿಯಸ್ ಆಗಿದೆ. ಸೊ ಇದು ವೇರ್ ದ
ಗ್ರೀವಿಯನ್ಸ್ ಇದೆ ಅಷ್ಟೇ, ಗ್ರೀವಿಯಸ್ ಹರ್ಟ್ ಏನಿಲ್ಲ. ಅವರು ಬರಲಿ, ಎರಡು ಕ್ವಾಶ್ ಮಾಡೋಣ. 1 ಡೆಬ್ರಿಸ್ ಹಾಕೋದಕ್ಕೆ ಜಗಳ. 1 additional SPP to emergent notice in the meantime till the appearance of the complainant. Yes, next.
93.
Petitions counsel.
Maintainability of second petition.
Withdrawn.
ಮಾಡಿದ್ದಾರೆ.
Yesterday it was withdrawn.
ಇನ್ನೊಂದು ಯಾವುದು?
Crime stage ಫೈಲ್ ಮಾಡಿದ್ದೇವೆ.
ಇದು ಕ್ರೈಮ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಫೈಲ್ ಮಾಡಿರೋದು.
ಚಾರ್ಜ್ ಶೀಟ್
ಇದೆಯಾ ಇದರಲ್ಲಿ?
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್. Copy of the statute is also filed.
ಒಂದು ನಿಮಿಷ. CC.
This is the 5th complaint they have filed. First complaint was filed.
Respondent.
First complaint.
ಆಯ್ತು ಎಂಟಿ ನಾನೇ ಅವರು ಮುಗಿಸ್ಲಿ.
First complaint file ಮಾಡಿದ್ರು, ಕೋರ್ಟ್ ಮುಂದೆ ಬಂತು, ಕ್ವಾಶ್ ಮಾಡಿದ್ರು.
Second similar setup.
ಕೋರ್ಟ್ ಮುಂದೆನೆ ಬಂದು ಕ್ವಾಶ್ ಆಗೋದು ಇನ್ನೆಲ್ಲ
ಅಲ್ಲ, ತಮ್ಗೆ ಸೆಕೆಂಡ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು ಕಡೆಗೆ ಅದರಲ್ಲಿ ಎಕ್ವಿಟಲ್ ಆಯ್ತು ಚಾರ್ಜ್. ಥರ್ಡ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರು ಅದು ಪೊಲೀಸ್ನವರು ಹಾಗೆ ಹೀಗೆ ಮಾಡಿದ್ರೆ
ಹಾಗೆ ಹೀಗೆ
ಅಂದ್ರೆ ಏನ್ ಆಕ್ಷನ್ ತಗೊಳ್ಳಿಕ್ಕೆ ಆಗಿಲ್ಲ ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ. ಇದು ಫಿಫ್ತ್ ಕಂಪ್ಲೇಂಟ್ ವಿಚ್ ಇಸ್ ಬಿನ್ ಫೈಲ್ಡ್.
ಇದು ಹೇಗ್ ಮಾಡೋಣ ಹಾಗಾದ್ರೆ
ಸ್ವಾಮಿ?
ಇದು ಹೇಗ್ ಮಾಡೋಣ?
ಅಲ್ಲ 351, 74 and common intention.
Yes, sir.
ಅದು bailable. Sorry.
Allegation of threatening with acid attack. She's 20 years and he publishes a wedding invitation card saying that you will have to marry me, if not I would pour acid on you.
5 ಕೇಸ್ ಅದೇ.
ಓ
5 ಕೇಸ್ ಅದೇ ಸ್ವಾಮಿ.
ಇದೇನು ಡರ್ ಸ್ಟೈಲ್ ಅಲ್ಲಿ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ ಎಲ್ಲ?
ಬೇರೆ ಬೇರೆ ಅವ್ರನ್ನ ಇವ್ರನ್ನೆಲ್ಲ earlier complaint.
When the wedding card is here, please, and it was thrown on the face of the complaint, please.
ವಾಶ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ, ವಾಶ್ ಮಾಡಿದ್ವಿ.
ವಾಶ್ ಮಾಡಿದೀರಾ?
ಅಲ್ಲ, ವಾಶ್ ಮಾಡೋವಾಗಲೂ ಇದೆ ಆಸಿಡ್ ಥ್ರೆಟನ್ ಮಾಡಿದ್ರು, ನಿನಗೆ ಹೊಡೆದಾಕ್ಬಿಡ್ತೇನೆ ಹಾಗೆ ಹೇಗೆ ಅಂತ ಹೇಳಿದ್ರು ಅಂತ. ಅದು ವಾಶ್ ಆಯ್ತು.
ಅದು ಆಸಿಡ್ ಕ್ವಾಶ್ ಆಯ್ತಾ?
ಅದೇ. ಇನ್ನೆರಡು ಕಂಪ್ಲೇಂಟ್ ಒಂದು ಎಕ್ವಿಟಲ್ ಆಗಿದೆ.
ನೀವು ಆಸಿಡ್ ಡೀಲರ್?
ಐ ಆಮ್ ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್.
ಅಗ್ರಿಕಲ್ಚರಿಸ್ಟ್
ಲೋಕಲಿ ದೇರ್ ಇಸ್ ಇಂಟರ್ನಲ್ ಪಾರ್ಟಿ.
ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ತಾಳಿ.
ಸಾರಿ
ಸ್ವಾಮಿ, 4 ಸರಿನೂ ಆಸಿಡ್ ಹಾಕಿದ್ರ? ಒಂದೇ ಸರಿ ತಾನೇ ಹಾಕಿದ್ದು? ಅವಾಗ ಅಲ್ವಾ ಹಾಕಿದ್ದು? ಅಲ್ಲ, ಥ್ರೆಟನ್ ಮಾಡಿದ್ದು. ಕ್ವಾಶ್ ಆಗಿದ್ಯಾ?
It is the threat, because he's a rowdy.
ಅಲ್ಲ, ಕ್ವಾಶ್ ಆಗಿದ್ಯಾ? ಎಷ್ಟ್ ಸರ್ತಿ ಥ್ರೆಟನ್ ಮಾಡಿದ್ರು?
This is an older complaint which was registered 10 years prior, please.
ಯಾವುದು ದಿಸ್?
The earlier complaint which is quashed.
ಅಲ್ಲ, ಕ್ವಾಶ್ ಆಗಿರೋದೆಲ್ಲ ಯಾವಾಗ?
17-18. I have not put in my appearance, please, Milad. Am I permitted to file my objections, Milad?
You file your objections. See, if on the alleged acid thing, if crime has been quashed throughout, ಮತ್ತೆ ಅದರ ಮೇಲೆ ಎಷ್ಟು ಸರಿ ಆಗ್ತೀರಾ ಕ್ರೈಮ್? ಇನ್ವಿಟೇಷನ್ ಪ್ರತಿ ಸರಿ ಪ್ರಿಂಟ್ ಆಗಿದೆಯಾ?
2025.
He is also married, please.
Who? Petitioner.
Petitioner is married to an advocate, please.
Standing counsel.
ನೀವು ಮಾಡೋಂಗಿದ್ರೆ ನಾನು ಹೋಗ್ತೀನಿ.
ಅಲ್ಲ, petitioner is married to her.
First petitioner married, the second petitioner is a brother, third petitioner is a mother-in-law. She is 74 years, disabled lady.
I would not press on her, please, but petition number 1, please, Milad.
ಒಂದ್ ಸರಿಗೆ ಸರಿ ಎಷ್ಟು ಸರ್ತಿ ಆಗ್ತೀರಾ?
Let me secure the records, my lord.
ಅವ್ರು ಮದುವೆ ಆಗಿದ್ದಾರೆ, ಮತ್ತೆ ಯಾಕೆ ನಿಮಗೆ ಪೀಡಿಸ್ತಾರೆ? ಮದುವೆ ಆಗಿದೆ, ಮದುವೆ ಆಗಿ ಅಂತ.
ಅಲ್ಲ, ಮದುವೆ ಆಗಿ ಅಂತ ಇಲ್ಲ. He is threatening me that I should marry him.
That's what I'm telling. He's already married. Why will he threaten you?
That is the case.
You're worried.
Maybe I should check the records, Milad. A date may be fixed, Milad.
That will do. Should not misuse the law. Yes, Jagdish sir. It's not.
At least accused number 1 I'll rescue the records.
ಅಲ್ಲ, ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಏನ್ ಮಾಡಿ ಈಗ ಅಲಿಗೇಷನ್ ಏನಿಲ್ಲ? 74.
I understand, I have not seen the file because in the order.
ಅಲ್ಲ, ಅಲಿಗೇಷನ್ is 74 and 351.
Correct.
ವಾಟ್ ಆಸಿಡ್ ಅಲ್ಲಿ ಆಸಿಡ್ ಅಟ್ಯಾಕ್ ಬೇರೆ ಪ್ರಾವಿಷನ್ ಇಲ್ವಾ ಅದಕ್ಕೆ?
Let me verify, my lord.
ಗ್ಲೋರಿಫೈಯಿಂಗ್ ದಿ ಒಫೆನ್ಸ್ ಏನ್ ಆಗಲ್ಲ ಇಲ್ಲಿ. Heard the learned senior counsel MT Nanaya appearing for the petitioner and the learned, I forget the name. Abhilash. Yes, so and so. Learned counsel seeks 4 weeks time to file statement of objections. ಏನ್ ಕಸ್ಟಡಿಯಲ್ಲಿ ಇದ್ದೀರಾ? ಏನಿಲ್ಲ ತಾನೆ? 4 weeks time to file statement of objections. The issue is that the petitioner accused number 1 has threatened, petitioner number 1 accused number 1 has threatened the complainant that he would throw acid. The complaint was, the incident is said to have happened 10 years ago. 4 crimes have already emerged on the said incident. The allegation now is that the accused number 1, who is already married, is threatening the complainant that she should marry him all over again. Since separate crimes are registered on the same incident and the same have been quashed or acquitted, permitting these crimes till the filing of the objections would become an abuse of the process of the law. Therefore, till the next date. Objection act. Yes, next.
Pledge. Sorry.
Appearing for the petitioner, my lord.
My lord, I am for the respondent number
I humbly pray for time.
After vacation, IO next.
Humbly pray for time.
ಸೋಮಶೇಖರ್ ಈಗ ಟೈಮ್ ಇಲ್ಲ ಕೇಳಕ್ಕೆ. ವೆಕೆಟಿಂಗ್ ಸ್ಟೇ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಆಮೇಲೆ.
ಒಂದು ಡೆತ್ ನೋಟ್ ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ.
306 ಅಲ್ವಾ?
306 ಚಾರ್ಜ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್.
ಆಯ್ತು, ನೀವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ತಗೊಂತೀವಿ ಅದನ್ನ ನೋಡುವ. ಎಸ್, ನಿಮ್ದೇನ್ ಮೇಡಮ್?
195.
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಸರ್.
ಮತ್ತೆ
Submission ಮಾಡ್ತೀನಿ.
ಎಕ್ಸಾಮ್ಷನ್?
No. Filing a memo. I'm filing a memo.
What
for,
memo?
Extension of TI.
Eh?
Temporary intention.
ಎಕ್ಸ್ಟೆನ್ಷನ್ ಆಫ್ ಎಂಟ್ರಿ ಮಾಡ್ರ? ಯಾಕೆ, ಯಾವ ಲಿಮಿಟೆಡ್ ಎಂಟ್ರಿ ಮಾಡ್ರ ಕೊಟ್ಟಿದ್ದೀರಾ? ನನ್ನ ಎಂಟ್ರಿ ಮಾಡ್ರ?
ಇಲ್ಲ ಸರ್,
ಮುಂಚೆದಾ? IO, yes. Immediately after vacation.
ಒಂದು ಸಬ್ಮಿಷನ್ ಪ್ರಿವಿಯಸ್ ಕೌನ್ಸಿಲ್ ಹೆಸರು ಡಿಲೀಟ್ ಆಗಬೇಕು ಸರ್.
ಹೌದು, ನಿಮ್ದೇ ಇಡೋಣ. ಕರೆಕ್ಟ್. ರಿಲೇಟ್ ದಿ ನೇಮ್ ಆಫ್ ಮಹೇಂದ್ರ ಗೌಡ CR. ನೀವು ಸೋಮಶೇಖರ್ ರಾಜವಂಶಿ. ಕರೆಕ್ಟ್. ಆಯ್ತು ಸರ್.
ಅವ್ರದ್ದು ಡಿಲೀಟ್ ಆಗ್ಬೇಕು ಸರ್.
ಆಯ್ತಲ್ಲ, ಮಾಡಿದ್ವಲ್ಲ. ಆಯ್ತು, ಹೇಳ್ಬಿಟ್ಟು ಕೊಡಿ, ಪರವಾಗಿಲ್ಲ.
This honorable court has passed criminal 306 of 24 and 16/8/37 of 25. After I have left this job, they have registered crime against me for 420 and 406.
ಯಾಕೆ ಜಾಬ್ ಅಲ್ಲಿ ಬಿಟ್ಮೇಲೆ ಮಾಡೋಂಗಿಲ್ವಾ? ಟಿಪಿಕಲ್ ಕೇಸ್
this court has
ಟಿಪಿಕಲ್ ಕೇಸ್ ಆಫ್ ಮಿಸ್ಟೇಕನ್ ಐಡೆಂಟಿಟಿ ಕೊಡಿ. ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಕೇಳುವ. List the matter immediately after vacation. No sir. Yes, ನನ್ನ ಮುಂದೆನೆ ಬಂದಿತ್ತಾನೆ. Yes, next. 196 after vacation interim order continues.
We filed a detailed objections already.
Okay sir.
Already filed. Vacating of interim order.
ಅದು ಹಾಕಿದಿರಲ್ವಾ? List the matter on 10th ಬೇಡ, 17th June, 18th June. Interim orders in all these cases shall continue till the next date of hearing. In those cases where interim order is not granted, in the light of the interim order subsisting in all the companion petition, there shall be an interim order in all the cases till the next date of hearing.
97.
Educating authority, my lords. Under section 6, it has to be a bench. My lords should please notice this in.
Oh, idena adu?
Now what they have done is, my lords, they freeze my bank account which contains 36,000 rupees.
ಯಾಕೆ ಬೇಕು, ಬೇಡ ಬಿಡಿ ಅದು ನಿಮ್ಗೆ. ಮತ್ತೆ
The company is looking at going public, my lords.
36,000 ರೂಪಾಯಿ ಇಟ್ಕೊಂಡು you want to go public?
Even for an order like this, my lords, when we are going to be opening up to the market, it will not happen. But more so, my lords, kindly look at who passes the order. Now we have one member who is a finance member.
But I have passed a detailed order in other case. Which is this? Idalla, I have passed a detailed order to that Mayank.
So there are several judgments. There are division bench judgments upholding that.
So, my lords, the matter has gone up to the Supreme Court. Supreme Court has stayed the order passed by the Delhi High Court. My lords, the Sikkim High Court was the first.
It can't, sir.
It has to be more than one member.
It can't be. ಏನಿದು ಇಡಿ ಅಂದ ತಕ್ಷಣ ಏನ್ ಬೇಕಾರು ಅಂತನ?
No, not like that.
Then ಒಂದೇ ಮೆಂಬರ್ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ತಾ ಇದೀರಾ ನೀವು? When the quorum requires 3.
No, but then the courts have consistently held that it is for him. Anyway, let him finish.
In Virendra Papi's matter, that's what my lords should please to notice.
ಅದ್ರ ಯಾವ್ದೋ ಒಂದ್ರಲ್ಲಿ ಮಾಡಿದೀನಿ ನಾನು.
Section 6, subsection 5 is very clear, my lords.
No, your lordship had noted it only as a point for us to argue.
ನೀವು
but
ಮಾಡಿಲ್ಲ.
there is no order.
Reply.
There is no order.
Reply. ಆ ನಂಬರ್ ಕೊಡಿ ಅದು.
My lords, if section 6, subsection 5 is just noticed.
That's what I have quoted. I have passed a 4-page order in that, sir.
No. It's not an order. Lordship,
whatever I pass is an order.
Yes.
It may not be interim order. Yes.
Lordship,
the whole sequence was Sikkim High Court was the first court which said you need more than one member. There has to be a judicial.
What has happened to that?
That, my lords, after that comes this order.
Which High Court has said obre saku anta?
Then, my lords, Delhi High Court, only one is enough. Section 6, subsection 5, it says a chairman with 1 or 2 members was construed to mean only 1 or 2 members. It could be
Aitu.
one member.
Sir, that is.
That went to Supreme Court, that is state.
Then subsequently, the other courts which took the view as J. Shekhar are all connected along with the matter which is stayed in the Supreme Court.
ಇದನ್ನು ಅಲ್ಲೇ ತಗೊಂಡು ಹೋಗ್ಬಿಡಿ.
My lords is going to be holding
ನಾನು ಕಳ್ಸಕ್ಕಾಗತ್ತಾ ಹೊಡಿ?
minimum 2 at least.
No, no. I am of the view that cannot be. It is quorum non judice. ಸುಮ್ಮನೆ statute ಅಲ್ಲಿ ಏನಕ್ಕೆ ಮಾಡ್ತಾರೆ?
The quorum non judice argument is not available to this writ petitioner.
Why?
Because he participated in the proceedings, filed his objections.
No,
Now at
no,
this point
yes,
in time,
no estoppel against statute.
No, Lord, it is not a case of inherent lack of jurisdiction.
Oh,
Courts
it
have
is.
recognized
Quorum
that
non judice,
single-
sir. Quorum non judice is inherent lack of
We
jurisdiction.
have latest judgments of the
ಕೊಡಿ,
two
latest
high
judgment
courts.
ಯಾವ್ದು ಕೊಡಿ?
Two high courts.
ಕೊಡಿ, ಕೊಡಿ.
Whole sequence we have, right from 2015 till now, matter where it stayed in the Supreme Court, all matters stand along with that.
But in the
The first judgment is of Sikkim, my lords, where they.
No, first tell me, ASG ಅವರೇ, what is the hitch in appointing another person?
Lord, that
What's
Lord,
why?
Lord, that I may not be
There
able
should
to-
not be a difference of opinion ಅಂತನಾ?
No, not like that.
ಮತ್ತೆ?
Lord, I may not be able to answer that question now, but the question is, Lord, if my learned friend has concluded, but I have submissions to-
ಈ ಟೈಮ್ ಅಲ್ಲಿ ಯಾವ ಕನ್ಕ್ಲೂಷನ್?
ಅಲ್ಲ, ಅವ್ರ್ದು. If he has finished.
He is getting concluded.
ಅಲ್ಲ, if he has finished, I don't want to interject him.
Section 6, subsection 5, I may just read.
No, this even in that matter, I am of the view that it can't be. You can't have one member, that too finance member.
Language itself is very clear, my lords. They say, subject to the provisions of this act, the jurisdiction of the adjudicating authority may be exercised by benches thereof. A bench may be constituted by the chairman of the adjudicating authority with one or two members. That's the language. With is inclusive. Now, what Delhi High Court.
ಅಲ್ಲ, one member ಇದೆಯಾ ಅಲ್ಲಿ?
Chairman with one.
So chairman is one. So another member ಇರಲೇಬೇಕು.
But this was interpreted by the Delhi High Court, leaving out with, my lords. They said one or two is enough. With is inclusive.
Yes, ASG ಅವರೇ.
Lord, please have a look at couple of submissions. Number one, my lord, there is an alternate remedy available. In fact,
quorum non judice ಗೆ no alternate remedy. ಆಮೇಲೆ
Allah, yes,
Jurisdiction,
participated. Yes, participated.
no amount of participation will close.
For quorum non judice, please see the Chhattisgarh High Court judgment.
Yes, sir.
Para 56. Para 56.
ಎಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಈಗ ಕೊಟ್ಟೆ.
ಈಗ ಕೊಟ್ಟಿದ್ದ. ಓ, ಲೇಟೆಸ್ಟ್.
This is the latest.
ಇದರಲ್ಲಿ ಸಿಂಗಲ್ ಮೆಂಬರ್ ಆಗ್ಬೋದು ಅಂತಿದ್ಯಾ?
Para 56, my lord.
Division bench.
Division.
ಸಂದೇಶ್ ಸರ್.
There are two. There is also Telangana High Court. That's also
26.
That's also DB.
Along with that, my lords. Probably ಇದನ್ನ ಇನ್ನೂ challenge ಮಾಡಕ್ಕಾಗಿಲ್ಲ.
ಎರಡಿದೆ. And my lord, considering and my lord, there is one more reason, my lord, not to grant any interim relief. Because in the writ petition itself, the petitioner says he has not used this account since March 2023.
ಅಲ್ಲ, 36,000 ಏನಿಲ್ಲ.
ಅಲ್ಲ, March 23 ಇಂದ ಯೂಸ್ ಮಾಡಿಲ್ಲ. Then where is the question of granting? I mean, he should make out a case of hardship for grant of interim
No,
relief. He
that's
should
all right.
make out a
But
case of
what do you
hardship.
say about these two, sir? ಅಲ್ಲ, ಛತ್ತೀಸ್ಗಢ ಸರ್ 2026. ಅಲ್ಲ, ಡಿವಿಷನ್ ಬೆಂಚ್.
Both are DBs.
ಸೇಮ್ ಗ್ರೌಂಡ್.
Division bench was also of Andhra Pradesh. My lords.
ಅಲ್ಲ, ಇಲ್ಲೂ ಸೇಮ್ ಗ್ರೌಂಡ್ ಇದೆ. That's all right. This is new judgments.
This may be challenged next. We don't know, my lords.
I don't know.
My lords, all fall back on Shekhar's case.
Lord, for 3 years he does not use the account. Now, what is the urgency to seek stay of that?
Wants to go public, sir.
No, he has not used it for 3 years.
We'll answer this along with that. You just look into these two judgments.
It will have to be heard, but it may be called immediately after vacation. I'm ready in that.
Immediately after, of course, immediately after vacation. You're not going public in the vacation, right? 36,000 ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಅಲ್ಲಿ ಏನ್ ಪಬ್ಲಿಕ್ ಹೋಗ್ತಿದ್ದೀರಾ ನೀವು? No, correct. Now, the only account you have is this. 36,000 ಇದೆ. ಪಬ್ಲಿಕ್ ಹೋಗಿ ಮತ್ತೆ ಅಲ್ಲೊಂದು ಬೇರೆ ಎಲ್ಲ ಅವ್ರಿಗೆಲ್ಲ ಇನ್ವೆಸ್ಟ್ ಮಾಡಿಸಿ ಇನ್ನೂ ತಲೆನೋವಾಗುತ್ತೆ. ಅದಕ್ಕೆ ಮುಂಚೆ ಈ ಕೇಸ್ ತೀರ್ಮಾನ ಮಾಡಿಸ್ಕೊಂಡ್ಬಿಡಿ.
Now, my lords, without showing how we are involved with any laundry, an account of 36,000 under 17(4) it has been retained by the investigating officer.
But anyway, my lord, this, the public, there is a council submission, the writ petition grounds doesn't say so.
My lords, please notice you have taken the ground 20 quorum non-juris.
No, this going public, going public.
Going public, he get.
No, then my lord, it's a council submission. Then where is the urgency?
Going public cannot be pleaded, sir.
An account which is not operated for 3 years by his own admission. Then no, the only ground, the reply for that is, I am going public. Where is the averment in the writ petition? It's only a council
We did
submission
not
which
know
has no
then.
value.
Without power and jurisdiction. My lords, it goes
No,
No,
for
it-
that, my lord, I'm relying upon the latest DB judgments.
Don't go public in the vacations. You want me to pass it? The petitioner,
Can I just make one request? Now, if it's 36,000, my lords, lean on that. 36,000, you give a lean on that. Open the account. Account can't be kept like that.
the petitioner is before the court on a particular, on a circumstance, comma, inter alia. One, that under subsection 5 of section 6 of the Prevention of Money Laundering Act 2002, a quorum for deciding the cases is chairman with a member or 2 members. The issue is that the quorum, the issue is at presently, there is only 1 member and therefore it is quorum non-judice. The learned counsel, learned senior counsel Sandesh Chowta would further submit that the petitioner has 36,000 in his account and the account is frozen. It remains frozen for the last 3 years.
No. He says he has not operated it.
It remains inoperative for the last 3 years and however it is frozen now. The learned senior counsel further submit the company is wanting to go public. Therefore, the retention cannot be there nor the crime. Learned additional solicitor general Arvind Kamath would submit that the Telangana High Court, the High Court of Chhattisgarh have all upheld the single member operation under subsection 5 of section 6 of the PMLA, and they both are by the division benches of the respective courts. Therefore, would in that light, the learned counsel, senior counsel to go through the papers and answer the judgments rendered by the 2 different high courts on the issue by the next date, 3rd June.
Can there be a lien on that amount? 36,000.
ಹೆಂಗೂ ಆಪರೇಟ್ ಮಾಡಿಲ್ಲ ಬಿಡಿ, 3 ವರ್ಷ ಆಯ್ತಲ್ಲ.
I've expressed, my lords, why is it that we are so concerned with this 36,000?
3 years in they are not concerned.
But now, my lords, there's progress in the company.
30 days will adjourn. Yes.
Lord, just, would that other, the Tharwad bench matter, would it be taken up, my lord? I just wanted to know. NHA matter, it's there today. Just wanted to know, would your lordship take it up?
ನಿಮ್ದು ಆಗೋಗಿ ಡೆಲ್ಲಿಯಿಂದ ಮತ್ತೆ ಬಂದಿದ್ದಾರೆ ಇವರು.
This is latest, we missed out one ruling.
Well, there, my lord, I had sought for permission for
When
the
is-
arbitrator to
when is
proceed.
his flight?
12 a.m.
12 a.m. I will take it at 10 o'clock. Wait.
Or would your lordship accommodate tomorrow morning?
We'll see. Wait. Tomorrow I think I have a bench also. We'll see. Yes. Next. Irri. Let it get dark. ಆಮೇಲೆ ಹೋಗಿ.
Humble submission, my lord. 194 date.
In the annex to 198.
Humble submission, my lord. 194 date may become.
Immediately after vacation ಬರುತ್ತೆ. Vacating stay ಹಾಕಿದಿರಲ್ವಾ? Yes.
306 is the allegation, my lords. Charge sheet has been filed. Petitioner, my lords, was in relationship with the deceased for 5 years.
Ah.
He was undergoing depression, my lords.
You are undergoing depression.
He was undergoing depression.
You have made her to be depressed.
Well, that was not the only reason, my lords.
Ah.
She, my lords, she had no parents. She was taken care by, my lords, her foster parents.
No problem. Yes.
That is why, my lords.
One additional SPP to emergent notice.
Lords, now trial court is set to frame charge. May I request, my
problem.
lords, your lordship may defer
No,
framing
no
of charge,
issues.
my lords.
If you can't instigate, who else? Yes, next.
Lords, charge may be deferred, my lords.
No,
to the
no,
consideration.
Next.
199. Lords, may I request for a date after vacation?
After vacation, yes.
Any date, my lords.
No. Yes. Office objection comply ಮಾಡಿ first.
Comply ಆಗಿದೆ, council submission.
Council sub, ಎಲ್ಲಿದೆ council sub?
14.
ಸುಯೋಗ್. Office objections overruled. Yes. ಅದ್ ಮಾಡಿ ಆಮೇಲೆ notice. Next.
Lord, only a mandamus is sought in a maintenance case, Lord, with 2023 petition, Lord. Till today, interim maintenance also not
Not
paid.
granted.
Interim maintenance was ordered. If you filed a memo of calculation also. In spite of that, they're filing application by application. They're filing the application for challenging the orders before the appellate court. Then again remanded, Lord, now only a sort of mandamus to dispose of the main petition.
Within 3 months.
Please. 23 petition.
The petitioner is before the court. You are the wife, huh?
Please.
The petitioner is before the court seeking the following prayer. The petitioner is the wife, the first respondent, the husband. The dispute between the two has led the wife before the concerned court under section 12 of the Domestic Violence So and So Act. The orders of maintenance granted by the court were called in question before the appellate court and the matter is remitted back to the concerned court. The issue is of the year 2023. In that light, the concerned court shall conclude the proceedings in accordance with law within 4 months from the date of receipt of the copy of the order. It is needless to observe that the parties to the list would cooperate for such conclusion, failing which the concerned court is at liberty to pass necessary orders in accordance with law. Next.
Areas of mind. Areas also there.
You ಕೇಳಿದ್ದು speedy.
Both prayers.
Speedy ಅಂದ್ಮೇಲೆ ಈಗ needy ಬರಬೇಡಿ. Yes. Don't be greedy. Yes.
400. Your Lordship, 420, Your Lordship.
Maintainability.
Your Lordship, maintainability.
420 ಆದ್ರೆ?
Charge, Your Lordship, maintainability is with respect to another FIR in Kalburgi. That is with respect to only notice issued to us. We are not accused in that, Your Lordship. I shall not even press on that, Your Lordship. The FIR that's registered here, there's absolutely no material proof, no documentary proof, and he doesn't even know who the complainants are, Your Lordship. They just seem to make an allegation stating that they've given some cash. And please, Your Lordship, 5 lakhs, they claim that they've given it for some employment. Your Lordship, he's not even aware of who these people are, and all of this is
Accused will never be aware of who the complainant is.
Your Lordship in this is willing to even.
It is only a notice issued on a 91 CR.
No, that is with respect to the Kalburgi. In this is the FIR, Your Lordship. FIR in Davangere, Your Lordship, on 27/1. 11/10/2024.
Prayer page 27.
Please, Your Lordship. Please.
27. ಏನ್ ಕೇಳಿದಿರಾ?
Your Lordship, that is with respect to that might I seek, Your Lordship. I shall even cooperate with that
ಅದಕ್ಕೆ
investigation
maintainability
as long.
ಬಂದಿರೋದು. ಅಲ್ಲ ಕೋಆಪರೇಟ್ ಅಲ್ಲ, ಕಲಬುರಗಿ ಯಾಕೆ ಇಲ್ಲಿ ಕೇಳಿದಿರಾ?
Your Lordship, this is the.
To delete this prayer.
I shall, please.
The petitioner, heard the learned senior counsel Lakshmi Iyengar appearing for the petitioner. The petitioner seeks leave of this court to delete the first prayer as it was only a notice issued at an earlier point in time. The issue now is registration of a crime in crime number 228 of 2024 for offense punishable under section 420 of the IPC. A perusal at the complaint.
ಕೆಲಸ ಕೊಡಿಸ್ತೀವಿ ಅಂತ ಹೇಳಿ ದುಡ್ಡು ಇಸ್ಕೊಂಡಿದ್ದಾರೆ.
ಎಷ್ಟು ಇಸ್ಕೊಂಡಿದ್ದೀರಾ?
They claim that it's 5 lakhs, Your Lordship.
5 ಲಕ್ಷ.
They claim we don't even know, not even indirectly involved in any manner, Your Lordship.
So and so. Till the appearance of the complainant, there shall be an interim order of stay of all investigation. 2 ವರ್ಷ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ ನೀವು? ಅಲ್ಲ ಎಲ್ಲಿದೆ?
Nothing, Your Lordship. We got to know about it only.
Yes.
Maintainability ಮೇಲೆ ಬಂದಿತ್ತು ಅದಕ್ಕೋಸ್ಕರ.
Maintainability ಕಲಬುರಗಿ ಮಾಡಿದಾರಲ್ಲ.
I have not secured
There
the
shall be an interim order of stay of further investigation subject to the verification by the learned additional SPP of the stage of investigation as it is 2 years old. This the matter on this 9th of June, fresh matters.
Might I request that it's not subject to, Your Lordship, so that they don't hurry up and file something. As of now, I'm aware that there is nothing.
Yes, clarification.
Lordship,
ಇವತ್ತಿಗೆ ಇಲ್ಲದೆ ಇರೋದು ಅವತ್ತು ಫೈಲ್ ಮಾಡಿದ್ರೆ we will take note of it.
Your Lordship, I have verified that there is.
Between today and the next date, if they have filed a charge sheet, then we will take note of it, not a problem.
Please.
I only asked for the stage. I have stayed the proceedings now.
Please, Your Lordship, obliged. I shall file a memo to that.
ಎಲ್ಲಿ?
I'll ask him to.
Yes. ಇನ್ನ ಬೇರೆ ಯಾವ್ದಾದ್ರು jurisdiction ಅಲ್ಲಿ ಅದು ಕೇಳ್ಬಿಡಿ prayer.
Your Lordship, there's a Delhi lawyer who had drafted and filed.
ಡೆಲ್ಲಿ ಲಾಯರ್ಸ್ ಎಲ್ಲಿ ಬೇಕಾದ್ರೆ ಕೇಳ್ಬೋದು ಅಂತ, just because it is Delhi.
They claim that this is.
Yes.
Two hundred and one.
AVIO. Post immediately after, Vikram sir, ಯಾರಿಗೆ?
Well, I had appeared for this. I think last time I was told your lordships got a little upset because Madhu had brought your lordships attention some some paper publication. It could be called after vacation. Your lordships have anyway directed that keep that amount separately.
Yes.
We take our chance.
R3, ನೀವು R3 ಯಾರಿಗೆ?
R3. R2.
ಓ, ಆ ಮ್ಯಾಟ್ರಾ? ಆಯ್ತು. Yes. The heard the learned counsel Madhu and Rao and learned senior counsel Vikram Huligold appearing for the respondent list after vacation. Interim order subsisting will continue to the next date of hearing.
Let them keep a lien on that amount.
9th June.
9th,
That day will
let
do.
there be a lien on that amount.
ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ ಸರ್?
My complaint may be taken. My complaint they are not taking.
ಇಲ್ಲ, ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ?
My personal account, it is not bank, company's account.
ಆಯ್ತು, ಅವತ್ತು ನೋಡೋಣ.
Personal account they are.
Yes, next.
202.
For the petition. Counsel submission for the reason entire charge sheet material ಕೇಳಿತು. I'm filing it along with a memo.
ಅಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಿಲ್ ಫೈಲ್ ಮಾಡಿ.
And so far as
Accepting submission of his objections overruled.
It's offense under 115 subclause 2, 324 subclause 4 mischief, 126 subclause 2 wrongful restraint, 351 subclause 2 criminal intimidation, 351 subclause 3 breach of peace. Lords, the de facto complainant was running a cement shop, my lords. I purchased some materials, that is the allegation. Thereafter, my lords, I made part payment.
One additional SPP2 emergent notice in the meantime. Next. ಅದೇ ಮೇನ್ ಟೈಮ್. ಏನ್ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೀರಾ ಕೋರ್ಟ್ಗೆ? ಸಾಯಂಕಾಲ ಆದ್ರೆ ಆಗಲ್ಲ.
203.
203, can I request it to be taken up
after vacation? ಏನಿದು ಸ್ವಚ್ಛ ಏನ್ ಡೈರೆಕ್ಷನ್ ಇದು?
Solid waste.
ಕರೆಕ್ಟ್, ಇಲ್ಲಿ ಯಾಕೆ ಬಂತು?
Your lordship had fixed a timeline
ಹಾ.
and asked them not to deviate.
ಅಯ್ಯೋ, ಅದಾದ್ಮೇಲೆ 4 ಲಿಟಿಗೇಷನ್ ಮಾಡಿದೀರಾ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚಸ್ ಅಲ್ಲಿ ಮತ್ತೆ ಇಲ್ಲ.
Your lordship have it.
Yes, list after vacation. Next. Yeah, special order.
Appearance of petitioner, my lord.
Why special orders?
My lord, request amber submission, my lord. 6154 writ petition, my lord. Criminal petition 12751 separate, my lord. This is kabno adbitare.
But it's what had happened, my lord.
After vacation, senior engagement, my lord.
List the matter after vacation.
Kindly into my extension, my lord.
Interim order, if any subsisting, will continue.
But in so far as
Yes, post the matter after vacation.
Manoj,
2020 D-Link 204 ಇಲ್ಲ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಆಗೋಗಿದೆ.
what had happened in this matter, Manoj, the learned petitioner in the writ petition, Manoj, made a submission that there is a similar matter wherein the criminal petition has been filed. But Manoj, the writ petition becomes infructuous because his representation is already
But
considered.
after vacation.
Please.
Next is
205.
interim order ಇದ್ರೆ continue.
13B. But I raised an additional grounds for not in the application.
Immediately after vacation. 4th June. Yes. Objections if any by the next date. Interim order ಇದೆಯಾ?
Please.
Interim order if any shall continue to the next date of hearing. Yes, next.
Please.
Special order. ಯಾಕೆಲ್ಲ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ after vacation? Yes.
There is no interim order.
No interim order. Yes, B group will have interim order.
Already interim order, my
List
lord,
after
heard this
vacation.
matter
Yes,
and
next.
my lord, this refer to the other bench, so coordinate bench again refer to this bench, my lord.
ಏನ್ ಮಾಡಕ್ಕಾಗಲ್ಲ ಮೇಡಮ್.
I'm here and there, I'm bouncing back, my
Here
lord.
and
There is no
bouncing
interim
back.
term. Please, my lord,
ಎಲ್ಲಿಗೆ
I'm back
bouncing
to
back?
this court again, my lord, with a special order.
ಯಾವುದು ಸ್ವರೂಪ ಇದು?
It is an APMC matter where
Even
market
maybe
fee is not
disposed
paid.
of, and my lord.
We have
ನಾನು ಡಿಸ್ಪೋಸ್
filed-
ಮಾಡಿದ್ದೀನಾ?
ಇಲ್ಲ.
Maybe disposed of, my lord.
Maybe
since
disposed of today.
I'm ready to pay, my lord, with the
Seriously?
interest. Page number 52 may be taken, my lord.
Petitioning question has to be listed before the appellate bench having roster and circumstance. Seeking. But crime will not go away, madam, just because you pay it.
My lord, the only thing is, my lord, we have not paid the stipulated time, my lord.
List immediately after vacation. Yes,
There is no
next.
interim order, my lord, and I'm
No
ready to pay
problem.
with interest,
I
my
have
lord.
not granted and sent it. Yes, next.
Much of it.
Dismissal 207. 207 to 229.
All comply ಮಾಡಿದ್ರೆ
216 council submission have produced the document, one page is not available. That's the reason.
ಯಾವ್ದ್ರಲ್ಲೂ ಇಲ್ಲ, ಎಲ್ಲ 10th ಟೈಮ್ 7th ಟೈಮ್ 8th ಟೈಮ್ ಮಾಡಿರೋದು ಎಲ್ಲಾದ್ರಲ್ಲೂ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ.
216 I have complied the order sheet, council submission.
ಒಂದ್ ನಿಮಿಷ. The learned counsels would submit that the office objections have been complied with. In the event they are complied with as on today, the petitions would survive. In the event the office objections are
29
not
Lordship.
complied, are not complied as on today, the petitions would be dismissed for non-prosecution in light of the earlier orders. 10 times ಬಂದಿದೆ ಒಂದೊಂದನ್ನು. ಆಗಿದ್ರೆ ಹೇಳಿದ್ನಲ್ಲ, ಆಗಿದ್ರೆ ಸರಿ, ಎಸ್. ಆಗಿದ್ರೆ ಸರಿ, ಎಸ್.
It may be overruled, my lord, because the one page is not there in the.
Nothing, ಅದನ್ನ 10th time ಬಂದಾಗ ಓವರ್ ರೂಲ್ ಮಾಡಲ್ಲ.
Original record alla illa sumya. I have produced
Yes.
third time back.
129 Lordship. The officers raise objection in respect of the provision of law. We have challenged the notification. Officers want us to write it 482. We filed 226. Matter has come. Earlier I have challenged similar order. The coordinate bench said that.
ಅದಕ್ಕೆ ಎಷ್ಟು ಸರಿ ಕಾಯ್ಬೇಕಪ್ಪ?
Lordship,
ಇದನ್ನ ಹೇಳಕ್ಕೆ?
Lordship, one last date only I could not appear. Lordship, all my have made a submissions also. It has to be considered. That's it, Lordship. And he there in the judicial custody. They want. They are not accepting our memo appearance.
1 ನಿಮಿಷ madam.
229.
208 1 ನಿಮಿಷ. 207 208 dismissed. 209 same. 210 same. ಎಲ್ಲ ಆಫ್ ಇದು ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಎಲ್ಲಿದೆ ಬನ್ನಿ.
214 my lord. 214 my lord.
227 my lord.
214.
ಒಂದೊಂದ ಕರೀತಾ ಇದ್ದೀನಿ ತಾನೆ, ಮತ್ತೇನ್ ಕೇಸ್ ವೇಟ್.
211, 212,
213 same.
214.
That had come for the 7th time, sir. So file an application, yes. ತೊಂದ್ರೆ ಇಲ್ಲ, application ಅದಕ್ಕಲ್ಲ, recalling, yes. No, sir, yes, 214.
214 my lord.
Partly complied my lord.
Huh? Partly complied, dismissed, yes, next. ಎಲ್ಲ 7ನೇ ಸರಿ 8ನೇ ಸರಿ ಬಂದಿರೋದು, next. ಹಾಕ್ಬೇಕಾಗಿತ್ತು. 250, no please, yes. ಅದು ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗೋದು. File recalling application, yes. 16 council submission, office objection overruled. ಇದು ಅಷ್ಟೇ, ಯಾವುದು 217 council submission.
The certified copy is there.
ಹಂಗಾರೆ dismissed, yes. ಮುಂಚೆನೆ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಅವೆಲ್ಲ, yes.
218 my lord.
218 ಎಲ್ಲ ಗೊತ್ತಿಲ್ಲ, yes.
My lord.
218
This matter is in praxis my lord.
Learned council submits petition is rendered infructuous, disposed as having become in 219.
Appearing for petitioner, kindly issue notice, I'll take.
No issue notice, madam. Steps are not taken for 10 times, yes. Next, same. 220, same, dismissed.
221,
221 also same.
222.
22 my lord, comply ಮಾಡಿದ್ವಿ, ಅದು ಏನು objection ಇದೆ ಅಂತ ಗೊತ್ತಾಗ್ತಿಲ್ಲ.
ಅಯ್ಯೋ ಹೋಗಿ ನೋಡ್ಬೇಕಾಗಿತ್ತು ಸರ್, 7ನೇ ಸರಿ 8ನೇ ಸರಿ ಬರೋದಿಲ್ಲ ಅದು.
Fourth time.
Same, 4th time.
Fourth time.
ಬಹಳ ಸಂತೋಷ, yes.
No my lord, it's just.
Next.
My lord, ಅದು 3500 pages ಇದೆ my lord. charge sheet.
ಯಾವುದು?
My lord,
ಯಾವುದು?
223 my lord, serial number.
223. Comply along with.
More than 3000 pages ಇದೆ my lord, charge sheet.
ಏನ್ ಹಾಕ್ಬೇಕು ಅಂತ ಕೇಳಿದ್ದಾರೆ.
Certified copies apply ಮಾಡಿದ್ವಿ my lord. Even ಅದು true copy ಅಂತಾನು mention ಮಾಡಿ ಅದನ್ನ ಹಾಕಿದ್ವಿ my lord.
Accepting the submission ಇಲ್ಲಿದೆ. Accepting this submission of the council office objections overruled. Next. 224.
6 objections.
ಬೇರೆ objections ಇದೆ 224, 223. ಬೇರೆ objections.
Just ಅದೇ objection.
Just ಅಲ್ಲ, dismiss ಮಾಡಿದ್ದೀನಿ ಈಗ ನಾನು, ಅದು recall ಹಾಕಿ. ಅದೊಂದು objection ಮಾತ್ರ overruled. Yes.
224.
ನೀವು ಫೈಲ್ ಮಾಡ್ಬಿಟ್ಟು ಮರ್ತು ಬಿಟ್ರೆ ಆಗೋದೇ ಇಲ್ಲ.
ಅದನ್ನ ಪ್ರತಿ ಸರಿನೂ ಹೋಗಿ
ಮಾಡ್ಬೇಕು, ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಆಗಿ ಬರ್ಬೇಕಾಗಿತ್ತು ಇಲ್ಲಿ. Yes. You can't be careless, sir, having filed ಆಮೇಲೆ ಅರ್ಜೆನ್ಸಿ ಎಂಟ್ರಿ ಮಾಡಿರ್ಬೇಕು ಅಂತ. ಒಂದ್ ನಿಮಿಷ, 8 objection ಇದೆ, ಒಂದಲ್ಲ, ಅದು ಒಂದೇ ಇದ್ದಿದ್ರೆ ಮಾಡ್ತಾ ಇದ್ದೆ. 8 objection 8ನೇ ಸರ್ತಿ ಬಂದ್ರು ಮಾಡಿಲ್ಲ. ಎಸ್ ಎಲ್ಲ ಒಂದು, ಅಯ್ಯೋ 6 ಟೈಮ್ ಕಮ್ಮಿನಾ ಸರ್? ತೊಂದ್ರೆ ಇಲ್ಲ, ಎಸ್. ನೆಕ್ಸ್ಟ್
24.
ಸೇಮ್.
225.
ಪರವಾಗಿಲ್ಲ, ಎಷ್ಟನೇ 9ನೇ ಸರ್ತಿ ಇದು? ಓವರ್ರೂಲ್ ಆಗಿದ್ರೆ ಕೊಡಿ, ಓವರ್ರೂಲ್ ಆಗಿದ್ರೆ ಮಾಡಿ, ಇಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ಡ್. ಓವರ್ರೂಲ್ ಆಗಿದ್ರೆ ಮಾತ್ರ, ಎಸ್. ಓವರ್ರೂಲ್ ಆಗಿದ್ರೆ ಮಾತ್ರ, ಎಸ್. ನೆಕ್ಸ್ಟ್. ಕೋರ್ಟ್ ಯಾರು ಓವರ್ರೂಲ್ ಮಾಡಿದ್ರು? ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದಿಲ್ಲ, ಆಯ್ತು ನೋಡೋಣ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಲೆಟ್ಸ್ ಸಿ, ಒನ್ಸ್ ಅಗೇನ್ ಇಲ್ವೇ ಇಲ್ಲ, ಓವರ್ ಕೋರ್ಟ್ ಮುಂದೆ ಬಂದೇ ಇಲ್ಲ. 21/4/26 ಫಸ್ಟ್ ಟೈಮ್ ಬಂದಿದ್ದು, ಎಸ್. ಅಲ್ಲಿ ಹಾಕಿ, ರಿಜಿಸ್ಟ್ರಿ ಹಾಕಿ, ಎಸ್.
226.
ಸೇಮ್.
227.
My lords, 220.
ನೋ ಸರ್, ಅಯ್ಯೋ 2 ವರ್ಷದಿಂದ 2 ವರ್ಷದಿಂದ ಇಂಟ್ರೆಸ್ಟೇ ಇಲ್ಲ. ಈಗ ಡಿಸ್ಮಿಸಲ್ ಬಂದಾಗ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ನೆಸೆಸರಿ. ಐ ವಿಲ್ ನಾಟ್ ಸರ್, ನಥಿಂಗ್. 2 ವರ್ಷದಿಂದ ಯಾಕೆ ಇಟ್ಕೊಂಡಿದ್ರಿ ಸರ್? ಯಾಕೆ ಇಟ್ಕೊಂಡಿದ್ರಿ? ಒಂದು ದಿನಾನು ಬಂದಿಲ್ಲ, ಯಾಕೆ ಸುಳ್ಳು ಹೇಳ್ತೀರಾ ಸರ್? ತಗೊಳ್ಳಿ ಆರ್ಡರ್ ಶೀಟ್ ತಗೊಳ್ಳಿ. ಒಂದ್ ದಿನ ಬಂದಿದ್ಯಾ ನೋಡಿ, ಒಂದು ದಿನ ಬಂದಿದ್ಯಾ ನೋಡಿ. ವಾಟ್ ಎವರ್ ಸರ್, ವೈ ಡು ಯು ಅಟರ್ ಫಾಲ್ಸ್ಹುಡ್ ದೆನ್? ವಾಟ್ ಎವರ್ ಇಟ್ ಈಸ್ ಸರ್, ನೀವೇನ್ ಹೇಳಿದ್ ಇಂಟ್ರಿ ಬಂದೇ ಇಲ್ಲ, ಕೋರ್ಟ್ ಬಂದಿದೆ 3-4 ಸರಿ, ಎಲ್ಲಿ ಬಂದಿದೆ? ನೋ ಸರ್, ಅರ್ಜೆನ್ಸಿ 2 ವರ್ಷದಿಂದ ಇರಲ್ಲ. ಈ ಲಿಸ್ಟ್ ಆದಾಗ ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ. ಡೂ ಸಮ್ ವರ್ಕ್ ಸರ್, ಹೋಗಿ ಕಂಪ್ಲೈ ಮಾಡಿ ಸರ್. ಎಸ್, ಇದು ಮಾಡಿದ್ರೇನೆ ಸರಿ ಹೋಗೋದು.
27.
My lords, for office objection, they are mentioned as furnished charge sheet. The entire file itself got missing, my lords.
ಎಷ್ಟು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಮೇಡಮ್?
My lords, first is provisional order to be corrected. My lords, in that 5 objection I mentioned, my lords, provision to be corrected.
Dismissed,
correct,
go and comply.
No, my lords, overruled.
It is 9th time it is coming, 5 objections,
My lords,
yes.
all this be overruled, my lords.
No
The
sir,
files are not
nothing,
available because the file is
nothing.
missing, my lords.
File recalling, go comply, recalling application.
My lords, the file the application because of
9 ಸರಿ ಕಾಯ್ಬೇಕಾ ಸರ್ ಅದಕ್ಕೆ?
ಅದು ಫೈಲ್ ಮಿಸ್ ಆಗಿದೆ ಸ್ವಾಮಿ, ನಮ್ಮ ಹತ್ರ
ತೊಂದ್ರೆ ಇಲ್ಲ.
return
Yes. Next.
28.
Same order.
229.
Lordship, December we have
Then
filed it.
maintainability
Second time
na.
it's coming, Lordship. Lordship, not maintainable because we filed it 226. Why it's coming by 224?
That's the only objection I noted.
7 objections there. 7 objections
what
there,
is
Lordship.
that, sir?
Notification.
What is that, sir?
Certified copy of the notification.
What is that, sir? 7 objections.
Lordship, court fee is there that we already
Whatever,
paid.
sir. Should I, ನಿಮ್ಗೆ separate again pardon
Lordship,
ತೋರಿಸ್ಲಾ?
we are following
Should
it
I-
up.
No, all right. You may be following it up. ಎಲ್ಲ dismiss ಮಾಡಿದ್ನೋ ಇಲ್ವೋ ನಾನು? ನಿಮ್ಗೆ ಯಾಕೆ ಸ್ಪೆಷಲ್ ಟ್ರೀಟ್ಮೆಂಟ್?
The reason is that Lordship, they
Why
want
special treatment?
because it is Lordship, we never intended to file under 482.
That's not the only objection, sir.
Lordship, notification, certified copy of the notification.
Not the
Lordship,
only
kindly.
objection.
I will read it also.
One ನಿಮಿಷ sir. Page 23 to be stitched properly. ಇದು ಮಾಡಕ್ಕಾಗಲ್ವಾ? ಇದು ಆಗಲ್ವಾ? What the hell?
I have 7 pages.
What do you
It's
mean?
with me with 7.
Provision of law to be stated, certified copy quashing,
Of
proof of
notification.
petition of judicial custody to be filed,
He is
details of annexure B.
Lordship, he is in judicial custody. We have filed memo of parents.
File it, yes. ಯಾವ ವರ್ಷದ ಇದು? 25.
December.
Immediate file ಮಾಡಿ after vacation.
First week, meantime I will comply it. Lordship.
Yeah, no, first week you comply. Yes. Why special treatment you tell?
There's no treatment, Lordship, because the reason is that our objection in respect of
ಎಲ್ಲರಿಗೂ
provision of law.
ಎಲ್ಲರಿಗೂ
We don't want 42, we have 22.
ಅದೊಂದೇ ಅಲ್ಲ ಇರೋದು.
Submission also, Lordship, it is there.
What submission, sir? ಯಾವ submission ಇಲ್ಲ. Yes.
Reporting settlement.
You tell me why I should show special
Lordship,
concern.
because
ಇಲ್ಲ
482 we don't, we filed it 226. We are pressing for the 226.
ಅದೊಂದು objection I will overrule, sir. No problem.
Certified copy, notification we are challenging. Certified copy, where the notification, certified copy will get it.
ಬೇರೆ ಸ್ಟಿಚ್ ಮಾಡಕ್ ಆಗಲ್ಲ ಸರ್ ಸರಿಯಾಗಿ.
I'm sorry for that. If that's that thing, it is not there with me, Lordship, the objection that one.
Then
I'll comply it.
should you not go and see? Not stitched properly, prayer not proper.
What is happening? Sometimes we go and we don't get the file. That is a difficulty.
Why, sir?
But I'm not will take it to make it as excuse. Only my request is, Lordship, 2 weeks will be given. I will
You come immediately after vacation. You file a application for recalling. We'll do it. Yes.
Reporting settlement 230.
Serial number.
One submission, my lord.
214, my lord.
214.
ಅಲ್ಲ 215 ನಂದು ಸ್ವಾಮಿ, ಅವ್ರದ್ದು 214 ಆಗಿದೆ. ನಾನು ಕನ್ಫ್ಯೂಸ್ ಆಗಿ ಅದನ್ನ ಹೇಳಿದೆ.
ಏನಾಯ್ತು ಈಗ ಅದಕ್ಕೆ?
214 ಅಲ್ಲಿ ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಹಾಕಿದೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ. Yes. ಎಲ್ಲ ಎಷ್ಟೆಷ್ಟು ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಕಂಪ್ಲೈ ಮಾಡಿ.
ಒಂದೇ ಇರೋದು ಮೇಡಮ್.
ಒಂದೇ ಇದ್ರೆ ತೊಂದ್ರೆ ಇಲ್ಲ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಇದೆ. ಒಂದೇ ಇದ್ರೆ ನೋಡಿ ಮೇಡಮ್.
ಮ್ಯಾಮ್ 215 ಅಲ್ಲಿ 7 objections ಇತ್ತು ಸ್ವಾಮಿ.
7 objections ಇದ್ರೆ dismiss, nothing. ಎಲ್ಲ 7th time, 8th time, 9th time ಯಾರಿಗೂ ಬಾದರೇಶನ ಇಲ್ಲ ಹಾಕದ್ಮೇಲೆ.
ಅದು ಟೈಪ್ ಮಾಡೋದಕ್ಕೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು
ಅಯ್ಯೋ ಸ್ವಲ್ಪ ಟೈಮ್, 2 ವರ್ಷ. Yes.
Kindly, my lord.
No.
ಇನ್ನೊಂದು settlement ಇದೆ ಕರೀತಾರೆ.
ಅವ್ರದ್ದು ಯಾವ್ದು ಒಂದೇ ಅಬ್ಜೆಕ್ಷನ್ ಅಂದಿದ್ಯಾರು ಈಗ?
No, my lord.
6 ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ.
My lord, ಅದರಲ್ಲಿ ಮ್ಯಾನ್ಸ್ಕ್ರಿಪ್ಟ್ ಟೈಪ್ ಮಾಡೋಕೆ ಸ್ವಲ್ಪ ಟೈಮ್ ಬೇಕು ಸ್ವಾಮಿ, ದಯವಿಟ್ಟು.
Nothing. No, sometimes you have to be harsh. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ಇದನ್ನ ಏನು ಮಾಡಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡೋ ತಗೊಳ್ಳೋದು, ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೈ ಮಾಡಲ್ಲ. Yes. Next.
Reporting settlement ಆ ಕಡೆ ಇಟ್ಬಿಟ್ಟ.
230.
230.
ಏನದು?
Settlement, 498.
ಕೊಡಿ.
Both are there. Leave it together.
ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ಇದೆ ಇದು? ಒಂದೇನಾ?
2 matters. Actually 3 matters.
ಕೊಡಿ.
Remove the another matter. 230.
2 matters close ಕೊಡಿ.
3 matters.
4 years I file after.
200.
Respondent to.
Keep the file.
ಅದು ಕೊಟ್ಬಿಡಿ settlement. Yes, next.
Hard sheet signatures. 231.
Milords,
Joint memo for settlement.
Appearing for respondent.
Milords,
The POXO matter, my lords.
Folks, after vacation, yes.
Milords, here on the husband, it is only criminal intimidation, Milords.
No, sir, after vacation, yes. Any settlement, thane, it's not on merits, yes.
My lords, quoting settlement 232.
Offense,
My lords, SCS, prevention of atrocity of SCS.
ಆಮೇಲೆ
And then,
Appear for the second respondent, she is present.
ಕೊಡಿ.
Petition. the
Give it,
respondent, both are
yes,
present.
my
yes,
lords,
yes, next.
connected matter 230 list serial number,
Yes, next.
serial number 2. Even both.
Connected matter serial number 2 ಯಾವುದು?
6336.
Yes, ಆಮೇಲೆ
Asked. Yes, sir.
next,
233.
Obliged.
Hard sheet signatures.
next.
Milords 233 by lots.
233.
Offense,
498 by
ಕೊಡಿ.
lots, settlement ಆಗಿದೆ
Yes,
mediation.
ಕೊಡಿ. 235, 234 ಏನು? 234 ಏನು?
Settle my lords. What is here, my lords?
ಕೊಡಿ. Mediation ಆಗಿರೋದು ಕೊಡಿ. Page 135, N Vijay. Yes, next. 235,
235, my lord, for the petitioner. In this, it may be taken up after vacation, my lords, because
vacation.
we have
236.
already signed the agreement.
236, offense,
Complainant is present. SC/ST atrocity plus 118.
118,
Complainant also present.
236, yes, parties are present?
These all are present.
All right,
please,
yes,
Lord.
next.
Hard sheet signatures.
237,
Lordship, for petitioner, your lordship, kindly have it after.
after vacation. 238,
To the petitioner, my lord, offense of dacoity, my lord. pardon.
Dacoity,
Please, my lord, however, the petitioner was never arraigned in the FIR. There's no allegation against him. He's a police inspector of the Chamarajnagar station. He was at the spot along with his team based on source information.
yes.
Subsequently, IU has recovered counterfeit notes as well, my lord. But there's nothing.
Anyway, stay ಇದೆಯಲ್ಲ,
My lord, no, it's a fresh matter, my lord.
we'll take it after vacation.
Please, settlement complaint is present, but
But because it is dacoity,
Please,
please,
my lord,
yes. After vacation, immediately.
grateful.
Dr. List 233 ma'am.
Sorry.
239.
RE policy. ಅದು ethanol ಮುಗಿಬೇಕಲ್ಲ? I have to hear ethanol now. Immediately after vacation, 2nd June.
On the report.
No, 2nd June at 2:30 PM. Intermodal will be continuous.
241 settlement.
241 settlement.
Please.
Offense ಏನು?
ಅದೇ masjid, the hospital case, all parties. 241, 42 and 43.
240 ಏನು madam? Further hearing.
ಅಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮೇಲೆ 4 o'clock. ಒಂದು ನಿಮಿಷ.
Oh, wait. Wait. Yes. 241, 42, 43 closed.
Please.
Huh?
ಇದೆ.
Out sheets. ಎಲ್ಲರೂ ಇದ್ದಾರಾ? ಇಲ್ಲ ಹಾಸ್ಪಿಟಲ್ ಇದ್ದಾರಾ? ಹಾ, ಸರಿ.
My lord, 245 and 246, my lord.
ಹಾ.
Mediation is going on between the
It is
parties. It
after
may be
it will come after vacation.
244, my lords.
244 also after vacation. ಇಲ್ಲ ಇದು further hearing ಹಾಕಿರೋದು for a purpose. We'll list it after vacation.
Lord, list 3, serial
Reserved. Yes.
Please.
list 3, serial number 4, my lord, bail matters 2025.
Bail ಇದೆಯಾ ಇವತ್ತು?
ಲಿಸ್ಟ್ 3 ಒಂದಿದೆ.
Connected matter
List
ನಾಳೆ
3,
ಇದೆ.
my lord.
Connected
List
matter, my lord, is before the coordinate bench, my lord. My lord, it may be tagged along with, my lord.
ಇದು bail matter ನಾಳೆನೇ ಹಾಕ್ಬಿಡಿ ಮೇಡಮ್.
My lord,
ನಾಳೆ
list
ಬರುತ್ತೆ.
3, serial number 4, ನಾಳೆ coordinate bench ಮುಂದೆ connected matter ಇದೆ.
ಆಯ್ತು ಇದು ಟ್ಯಾಗ್ ಆಗ್ತದೆ.
It may be tagged along with, my lord.
ಆಯ್ತು.
Passed over matter, your lordship.
Wait, sir. Yes.
230 moot matters. Courting settlement. Bill number 1, Sri Avinash P.
Lord, it covers a judgment, my lord, where, my lord?
Offense.
498A, this is maintenance, my lords. They have settled, my lords. In this moment, my lords, the wife is not coming before this.
After vacation. Yes.
Allah,
judgment is as.
After vacation.
When,
yes.
when she enters to the settlement.
After vacation, yes. Next. Next.
One date maybe.
5th at 4 PM to report settlement.
She is not at all coming.
5th June.
Settlement ಆಗಿದೆ ಅಯ್ಯ ಹಾಕಿದೆ.
Yes.
Please.
Next.
Number 3, see Sagar in.
Petition settlement.
Offense.
498.
Next.
Obliged.
For withdrawal, seal number 4, Shitesh Kumar.
After vacation. Okay. Withdrawal.
All of them are withdrawn.
ಎಲ್ಲ withdrawal.
8, 9, 10, 11 access.
Dispose.
Bail matter is serial number 5, my lord, in list number 3. He can, charge sheet has been filed.
Bail?
Yes, my lord.
I'm appearing behalf of petitioner in list 3, item number 5, my lord.
Call out ಮಾಡ್ಬಿಡಿ madam.
List number 3, orders, seal number 1.
ವಿಖ್ಯಾತ್.
Cancellation of bail.
ಇದಾ?
ಹೌದು. Connect.
Complainant.
Correct. Connect matter is stay in the investigation again.
List after vacation. Yes.
Seal number 2.
ಮಧುಕರ್. ಇದು ಅಷ್ಟೇನೆ cancellation of bail. List after vacation.
Seal number 3.
ನಾಳೆ. Yes.
Seal number 4.
My lords, it has to be connected. I'm
4 ಅಷ್ಟೇ same. Serial number 5.
Orally, charge sheet has been filed.
Yes, madam. Charge sheet you. ಆಯ್ತು ಬಿಡಿ connected matter. Yes.
5.
What's appearing on behalf of petitioner, lords in 5.
Charge sheet has been filed. Let him approach the trial court.
You approach the trial court again when on the change circumstance. ಇಲ್ಲ ಅಂದ್ರೆ ಬಿಡಿ next ಬರ್ಲಿ after vacation. Yes.
We'll approach, my lord.
ಏನು offense ಏನು?
Offense is 310, my lords. My lords, also, my lords, there is inordinate delay in filing of complaint, my lords, 1 day.
But anyway, charge sheet has been filed. Let him approach the.
Lords, it doesn't
It's
have
better
any
ಅಲ್ವಾ?
antecedents also, my lords.
ಆಯ್ತು ಬಿಡಿ ಬರ್ಲಿ. List before the regular court day after tomorrow.
Obliged, my lords.
Yes. ಇನ್ನೇನಿದೆ ಮೇಡಮ್? ಕರೆಕ್ಟ್.
Passport matter. One number 1.
233.
Correction, your lordships, instead of 2 to 5, it's 2 to 6.
What is that?
Citation, man.
For what?
Yesterday I could not reach here.
Which one?
Hubli matter.
ಯಾವ ಹುಬ್ಳಿ ಮ್ಯಾಟ್? ರಿಸರ್ವ್ ಆಗಿದೆಯಾ?
Reserve ಆಗಿದೆ.
ಕೊಡಿ. 14% ತೊಗೊಳ್ಳಿ ಕೊಡಿ.
Thank you, my lord.
ಕೊಡಿ. ಏನ್ ಕರೆಕ್ಷನ್?
Lordships, 2 to 6, it has to happen instead of 2 to 5, your lordships. 6 is also the family member only.
ಇದು
First petitioner.
ಅಕ್ಯೂಸ್ ಕೊನೆಗೆ ಕ್ವೆ 2 to 6 till the next date of hearing. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಕರೆಕ್ಷನ್ ಮಾಡಿ ಅಪ್ಲೋಡ್ ಮಾಡಿ.
Passport matter. List number 2, seal number 10.
ವಿನಾಯಕ್,
Let him not argue at this, sir.
ನೀವು ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ನಿಮ್ಮ ತಗೊಂಬಿಡಿ, ಅವ್ರದ್ದು ಏನ್ ಮಾಡ್ಕೊಂತಾರ ಮಾಡ್ಕೊಳ್ಳಿ. ಯು ಟೇಕ್ ವಾಟ್ ಎವರ್, ನೀವು ಕಂಪ್ಲೇಂಟ್ ತಂದು ನೀವು ತಗೊಂಬಿಡಿ, ಮತ್ತೆ ಅದು ಬರಲ್ಲ.
ಅವ್ರು ಇನ್ನು ಆನಂದ್ ಅವ್ರದ್ದು ಚೆಕ್ಸ್ ಕೊಡ್ಬೇಕು.
ಕೊಡ್ತಾರೆ, ಎಲ್ಲ ಕೊಡ್ತಾರೆ, ನಿಮ್ದು ಏನೇನಿದೆ ಎಲ್ಲ ಕೊಡ್ತಾರೆ.
Subject to he returns the pronote which he claims that he has not produced
That he will give, sir. What is it? He will definitely give.
Pending, don't worry about that.
My lords,
Petition and close ಮಾಡ್ತಾ ಇಲ್ಲ ನಾನು.
My lords, he is using this code to settle the others amounts. My lords,
ಮಾಡ್ತಾ ಇಲ್ಲ
if he is continuing, I will
stop
argue on
it.
merits, my lords.
I told you.
My lords.
Yes, ಇವ್ರದ್ದು ಕೊಟ್ಬಿಡಿ ಈಗ.
My lords, I am right. My instructions are there, my lords. If he is continuing like this, that he has to insist for others' money, I am not going to pay him. I will continue with the argument.
He is ಅವ್ರ ದುಡ್ಡು ಕೊಡ್ತೀರಾ?
ಅವ್ರದ್ದು pronote
ಇದೆಲ್ಲ ಯಾಕೆ ಮತ್ತೆ ಟ್ರಯಲ್ ಲೆಟ್ ದಿ
Yes, my lord.
ಟ್ರಯಲ್ ಗೋ ಆನ್.
Any date, my lords, I will argue on merits. My lords.
We'll dismiss it now. Ashok.
I'll have one submission. my
Lordships
lords.
have,
In respect of
your
the
lordships have
merits-
heard it, my lord, let it be dismissed, my lord. That's the only argument.
My
There's
lords,
an offense against the
I
society.
have never placed any other things before my lordships because my lordships of the letter and spirit, my lords, that his amount as a complaint to be settled. My lord, now he is pushing me to settle somebody's amount who is unparticularized items he is mentioning.
Your complaint ತಗೊಂಡ್ಬಿಡ್ಲಿ.
It is completely unacceptable, my lords.
Complaint, petition will be pending, complaint ತಗೊಂಡ್ಬಿಡ್ಲಿ.
This hour, my lord, he wants to
ಅವ್ರು
talk
ಕೊಟ್ಬಿಡಿ
Bible, my lord, you know, let him
Vinayak,
talk. I have no issue.
whatever you have to give it.
My lords, one pro note which he claims he has, I have no idea
That he will give, sir.
he has to give, my lords. He has to return that.
ನಾನು ಕೊಟ್ಟ ಮೇಲೆ ಕೊಡಿಯಪ್ಪ ಅದಕ್ಕೇನಿಲ್ಲ ನಾನು ಕೊಟ್ಟ ಮೇಲೆ ಅದನ್ನ ಕೊಡಿ
Alala, correct. But my lords, he is using this court as a settlement. My lords, he is pushing me to settle. Civil court allu itar illu bandbiಟ್ಟು.
ಇವ್ರದ್ದು ಕೊಟ್ಬಿಡಿ, ಮಿಕ್ಕಿದ್ ನೋಡೋಣ.
My lords, if he is continuing with the others, my lords, I may be permitted.
No, sir. ಅವ್ರದ್ದು ಕೊಡಿ. We will post it on 5th June. By then you settle everything. That's because he's a council, I'm telling. Give it, ಕೊಡಿ ಎಲ್ಲ.
Please, my lords, before that, my lords,
6,50,000.
one request, if I may, my lords, I may be permitted to pass on one affidavit, in which I have mentioned that what is the amount he has paid and what I owe him. My lords, as a matter of fact, I have paid him 16 lakhs in lieu of 8 lakhs what he has paid. But still now I am giving a check of 2 lakhs, my lords, which he should admit that his money is returned.
6,50,000.
ಇಷ್ಟೊತ್ತಲ್ಲಿ ಕಂಡೀಷನ್ಸ್ ಎಲ್ಲ ಹಾಕ್ಬೇಡಿ,
Alla
ಚೆಕ್
condition.
ಕೊಡಿ.
My lords, if I don't do this, my
6,50,000.
lords, I may not be
That's the
doing justice to
principal
the entire matter, my lords. What has happened, my lord, kindly see, entire, my lords, on affidavit, I am placing that what is the amount he is due.
ಈಗ ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಈಗ ಎಷ್ಟು ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೀರಾ ಕೊಡಿ.
ಎರಡು check ಕೊಡಿ.
Without prejudice to both of your contentions, you accept it, I'll take it on 5th. We'll close it on 5th. All right.
Please, I'm issuing 2 checks to him, my lords.
ಎಷ್ಟು ಚೆಕ್?
ಎರಡು ಚೆಕ್ 1 ಲಕ್ಷ.
1 ಲಕ್ಷದ ಎರಡ?
ಇಲ್ಲ 50,000 ಎರಡು. My lords, what has happened yesterday, the last instance, my lords, whatever I had given.
ಎಷ್ಟು ಬರ್ಬೇಕು ಆನಂದ್ ನಿಮ್ಗೆ?
6.5 ಲಕ್ಷ.
6.5 ಲಕ್ಷ ಪ್ರಿನ್ಸಿಪಲ್ ಅಮೌಂಟ್.
ಇಲ್ಲ, in fact, my lords, I have paid 7 lakhs more, which I am placing on affidavit. He has not placed
ಆಯ್ತು,
one
ಅದು
single
ಕೊಡಿ
item.
ಅವ್ರಿಗೆ. Affidavit copy ಕೊಡಿ.
Affidavit I am filing.
Place the matter on 5th June for further hearing.
Please.
Yes.
And 2 checks, my lords, 1 lakh I have.
ಏನ್ ಬೇಡ, ಅದು ನೀವೇ ಇಟ್ಕೊಳ್ಳಿ. ಬೇಕಾ ಈಗ?
ಬೇಡ.
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 Yes.
I'm placing
ನೀವೇ
it.
ಇಟ್ಕೊಳ್ಳಿ. Yes. We'll pass appropriate orders on 5th. All right? Yes.
Greatly obliged.
Obliged.
My lords, he grossly misused the generosity which this court extended. My lords.
Adjournment ಆದ್ಮೇಲೆ argument
Well,
ಯಾಕೆ?
just I want to bring the notice to this court, my lords. In the letter spirit mediation allee, he claimed for all others and came back with failing the mediation, my lord. In letter spirit, my lords, as per the direction, the instructions issued by lordships, I went to mediation. I assured, my lords, I may be permitted to place each and everything that all others also have issued the notices. I am asking them to come and immediately, my lords, cancer patients is
Fifth.
my lords, cancer patient is not a complainant in his complaint.
ಅಯ್ಯೋ
only.
5ನೇ ತಾರೀಕು.
Are your clients watching on the YouTube? Then come, let's see.
ಇಲ್ಲ, ದೀಪಂ ಸಿಲ್ಕ್ಸ್ ಅವ್ರು ಇಲ್ಲೇ ಇರ್ತಾರೆ
ಅಲ್ಲ
ಬಿಡಿ.
ಇಲ್ಲೇ ಇದ್ದಾರೆ ಅವರು.
ಮತ್ತೆ
The director is here.
This court knows well, my lords. It's not for the video. It's not for my lordships.
Come, we'll go.
Yes. ಹಾ
63, 64, 65.
Jargold, not for the petitioner. Not
ಇದು
the- can I-
ನೀವು ಲಿಸ್ಟ್ ಕೊಡಿ ಏನೇನ್ ಬೇಕು ಅಂತ, ಸ್ಯಾಲರಿ ಕೊಡಕ್ಕೆ ಅದೆಲ್ಲ ಕೊಡ್ತಾರೆ ಅವರು.
Not GST, I need to pay last year, I have paid, 260 crores GST, for the financial year 25-26, not salary and not GST, and not day-to-day expenses would be fine. Or let the gold remain there.
Yes.
No, 2 things.
GST.
Considered for salary and GST.
ಅಷ್ಟೇನೆ ಕೇಳ್ತೀರಾ? This
Not
court
day-to-day running.
on ಎಲ್ಲಿ ಅದು ಆರ್ಡರ್ ಮೇಡಮ್ ಜಾರ್ಗೋಲ್ಡ್ ಅವರು? This court on 16/4/2026 had passed the following order. The learned counsel P. Prasanna Kumar submits that a detailed list of necessities would be placed before the respondent investigating officer with regard to the salaries, the GST or any other statutory payment to be made in
Not
the event.
For day-to-day running, little expenses for day-to-day running the business.
Day-to-day
I'll
running.
place accounts.
You're not opening the office.
I'll place the
GST
accounts.
also, in the event the petitioners would file necessary application before the and place it before the investigating officer, the account shall be defrozen to that effect. This is in amplification of the order dated 16/4/2026. List the matter on 7th June, 8th June.
Please.
ನನ್ನ ಹತ್ರನೇ ಬರ್ಬೇಕು.
Please, please.
Yes.
All three matters.
Huh?
Three matters.
All the three. Yes.
67.
Appearing for petition, Your
Ah.
Lordship. Relaxation of condition for vehicle release, Your Lordship. That
67, 69 here it is.
67 and 69.
ಯಾರು ಮಾಡಿದ್ರು ಬರೆಯಕ್ಕಾಗಲ್ಲ. Day after tomorrow will take. Please day after tomorrow. ಎರಡು ನಾಡಿದ್ದು ಬರೆಯೋಣ.
Great, Your Lordship. The fresh matter, Your Lordship.
Fresh matter.
CID resolution.
Next. ತಗೊಂಬಿಡಿ.
ಸಬ್ಮಿಷನ್ ಇದೆ ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 24 ಮೈ ಲಾರ್ಡ್. ಅದರಲ್ಲಿ ಡೇಟ್ ಹೋಗ್ಬಿಟ್ಟಿದೆ. ಸ್ವಾಮಿ ರಿಪೋರ್ಟಿಂಗ್ ಸೆಟಲ್ಮೆಂಟ್ ಇತ್ತು. ಮ್ಯಾರೇಜ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಆಗಿದೆ.
ಯಾವ್ದು ಪೋಕ್ಸೋನಾ? ಬರ್ಲಿ, ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ?
ಅದು ಇವತ್ತಿಗೆ ಮುಗ್ದೋಗುತ್ತೆ, ಸರೆಂಡರ್ ಆಗ್ಬೇಕು. ಇವತ್ತಿಗೆ ಮುಗ್ದೋಗುತ್ತೆ, ಸರೆಂಡರ್
ಅದು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀನಿ. ಅದು ಡೋಂಟ್ ಎಂಟ್ರಿ ಮಾರ್ಡರ್ ಸ್ಟ್ಯಾಂಡ್ ಸೆಕ್ಷನ್ ಇಡ್ ಮಾಡಿ. ಅದು ಡೋಂಟ್ ವರಿ. ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದೀನಿ ತಾನೆ?
ಸ್ಟೇ ಕೊಟ್ಟಿದ್ರಿ ಸ್ವಾಮಿ. ಮತ್ತೆ ಜಸ್ಟಿಗೆ ಸರೆಂಡರ್ ಆಗ್ಬೇಕಿತ್ತು ಇವತ್ತು.
ಐ ವಿಲ್ ಎಕ್ಸ್ಟೆಂಡ್ ದಟ್. ವಿಲ್ ಪಾಸ್ ಎನ್ ಆರ್ಡರ್ ಆಫ್ಟರ್ ವೇಕೇಶನ್.
Serial number.
ನೀವು ಮಗು ಕರ್ಕೊಂಡ್ ಬರಕ್ ಹೇಳ್ಬೇಡಿ ಅಂತ ಹೇಳಿಲ್ವಾ ಅವತ್ತೇನೆ? ವೈ ಡು ಯು ಟ್ರಬಲ್? ಎಸ್.
Serial number.
Serial number 24.
ಲಿಸ್ಟ್ 24. ಅದು ಎಂಟ್ರಿ ಮಾರ್ಡರ್ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬೇಕು, ಇಲ್ದಾರೆ ಜೈಲ್ಗೆ ಹೋಗ್ಬೇಕಾಗತ್ತೆ ವಾಪಸ್. ಎಸ್, ನೆಕ್ಸ್ಟ್.
Matter pertaining to Dharwad bench passed over.
Lordship may have to take 10 minutes.
Huh?
Lordship may have to take some 10 minutes.
ಎಲ್ಲೇ 10 ಮಿನಿಟ್ಸ್ ನೋಡೋಣ. ಎಸ್, ವಿಲ್ ಸಿ ಮೇಡಮ್. ಕರಿ ಬರ್ಲಿ ಅವ್ರೆ.
I have one, I'm sorry.
ಹಾ, ಪೋಯ್ ಸರ್.
Sorry, my lords, I have one request, my lords. I'll make that request. My lords, senior Mr. Holla is there, my lords, but my request is if senior permits me 10 minutes, because
Your Lordship had asked us to
Ethanol
wait.
matter.
Not the ethanol.
Oh, 1 minute then. Let me finish.
Or petrol, Your Lordship.
Well, let me finish that.
Please.
Sir.
5 minutes, my lord, go back and come.
I'll come back 6:45. Yes. Attorney sir is also waiting.
No. We will wait till the record should come.
So I'll come back.
Not fair on our part, my lord. Make your lordship, my lord. Till this 2:30 to 6:30 is not 4 hours.
We'll come back.
5 minutes.
Just clear all the things. I'll just
I'll keep this one.
Then I'll clear it. No, within that time, I'll no, somebody will come.
ಎಲ್ಲ ಮಿಕ್ಸ್ ಆಗಿದೆ. 5 ನಿಮಿಷ ಇದೆ. Ma'am?
ಸೆಟಲ್ಮೆಂಟ್ ತಾನೆ ಆಗುತ್ತಾ? ಫೈಲ್ ಇಲ್ವಾ? ನಾಳೆ ಬರುತ್ತೆ. ಇಟ್ ವಿಲ್ ಕಮ್. ಎಸ್, ಸೆಟಲ್ಮೆಂಟ್ ತಾನೆ. ಆಯ್ತು, ಆಗುತ್ತೆ ಬಿಡಿ. ಯು ವಾಂಟ್ ಟು ಲೀವ್ ದ ಕೋರ್ಟ್? ಮಾಡ್ತಾರೆ, ನಾಳೆ ಬರುತ್ತೆ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿ ಬರುತ್ತೆ. ಯಾವುದು ಲಿಸ್ಟ್ 3 ವೇಲ್ ಮ್ಯಾಟ್ರಾ? ಯಾಕೆ ನಾಳೆ ಎಲ್ಲೋ ಕನೆಕ್ಟ್ ಆಗಿದೆ ಅಲ್ಲ ಅಂದ್ರಿ? ಲಿಬರ್ಟೀಸ್ ರಿಸರ್ವ್ ಮೂವ್ ದ ವೆಕೇಶನ್ ಬೆಂಚ್. ಇಲ್ಲ, ನನಗೇನು ಬ್ರೇಕ್, ಅವರು ಇಲ್ಲಿ ಹೋದ್ರ ಬರಕ್ಕೆ. Yes, who's going to start?
My lords, I have taken senior Mr. Holla's permission, my lords, to go before him. He has permitted me, subject to you, my lords, permitting me. I'll take not more than 10 minutes.
Sir, Holla sir permit ಮಾಡಿದ್ಮೇಲೆ ನಾವೆಲ್ಲ permit ಮಾಡ್ದಂಗೆ.
I'm grateful, and I'm grateful to my senior.
Madam, ಇರಿ. Yes. ಅಲ್ಲ, ಪ್ರಭು ಸರ್ ತಾನೇ ಇರೋದು ಜೊತೆಗೆ? Opposing you, all right. After this, yes.
My lords, may I?
Yes, sir. Yes.
Yes, ma'am. My lords, not 10 minutes by the clock, even less than that.
Yes,
my lords, the learned attorney, my lords, has taken your lordships through the contract. I will not repeat any one of them. I'm adopting each one of those arguments. My lords,
yes.
Who are we? We are interveners, my lords, who are about 12 in number, who generate, my lords, ethanol. And there are, my lords, 3 factual matters that I will place.
Attorney sir is left. All right. Yes. No problem. Yes, sir. Yes, Poe, sir. Yes.
Yes, my lords. My lords, as much as my esteemed friend Mr. Navadgi's clients are, my lords, dedicated plants, we are dedicated plants as well. Therefore, my lords, on an article.
One clarification, Poe, sir. You are not the ones with whom agreement is entered into.
That is correct. That's the only distinction, my lords. Yes, my lords, we do not have, therefore, in my submission, my lords, 3 categories. There are ethanol manufacturers generally. Within that ethanol manufacturers, there are dedicated ethanol plants, my lord, DEPs, which we belong to as much as the petitioners. The only distinction is the petitioners have a long-term offtake agreement, LTOA. We do not have an LTOA.
Yes.
Therefore, my lords, to the extent of 1.44 crores, which is committed in that LTOA, we certainly cannot claim a right over and above that because, my lords, they have an LTOA, we don't. But the crucial aspect, my lords, in this particular tender is that in as much as the LTOA agreements were entered into by the petitioners after an expression of interest process, and that expression of interest protected the LTOA quantum no doubt in their favor and indicated that for anything in excess of the LTOA quantum, they would fall within the ethanol procurement policies of the government, which the learned attorney has, my lords, sanctioned. In that light, please see, my lords, where we stand. When this tender was called, we participated. Now, please see at page 99, my lords, which was shown in that expression of interest. I'll not take trouble your lordships to go through. There is, my lords, we have filed an additional affidavit. The learned attorney, my lords, in the convenience compilation also put it. Now, my lords, in that expression of interest which was issued when the LTOA agreements were signed by the petitioners, that expression of interest indicated that Karnataka was allocated, my lords, 18 crore liters.
Correct.
And within that 18 crore liters, my lords, whoever got the LTOA contracts got it. For a minute, my lords, whilst I had much to say in terms of the contract clauses, etc., please keep it by for a minute, my lords, because the learned attorney has said all of it. Please see the tender inviting condition and the tender condition, which is now, my lords, in court, which in my respectful submission has not been challenged by the petitioners. In fact, the
tender is not challenged, correct.
Correct. Therefore, the petitioners, in as much as we participate under a tender, receive certain letters of award in our favor. Having received the benefits of the tender, The only question is, can I then, my lords, approbate and reprobate and then say that a tender condition which is based on which that there is a letter of award issued, that condition should not be implemented. My lords, your lordships have held from Kamadhenu cattle feeds, in fact, your lordships indicated, from G.J. Fernandes, Kamadhenu cattle feeds, Tata Cellular downwards. The jurisprudence laid down by this honorable court and the Supreme Court is, my lords, 2 counts. 1, a tender condition cannot ipso facto be challenged because that is the realm of contract. Either you participate with those conditions or don't participate, walk away from it. But if you find that a tender condition is expressly violative of either a fundamental right or, for that matter, a statutorily recognized contractual right, then you have to, my lords, call that tender in question before you participate in the tender, indicating that I will not bid under those parameters because that bid condition itself erodes me. But that is not done. The petition filed before your lordships, the initial prayer was, I have given a representation to take more than 1.44 crores because I have 9 crores. Please get them to consider. The amended prayer is, please direct them now to take what I have in terms of my design capacity, etc. For a minute, my lords, please see the tender condition now, which is, my lords, in the writ petition itself. I will trouble your lordships with just one condition and then, my lords, stop at that condition itself. Please see, my lords, at page number 72 is the tender document. That is the notice inviting tender by the all marketing companies. Please straight away come to, my lords, page number 84.
Yes, sir.
My lords, kindly see in 84 at the middle of the page. Preferential allocation to cooperative sugar mills and dedicated ethanol plants, DEPs, having LTOA. That is the petitioner here. Cooperative society, nobody is questioning. They have first priority. And then, my lords, comes the dedicated ethanol plants having LTOA. My lords, please ignore the next 2 paragraphs of it because I don't question that LTOA has got that priority. Please see, my lords, the 3rd paragraph thereafter. In case any DEP, after, my lords, Roman 2, in case any DEP does not meet the above criteria, no preferential allocation will be given for such offered quantity, and the allocation shall be done as per the allocation criteria applicable to non-DEPs. Now, please see the next paragraph, my lords. For all DEPs under EOI 1 and EOI 2, additional quantity offered, if any, beyond the long-term offtake quantity, which is pro rata calculated on quarterly basis, shall not be considered for preferential allocation. Allocation of this additional quantity offered shall be done as per allocation criteria applicable for non-DEPs. Therefore, up to 1.44 crores, certainly they have priority. But beyond 1.44 crores, that is the delta between the LTOA quantum and the design capacity. The design capacity being what is hinged for the LTOA agreement, no problem. That delta, my lords, the contract, the tender condition says, will not be considered for preferential allocation. Now, my lords, 2 submissions. Either the argument is that this tender condition, which is at page 84, is in direct contradiction to 6.8 can be an argument. If it is, then, my lords, when they participated in the tender, the least that is expected is that the tender condition, my lords, then is challenged for 2 reasons I say so. Your lordships have held that legitimate expectation arises not in vacuum. It arises based on the tender inviting conditions, that my legitimate expectation is under those conditions I will be treated fairly and in juxtaposition to everybody else equally, and therefore I will get a treatment. Now, what is the condition? 1.44 I will get preference. They got it. In fact, they got 3.6 crores. Now, my lords, after 4.36, etc. 3.92, my lords, I'm sorry.
Yes, 3.9, correct.
Yes. 3.92, my lords. Now, in addition to 3.92, if they have to get even 1 liter, then that goes, my lords, in the additional quantity offered, which the tender says now there will be no priority. Well, the minute that tender condition continues to stand, respectfully, the petitioners can't claim legitimate expectations before your lordship to say, I have put up a design capacity of 9 crores. That was known in the subvention scheme. I was given a dedicated ethanol status. Therefore, now please consider me. My lords, the one other corollary submission to it. This would mean that they are expecting your lordships as a constitutional court to, my lords, therefore implement their contract over and above, my lords, a tender condition which stares in their face, which condition till date has not been challenged. And my lords,
in the teeth of no challenge.
In the teeth of no challenge, my lords. And therefore, if there is a problem, my lords, in the LTOA agreement to say 1.44 shouldn't be the number, 9 crores should be the number, The LTOA itself has a dispute resolution mechanism which requires, my lords, arbitration under clause 22.3 of that LTOA. Now, if the petitioners believe that the oil marketing companies are not abiding by it, they could have invoked arbitration. No arbitration is invoked, which means the contract stands as it is. Now, if there is a contract which is a bipartite or a tripartite contract, and there is a tender, my lords, which is actually an in rem document calling for offers, and based on the invitation to treat, I have made an offer and there is a concluded contract in my favor. May I, my lords, respectfully place this question? Would they then ask your lordships to give the first contract, which is a bipartite or tripartite contract, weightage over a contract that has come out, my lords, by a tender discovery, which, my lords, has not been challenged? That, my lords, is the fulcrum of my submission. My lords, the second submission, my lords, which I make before your lordships is, for anybody to claim, my lords, legitimate expectation in terms of saying that I have procured, I have built a capacity which is a design capacity, and therefore I have generated ethanol in that capacity, you now, the procuring entity, must buy that. My lords, that would be to benchmark, my lords, that they have a particular right, statutory, contractual or otherwise, for that procurement. And number two, my lords, that right overrides any other tender condition that has, my lords, been imposed. For which my respectful submission is that can't be the case, because they are dedicated, I am dedicated. How am I dedicated, my lords? I'll indicate. They are dedicated because, my lords, in 2021, because loans were not coming to those companies, for the interest subvention and the banks to be guaranteed, these tripartite contracts came about, my lords, where they said that where the government indicated that we will give you a guaranteed offtake, therefore the banks will give you loan, and therefore, but you will dedicate your capacity to me. But that dedication was, my lords, not limited to oil marketing companies of the public sector alone. That dedication, my lords, also applied to Naira and Reliance, which are the private sector entities. My esteemed friend, my lords, for the petitioners indicated that there is no private procurement. My lords, I have submitted, there are two private procurements that have occurred by Naira. My lords, those tender documents are at, my lords, page 65 of the additional affidavit I have filed. At page 65 is the Naira tender. At page 43 is the Reliance tender. 110 crore liters have been procured by those two entities from these DEPs and non-DEPs. Why am I a DEP, my lords? Although I don't have an LTOA, the LTOA at best, my lords, gives them that dedicated status and that procurement for 1.4. In my case, when I established my plant for environmental clearance, there was a notification under the Act which indicated that if you want accelerated environmental clearances for these plants, you will provide an affidavit and dedicate your facility as a DEP only to the oil marketing companies, only subject to which environmental clearance was given, and all of us did it. All the interveners, my lords, in my IA did so, and we are today, my lords, dedicated. We cannot supply to anybody else except the 4 state oil marketing companies and the 2 private companies. Well, in that light, my lords, my respectful submission is there is no difference whatsoever in the status that we both have. The only difference is up to 1.44 crores, the petitioners have a preference. Anything beyond that, my lords, even this 3 point, in fact, I should have been challenging it, saying how are they given 3.9 crores? Because they should all fall in the same bracket, my lords, and then go by lots. But I am not challenging it because I have got, my lords, my due. In that light, my lords, in the contract, please see one clause, my lords. I will not trouble your lordships with the clause to read the clause. My lords, in the clause 2.2, my lords, indicates what the design capacity is. And fortunately for me, in this contract, the petitioner's design capacity is only, my lords, 1.44. And in 2.4, there is a specific undertaking that the petitioners will not object to the oil marketing companies procuring the ethanol from anybody else. And they will not seek compensation for anything, my lords, in excess that has been procured. My lords, therefore, my prayer, my lords, is limited to this issue. There is a tender called. The learned attorney has put, my lords, the sequence on which the tender has been issued. We are, my lords, a surplus state. Out of the 18 crores, my lords, whatever is allocated. My lords, respectfully, if the petitioner's argument must fly and his relief must be granted, the entire allocation which is given to me as non-DEP will stand scuttled, my lords, and we will be left possibly with 5 or 6%. With which, my lords, if they are not, they say that they will go into a financial doldrum. Reciprocally, I am a dedicated plant. I will go into a financial doldrum. My lords, last submission I make is, my lords, in the light of, again, GJ Fernandez and Tata Cellular, no challenge to the tender is death knell for them, my lords. Reciprocally, I will also make one other submission and stop. They could not even have challenged this tender condition because, my lords, your lordships have held that a tender condition can be challenged only if it can be shown to be, my lords, either manifestly arbitrary or eroding a statutory right or, my lords, a constitutional right. This is only a scenario to say, I will not give you priority. At best, it prevents a contractual right, which gives them a cause of action, my lord, to arbitrate under the contract. Therefore, my lords, my prayer is that the prayer as sought by the petitioners ought not to be granted. Whilst, of course, the petitioners have a priority for 1.44, which I am not, my lords, limited to my interlocutory application, I am not challenging it. That's, my lords, my respectful submission. I'm grateful, my lords, for the opportunity, and I'm grateful to my senior, my lords, for having let me go in pride. He's senior to me, my lords, he's my guru, and I'm grateful for it.
ಎಲ್ಲರಿಗೂ ಹೌದು.
What I'm making. Please look at, my lord, the LTOA itself. It is signed, my lord, if you look at page 146 of the, my lord,
Convenience compilation.
Yes. It is signed at Mumbai.
Yes.
Please look at the bottom.
Yes.
Now, my lord, please come to page 163, clause 21. Exclusive jurisdiction, my lord, in Mumbai.
A dispute resolution.
This is, my lord, the dispute, my lord, that they are raising. This is one. That's why I said technical. Second thing is, they have suppressed, my lord. If you are not to look at, my lord, they prepared a convenience compilation because their writ petition was inconvenience for them. For this simple reason, they did not produce, my lord, that EOI 1. I'll tell your lordships why, my lord. Can I request your lord to look at, my lord, page 77? That's, my lord, where it starts. Please come to
the compilation.
Yes. Please come to, my lord, page 90.
Yes, sir.
Inconvenient, my lord, for them in the writ petition because this was not produced in the writ petition. Please have a look at the writ petition. This was not there. I'll tell
Yes,
you,
sir.
lordships, why.
Yes.
Please come to, my lord, page 90. Procurement process. My lord, the tender itself specified in what manner we will, my lord, purchase later. Please look at this, my lord. Procurement process. Supplier shall, after successful commissioning of the ethanol plant, need to participate in the prevailing ethanol procurement process, which is the process followed by OMCs for procurement of ethanol. This process is guided by the directions, advice issued by the MNOP, that's the Ministry of Oil and Natural Gas, and Government of India from time to time. 2. Supplier will register himself with OMCs, BPCL, through a vendor registration process in order to participate in the bids. After successful registration, supplier will participate in the quantity bids floated by the OMCs for their location-wise requirement of ethanol. Location-wise, my lord, becomes extremely important because the whole, my lord, I'll tell you, lordships, my lord, because if your lordships look at, my lord, the tender itself, they have, my lord, indicated, my lord, various states. Page 78. What state? How many, my lord? What is the percentage, my lord? What's
that I have seen. Yes.
I'll tell you, lordships, why. They did not want, my lord, fuel to be burnt. Supposing, my lord, they want to, my lord, import it from Gujarat to Karnataka. You know, you are wasting fuel, my lord, to bring fuel. Therefore, my lord, they wanted, my lord, zone wise, and therefore, my lord, page 90, bullet point number 2, last sentence. Supply will participate in the quantity bids floated by OMCs for their location wise requirement of ethanol. Then, my lord, quantity bids. Sorry.
Yes, yes, sir.
Quantity bids, third bullet point. Quantity bids shall, for full requirement of ethanol year, that
Shall
will not
be
supply
released,
year,
yes.
ESY, shall be released at the beginning of the ESY. OMC shall offtake and the supplier shall provide the quantities of ethanol as agreed in the annual allocation plan. Rest, my lord, then, my lord, 1, 2, 3, fifth bullet point. All allocations, subsequent reallocation, my lord, please mark this again. All allocations, subsequent reallocation will be carried out at the discretion of the OMC. LOA will be issued by individual OMCs for allocated quantity. Supplier will sign an annual contract agreement with each OMCs for the allocated quantity after submitting so on, so on. My lord, this was the procedure that was contemplated, my lord, in the tender itself. And now please come to, my lord, LTO itself. This is made a part of the contract itself.
Page
12, my lord, page 150. 150. All terms. That's why I said inconvenience, my lord. They did not produce it. Anyway, my lord, it's not. My lord, I'm sure my learned friend, my lord, was not there. We seniors, my lord, come here. My lord.
Yes.
Please look at my lord, 12.14. All terms and conditions mentioned in the expression of interest, letter of intent issued by the OMCs and buyers in relation to signing the agreement.
12.1.
Yes, 12.1, 1.2.14.
1.2.14.
Page 150.
ಅದೇ ಅಲ್ಲಿದೆ 12 point. Yes.
All terms and conditions mentioned in the EOI, letter of intent issued by the OMCs, buyers in relation to signing of the agreement shall be deemed to included in this agreement by reference. Therefore, my lord, clause para 10 of the procurement process, my lord, which was there, is what, my lord, they said will be followed in future by, my lord, the OMCs and also, my lord, by the successful bidders. Petitioner was one successful bidder. He knew this. That's why, my lord, he did not produce this. That's my, of course, technical allegation, my lord, statement. But the fact is, 10 has to be followed. 10, my lord, specifies. Then, my lord, please, since your lords are at 150, please look at 2.1.
Supply, seller.
Yes. Seller agrees to supply. Buyer agrees to purchase. Ethanol under the terms and conditions in the quantities. Supply price determined in accordance with and subject to the terms and conditions of this agreement. Then, my lord, paragraph clause 2.2. Ethanol plant, my lord, will be at, my lord, 1.44. That your lordships have seen. 2.4. OMCs, my lord, will be entitled to appoint suppliers for the supply of ethanol at designated location. My lord, again, my lord, designated location. Seller agrees not to dispute, object, challenge the appointment of other sellers, suppliers of ethanol for designated locations. That's why, my lord, designated locations, your lordship saw, my lord, in this. And if your lordships come to, my lord, our statement of objections, my lord, we have filed. Court of, madam.
Yes,
Namdondu statement of objections of 5 to 11 ಅಂತ ಹಾಕಿದೀವಿ. ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಬೇಕಾ?
ಕಾಪಿ ಉಂಟಾ?
ಇದೆಯಾ? ಇಲ್ಲೇ ನೋಡಿ ಮೇಡಮ್, ಇಲ್ಲಿದೆ ನೋಡಿ, ಎಕ್ಸ್ಟ್ರಾ ಕಾಪಿ ಒಂದು ಇದೆ ನೋಡಿ.
ಮೇಡಮ್ ಕಾಪಿ ತಗೊಂಡು.
ಇಲ್ಲ, ಸ್ವಲ್ಪ ದಪ್ಪ ಇದೆ ಅಮ್ಮ, ಪರವಾಗಿಲ್ಲ, ಇಲ್ಲದೆ ರೀತಿ ತಗೊಳ್ಳಿ. Statement of objections on behalf of respondents 5 to 11 ಅಂತಿದೆ. ಇಲ್ಲಮ್ಮ,
ಇಲ್ಲ ಅದೇ ಕೊಡಿ.
ಇಲ್ಲಮ್ಮ, ಅದಲ್ಲ 5 to 11 ಅದಲ್ಲ, ಅದು ರಿಟ್ ಪಿಟಿಷನ್ ಇರಬೇಕು.
ಅಲ್ಲ, ಅದೇ ಕೊಟ್ಬಿಡಿ ಸರ್. ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಉಂಟಾ?
ಇದೆ.
ಹಾಗಾದ್ರೆ ಕೊಡಿ.
Please come to, my lord, EOI 2.
Page, sir.
Please come to running page, my lord, 81. Sorry, 105. 105.
I am there. Yes.
This is, my lord. Sorry.
No, my lord. Contract is this is contract.
1 minute, my lord. No, not that. Sorry. EOI. Where is that? 53, my lord. Sorry. 53. That's, my lord, the second EOI they floated. That's also not produced by them.
Yes.
If your lordship look at, my lord, the top expression of interest for signing long-term offtake agreement with the upcoming dedicated ethanol plants in the states of Tamil Nadu, Kerala, Andhra Pradesh, Telangana, only a specific state. Karnataka is not there. Why, my lord, I am pointing this out is, please come to, my lord, table 1 at page 54 of this document. Tamil Nadu, my lord, what, my lord, they were all deficit. Yes, deficit states. That's why, my lord, this is what, my lord, this is the reason.
Karnataka is not a deficit state, so that is not there.
Correct. Therefore, my lord, this location-wise, my lord, supplies is, my lord, a prominent, my lord, object of, my lord, this entire EOI 1 and 2. Then, my lord, what happens is, if your lordships look at the L2A, my lord, their agreement itself. If your lordships come to, my lord, your lordship, my lord, I pointed out, my lord, clause 2.2. Please come to, my lord, 6.1, 152 page. Adralli.
Yes.
Again, my lord, 6.1 refers to, my lord, location-wise, my lord, requirement of ethanol. Last sentence, Bharat. Then, if your lordships come, why, my lord, I pointed out is, earlier also, my lord, it said location-wise, 2.1. Either, you know, location-wise. Now, please come to, my lord, 6.6. Ethanol so produced from additional capacity stated in 6.5 may be procured through prevailing ethanol procurement process followed by OMCs or private OMCs on need basis. So, my lord, it was a need basis, my lord. This is what, my lord, they've entered into this agreement. Then, my lord, 6.8. In the EOI floated for setting up the dedicated ethanol units, in case the bidder is being issued LOI for the quantity lesser than the quantity which they have bid, then, my lord, best endeavor basis. My submission to your lordship is best endeavor basis, my lord, can only be, my lord, not something, my lord, which can be that, my lord, we will check out everybody and I'll give it to you only. It is, my lord, the best endeavor has been, my lord, interpreted as a reasonable, my lord, this thing. There are a couple of judgments. One judgment I'll give you, lordship, my lord, for the convenience compilation. What happened? Give it to the judge. Give one to the AG. What is this? Give one to the judge first. Judge record there. My lord, there is a judgment.
Best endeavor.
Best endeavor. That is, my lord, interpreted. In, my lord, in what manner can it be interpreted? Strictly, but, my lord, sometimes, my lord, we overreact. Please come to, my lord, paragraph, page 5.
No, there should be best endeavor here also. Yes.
As regards the first point, my lords, get that page 5. Third unnumbered paragraph from the bottom, my lord.
Yes.
As regards this first point, it seems to be desirable at the outset.
Marked it. I'll see. I'll go through it.
I have put, my lord, if your lordship sees, I have put, my lord, the
paragraphs
paragraph
highlight ಇದೆ.
ನಾನು paragraph ಹಾಕೊಡ್ತೀನಿ ಬೇಕಾದ್ರೆ ತಮಗೆ.
ಅಲ್ಲ ಇಲ್ಲಿದೆ highlight it is good that it is like this.
Right.
Whoever has done it correct, it's good that it is like this so that I need not wander everywhere.
Second judgment ಅಲ್ಲಿ paragraph 18 ಅಲ್ಲಿ ಅದು ಮಾರ್ಕ್ ಆಗಿಲ್ಲ. ಅದು
paragraph ಇದೆಯಾ?
Paragraph 7, my lord. Bottom, my lord, of page 18.
Paragraph index ಅಲ್ಲಿ ಹಾಕಿಲ್ಲ paragraph.
ಇಲ್ಲಿ ನಾನು ನಾರ್ಮಲಿ ಹಾಕ್ತಾ ಇದ್ದೆ, ಅವರೇ ಮಾಡಿದ್ರು. ಸೊ paragraph 7, my lord.
ಇಂಡೆಕ್ಸ್ ಅಲ್ಲಿ paragraph
ಹಾಕಿಲ್ಲ, ಹಾಕ್ತೀನಿ ನಾನು. ಅದೇ ನಾನು ಹಾಕೊಡ್ತೀನಿ ನಾನು. ಬೇರೆದರೆಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ. Interpreting contractual terms, my lord, I will skip all that. Then, my lord, if your lords come to the next judgment at next page, Food Corporation of Kamadhenudರಲ್ಲಿ, please come to, my lord, paragraph, my lord, 8. Why I am pointing this out is page 71.
Yes.
71. Because, my lord, AG has, Attorney General has given, my lord, number of judgments. This is, my lord.
ಕಾಮಧೇನು ಕ್ಯಾಟಲ್ ಫೀಡ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಷ್ಟೇ, ಇದು ತಮಗೆ ಗೊತ್ತಿರೋದೇನೆ. Page numbers are wrong. This is wonderful. My lord, ಅದು ಪೇಜ್ ನಂಬರ್ ಅನ್ನು ರಾಂಗ್ ಹಾಕಿದಾರಂತೆ. ನಾನು ಇದನ್ನ ಕೊಟ್ಬಿಡ್ತೀನಿ.
ಇಲ್ಲ, ಕರೆಕ್ಟ್ ಮಾಡಿ ಕೊಡಿ.
ಪ್ಯಾರಾಗ್ರಾಫ್ ಹಾಕೊಡ್ತೀನಿ ನಾನು.
Even the paragraphs in the index.
I'll put that and then half an hour ಅಲ್ಲ ಈಗಲೇ 10 minutes we'll give it.
Yes, sir.
Then, my lord, if my lords come to, my lord, I have prepared, my lord, one list of dates and synopsis just to assist, my lord. Not that it's easy. We will.
ಅದೇ ಕೊಡಿ. ಅಲ್ಲೇ ಕೊಡಿ. Yes, sir.
My lord, that procurement process para 10 ಇದು ಹಾಕಿದ್ದೀನಿ. Clause 10 which I read, my lord, earlier. First page ಅಲ್ಲಿ last ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ.
Yes.
Para 10, my lord, clause 10 of that EOI 1 sets out, my lord, all this. Then, if your lordships turn the page over, his application, my lord, he, my lord, says 9.2. No, it's not 9.2. It is, my lord, 6. My lord, if your lordship look at, my lord, the EOI 1, page 82, specifically says design capacity, in what manner it has to be, my lord, computed. Para 2 nalli, I have set out it, my lord, it comes to only 6.15, not 9.26 as they are saying. Computation is, my lord, in what manner it has to be done. Please look at, my lord, the EOI itself, 1 nalli is there. There is a formula indicated.
That's what the learned attorney also read.
Yes. Therefore, my lord, it is only 6.15 liters is the design capacity. My lord, design capacity which they bid, only that they can, my lord, take into account, not, my lord, what they have subsequently, my lord, increased. Then Long-term elderly, none, I have put out, my lord, all this. Relevant clauses of the agreement, my lord, what they are, my lord, I have put it out. Petitioner, my lord, is free to set up annual design capacity offered in its application. And tell you, adu, clause 6.5 ಅಲ್ಲಿ ಇದೆ. If your lordships come to my lord, page 152 of this convenience compilation.
I'm there.
Yes, 6.5. Shortlisted bidder is free to set up plant up to the annual design capacity offered in his application. Up to the design capacity offered in his. That's why my lord is 6.15, not 9.25. Then the clause 6.9, if your lordships come to my lord on the next page. 153.
I'm there, sir.
EOI for quantity bids for full requirement of ESY shall be floated prior to the start of ESY to the registered vendors only. Thereafter, EOI for the quantity bids shall be floated for the shortfall quantity, addition requirement if any, purely based on requirement of the buyer. Location wise, my lord, again, my lord, again and again, my lord, location wise, individual OMC wise, quantity to be supplied in each ESY quarter shall be allocated to the seller buyer as per the prevalent allocation criteria. My lord, they can't say in the light of, my lord, clause 10 of the EOI 1, in the light of, my lord, this very, my lord, clause in the LTOA itself, they can't say, my lord, they have a monopoly. And, my lord, the contractual terms, my lord, my submission to your lord is, first of all, for, my lord, the legitimate expectation to, my lord, apply, contractual terms, my lord, must be, my lord, in their favor. In fact, contractual terms are not in their favor, would be my submission. Therefore, legitimate expectation, my lord, does not apply. Assuming for the sake of argument, my lord, legitimate expectation, then, my lord, public interest and all that, my lord, has been argued. I don't want to, my lord.
Legitimately does not apply.
Then, my lord, all allocations, B, 6.9 only. It's, my lord, they set out the whole thing. Therefore, my lord, my submission to your lordship is that, my lord, they have, my lord, been not successful. They have got, my lord, 3.19, notwithstanding, my lord, they are entitled, my lord, 1.44. My submission is that, my lord, they are not entitled to this. Lastly, my lord, my submission to your lordship is, look at, my lord, paragraph, my lord, annexure 3 of that EOI 2, page 185. Just one this thing, my lord, I'll point out.
Yes, sir.
185. Allocation methodology. Idrally, if your lordship sees, bidder shall quote only the total ethanol quantity to be supplied by them against quarterly so and so, so and so. Then, following states and union territories, please look at this, my lord, mapped as zones for allocation methodology. All northeastern states, my lord, in one, Chandigarh and Punjab one, Tamil Nadu and Puducherry one, the Gujarat, Dadra, Nagar, Haveli and Daman. This is, my lord, the second EOI. Why, my lord, again and again I'm pointing out is location wise, my lord, is what is, my lord, harped upon, my lord, less stressed, my lord, at every, my lord, turn and twist I'm telling. In fact, if your lordship look at, my lord, 185 only, after that Punjab, Tamil Nadu, Gujarat, Jammu, last sentence.
All other balanced states shall be defined as standalone
zones. Zone wise, my lord, therefore, my lord, they are saying shall be mapped zone wise. Again, my lord, location, again and again location, zone wise. Therefore, my lord, there are some, my lord, methodology. Even in, they say there's some methodology in madness also. This, my lord, ethanol, what happens is they had to, my lord, increase ethanol. In the light of, my lord, what has happened, my lord, in Iran, my lord, it's good that, my lord, we have 20%, my lord, petrol, my lord.
No, but we have no problem. That's what is said.
And lastly, my lord, if total quantity offered by all other LNA, after that balance state, page 185, if total quantity offered by all participating vendors for a quarter is less than the requirement, my lord, whole of it should be given. In case, my lord, offered by all next to. However, in case the total quantity offered by all participating vendors for a quarter is more than the total requirement of OMCs for the said quarter, following methodology shall be adopted for accepting the offers for the quarter and subsequent allocation. What are they? The zones, again, my lord, zones. Zone where the offers from the distilleries located within the zones are less than the requirement of that zone, they shall be considered as deficit zones. For these zones, offers from the vendor shall be accepted in full and for allocation. Second bullet point. Zones where the offers from the vendors located within the zone is more than the requirement of that zone, they shall be considered as surplus zone. For these surplus zones, first preference, my lord, is to sugar, my lord, cooperatives. Only last layer. Last but one bullet point. Then, my lord, LTO agreement holders. Therefore, my submission is that, my lord, there are, my lord, methodologies which are indicated, my lord, in the OM, my lord, EOI, which is part of the agreement, and, my lord, they deliberately, my lord, did not produce that. Therefore, my lord, my submission to your lord, you see, the writ petition, my lord, is devoid of merit, my lord. Illere ನಾವು ಇದನ್ನ ಮಾಡ್ತಾನೆ ಇರ್ತೀವಿ. More than this, I don't want, my lord. Anything else? Yeah, give it to him. Please, my lord, 89 ತಾವು ಬಂದ್ರೆ in the convenience compilation.
Yes.
Last supply 9 ಅಂತ ಬರುತ್ತೆ.
89
page. Last ಅಲ್ಲಿ supply condition. Suppliers need to supply the complete production quantity to OMCs only. However, with written permission, OMCs supplier can supply
private oil.
In fact, I am told that, my lord, the Reliance and, my lord, Nayara are, my lord, purchasing, my lord.
That's what POSR also told.
That's right. Therefore, correctly, okay. At least in 10 you should have done, no? All right. My lord, paragraph ಹಾಕಿದ್ದಾರೆ. I normally do that, but that's all, my lord. Therefore, my lord, my submission is that this, my lord, petition is devoid of merits and liable to be dismissed. Come.
They always seem to be speaking last.
No, last
Sir?
man is always, you know,
Yes,
the best,
always.
best, my lord, voice.
Last and least. I want to place it on only one point. Like in Salmon, Lord, right is equal to duty. Right creates an obligation for duty. In this case, Lord, if there's an obligation, there's breach. But if there's an expectation, there's only hope.
That's what. Every grievance cannot give a right.
Can't give a right. Therefore, today all your lordships have in this case is a hope. The hope that I can get up to my maximum design capacity, which was an option given to me under the contract. I could choose to do it. I could choose not to do it. If I did it, there could be a scenario tomorrow, my lord, where the contract can be amended to increase the design capacity from annual offtake capacity from 1.44 to whatever is the capacity. Therefore, the contract makes it very clear that if it has to create an obligation, there has to be an amendment. Your lordship recollects that clause.
Amendment, yes.
No. In the contract itself, there is one clause.
Correct. Adanna attorney read it out.
Yes, Lord.
Page ಹೇಳಿ.
Lordship may kindly see clause 5. I'm sorry, clause 6.7. 6.7. Annual
amendment in future.
Yes. Which this, my lord, is a clear indication of the fact that if in future it is going to be enhanced from 1.44 to 5 or 6 or 2,
So
there has to be an
this has
amendment.
to be amended.
So if it is not amended, there has a consequence, which is why I'm saying when you say and argue legitimate expectation as they're trying to argue, my lord, legitimate expectation in the context of a contract is simply fairness. That I should be treated fairly because it is only a doctrine, my lord, to prevent arbitrariness. But when there's a contract which provides for a mechanism by which your right will be enhanced by amendment, it necessarily means that what is not there cannot become a right simply because it is contained in clause 6.8. 6.8 therefore indicates only an expression of an expectation from them which results in a hope that they may give me more. But that does not create an enforceable right. For it to be an enforceable right, Lord, it should come under 6.7. The day it is amended, it becomes enforceable. The day until it is amended, it remains a hope or an expectation from the petitioner. Now, my lord, I represent Indian Sugar Manufacturers Association, which has, my lord, about 67 who've been awarded the contract in this case after a process of tendering.
You have an agreement with you?
No, I don't have a dedicated agreement. I'm saying
Holder's clients have an agreement. Yeah, you have the offtake agreement you have with you?
Dedicated, not LTOs. We don't have LTOs. We don't have
LTO ಅವರು ಇಲ್ಲಲ್ಲ?
We are only awarded the
ಅವ್ರ ಹತ್ರ ಇದೆ.
contract.
ನಿಮ್ಮ ಹತ್ರ ಇದೆ.
But there is a slight difference in our case. In our case, not under the 2018 policy, all sugar manufacturers were encouraged, my lord, to start ethanol plants. So we also started ethanol plants. Under that, my lord, there was a subvention benefit given to us, subject to one condition that you must give 75% to oil manufacturing companies. Therefore, it becomes a question of ultimately balancing. of competing interests. Because my lord, the second I'm told I should supply 75% of my capacity to an oil manufacturing company, it casts an obligation on me not to sell the 75% to anyone else.
Correct.
Therefore, my lord, 75% the oil manufacturing companies must lift from us. What I'm pointing out is only this, my lord. In a host of circumstances where there are competing alternatives and there are competing requirements to be met by oil manufacturing companies as well as the government, then the government has an obligation to ensure everyone's interests are protected, not just an expectation from one of the parties. And that I've produced, my lord, along with my statement of objections, the notification issued by the government, where, my lord, I was given a benefit of interest rate benefit and therefore a consequent obligation on my part to give 75%. And ultimately, it's a commercial bargain. He was given 1.44. His commercial bargain was
3.92. It has already
not
gone.
that. The commercial bargain in the contract. In the contract is, it is up to you. I am not asking you to do it. The oil manufacturing companies never said it is, I require you to do it. It is up to you, which is, my lord, what clause 6.5 is.
Yes.
You are free to set it up. My lord, all I'm saying is, in a reading of all
There
these
is free to set up a plant
you
according
can
to
set up a plant higher than 1.44, or you can let me. If, my lord, ultimately you want to take a chance, you take a chance. But if you take a chance, you can't turn on make it an
So
obligation.
merely because you have set up a plant of 1 lakh crore for it, not doesn't mean that OEM should
Take
give
it.
that.
No, Manish, therefore I'm saying, if it was your option, you can't change your option to someone else's obligation. The right obligation, duty, principle, not in my humble submission, apply to this case as well.
Wants more now.
He wants more, of course. Everyone wants more, Lord. You know, like in Oliver Twist.
So that is why
Oliver Twist also wanted more.
Hello.
But all he got, Lord, was
that is why a dil mange more will not give any right. Yes.
I have same judgments.
Sorry, sir, I did not see.
I didn't want to interrupt my learned friend. We are going to certainly hear a treat from him. Since I used the words, there is a distinction between anticipation and expectation.
Expectation.
I thought I should not be wrong. I just want to read out what exactly is the distinction. Expectation is a firm, often rigid belief that a specific outcome will happen.
Yes.
Frequently leading to disappointment if unmet. Anticipation is an eager, positive looking forward to an event, allowing for flexibility and excitement.
Additional statement. So this is anticipation. That is excitement. Excitement of success. Yes, sir. So ellardu aitalla? Yes, sir.
some judge with same legitimate expectation. Yes.
But the learned attorney general said, we can't put the clock back. I know not my clock is ticking.
Don't worry about it, sir.
No, but still not.
No, I will shut my eyes on the clock. You can carry on. Yes.
But I want to factually, in a minute, clear this confusion relating to the design capacity. What is my design capacity as admitted by them, not in dispute? One sentence in their additional statement of objection, Lords may kindly see. Additional statement of objection filed by the OMCs. By OMC.
CV Angadi antiದೆ ನೋಡಿ. ಒಂದು green sheet ಅಲ್ಲಿ. Yes.
In that note, in their additional statement of objection, paragraph 17, Lords may kindly see.
17.
17.
Yes, sir. Under clause 6.2.
Yes, there they say, Lords, may I request Lordships to kindly see 18. No, this
17 or 18?
No, this is one second. I'll just, there are two sets of statement of objections there.
I am holding additional filed on 4/4/26.
I'll just point out. Let's kindly see para 7. I'm sorry. Para 7 in that additional statement.
Yes, sir. In the above background.
Yes. In the above background, it may be noted that an expression of interest dated 27/8/2021 was floated by OMCs for signing long-term bipartite agreement with upcoming dedicated ethanol plants in ethanol deficit states for supply of denatured anhydrous ethanol to OMCs. The copy of the notification inviting so and so is produced as Annexure R8. Kindly see the next sentence. The petitioner participated in the said EOI with its planned capacity of 6.1 crore liters, even according to them. Copy of the bid document as submitted by the petitioner is produced as Annexure R9. Now, Lordships may kindly see R9. When in 2021, when I filed my application indicating my design capacity at page 178, how I indicated. Page 178, Lordships may kindly see me. I said my design capacity is page 178.
I'm there.
Design capacity is 300 days. Sorry, 300 KLPD. That's kiloliters per day. For that year, I said 205 days.
Yes.
That comes up to 615.
Yes.
But I do not want to really enter into the controversy as to whether it is 6.15 or 9.3 crores, because we are really requesting your Lordships to interpret 6.2 or 6.8. Whatever be the design capacity, they are bound to memo. They are 9 crore in their IEM. The reason why this happens, the design capacity is always calculated on the basis of what is my capacity to produce ethanol on a per day basis. That is 300 KLPD. There is no dispute between us. I can thereafter plan my operations 100 days, 200 days, or 300 days. Accordingly, it increases. For that year, I said 600 and 205 days. Therefore, it became 6.16 crores. Thereafter, I said I can manufacture more. It is 9.3 crores. Now, interestingly, that I will explain. That Lordships have seen how design capacity is manufactured. But in their website, which reflects my design capacity, I want to produce that memo, which shows that my design capacity is 9 crore. 90,000 litre, 990. Please give that memo. Esther, give me that memo, new memo website. This is their website. From their website about VIMPL, Lordships may kindly see. Yes, kindly see, it's not numbered, but if Lordships are to see
300 ಅಂತ ಇದೆ ಇಲ್ಲಿ.
300 ಕೆಳಗಡೆ annual production capacity 99,000.
9893. Yes.
There's no dispute about that, and the fact that they have given us more than 1.4.
Even on their website, it is the same.
Yes.
We are saying.
Now, the learned Attorney General, I must say, without any hesitation, in all humility, has given a vivid explanation about the ethanol scenario of the country and also the law relating to public policy. I cannot obviously have any dispute, but that may not really address the issue which we have raised before your Lordships. Number one, and I'm quite unequivocal in making this statement. In this case, for the purposes of Lordships' interpretation of the agreement, there is no public policy element. Lordships may kindly note. Though state or its instrumentalities, whenever they deal, there is always a public interest involved. But what is that we have requested Lordships to interpret, there is no public policy element, number one. There is no public interest involved in the sense that their decisions is based on public interest. In fact, the public policy statement is what I began my argument by placing before your Lordships, the Niti Aayog statement. That Niti Aayog statement says, please take steps to procure ethanol to meet the 20% target, and for that purpose, enter into agreements wherein you bind people like us to supply to them. Therefore, the L2AK. There has been thereafter no change of public policy by which they have been asked to go against this contract or procure ethanol from other non-DEPs overriding the contract. So there has been no public policy element, is my respectful submission to your Lordships. Then Lordships may kindly see, the other argument which was advanced is, in exercise of statutory power, you cannot bind me if I act in public interest. This is the second limb of the argument of the learned Attorney General. This is not a statutory power at all. This is purely contractual in nature. Therefore, the question of they deviating from any statutory power vested in them in taking the present action does not arise. Lordships may kindly take note of them. I'll make a short note and hand it over, my lords, later. But then there was a reference about the order of the Honorable Supreme Court arising out of the interim order.
Yes.
But I must place.
No, that's only interim order.
No,
The apex court has said to consider every aspect.
Also make it very clear that we are very conscious to say we do not express anything on merits. It is for the High Court to decide
Correct.
the matter.
That is
on
what
merits.
para 22 onwards. That is what
I
is
just wanted to.
correct. Nobody says.
No, I'm not. There was
No,
one.
this much argument was not needed at all. If apex court had said one more line extra.
Just pointing. Then, Lord, this is a another attractive argument, which says that we are asking lordships to rewrite the contract. But my answer before your lordships is, it's true that someone is asking lordships to rewrite the contract. It is not us, but they. And I like demonstrate your lordships how. By asking your lordships to completely obliterate 6.8, they want lordships to rewrite the contract. All that we are saying is we do not want to rewrite the contract. We are reading the contract as it is. All that we are asking your lordships is kindly read 6.8 and see as to whether they are obligated to fulfill their obligations as promised by them in 6.8. The question of rewriting the contract does not arise. In fact, a word was used by the learned attorney saying that assuming it is vanished. No,
6.8.
6. If it is vanished, that amounts to rewriting the contract. If their action is today accepted that we will not give preference, it amounts to rewriting the contract. So that is rewriting the contract and not certainly the submission of ours. And that other submission was connected that for the future, you may include it. All that it says is annual offtake quantity is 1.44. 6.8 is over and above 1.44. You can increase 1.44. That is all it means. But today we are not asking for increase of 1.44 at all.
So you are asking for whatever ethanol you have produced in this, you should be bought.
It should be purchased by them.
That is what you are asking.
Yes, additional offtake quantity. Now, lords, is this argument? Sorry. No, I'll come. The argument of anticipation and expectation. But I'll address legitimate expectation little later.
Little later?
Immediately after this.
Yes. All right.
Immediately after this.
Right.
But my answer to this anticipation and expectation is one way they're right. If lordships have to see 6.8, it starts by saying 1.44 we'll purchase.
Yes.
6.8 we may offer. That is our anticipation. Our anticipation is they may offer. Once they offer, then it becomes an expectation that they will give.
Once they offer.
Once they offer, no, I'm coming to. Once they offer, then it becomes our expectation that you will fulfill the priority clause which you.
No, they have not at all offered.
They offered.
They offer. That is 3.92 varige.
No, but I'll explain. They offered more than 1.4.
Correct.
They offered more than 1.4. But this is not an offer just to us. When the demand is more, they invoked 6.8. But I will revisit this argument once.
See, because to achieve the 20% demand became more.
Yes.
So then they offered 1.44 is the contract. But if you can you give us more, so they gave you an option, then option first. So 3.92 varagu hoytadu. 1.44 went to 3.92, but it is not in accordance with the 6.8.
That's exactly
where they had,
in fact,
where they had assured that they would take everything. That is what you legitimately expect.
That's it. Therefore, from anticipation to expectation is within 6.8 itself. It is not that I was anticipating this. I was not, but I was sure once they decide.
Anticipation to expectation.
No, it happens because if they decided this year only 1.44 we are going to take, anticipation would have stopped there. But that is the answer insofar as that is concerned.
Nowadays, Lord, we have a legitimate expectation. Your lordship will sit till 7:38.
That's the problem.
True. I hope everybody at home understands that they have a different legitimate expectation. Correct. That we go back home at 4:30.
No, maneg hodmele there is only one expectation. That bada bidi.
No, their legitimate expectation is 4:30 maneg hogtivi anta.
Yes.
Now let's So therefore, my lord, this anticipation, expectation are very catchy words, but when no, I'm just bringing to lordship's notice. Even if we have to answer those words, also it is exactly like that. But kindly see this best endeavor basis. A best endeavor basis, according to the learned Attorney General, without meaning anything, is that we try to see what is the demand, and among what is available, we distribute it as much as possible. We do. My most respectful submission to your lordships is that
one clarification.
Yes, ma'am.
Now this best endeavor basis is what is said. Now your plant is already there. You are producing ethanol.
True.
When you are producing ethanol in terms of 6.8, to take it from you is good, or again go in for search of ethanol or take it from them?
Yes. Well, I will answer the same thing. But if they have a choice,
no, they do have discretion. It is not that 6.8 binds them that they should take only from you.
No, I'll just answer that. If they have choice of more than one supplier, I'll pause here for a minute. If they have a choice of more than one supplier, preference should be given to us. And I don't say it. This is exactly the word of 6.8 as it ends, which says, if we take more than what is offered in the 1.44, it will be, the procurement process will be through priority. But that word is not insignificant. It is very, very significant. Priority simply means I being given preference over others. Who are the others? It is Mr. Holla's clients or Mr. Jan's client or Mr. Sajan's clients. We cannot be treated together. We must be given priority over others. Simple. The reason.
Because of 6.8.
6.8, because, my lord, I have set up this plant because of this contract. Today, my lord, none of them have set up this plant with any promise that they will 6.8 is there.
Holla sir's clients?
No, 6.8 illa. 6.8 is not there in their contract. No, I have the contract.
It's here.
6.8 is not, and I'll tell you why 6.8 is not there. But the oil companies realized that we have signed with DEP so much, we don't require any more. Therefore, for others, they started saying that we will buy it. Today, my lord, for what we are placed at a situation as if there is no contract at all.
You have a contract. Yes.
No, today, if we are
the market difference between your status to the others is you have a contract.
We have a contract which gives us priority, and this is all. Let's see that is, and that connected argument of departing from contractual terms in public interest, according to me,
that is not there.
Is a misnomer. There is nothing like you can't sign a firm contract and then say I go out of it by way of public policy. Sorry, public interest. Unless, my lords, they invoke force majeure clause, which is a part of it.
That's not.
No, I'm just bringing to lordship, or they terminate the contract. Then, the argument of qualified acceptance was made under section 7. I have to answer that. The qualified acceptance is if we again, same. The answer is the same. If we offer, that is the qualification. Once they offer it, they are bound to adhere to the priority. That is the answer under for section 7. Then I want to refer.
Learned attorney referred to section 7 of the Contract Act to contend that you have accepted the terms of the contract. It has become absolute.
True.
6.8 is also a term of the contract, but it is hedged by conditions under 6.2.
Yes.
Where once 6.2 you have offered, you are given some offer which you have accepted 1.44 liters.
Correct.
Then 6.8 kicks in only as a discretion to add up if they want it.
But I will.
That's the submission.
That is
if
the
I have
submission,
understood
and
correctly.
I will, to a great extent, that part of the submission is correct. And I'll answer your lordships to this extent. The discretion or the decision to procure more than 1.44 crore liters is theirs.
Correct.
But it is only the discretion once you exercise 6.8. All that I'm saying is once you exercise that 6.8 and I bid more than what is, that's what the wording is. If I have bid more than the annual offtake quantity, your bid will be considered, that is whatever I have bid, 9.9 crores in this.
Correct.
In priority over others. Today, what is the answer they are giving is, no, I can't give him 9.9 because I have to give it to Mr. Uday Hola, I have to give it to Mr. Dhyan Chandappa, and I have to give it to Mr. Sajid Pal. That is where this priority comes. That's all I'm saying. That qualified acceptance is this. That qualification is their decision to buy more. But it's simple. If the demand is more and there are more suppliers, you give preference to us. If the demand is more, if the demand is less, then
Demand obviously is more. There is no doubt.
When the supply is more, than the requirement,
We'll
then
consider.
how do you prioritize? You prioritize by contractual persons.
Let's see.
But I'll just complete. I have a couple of other submissions to be made very quickly.
Couple of other submissions.
Section 30, no,
yes.
section 32, I just want to point. Contingent contract. They all were almost suggesting that this is a contingent contract.
Because it is conditional on 6.8 is a contingent is what you say.
Assuming if it is contingent.
Because
on
in the
happening-
event demand is more, they should give take it. So it becomes a contingent
They
contract.
take a decision. That is 32 minutes. Then minutes, the 37 parties to the contract set of promises. These are all set of promises made mutually and they require to be accepted. Which is that? What is this? No, I'll come. I'll just answer. But then, Lordships may permit me to this concept of doctrine of legitimate expectation. On that. I must bring to Lordships notice, as I have understood, and this is what now the Honorable Supreme, the latest judgment of 2026, authored by Lordship Justice Parthival.
Alokara. 26 is Alokara.
ಇನ್ನೊಂದು ಲೇಟೆಸ್ಟ್ ಬಂದಿದೆ
ಕೊಡಿ.
His Lordship Justice Parthival judgment. There, I'll just state the proposition of law. What their Lordships actually makes a distinction is, though the doctrine of promissory estoppel and doctrine of legitimate expectation try to achieve the same object, doctrine of promissory estoppel operates in private law, that is contractual law.
Yes.
And legitimate expectation operates in public law when there is no contract. Though, my lord, sometimes they overlap. But this is, I had marked.
IFGL.
IFG. May I request Lordships to permit me to first refer to paragraph 100. I won't read the whole thing. Para 100. Under English law, the doctrine of promissory estoppel has evolved alongside the doctrine of legitimate expectation. The latter is anchored in the principles of fairness in public administration and is attracted when a public authority by its representations or conduct leads an individual to entertain an expectation of receiving a substantiative benefit. The contours of doctrine so and so. Kindly skip all that note. Kindly see para 101. Under English law, the doctrine of legitimate expectation initially emerged within the domain of public law as an analog to the doctrine of promissory estoppel in private law. Over time, however, English law has drawn a clear distinction between the two, treating legitimate expectation and promissory estoppel as discrete remedies operating in spheres of public law and private law, respectively. Now, let's kindly see para 103. This is the well-settled position. Consequently, while the basis of the doctrine of promissory estoppel in private law is the promise made between the two parties, the basis of the doctrine of legitimate expectation in public law is premised on the principles of fairness and non-arbitrariness surrounding the conduct of public authority. But in this case, both of them apply. First is not my right is on the ground of promissory estoppel based on the contract. Legitimate expectation is an alternative argument saying that you allowed me to set up the bank. In the EOI, when you set up, which you issued in 2021, you made me believe.
Para 123 is the ratio.
Please. Assurance was not limited to qualified one. It was not intended to mean the benefit would be available only until the industry came. Lordship, sir.
Yes, sir.
123 is Lordship's referred. 121.
121, 122,
Yes.
123.
Yes. So this Lords would be the issue relating to promissory estoppel. Therefore, my submission to your Lordships is.
So what the state should do is at para 134.
Yes.
Then,
Yes. I marked it.
All
In
right.
fact, I marked it. I knew exactly, but somehow I couldn't read it because of the time constraint.
Because state is a contracting party.
I know,
here.
we cannot colonial conception itself a sovereign dispensing absolute
Yes.
discretion. No matter why I took that effort to bring to Lordship's notice is this, when they were, so this is an alternative argument, but by virtue of the contract, they are bound. Of course, alternatively, my lords, I was expected. The reason why I say my lord, legitimate expectation is, give me the last 3 years. Preference.
ನೀವು ಜನೌಷಧಿ ಕೇಂದ್ರದ ಯಾಕೆ ಹಾಕಿದ್ದೀರಾ?
ಅದರಲ್ಲಿ legitimate Mogaire's case, that is.
Correct.
Lordships
That
have
is ಜನೌಷಧಿ ಕೇಂದ್ರ.
Yes, yes. Their lordships have referred to this.
No, there it was public interest was involved.
Correct, correct. Last year. Lords, I just this then. One second.
See, that is why illi why I wrote that is.
Please.
The state cannot in the hottest haste summarily pull the rug beneath the feet without compelling public interest.
True.
Public.
Yes. No, that's exactly that. That's what the lordship is also. Unless there is a overwhelming.
That's what I'm saying.
Yes, it is now. No, I'm not in all fair challenging any malice against them. It is a decision which they have taken arbitrarily in preferring, in treating all of us.
So the argument is you need not challenge the clause.
We need not.
You only want
No, I will.
the interpretation of that clause.
Yes, clause. Now, Lord, about this argument which has been advanced by Mr. Sajan Povaya, Major, I did not challenge the entire. Lord, I was just asking him about that Kannada Gade, whether I call my son-in-law, Aliyanna Magalaganda, it's the same thing. I am contract. No, I am saying, Lord's contract. I am saying, this is an argument where they say we violate the contract, issue a tender document which is on the teeth of it is illegal, but if you do not challenge, you do not enforce the contract. I am saying the same thing. I am saying I want the contract to be enforced. Once the contract is enforced, everything else falls. But also kindly see the reason there is no necessity of challenge. Kindly see the contract itself once again. At page 150, 165, 164. 164.
Is it a prior commitment by them?
Sorry,
is it a prior commitment by them that they would definitely take everything?
No, they have done it.
You are saying legitimate expectation.
Last 3 years they have done it. That's what I.
Earlier they have done.
Last 3 years continuously, where they specifically said, what is it? They said priority will be given to us. That is the clause. Please give it.
ಅದರಲ್ಲಿ ಆರ್ಟಿಕಲ್ 14 ವೈಲೇಷನ್ ಎಲ್ರಿಗೂ ಅದೇನೆ.
Last 3 years what they have done. All over the last paragraph, they have also admitted in the counter statement.
ಇರ್ಲಿ ಬಿಡಿ ಸಾಕು.
Just point. DEPs who have a long-term offtake agreement with OMCs and have been declared as commission in line with the LD shall be given first preference of allocation up to design capacity as accepted by OMCs post evaluation.
So your submission is when that is there, they cannot renege that prior commitment.
And not 1 or 3 years.
All right.
But I just want to complete this argument of tender being not challenged. 23.6 lots. I'll just read this one. I'll not.
Dispute resolution.
No. 23.6 actually says each of the parties, that is, undertake to page 164.
Each of the parties, yes.
Each of the parties here to undertake to execute, to do and take all such steps as may be required to give effect to the provisions of this agreement. They were expected to act in accordance with the agreement, not act.
Act contrary to the agreement.
Now, sorry.
Not expected to act contrary to the agreement.
And also kindly look at my situation. There is a tender called where I have the oil ready to be supplied. I have to supply whatever is given. And I bid for 9.9 crore liters. As soon as they allocated, I wrote that email, which I
that you took me through. Yes.
Therefore, that is one thing. Then they were saying, sorry, we are seeking, and then they say, Reliance, Nayar, and all, they can sell it. I have no objection if they any of them want to sell. I think that.
Sir?
admit that it is saleable to Niagara and
No,
it
no,
is-
no, there is no, it's not possible.
ಅಲ್ಲ, he will not come in the way.
We will not come in there. Alla, ಅವ್ರಿಗೆ there is no bar. For us, there is a bar.
no, I can only sell.
No, no, there is no, our, Mr.
75% I have to sell to oil
Mr. Sajjan's argument is very nice. Dedicated means what? Dedicated means I can sell to them and to 3 private companies. Obviously, ethanol cannot be, it has to be sold to oil companies only, like similar to them.
ಅಲ್ಲ, it has to be sold to oil companies.
That
It's
doesn't
not.
become dedicated. Dedicated means to them. Available to all of them is not dedicated. Exclusive. Sir, I have, sir. I'll just complete. Sir. Lords, I'll just complete this Bombay jurisdiction. I'm sure they're not very serious about it. Then, Lords, one judgment the Mr. Hollam Lord cited, that actually throws light on what we have been arguing. Mr. Hollam, I just marked it and kept. But kindly see Mr. Holla's compilation judgment which they have given. Madam, this is NBCC India Limited with Sri Ram Trivedi. But this directly answers the argument of best endeavor basis. Madam, Holla compilation.
Yes, ಯಾವುದು?
It's page 18, para 7. On what is the best endeavor?
Best endeavor.
Best, but kindly see, this answers, this in fact helps me. Clause 20. May I request? Page 18, clause 7.
Yes, sir.
Clause 20 of the letter of allotment provides that the appellant shall endeavor to complete the construction of the dwelling unit within 2.5 years from the date of the letter of allotment. The expression endeavor meant that the appellant would make an earnest effort to hand over possession by that date. Even if the expression does not mean an absolute commitment to hand over possession on or before specified date, this expression has to be read in the context of the entirety of the clause. To construe the expression as leaving the date for handing over possession indefinite and at the absolute discretion of the developer would leave the purchaser at the mercy of the builder. Clause 20 must be construed to require the builder to make all reasonable efforts to comply with the duty to hand over the possession by the stipulated duty. The burden would lie on the developer to explain the steps taken to comply with the contractual stipulation. No, their only explanation is not new players have emerged and I need to satisfy everybody else. Then what's
No, their contract stipulated something